society should be organized. We can achieve colorblind neutrality and ideological neutrality only if we refuse to assess these aspects. Kennedy's article proposes, his own practice to the contrary notwithstanding, to judge the work without considering its subject and purpose. This is an evasion of politics. 73. V. Conclusion. If there is a conceptual theme to this article, it is that of positionality, or situatedness. The individual in his or her culture, the individual as a practitioner of an ideology, the individual in relation to his or her own neurotic structures, is always somewhere, has always just been somewhere else, and is empowered and limited by being in that spot on the way from some other spot. Communities are like that too, though in a complicated way. One of the things that defines a community's position, its situation, and the specific possibilities that go with it is its history of collective accomplishment. Another is its history of crimes against humanity. It seems unlikely that there are communities without such histories. The crime of slavery is deep in the past of white America. Ever since slavery, though, in A Cultural Pluralist Case for Affirmative Action in Legal Academia 175. Each succeeding decade after the Emancipation Proclamation, we have added new crimes until it sometimes seems that the weight of commission and omission lies so heavily on non-white America that there just isn't anything that anyone can do about it. All anyone can hope is to be out of the way of the whirlwind, both the big one and all the little ones played out in day-to-day life. The bad history also creates opportunities that other communities don't have, or have in different ways. It would be quite something to build a multicultural society on the basis of what has happened here, where we have neither a consensual foundation in history nor a myth of human benevolence to make it all seem natural. An American multicultural society will arise out of guilt, anger, mistrust, cynicism, bitter conflict, and a great deal of confusion and contradiction if it arises at all, and it would be, to my mind, the more wonderful for it. Of course, the specific proposal put forth above, for a kind of cultural proportional representation in the exercise of ideological power through legal academia, would be a very small step in that direction. As is true of any very specific proposal that can be implemented right now by small numbers of people holding local power, it is a drop in the bucket. However, the minute we imagine it as a government policy applied in a consistent way across the whole range of situations to which it is arguably applicable, it loses most of its appeal. First, none of us local power holders could do much to bring it about, and, second, taking the proposal seriously as state policy might lead to all kinds of disastrous unintended side effects. This has been a proposal for drops in the bucket, not for the reorganization of state power. If it made a trivial contribution at vast social cost, we could abandon it as we adopted it, faculty by faculty, decision by decision. If it worked, the kerplunk of drops falling in nearby empty buckets might cause others to prick up their ears. In any case, legal academics can and should exercise their power to govern themselves in accordance with the ideals of democracy and intellectual integrity ideals. That white supremacy compromises all around us. The Mishpi Indian Case. Translating Yanandio by Precedent and Evidence, the Mishpi Indian Case. Gerald Torres and Catherine Milun. ILA Song, a poem of itself, the word self a dirge, amid the wilds, the rocks, the storm, and wintry night, to me such misty, strange tableaus the syllables calling up. Walt Whitman, Yanandio. When Walt Whitman wrote his poem Yanandio for the collection Leaves of Grass, he added the following parenthetical explanation under the title, "The sense of the word is lament for the Aborigines." It is an Iroquois term, and has been used for a personal name. In fact, Yanandio also is the title of a long narrative poem by William H.C. Hosmer, published in 1844, with the subtitle Warriors of the Genesee, a tale of the 17th century. That poem, Hosmer wrote, is a description of the memorable attempt of the Marquis de Nonville, under pretext of preventing an interruption of the French trade, to plant the standard of Louis XIV in the beautiful country of the Senecas. In a note following the poem itself, Hosmer explained that Yanandio was a title originally given by the Five Nations to M. de Montmagny, but became a style of address in their treaties, by which succeeding governor-generals of New France were designated. It is easy to understand that Whitman took Yanandio to signify lament for the Aborigines. If Yanandio is indeed the word the Iroquois used to address the state, then as Whitman says in his poem, its mere mention is itself a dirge. For the Iroquois, Yanandio itself took on new meaning as the relation to which it referred shifted. Even as the word became a greeting, its meaning was different for the Iroquois than for the French and other Europeans with whom the Iroquois had contact. This cascade of meanings reflects the highly volatile system of relations produced by contact between the Iroquois and the various Europeans intent on opening up or claiming the New World. The telling of stories plays an important role in the work of courts. Within a society, there are specific places where most of the activities that make up social life within the society simultaneously are represented, contested, and inverted. Courts are such places. Like mirrors, they reflect where we are, from a space where we are not. Law, the mechanism through which courts carry out this mirroring function, has a curious way of recording a culture's practices of telling and listening to its stories. Such stories enter legal discourse in an illustrative, even exemplary fashion. Yanandio, the address, the salutation, became a medium through which contending Indian and European cultures interacted. The evolving meaning of the salutation reflected changing relations of power as the Indians' early contact with European explorers themselves evolved into contact with the states represented by those explorers. Likewise, the land claim suits filed by various tribes during the 70s served as a channel through which some Indians attempted to communicate with the state, this time through the medium of courts. In order for the state to hear these claims, however, these Indians were forced to speak in a formalized idiom of the language of the state, the idiom of legal discourse. This paper analyzes one such land claim suit, Mishpi Tribe v. Town of Mishpi, and the formalized address that it incorporated. What happens, we ask, when such claims receive a legal hearing? We suggest that first they must be translated by means of examples that law can follow, precedent, and examples that law can hear, evidence. We should suspect that the legal coding through which such translation is conducted highlights a problem inherent in the postmodern condition, the confrontation between irreconcilable systems of meaning produced by two contending cultures. The postmodern condition is a crisis of faith in the grand stories that have justified our history and legitimized our knowledge. The very idea of what we can know is unstable. The crisis in the law which emerged with the legal realists and the attempts to reconstitute formalism as the basis for survival of the rule of law also reflect our postmodern condition. In the case of the Mishpi, the systems of meaning are irreconcilable, the Mishpi to having to petition their anti-guardian to allow them to exist, and the history of that domination has determined in large measure the ways the Mishpi must tour their petitions. The conflict between these systems of meaning, that of the Mishpi and that of the state, is really the question of how can we know which history is most true. Yet the difficulty facing the Mishpi in this case is not just that they cannot find the proper language with which to tell their story or capture the essence of the examples which would prove their claims. The problem with conflicting systems of meaning is that there is a history and social practice reflected and contained within the language chosen. To require a particular way of telling a story not only strips away nuances of meaning, but also elevates a particular version of events to a non-contingent status. More than that, however, when particular versions of events are rendered unintelligible, the corresponding counter-examples those versions represent lose their legitimacy. They come unglued from both the cultural structure that grounds them and the legal structure that would validate them. The existence of untranslatable examples renders unreadable the entire code of which they are a part, while simultaneously legitimizing the resulting ignorance. This essay examines the nature of that ignorance. Ignorant, of course, merely means uninformed. The central problem addressed by this essay is whether the limitations of the legal idiom permit one party truly to inform the other, or conversely, whether the dimension of power hidden in the idiomatic structure of legal storytelling forecloses one version in favor of another. Note that this essay is not the story of different voices. Translating Yanandio by precedent and evidence, the Mishpi Indian case. When you are powerless, you don't just speak differently. A lot, you don't speak. Your speech is not just differently articulated, it is silenced, eliminated, gone. You aren't just deprived of a language with which to articulate your distinctiveness, although you are deprived of a life out of which articulation might come. The law does not permit the Mishpi's story to be particularized and yet to remain legally intelligible. By imposing specific ethno-legal categories such as tribe on the Mishpi, law universalizes their story. This universalizing process eliminates differences the dominant culture perceives as destabilizing. Criticism of the imposition of cultural legal categories on subcultures should not, however, be used to fetishize the idea of difference. Instead, the inability of the law to hear, or equally to weight, culturally divergent versions of the truth should be examined to help us understand how social knowledge is constructed. Similarly, a recounting of the Mishpi's travails in their attempt to tell their story does not yield an object lesson in the open texture of American pluralism. Some versions of reality are foreclosed, plain and simple. The legal boundaries made apparent in the Mishpi's story require that they remain frozen in time. Cultural evolution itself is prohibited for the Mishpi. This essay examines the nature of telling within the confines of litigation. What constitutes proof and what constitutes authority? What are the pragmatics of legal storytelling? Pragmatics in this context might be analyzed best in terms of a game. Any game must have rules to determine what is an acceptable move, but the rules do not determine all available moves. Although the total content of acceptable moves is not predetermined, the universe of potentially permissible moves is limited necessarily by the structure of the game. All language, but especially technical language, is a kind of game. What rules govern discourse in the legal idiom? What kind of knowledge is transmitted? What must one say in order to be heard, what must one listen to in order to speak, and what role must one play, to be the object of a narrative? By highlighting the peculiar nature of legal discourse and comparing it to other ways of telling and reading the Mishpi's history, we can explore and make concrete the roles of power and politics in legal rationality. The Mishpi case is especially well suited to this investigation because it casts so starkly the problem of law as an artifact of culture and tour of law applied to the Mishpi case permit only a limited kind of cultural vision, on from the perspective of the dominant culture. A pluralistic conception of justice may require // the incorporation of those conflicting views, but / z law, in this instance, may not be where justice is found. J. ELA looking back at Indians and Indians looking back, the case in 1976 in Mishpi Tribe v. Town of Mishpi registered the Indian community at Mishpi on Cape Cod sued to recover tribal lands alienated from them over the last 2 centuries in violation of the Indian Non-Intercourse Act of 1790. The Non-Intercourse Act prohibits the transfer of Indian tribal land to non-Indians without approval of the federal government. The tribe claimed its land had been taken from it, between 1834 and 1870, without the required federal consent. According to the Mishpi, the Commonwealth of Massachusetts had permitted the land to be sold to non-Indians and had transferred common Indian lands to the town of Mishpi. The defendant, town of Mishpi, answered by denying that the plaintiffs, Mishpi, were a tribe. Therefore, they were outside the protection of the act and were without standing to sue. As a result, the Mishpi first had to prove that they were indeed a tribe. A 40-day trial ensued on that threshold issue. The Mishpi were required to demonstrate their tribal existence in accordance with a definition adopted by the United States Supreme Court at the turn of the century in Montoya v. United States. By a tribe we understand a body of Indians of the same or a similar race, united in a community, under one leadership or government, and inhabiting a particular though sometimes ill-defined territory. This is a very narrow and particular definition. Judge Skinner agreed to allow expert testimony from various social scientists regarding the definition of Indian tribe. By the closing days of the trial, however, the judge had become frustrated with the lack of consensus as to a definition. In the end, he instructed the jury that the Mishpi had to meet the requirements of Montoya rooted in notions of racial purity, authoritarian leadership, and consistent territorial occupancy in order to establish their tribal identity, despite the fact that Montoya itself did not address the Non-Intercourse Act. The case providing the key definition, Montoya, involved a company whose livestock had been taken by a group of Indians. The company sued the United States and the tribe to which the group allegedly belonged under the Indian Depredation Act. This act provided compensation to persons whose property was destroyed by Indians belonging to a tribe. The theory underlying tribal liability is that the tribe should be responsible for the actions of its members. The issue in Montoya was whether the wrongdoers were still part of the tribe. The court found they were not. Beyond reflecting archaic notions of tribal existence in general, the Montoya requirements incorporated specific perceptions regarding race, leadership, community, and territory which were entirely alien to Mishpi culture. The testimony revealed the Montoya criteria as generalized ethnological categories that failed to capture the specifics of what it means to belong to the Mishpi people. Because of this disjunction between the ethno-legal categories and the Mishpi's lived experience, the tribe's testimony and evidence never quite signified within the idiom established by the precedent. After 40 days of testimony, the jury came up with the following irrational decision: the Mishpi were not a tribe in 1790, were a tribe in 1834 and 1842, but again were not a tribe in 1869 and 1870. The jury's finding was irrational because the judge had instructed them that if they concluded that the Mishpi had ever relinquished their tribal status, they could not regain it. Based on the jury's findings, the trial court dismissed the Mishpi's claim. The Mishpi immediately challenged the trial court's dismissal on several grounds. The tribe argued that the jury verdict presumed it had disbanded voluntarily at some point, a presumption the tribe alleged had never been proven. Further, the tribe alleged that the verdict was entirely inconsistent with the trial court's instruction that once the jury found tribal existence ceased at a given time, it could not find the tribe existed again at a later date. The First Circuit rejected the Mishpi's assignment of error and affirmed the trial court's decision to dismiss their claim. The United States Supreme Court subsequently denied the tribe's petition for certiorari, allowing the First Circuit's decision to stand. A. The baked and the half-baked. Whether the Mishpi are legally a tribe is, of course, only half the question. That the Mishpi existed as a recognized people occupying a recognizable territory for well over 300 years is a well-documented fact. In order to ascertain the meaning of that existence, however, an observer must ask not only what categories are used to describe it but also whether the categories adopted by the observer carry the same meaning to the observed. The earliest structure used for communal Mishpi functions, a colonial-style building that came to be known as the Old Meeting House, was built in 1684. The meeting house was built by a white man, Shir Jashub Born, as a place where the Mishpi could conduct their Christian worship. Shir Jashub's father, Richard Born, had preached to the Mishpi and oversaw their conversion to Christianity almost a generation earlier. The Born family's early interest in the Mishpi later proved propitious. The elder Born arranged for a deed to be issued to the Mishpi to protect their interest in the land they occupied. Confirmation of this deed by the General Court of Plymouth Colony in 1671 served as the foundation for including Mishpi plantation within the Pro. Translating Yanandio by precedent and evidence, the Mishpi Indian Case 18X. Section of the Massachusetts Bay Colony. As part of the colony, the Mishpi were assured that their spiritual interests, as defined by their Christian overseers, as well as their temporal interests, would receive official attention. However, the impact of introducing the symbology of property deeds into the Mishpi's cultural structure reverberates to this day. Whether the introduction of European notions of private ownership into Mishpi society can be separated from either the protection the colonial overseers claim actually was intended or from the Mishpi's ultimate undoing, is of course, central to the meaning of ownership. Colonial oversight quickly became a burden. In 1760, the Mishpi appealed directly to King George III for relief from their British overlords. In 1763, their petition was granted. The Mishpi plantation received a new legal designation, granting the proprietors the right to elect their own overseers. This change in the tribe's relationship with its newly arrived white neighbors did not last long, however. With the coming of the colonies' war against England and the founding of the Commonwealth of Massachusetts, all previous protections of Mishpi land predicated on British rule quickly were repealed, and the tribe was subjected to a new set of overseers with even more onerous authority than its colonial lords had held. The new protectors were granted oppressive powers over the inhabitants, including the right to lease their lands, to sell timber from their forests, and to hire out their children to labor. During this time, the Mishpi were on their way toward becoming the melange of racial types that ultimately would bring about their legal demise 200 years later. Colonists had taken Mishpi wives, many of whom were widows whose husbands had died fighting against the British. The Wampanoags, another southern Massachusetts tribe that suffered terrible defeat in wars with the European colonists, had retreated and had been taken in by the Mishpi. Hessian soldiers had intermarried with the Mishpi. Runaway slaves took refuge with the tribe and married Mishpi Indians. The Mishpi became members of a mixed race, and the names some of the Mishpi carried reflected this mixture. What was clear to the Mishpi, if not to outside observers, was that this mixing did not dilute their tribal status because they defined themselves not according to racial type but rather by membership in their community. In an essay on the Mishpi in the Predicament of Culture ***, Professor Clifford explained that despite the racial mixing that had historically occurred in the Mishpi community, since the tribe did not measure tribal membership according to blood, Indian identity remained paramount. In fact, the openness to outsiders who wished to become part of the tribal community was part of the community values that contributed to tribal identity. Thus, the Mishpi were being penalized for maintaining their Aboriginal traditions because they did not conform to the prevailing racial definition of community and society. In 1833, a series of events began that culminated in the partial restoration of traditional Mishpi rights. William Apes, an Indian preacher who claimed to be descended from King Philip, a Wampanoag chief, stirred the Mishpi to petition their overseers and the governor of Massachusetts for relief from the depredation visited upon them. What offended Apes was the appropriation of the Mishpi's worshipping ground by white Christians. In response to the imposition of a white Christian minister on their congregation, they had abandoned the meeting house in favor of an outdoor service conducted by a fellow Indian. The petition Apes helped to draft began, "We, as a tribe, will rule ourselves, and have the right to do so, for all men are born free and equal, says the Constitution of the country." What is particularly important about this challenge is that it asserted independence within the context of the laws of the state of Massachusetts. The governor rejected this appeal, and the Mishpi's attempt at unilateral enforcement of their claims resulted in the arrest and conviction of Apes. The appeal of Apes' conviction, however, produced a partial restoration of the tribe's right of self-governance and full restoration of its right to religious self-determination, for the tribe was returned to its meeting house. When the white former minister tried to intervene, he was removed forcibly and a new lock was installed on the meeting house doors. By 1840, the Mishpi's right to worship was secured. Control of the land remained a critical issue for the Mishpi. By late in the 17th century, the area surrounding the homes and land of the South Sea Indians had been consolidated and organized into a permanent Indian plantation. The Mishpi's relationship to this land, however, remained legally problematic for the Commonwealth. In 1842, Massachusetts determined that the land was to be divided among individual Mishpi tribe members, but their power over it was closely circumscribed. They could sell it only to other members of the tribe. The plantation could tax the land, but the land could not be taken for non-payment of those taxes. In 1859, a measure was proposed to permit the Mishpi to sell land to outsiders and to make the Mishpi full citizens of the Commonwealth. This proposal was rejected by the tribe's governing council. In 1870, however, the Mishpi were granted rights to alienate their property as full-fledged citizens, and their land was organized by fiat into the town of Mishpi. It was the land that had moved out of Indian control, 11,000 acres of undeveloped land estimated to be worth $50 million, that the Mishpi Wampanoag Tribal Council sued to reclaim in 1976. Some of the land had been lost in the intervening years, and more was in danger of being lost or reduced to non-exclusive occupancy. The council based its claim on the Non-Intercourse Act, which prohibits the alienation of Indian lands without federal approval. The act applies to transactions between Indians and non-Indians, and, despite its inherent paternalism, serves to protect tribal integrity. However, the Non-Intercourse Act applied only if the Mishpi had retained their tribal identity, defined, however, by the white man's rules of the game, from the mid-17th century until they filed their land claim action in 1976. In order to fall within the scope of the Act's protection, the Mishpi had to prove first that they were indeed a tribe, and that their status as such had not changed throughout this period. If the Mishpi were no longer a tribe, or if they never had constituted a tribe in the first place, the protection provided by the Act evaporated. If, however, the Indians retained their tribal status, then the transactions that resulted in the loss of their village were invalid. At the very heart of the dispute was whether the Mishpi were legally a people and thus entitled to legal protection. Many of the facts underlying the Mishpi suit were not disputed. What the parties fought about was the meaning of what happened. Seen from the perspective of the Mishpi, the facts that defined the Indians as a tribe also invalidated the transactions divesting them of their lands. From the perspective of the property owners in the town, however, those same acts proved that the Mishpi no longer existed as a separate people. How, then, is an appropriate perspective to be chosen? As told by the defendants, the Mishpi's story was one about four small, mixed community fighting for equality and citizenship while abandoning, by choice or coercion, most of its Aboriginal heritage. Using the same evidence, the plaintiffs told a very different story. It was the story of cultural survival. Residents of Mishpi had managed to keep alive a core of Indian identity over 3 centuries against enormous odds. They had done so in supple, sometimes surreptitious ways, always attempting to control, not reject, outside influences. 19. Which of the two conflicting perspectives is the proper one from which to assess the facts underlying the Mishpi's claim? The answers provided by the courts that considered their claims exemplify both the use and abuse of examples in American law. As the next section illustrates, the exemplary nature of legal argument is bounded by the rules that control the substantive demonstration of the issues in dispute, as well as by the authoritative use of previously decided cases. Demonstration 7 and authority are two ways in which examples are used to structure legal understanding. Yet the choice of examples is not a neutral process, it always involves adoption of a substantive perspective. The abuse of example arises when the substantive perspective, that is authorita. Translating Yananto by precedent and evidence, the Mishpi Indian case, tively adopted, is treated as though it arose naturally. 4. A exempla gratia. Two closely related kinds of examples seem to be at work in legal discourse. First, there is the author-example, that which determines whether or not one may proceed toward obtaining a legal remedy for a perceived injustice. Precedent, even in the context of our statutory age, is the cardinal manifestation of the authoritative example. A statute such as the Non-Intercourse Act may be a source of law, but courts, using a variety of common law techniques, ultimately determine the meaning of that statute. The role of authoritative examples thus is twofold: specifying the outer limits of a particular legal pronouncement and, at the same time, establishing a foundation for subsequent interpretations of those limits. This bifurcated function allows legal authority to appear as though it were timeless. The example from the past is merged with a new example from the present. Linearity is redefined as simultaneity. The past is always present in the form of the authoritative example. Precedents accumulate as a present body of law, but the fact of accumulation leaves the body forever present yet forever incomplete. The second kind of example at work in legal discourse might be labeled explanatory. An explanatory example is a statement or exhibit, either real or interpretive, taken as evidence of the sufficiency of a legal claim. In contrast to authoritative examples, which govern whether or not a particular legal claim can be pursued at all, explanatory examples flesh out legal claims, giving them substance within the confines established by the controlling authoritative example. Explanatory examples must be constructed to showcase the reality being tested by a given legal claim in terms recognized by the governing authoritative examples. Explanatory examples may both give meaning to the facts that underlie a legal claim and provide a basis for distinguishing that claim from apparently relevant, but undesirable, authoritative examples. There are, of course, rules governing the use of either type of example. The essence of these rules is the predictive power they yield. Their predictive value resides in their power to inform legal actors how a given dispute will be resolved. However, the rules themselves are absolutely determinative only of the actual dispute to which they are applied, hence, their predictive potential necessarily involves something of a gamble. When seeking an authoritative example, an attorney or a judge always must determine at the outset whether the facts of some previously resolved dispute are sufficiently similar to the controversy at issue to dictate how the parties to that controversy ought to be treated. In order to make such a determination, the judge or attorney must closely examine the factual setting of the prior case, the legal precedent serving as authoritative example for similarity, difference, and importance relative to the present dispute. In a system that uses previously decided cases as the foundation for authoritative statements, at least two questions of fact are central to resolving a given dispute. First, what facts may be recognized as proof of the legal claim? Second, what facts are recognized as legally determinative in the search for an authoritative example? In short, what facts count in this search? Determining which facts are critical and which interpretation of the facts is most like the authoritative interpretation is a continuing process. The translation of the raw material of life into legally cognizable claims is at the heart of the lawyer's art, but like any other extremely stylized art form, the artist's creativity is constrained by the structure of the project. The centrality of the meaning of facts, in the sense of what happened, recurs constantly. From precedent we get two additional kinds of examples: first, the example of authoritative fact patterns, and second, the example of authoritative interpretations of those fact patterns. Judicial opinions typically begin with a statement of the facts in dispute. The statement usually presages the conclusion, but the precedential import of the facts changes as the meaning of the case changes over time. The simple conclusion that a court reached may not be the proposition for which the case is cited. The illusory factual statement ultimately loses its mooring in the specific case. Thus, which facts are authoritative will change as the case is made to fit into an evolving system of relations that gives it meaning. In cases in which different courts try to answer the same legal question, creating or discovering a set of authoritative interpretations lies at the heart of the attorney's task. These interpretations must be used to frame the raw material of a given case so as to suggest it is sufficiently similar to previous cases or to some articulated statutory standard in order to justify a court's listening to the claim and subsequently granting the desired reliefs. 20 Intuitively, one assumes that everything potentially helpful to telling the story behind a given legal claim ought to be allowed as part of the explanation. The reality of the legal process requires, however, that the story be told in accordance with a set of rules developed to protect the integrity of a subsequent decision as precedent or authoritative example. Further, the rules that limit notions of relevance to the authoritative commands also guide the structuring of the presentation. b. The rules of the game: telling a relevant story. The rules governing how one tells a story in court are supposed to protect the court from wasting its time by listening to immaterial information or testimony that might confuse or prejudice the ultimate decision-makers about what they are supposed to be deciding. These rules turn on the legal concept of relevance. Typically, a legal claim is composed of elements that must each be proven independently. Relevant evidence is a statement or exhibit that tends to demonstrate the relationship between a factual assertion and a particular element of a legal claim. According to the Federal Rules of Evidence, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. 2 degrees. Thus relevance, the foundation for rules permitting the introduction of evidence, controls and is controlled by the existence of other facts, which themselves are controlled by the substantive standard or statute being litigated. Relevance is the guide, but the question remains, relevant to what? Treating relevance as though it were a neutral analytic category takes our attention away from the substantive standard being disputed because it requires the judge making the relevance determination to treat the substantive standard as a given. In cases like MISP, the underlying standard is often the heart of the dispute. Reread the definition. Relevance is a probability determination. The judge is to ask herself, if I let this evidence in, will it add any probative value to the facts we already know? This inquiry begs the question of whether the facts already admitted are those that ought to be in. The legal concept of relevance empowers a court to approve or disapprove certain narrative elements of a party's story. A court's evidentiary rulings, however, do not control truth but, rather, translate it into the terms of the substantive statute or standard at issue. The truth value of a particular fact within the confines of legal discourse, therefore, is directly related to whether it explicates the substantive claim being adjudicated. The issue being litigated is the measure of truth. Remember Judge Skinner's frustration at the testimony of the various experts concerning the definition of tribe. He had fully expected to consider some objective or, at minimum, generally accepted, definition of this ethno-legal category. Finding no agreement, Judge Skinner turned to a legal standard that was completely a contextual, as well as profoundly ethnocentric, by using Montoya to assess the MISP's claim to tribal status. Judge Skinner translated, via Montoya, the lived experience of the MISP into an objective, a contextual legal category. The process of legal storytelling and relevance determination is more like a gathering of material for an index than the telling of a classic narrative. Facts are assembled to tell a story whose conclusion is determined by others. Each fact must point to the next, in not a temporal sense but, rather, only in the sense dictated by. Translating Yanandio by precedent and evidence, the MISP Indian case. The substantive standard being litigated. The determinations of relevance. What can be admitted as evidence locate the court as the indexer, the one who determines significance. The story told by the parties must point back constantly to the story told by the court and the precedents, which, of course, are merely the stories deemed acceptable by previous courts. By structuring legal storytelling in this way, questions of power, perspective, and value are evaded. So what kind of story can be told within the confines of legal discourse? Let us turn to the story of the MISP Indians and listen to the story they tell about themselves and the story that is told about them, and then decide which story makes more sense. See Law Looks, Documentary Evidence. In response to the MISP's claims, attorneys for the town of MISP argued that the tribe lacked racial purity, and that it failed to retain a sufficient degree of self-government. It exercised little if any sovereignty over specific territory, it maintained no perceptibly coherent sense of community, and therefore was not a tribe as defined by the Supreme Court in Montoya. The defense's main witness, Francis Hutchins, a historian, offered 5 days of exhaustive testimony. Although he and the MISP referred to more or less the same documents, his positivistic account of the MISP's history left no room to suggest that certain land deeds in fact reflected white, rather than Indian, notions of land ownership. The very acceptance by the court and the witnesses of the symbology of deeds presupposed a certain structure for the MISP story. This structure, framed with the European indicia of ownership, was asserted by the defense as the only basis for the tribe's claims. In doing so, defendants' counsel translated the tribe's claims into terms foreign to the MISP. This rhetorical move stripped the land claim of nuances that deeds could not replace. The deeds not only reconstituted the tribe's basic claim but also temporalized it. Deeds set it apart from the evolving tradition of the Indians' relationship to their physical surroundings, and, at once, both elevate and debase their relationship to the land. With regard to political leadership, the defendant's historian found scant historical traces of Indian government at Mishpi. The court apparently did not recognize any irony in the defense's attack on the Mishpi's claim of self-government. According to the defendants, the Mishpi could be self-governed only if the tribe adopted political forms susceptible to documentary proof. Unfortunately, the tribe did not see fit to create that kind of proof of its political existence, since the court was asking for evidence of the type of political life that white Europeans, but not the Mishpi, recognized as legitimate. The Mishpi tried to point out what was appearing as a lack or gap in the defendant's account of their history was something that they simply would not have recorded in written form. Within the idiom of documentary evidence as written record, because the Mishpi Indian culture is rooted in large measure on the passing of an oral record, their history could only signify silence. The commonplace view, replicated in the process of legal proof, is that facts only have meaning to the extent that they represent something real. The stories that members of the Mishpi tribe told were stories that legal ears could not hear. Thus, the legal requirements of relevance rendered the Indian storytellers mute and the culture they portrayed invisible. The tragedy of power was manifest in the legally mute and invisible culture of those Mishpi Indians who stood before the court trying to prove that they existed. We are doubtless deluding ourselves with a dream when we think that equality and fraternity will someday reign among human beings without compromising their diversity. For one cannot truly enjoy the other, identifying with him, and yet at the same time remain different. What were the underlying structures or categories guiding the determination of what evidence in the Mishpi trial was deemed material, that is, within the confines of the legally defined dispute? In order to construct an answer, it is necessary to examine two other problems underlying the materiality of the evidence offered by the defense. First, in claiming blood as a measure of identity, the defense argued, to the all-white jury, that black intermarriage made the Mishpi's proper racial identification black instead of Indian. Because of the racial composition of the community, that the jury would be composed exclusively of white people virtually was guaranteed by the voir dire, in which prospective jurors were asked whether they were themselves Indian, had any known Indian relatives, or had ever been identified with organizations involved in Indian causes. White intermarriage was mentioned only in passing. Second, the trial court instructed the jury that the tribe could terminate through social or cultural assimilation of English forms and English labels. 23. The court interpreted Mishpi adaptation to the dominant culture, necessary for their survival as an independent people, as proof that the tribe had surrendered its identity. This interpretation incorporates a dominant motif in the theory and practice of modern American pluralism. Ethnic distinctiveness often must be sacrificed in exchange for social and economic security. In their appeal to the United States Court of Appeals for the First Circuit, the Mishpi argued that integration and assimilation have expressly been held insufficient to destroy tribal rights. 25 notions of social and cultural assimilation, such as those upon which the defense relied, impute reified social standards to Indian communities which deny not only their right to historical change but also the reality of their paradoxical continued existence. If the Mishpi only could be Indians by fitting into the definitions relied upon by the court and the defense, then their lived experience was devalued to the extent it did not conform. Moreover, by arguing that the Mishpi had been assimilated into the dominant culture merely because they had adopted some forms of that culture meant that the Mishpi could not change, even if they determined that some cultural adaptation was necessary to their own cultural survival. Thus, the story of the Mishpi and their otherness can be told in several ways. Whether that story could be told in a way that is legally relevant, while still encompassing the multiple paradoxes of the general inquiry, remains the central problem. At least one version of the Mishpi story begins with the rise of Indian consciousness in the late 60s and 70s, which resulted in compelling political expression, partially through established legal mechanisms and institutions. Among the manifestations of this consciousness were the Indian land claim suits of the 70s. These legal attacks on what were believed to be secure land titles were devastatingly upsetting to white landowners, largely because they had the potential to undercut more than a century of settled expectations and redistribute power in a material way. The suits sought to shift control over the most basic material resource, land. What made the Mishpi's challenge particularly disconcerting to the white landowners was that it was conducted according to rules now frightened. Non-Indian landowners felt compelled to respect a lawsuit. The Mishpi's story might begin another way. From the founding of the plantation for South Sea Indians and the village of Mishpi until the mid-60s, the area now known as the town of Mishpi was controlled by people who identified themselves as Mishpi Wampanoag Indians. The Indian people of Mishpi exercised all the political power normally associated with Massachusetts' municipalities, including control over land use and permits for public activities. How the Mishpi actually described themselves was immaterial to their exercise of power. The normal disputes that arose out of the conduct of municipal affairs were, in effect, family squabbles. Even if some Mishpi did not approve of how others were acting, the integrity of the group remained unchallenged. Circumstances drastically changed, however, in the mid-60s. An influx of non-Indians who were not incorporated into the Mishpi people shifted the balance of political power in the town. With a change of political power in the community from Indian to non-Indian. Translating Yanandio by precedent and evidence, the Mishpi Indian Case 187. Came changes in the material conditions of life in Mishpi. Land formerly open to the community was posted by its new private owners. Seaside resort developments were planned where only unspoiled woods and shoreline existed before. These changes were unsettling to the long-term Indian residents of Mishpi, who turned to the Non-Intercourse Act as a means of halting development and restructuring political power in their town. The story might begin yet another way. In Tigo 1 in Montoya v. United States, the United States Supreme Court declared, by a tribe we understand a body of Indians of the same or similar race, united in a community under one leadership or government, and inhabiting a particular, though sometimes ill-defined territory. The Montoya definition of tribe was crucial to the Mishpi's claim, since the Non-Intercourse Act, the legal heart of their land claim suit, protected only tribes from the depredations of unscrupulous or unwise land deals. Rather than proving tribal identity in their own terms, the Mishpi were forced to present themselves in terms adopted by Montoya and subsequent cases. More important, there was little authority on the definition of a tribe. A group of Indians could be described legally as a tribe or a band, or as a tribe for some purposes but not for others. The structure of the narrative required by the precedent as fact-denuded rule privileged the definition adopted by Montoya. The privileged Montoya narrative rested not merely on the foundation of rules governing both authoritative, fact-denuded, and explanatory, fact-filled, examples. The legal narrative was privileged because the rules governing the construction of the storytelling encompassed a complete perspective. Those rules of evidence give preference to documentary evidence over mere recollection of the tribe's members. Recorded memory relies less on the memory of the teller. The elevation of documentary evidence over oral recollection effectively debased the Mishpi's foundation of self-knowledge, their way of looking at, and knowing, themselves. More important than just controlling the telling of stories in legal discourse, the rules also project reified social relations. The material social relations of the Mishpi that cannot be called up through documentary evidence had to be made to fit the model of Indian society projected by the rules. The relations must be translated into the form established by the rules to be comprehended by legal discourse, regardless of whether the self-constructed reality of the Mishpi corresponds to the legal model. Worse, these reified social relations are projected upon a background of settled expectations that run directly counter to the claims the Mishpi made. In order for their legal claim to make sense, it had to be phrased within a strictly legal context, and that context had to include the justification for displacing 2 centuries of the way things are. In the context of this lawsuit, once tribe became exclusively a legal construct, it embodied all of the subsidiary or provisional social meanings that gave it life within a pseudo-objective legal form. By entering the universe of legal discourse, the term tribe, in the context of the Non-Intercourse Act, had no meaning for the internal perspective of people claiming that status. Instead, tribe means a group of indigenous people who have structured their existence in such a way that outsiders, specifically legal experts, would say the grouping is a tribe. Thus, the legal notion of tribe contains within it projected ethnological categories as well as political categories. A tribe is incapable of legal self-definition. Instead, it must point to something that will then point back and lead others to declare that the tribe is indeed what it claims to be. That something functions as an index equal sign. In other words, the information the sign supplies does not dispose of the legal identity but merely suggests where an answer may be found. The things that the Indians must point to in order to establish they form a tribe are the authoritative examples discussed earlier. These authoritative examples are index-like in nature because they define the significance of other signs. Land can function as such a sign. The land is a constituent element of the tribe itself. Without the requisite documentation, the land is only a part of the tribe's cultural self-definition. Legally, though, it is meaningless. A tribe can point to the land it occupies and controls as a sign that it exists. Thus, although the land becomes part of what constitutes tribal existence, it is a signal that the law can ignore. But if a tribe is still capable of constituting itself outside of the legal process, what need is there for legal recognition? The law polices the boundaries between contending cultures and provides one possible foundation for the integrity of subordinate cultures. As has been illustrated, law also can be culturally subversive. For example, the index equal value of land in establishing identity is completely different than the legal value of land inscribed in deeds. The latter is legally recognized as ownership, carrying with it all the legal freight that ownership implies. The former may have constitutive power, but it appears to signify nothing when translated into the idiom of legal discourse. In this way, the law can undermine the foundational significance of land for a particular culture. A deed signifies ownership. In the discourse of law, ownership of some interest is the most important relationship to land which one can have. Yet, according ownership, this role includes the important constitutive power specific land has for people and communities. We see this tension everywhere in the penny auctions of the recent farm crisis and in the land claim suits brought by Indians. The importance of community identity looms as large as the importance of ownership for any individual proprietor. The elevation to a dominant position of one aspect of a complex relationship reflects the power inherent in legal discourse to corrupt meaning, as well as the role of legal translation in that process. 6. Conclusion. Hesse once wrote that the relationship between the individual and the community can be looked at in only two ways. Either we start from the substantiality of the ethical order such as, the traditions and laws of a given community, or else we proceed atomistically and build on the basis of single individuals. BD. Regulation of the interaction of groups within a polity that has taken the individual as a foundation of its moral and political order assumes a special poignancy where cultures conflict irreconcilably. Law provides no place of grace, because what is at issue is the definition of the polity. To grant subgroups a special status or alternative basis for defining themselves calls into question the substantiality of the ethical order that defines rights in terms of individuals, yet structuring the debate in this way, as illustrated above, merely means that the proponents of the preservation of Aboriginal claims ultimately will lose. It does no good to claim otherwise, unless the basis for the Aboriginal claims can be reconstructed on the basis of group identity. The preservation of an alternative order is a direct challenge to the plenary power of Congress and to any notions of sovereignty other than a dependent sovereignty so constricted that it cannot deflect countervailing normative visions of community. The law, as it has been narrowly conceived in this essay, creates at most a space where politics may be practiced, but in itself it is an ineffective form of politics, especially for those who would change the prevailing order. As was argued in an earlier essay, the hope for the development of alternative cultural norms lies in the creation of a real cultural pluralism. A real cultural pluralism is one that, within the context of a democratic polity, respects the cultural foundations for differently conceived notions of the good and provides a social space for such conceptions to take on material form. The material aspects of a culture's existence should not be underestimated. Without the concrete capacity to reproduce itself, a culture must wither and disappear. With the disappearance of each culture, the range of possible futures available to individual persons must also wither and decline. Our culture enables us to make sense of our lives and determines, to a large extent, which life choices we make. And those choices must. Translating Yanandio by precedent and evidence, the Mishpi Indian case. Make sense according to the stories our culture tells about us. We decide how to lead our lives by situating ourselves in certain cultural narratives, by adopting roles that have struck us as worthwhile ones, as ones worth living. Yet our upbringing isn't something that can just be erased. It is, and always remains, a constitutive part of who we are. Cultural membership affects our very sense of personal identity and capacity degree rather than wash individuals clean of any differentiating characteristics as a logical step prior to the assignment of rights. The recognition of cultural identity as an irreducible component of personal identity requires that we ask how group membership ought to be taken into account. Importantly, this recognition requires us to ask how group membership determines the capacity of the individual, who is the concern of liberal theory, to make worthwhile choices. If the failure to respect a cultural grouping results in a limitation of the individual's capacity for self-determination, then the political choice leading to that end is indefensible on liberal grounds. The Hegelian characterization of the tension between the individual and community presumes a single polity. The question it cannot answer is whether a truly culturally pluralistic, liberal, democratic system is feasible. Are we willing to have truly independent cultural enclaves that define their own polity or create their own normative definition of community? The acceptance of such a possibility generates the potential for alternative cultural spheres in which the future may be imagined in a variety of ways, including rejection of the Enlightenment project that lies at the heart of liberal democratic theory. If that liberal faith is abandoned, what is the basis for mediating disputes between cultures? Without a re-examination of the foundation for liberal rights, the attempt to remake the argument for Aboriginal claims from the perspective of liberal theory is fundamentally misguided. Before these questions can be answered, remember that cultures have a material and intersubjective dimension. The debate about Aborigine NAL claims in late 20th century America cannot be limited to the realm of liberal democratic theory, but the debate also must include a critique of the material conditions in which Indian life reproduces itself. Cultural identity is integral to individual self-identity. To maximize the range of life choices and to preserve the capacity for individual integrity requires, in the context of Aboriginal claims, that the cultural integrity of tribes be maintained. The law as presently structured allows no clear way to achieve that end. In fact, the reality of Indian life is, in a real sense, untranslatable. This untranslatability has a material dimension. Land claims have not a true Aboriginal foundation but, rather, a legal mooring in the state, a mooring subject to change and re-evaluation. The developmental priorities are set not by Indians but by others. The very theory of Indian sovereignty is debased by the plenary power of Congress. The tragedy, of course, is that the failure is not merely a failure of theory. The reservation system was badly conceived, but it never was truly intended to provide a foundation for potentially competing powers. The reservations were designed to pacify, not to compensate. The loss that Indians have suffered is material both in the damage to real people and in the destruction of cultures. What has been ruined may be irretrievable, and the continuing loss inexorable. To the extent cultures are destroyed or rendered incapable of self-expression, we are destroying individuals in disservice to what are ostensibly our own underlying values. We have two choices: pluralism materially redefined or the cultural assimilation implied in pluralism as we know it. Yet, as one observer has noted, protecting people's cultural community and facilitating their assimilation into another culture are not equally legitimate options. Asterisk. Metro Broadcasting Incorporated v. FCC, regrouping in singular times. Metro Broadcasting Incorporated v. FCC. Regrouping in singular times. Patricia J. Williams. He Supreme Court decision in Metro Broadcasting Incorporated v. FCC, which upheld limited preference programs to increase the number of minority owners of broadcast stations, was Justice William Brennan's last majority opinion before his retirement. Because his departure signals a significant shift in the balance of power on the court, some might perceive this case as the last hurrah of a dying liberal order. I believe, however, that this case represents an important element in a schema of vital civil guarantees that must be maintained and even expanded. This comment assesses the significance of Metro Broadcasting not merely as a nostalgic look backward, but also as the vehicle for greater comprehension of the significance of and necessity for group claims within our legal system. In addition, this comment considers the costs of pitting individual rights against group interests at a moment in our history when the groupings race and class intersect in such a way that race increasingly defines class, and such that the property interests of large numbers of white individuals are understood to be in irreconcilable tension with the collective dispossession of large numbers of people of color. One of the major issues in Metro Broadcasting was whether and to what extent the FCC's desire to promote racial and ethnic pluralism in programming is served by its choice to diversify broadcast ownership. Applying a standard of review that required the FCC's diversity program to be substantially related to an important governmental interest, the majority held that broadcast diversity was such an interest. According to the majority, although no necessary connection exists between ownership and diverse programming, both congressional and FCC findings strongly suggested that diversity would be promoted by increasing the representation of groups currently underrepresented among owners. The dissenters, adhering to a standard of strict scrutiny, attacked the majority's use of the substantial relation test as a dangerous validation of racial classifications and challenged the notion that broadcast diversity was a compelling governmental interest. Moreover, the dissenters argued that without some guarantee that any particular minority station owner would structure programming differently than a non-minority owner, the FCC's use of race and ethnicity as factors in its licensing decisions could not be considered narrowly tailored enough to meet the declared interest in diversity. Although the majority and the dissenters framed the issue in terms of disagreement about the standard of review, their underlying characterizations of the facts and weighing of the evidence were so polarized that the split probably would have remained even had they agreed on this doctrinal issue. The conflict underlying the opinions is revealed by the subtly nuanced and infinitely slippery vocabulary employed by each side. There was a covert adjectival war taking place in Metro Broadcasting, in which words were inflated like balloons in order to make the issue of diversity large or trivial, compelling or merely important, natural or momentary, grandly futuristic or of the local past. The intensity of these divisions is rooted in profound differences in political philosophy about the nature of group identity, individualism, and the role of the market. Justice Brennan's analysis placed issues on a historical continuum that looks both backward, to our divided and ruthlessly co-optive past, and forward, to our long-term interest in the cooperative diversification of our airwaves and our lives. The dissenters' insistence, on the other hand, on a guaranteed link between diversity in ownership and diversity in programming arises from a highly individualistic notion of discriminatory action in which a court can consider little history beyond the limited confines of an arm's-length commercially motivated bargain between neutrally feathered equals. Similarly, the majority and the dissenters differed in their understandings of the very meaning of necessity in their respective descriptions of racial categorization as a means to desired ends. For the dissenters, the term referred to an abstracted and absolute requirement of racial neutrality in the word of law. For the majority, it referred to the historically contextualized objective of media diversity, the achievement of which was constrained by a relative lack of alternative. Beyond that, the starting points of each differed. For the majority, its sense of narrowly tailoring race-conscious efforts to eradicate discrimination had as its referential backdrop a larger social context, while for the dissenters, the sense of the menacing, unbounded enormity of the very same measures arose out of their singular focus on a methodological individualism. I would like to reframe some of the issues from a perspective that does not assume that simply because a problem such as discrimination is societal it is irremediable, or that because a problem is individualized or privatized it is therefore effectively bounded. Whether racial imbalances are called societal or found to be the result of individualized injury, in either case there are overlooked, or underestimated, ways of looking at the problem which could provide both more latitude for courts and a clearer appreciation of the nuanced gradations that characterize judicial responses such as those in metro broadcasting. Il. Diversity and the recognition of Giro UPS. Roadcasting. Diversity is often portrayed as an attempt to propagate special interest markets or to ghettoize audiences into mass appeal, on the one hand, and minority markets, on the other. Its implications, however, are more complex. A real notion of diversity includes a concept of multiculturalism. This entails a view of a market in which there are not merely isolated interest groups, of which the mass market may be one, but in which mass accurately reflects the complicated variety of many peoples and connotes interactive and accommodative rather than dominant or even just majoritarian. This perspective embodies the historical connotations of the quest for diversity and the underlying intersection of race and culture. In particular, although it is true that there is no guaranteed relation between race and taste in television and radio fare, the seeming simplicity of this statement deserves some qualification. For example, the literal biological truth that blacks, or members of any other racial or ethnic groups, are not born with genetic inclination for things black is often used to obscure the fact that black, like most racial or ethnic classification, also defines a culture. Blackness as culture, perhaps more easily understood as such in the designation African American, plus usually evokes a shared heritage of language patterns, habits, history, and experience. Although all the cultures named by the FCC are exceedingly diverse, the most generalizable experience is that of battling cultural suppression if not obliteration, as well as discrimination and exclusion from the larger society. If we cannot conclude absolutely that the victims of racial oppression are always the best architects of its cure, we must nevertheless assume that the best insight and inspiration for its amelioration will come from those most immediately and negatively affected. This allowance is not merely a concession in a random contest of cultures, it is a recognition central to the checking and balancing, the fine line of restraint, that distinguishes a fluidly majoritarian society from a singularly tyrannical one. This notion of blackness as a culture, for example, and the recognition that this culture may be consistently suppressed or denigrated under the guise of neutral mass entertainment, may be difficult for people who identify themselves as part of the dominant culture to understand. The parallelism of whiteness as culture or as any kind of unified experience is not immediately apparent. While I remain convinced that there is a culture of whiteness in the United States, I appreciate the extent to which its contours are vaguely or even negatively discerned, so that its assertion is most clearly delineated as not other, and most specifically as not black. For the many Americans for whom minority cultures are themselves peripheral, I suspect that a realization that their Metro Broadcasting Incorporated v. FCC, regrouping in singular times, exists a culture of whiteness is occasioned only rarely. Perhaps the argument is more easily understood as a matter of ethnic heritage, perhaps it is easier to look at immigrant communities of those whom we now call whites in order to recapture the extent to which acculturation in the United States is assimilationist in a deeply color-coded sense. It is easy to forget, for example, that the first waves of Italian, Portuguese, Greek, Jewish, and Middle Eastern immigrants to this country were frequently considered non-whites and suffered widespread discrimination. It is therefore telling to note the degree to which we as Americans celebrate simultaneously our unity as a nation and the Ellis Island tradition of our variety. In the drive to achieve the unity to which our national mythology aspires, we frequently suppress, if not undo, the richness of our diversity by reconceptualizing any manifestation of it as a kind of un-American disunity. I think we do this by consistently, if unconsciously, underestimating ourselves as a distinct national culture and even denying outright the possibility of our power as a consuming, assimilationist force. We tend to universalize the characteristics commonly, if romantically, attributed to middle-class America: individualism, self-interest, self-assertion, so that the very force of our desire to embrace one another becomes an impediment to the necessary recognition that we are not the world. 3. Diversity and broadcasting. Even the existence of minority cultures, and not just of minority individuals. The attempt by the Marrow broadcasting dissenters to disclaim any relation between programming and ownership becomes rooted in paradox. The dissenting opinions contest any relation between the multiculturalism of programming and the racial or ethnic background of station owners, yet there clearly is some relation between programming and the beliefs of an owner. Just as clearly, there is some relation between one's heritage and one's beliefs. 193. Underlying the dissenters' attempted disavowal of the connection between ownership and broadcasting content is a paradigm in which the class characteristics of good ownership are assumed to transcend racial, ethnic, or other forms of identity. As a friend of mine is fond of saying, middle-class status is nothing more than the inner conquest of any perceived racial or ethnic identity at all. The complete young urban professional, or the accomplished businessperson, is one who has achieved a certain tweedy neutrality of dress, speech, mannerism, and desire. Although there is facetiousness in this depiction, there is certainly nothing too unfamiliar in it. It merely updates and caricatures the model of the rational man who dutifully delays gratification, acts in perfect self-interest, lives with one finger on the pulse of market appetite, patterns a lifestyle upon strong if shifting trends, and under no circumstances wears anything louder than oxblood, loden, or slate. Ironically, such an identity is not an expression of individuality, it is, rather, fashion, a collective aesthetic, a species of mass behavior wrapped in the discourse of self-interest. This deeply embedded notion of the rational market actor is in fact a conformed identity, so normalized that we seem to have lost the ability to see it as such. Nor is this identity really racially or ethnically neutral. For all the brilliant cultural mixtures in art, music, and film which America has given the world, middle and upper-classness remains deeply steeped in Western European traditions and dominated by strong Protestant values. To this day, 95% of all corporate executives, including communications executives, are white males, a figure that hasn't changed since 1979. Asterisk. As the Metro Broadcasting Majority observed, in 1986, minorities owned just 2.1% of the more than 11,000 radio and television stations in the United States. Moreover, as late entrants who often have been able to obtain only the less valuable stations, many minority broadcasters serve geographically limited markets with relatively small audiences. Furthermore, in an era of infomercials, the media is increasingly used simply to spread. 194. Rather than exchange information about markets, rather than ideas. Television and radio undoubtedly enable people to shop faster and better. It is easier than ever before to stay informed about a wide range of consumer goods and services. Yet even as these media replace libraries, the traditional bastions of our culture, they do not seem to be serving the same interests or function as libraries. They are not being geared for the sort of browsing in which there is no commercial stake. Although electronically conveyed knowledge indeed may be cheaper and easier to obtain in one sense, I wonder about a larger question: the degree to which information itself needs a patron or sponsor to be conveyed in the first place. Our modern-day patrons are no longer popes and princes, they are corporations and philanthropies. The degree to which advertising alone purveys and censors information seriously threatens genuine freedom of information. The degree to which the major media, the culture creators in our society, are owned by a very few or are subsidiaries of each other's financial interests must be confronted as a skewing of the way in which cultural information is collected and distributed. Thus, Executives in the communications industry exercise a power that is not merely concentrated but also propagandistic. They make far-reaching choices in a way that few others in our society can. They project their images of the world out into it. They do not merely represent, they also recreate themselves and their vision of the world as desirable, saleable. What they reproduce is not neutral, not without consequence. To pretend, as we all do from time to time, that film or television, for example, is a neutral vessel, or contentless, mindless, or unpersuasive, is sheer denial. It is, for better and frequently for worse, one of the major forces in the shaping of our national vision, a chief architect of the modern American sense of identity. Even assuming that profit-seeking behavior explains all or that materialism is itself a kind of culture, if the United States is to be anything more than a loose society of mercenaries, of suppliers and demanders, of vendors and consumers, then it must recognize that other forms of group culture and identity exist. We must respect the dynamic power of these groups and cherish their contributions to our civic lives rather than pretend they do not exist as a way of avoiding argument about their accommodation. We must also be on guard against either privileging in our law a supposedly neutral mass culture that is in fact highly specific and historically contingent, or legitimating a supposedly neutral ethic of individualism which is really a corporate group identity, radically constraining any sense of individuality, and silently advancing the claims of that group identity. This is not to say that all women or blacks or men see the world in the same way or only according to their cultures. I do not believe that a pure black or feminist or cultural identity of any sort exists, any more than I think culture is biological. I am arguing against a perceived monolithism of universal culture which disguises our overlapping variety, and which locates non-whites as separate, other, even separatist cultures, or as in the context of metro broadcasting that argues about whether such cultures even exist. The point then is not that whites cannot program for blacks, or that blacks would not watch programming aimed at Hispanic audiences. And the point is not, for example, whether white actors can convincingly portray Asian characters, as was so reductively maintained by the producers in the recent debate over the ill-fated Broadway version of Miss Saigon Degree, or whether a black actor should be able to play the lead in Shakespeare's Richard II. One do maintain that a certain institutional skewing has taken place if, within a supposedly diverse society, it is only whites who represent Asians, only men who play women, or only children who fill black roles. It would suggest a profound social imbalance if only North Americans compose the intellectual canon of South American history. And if rape occurs mostly to women, it seems peculiar to reserve control over the standards for its remediation exclusively to men. In fact, it is precisely these sorts of disrespectful exclusions that signal the most visible sites of oppression in any society. In our society, the most obvious means of Metro Broadcasting Incorporated v. FCC, regrouping in singular times 195. Tearing down such exclusions is dispersion of ownership. Participation in ownership of anything, but most particularly of broadcast stations or other tools of mass communication, is the gateway to our greatest power as Americans. Ownership enables one not merely to sell to others or to offer oneself to the call of the market, it also provides the opportunity to propagate oneself in the marketplace of cultural images. Participation in the privileges of ownership thus involves more than the power to manipulate property itself, it lends an ability to express oneself through property as an instrument of one's interests. We think of freedom of expression as something creative, innovative, each word like a birth of something new and different, but it is also the power to manipulate one's resources to sanction what is not pleasing. The property of the communications industry is all about the production of ideas, images, and cultural representations, but it also selectively silences even as it creates. Like all artistic expression, it is a crafting process of production and negation, in the same way that a painting may involve choices to include yellow and blue while leaving out red and green. When one translates this understanding of ownership into the context of broadcast diversification, the issue becomes not only what is sanctioned but also who is sanctioning. It is not that minorities live in wholly separate worlds, enclaves walled in by barriers of language, flavors, and music. Minorities are not languishing on electronically underserved islands, starving for the rap marimba beat of a feminist Korean-speaking radio DJ whom only similar others can understand. Nevertheless, a feminist Korean DJ is more likely to sanction insulting images of herself and more likely to choose to propagate images of herself which humanize her and her interests. Likewise, it is not that white owners cannot be persuaded not to rerun old Amos and Andy shows, in which white actors in blackface portrayed blacks in derogatory if comic ways and which reiterated the exclusive, until recently, image of blacks in the media. Rather, it is much easier and very likely not even necessary to persuade Bill Cosby, for example, to choose to run programming that challenges and variegates the perpetual image of blacks as foolish and deviant. In fact, I think that Bill Cosby's very success as owner, producer, writer, and actor in delivering an image of at least a certain middle-class segment of imagistic blackness into the realm of the normal, rather than the deviant, has run him up against yet an even more complex, if instructive, level of cultural co-optation. As the Cosby Show's warm, even smarmy appeal has made it a staple in homes around the country, black cultural inflections that were initially quite conspicuous, speech patterns, the undercurrent of jazz music, the role of Hillman College as the fictional black alma mater of the Huxtables, hairstyles ranging from dreadlocks to high-top fades, have become normalized and invisible. Moreover, the process of normalizing has exaggerated the extent to which the black middle class and white middle class are not merely derivative, but identical, so that the Cosby Show has been described as little more than a portrayal of blacks costumed in cultural whiteface. Although this whitening of its appeal is refined into the language of sameness, the process devalues and even robs the program of its black content. Thus, as black cultural contributions are absorbed into mainstream culture, they actually come to be seen as exclusively white cultural property, with no sense of the rich multiculturalism actually at work. Ultimately, the minority set-aside policies at issue in metro broadcasting must address this consuming, unconscious power as well. It is not enough to have one Bill Cosby or two Oprah Winfreys if overall power is so concentrated in one community that it remains inconceivable that power could have any other source. For benighted, and bewildered. Any basis for resisting this kind of analysis, I recognize, is the question of whether an expanded consideration both of injury to groups, rather than simply to individuals, and of remediation that extends beyond the limited life circumstances of a single litigant is a matter for the courts at all. The reflexive referral of all but the most privatized controversies to the legislature obscures the fact that even the narrowest contract or property dispute is never really as private as theory would have it. Courts always have to consider social ramifications that are rarely limited to the named parties, whether that consideration is of policy, the contemporaneous society of those similarly situated, or whether the consideration is funneled into issues of precedent, the prior or subsequent society of others. Indeed, I think we must begin to appreciate the extent to which courts actually deal in and perpetuate not merely individual property interests but also property interests that govern, silence, and empower significant groups of us as citizens. One device by which courts have traditionally limited challenges to the social status quo is the consideration of cases and controversies constrained within a paradigm of private contract law. This insistence amounts to considering all litigation from within a contractarian paradigm that fragments the social contract into a series of little contracts. In the context of cases about civil liberties, this can be downright destructive. As citizens, we tend to think of raw Hobbesian economic interest as being separate from the shrine in which our civil liberties, our freedom, and our humanity reside. Yet, as lawyers, we learn this is not so. Our liberty was always and is increasingly complex and contradictory, a symbology framed not just by economic notions in some general sense but also by specific contractarian ideas of commodification and bipolar exchange. The subjectivity of our civil and political selves is simultaneously objectified by our most distanced, arm's-length transactions. This results in a twisted conception of freedom in which the notion of ourselves as free becomes transformed into that of free agent. With this shift, another occurs: we no longer see freedom's inverse as domination, but rather only as the inverse of free agency. Thus, those who by one set of criteria are living in states of cultural, economic, or physical subjugation may be described as inefficient wealth maximizers, mere depoliticized shoppers who are irrational and undeserving by either choice or resistance. A model of constitutional jurisprudence based on this contractarian vision therefore fails to anticipate the situation in which an aggregate of private transactions in a society begins to conflict with express social guarantees. Those express protections or ideals are robbed of their force as law and become situated as external, implicit interference. Courts' ability to consider these matters is actually not as murky and unmanageable as the dissenters in Metro Broadcasting suggested. The impression that such matters are unmanageable is in fact built by a variety of rhetorical images. The dissenters waged a deflationary war on the value of diversity itself and on any evidence that diversity is a good, necessary, or considered goal. The Metro Broadcasting dissenters labeled the notion of societal discrimination amorphous, registered and reflexive. Actual legislative history was deemed too paltry. 10 congressional and agency findings were judged to be without a demonstrable factual basis. The attempt to defend historically vulnerable interests was reduced to the privileging of viewpoints, cultural identity was turned into racial stereotypes, degree and the judicial responsibility to check the tyranny of any majority was abdicated out of a hypothesized fear of advancing or benefiting special groups. Beyond this devaluation of the interests at stake, the dissents are peppered with inexplicably inverted agency, demonstrating that any language of reform may be turned inside out by conflating it with historical tropes of negativity, even as its substance is being relentlessly dehistoricized. Whereas segregation and group exclusion were once thought of as the stigmata of inferiority, now, according to the dissenters, it is the very identification of blacks and other racial minorities as groups which is stigmatizing, no matter that the project is inclusion. The South African government is cited to demonstrate the truism that policies of racial separation and preference are almost always justified as benign, even when it is clear to any sensible observer that they are not. Tempting me to some easy inversions of my own. In the United Metro Broadcasting Incorporated v. FCC, regrouping in singular times 197 states, policies of racial inclusion and community are almost always vilified as harmful even when it is clear to any sensible observer that they are not. It is not only the dissenters, however, whose language could stand reform. In the charged context of dismantling a system of favoritism that favored whites and disfavored blacks, the majority glibly reversed the vocabulary of preference so that it was blacks who were favored and whites automatically disfavored. The casual ahistoricism of this reversal implies a causal link between the inclusion of blacks and the oppression of whites. To give an example that would be extreme were it not asked so often, a student recently demanded of me, "Don't you think affirmative action is what creates a David Duke?" Blacks are positioned in this query as responsible for the bitterest backlash against them, an eerie repeat of the responses, one being the founding of the Ku Klux Klan, to black gains, having nothing to do with affirmative action, during Reconstruction. In fact, affirmative action and minority set-aside programs are vastly more complicated than this "you're in, I'm out" conception suggests. Nothing in this rigid win-slash-lose dichotomy permits the notion that everyone could end up a beneficiary, that expansion rather than substitution might be possible, and that the favoring of multiple cultures is an enhancement of the total rather than a sweepingly reflexive act of favoritism for anything other than the monolithic purity of an all-white nation. This particular evocation, of a corrupt system of favoritism seesawing between the deserving and the preferred, caters to an assumption that those who are included by the grace of affirmative action systems are therefore undeserving. I want to underscore that I do mean that it caters to, rather than creates, an assumption of inferiority, for the assumption of inferiority has a life that precedes and, unfortunately, will probably outlive affirmative action programs. The subtlety of this distinction has terrified even some few blacks into distorting historic assumptions of blacks as inferior into the weird acceptance of their exclusion as its cure. Sitting on university admissions committees, for example, I have seen black candidates who write on their applications comments such as, "Don't admit me if you have to lower your standards." I have never seen the same acutely self-conscious disavowals from students who are admitted because they meet some geographical criterion such as living in Wyoming, or France, or some other underrepresented area, or who are older re-entry students, or football heroes, or alumni children. I think this is so because these latter inclusionary categories are thought to indicate group life experiences, whether we call them cultures or not, that enrich rather than lower. The question, then, becomes not how to undo inclusionary affirmative action programs but, rather, how to undo the stigma of inferiority which resides not merely in the label or designation of race, but which, according to our national symbology, is actually embodied in black presence. If it were truly as simple as erasing labels, then perhaps enough whiteout in our cases and codes would eliminate the problem once and for all. However, it is the ferocious mythology of blackness, or otherness, as the embodiment of inferiority which persists whether blacks are inside or outside particular institutions, and regardless of how they perform. In the same vein, the majority employs the half-hearted ambiguity of benign racial classification in place of what might be more forcefully described as the principle of anti-discrimination. Furthermore, anti-discrimination and diversity are polarized in the dissents, so that it is no longer possible formally to recognize diversity without its being not merely risking being discriminatory. The quest for inclusion becomes transformed into the exact equivalent of that which would exclude. The slogan "separate but equal" is called up as the exact equivalent of the newly minted "unequal but benign." In only 25 years, blacks and Bull Connor have become relativized in this soupy moral economy. The focused and meaningful inquiry of strict scrutiny has become a needle's eye through which minority interests are too inherently suspect to pass. Racial and ethnic identification as that against which one ought not discriminate has been twisted. Now those very same racial and ethnic classifications are what discriminate. The infinite convertibility of terms is, I suppose, what makes the commerce of American rhetoric so very fascinating, but these linguistic flip-flops disguise an immense stasis of power, and they derail the will to undo it. Furthermore, the complication of this rhetoric, an ironic result of the judicial desire to simplify, seems to have resulted in an odd and risky quest by the Metro broadcasting dissenters to be rid not only of any undue power to discriminate negatively but also of the very ability to be discriminating in any sensitive, curious, or moral way. As I have written elsewhere, the idea that an egalitarian society can be achieved or maintained through the mechanism of blind neutrality is fallacious. Racial discrimination is powerful precisely because of its frequent invisibility, its felt neutrality. After all, the original sense of discrimination was one of discernment, of refinement, of choice, of value judgment, the courteous deflection to the noble rather than to the base. It is this complicated social milieu that must be remembered as the backdrop to what both the majority and dissenters refer to as preferences in this case. Racism inscribes culture with generalized preferences and routinized notions of propriety. It is aspiration as much as condemnation, it is an aesthetic. It empowers the mere familiarity and comfort of the status quo by labeling that status quo as natural. If we are to reach the deep roots of this legacy, anti-discrimination must be a commitment to undo not merely the words of forced division but also the consequences of oppressive acts. As in the old saw about the two horses given equal opportunity to run a race, but one of whom has a stone in its shoe, the failure to take into account history and context can radically alter whether mere neutrality can be deemed just. One consequence of a quietly racist aesthetic in which the status quo is naturalized is that any change will be felt as unnatural and thus as extremely unsettling. The costs of doing anything to alter the known, even when those alterations are matters of both social and self-preservation, are inflated to terrifying proportions. It is not surprising, therefore, that the Metro Broadcasting dissenters turned any express judicial consideration of even the merest whisper of institutional adjustment into a slippery slope of misfortune. The ubiquity of racism is made menacing in its enormity, the recognition of it as a social problem held out as a threat, as a hedge against doing anything at all about it. Rather than being allowed to feel good about tackling it at some level, we are threatened relentlessly with the clatter of domino theories. This small concession now, hisses the amicus brief filed by the Solicitor General's office, but what next? Do you really want those preferences in virtually any business? And would you want a preference moving in next door to you? To say nothing of marrying your sister. That the Metro Broadcasting majority resisted such fear-mongering is a hopeful sign. Indeed, it is my hope that this case represents a renewed willingness to consider the costs of limiting judicial scrutiny by an account of humanity which is isolated from history, accident, and inextricable contiguity. V. Conclusion. TEE majority opinion in Metro Broadcasting marks an important step toward a recognition of multiculturalism and of the need to take active steps to nurture such diversity. If the holding in this case does not guarantee that minority owners will change programming in any constructive way, it does at least increase the likelihood. 2 degree. Although the dissenters implicitly insisted on a guarantee that there be some relation, a necessary connection, such a strict guarantee can never be gained without expense to the freedoms provided by the First Amendment. Even diversity of employment at levels other than ownership is largely at the will and whimsy of those owners. If cultural diversity is, as even the dissenters acknowledge, an acceptable social goal, then alternative, creative means for its encouragement must be employed. That relation is fostered by making more frequent and enhancing the opportunities for minority owners and producers, who are more likely to. Metro Broadcasting Incorporated v. FCC, regrouping in singular times 199 hire minority writers, sponsor programs designed to serve the needs and interests of minority communities, and, perhaps most important, bring multiculturalism to mainstream programming. Beyond the limited context of broadcasting, what I hope will be enduring about this opinion is the respect it gives to these pronounced social recognitions of the desirability of diversity in all aspects of our economy and of multiculturalism in our lives. A, probably too, concrete illustration may indicate the reconceptualization of equality that is so urgently needed. Imagine a glass half full, or half empty, of blue marbles. Their very hard-edged, discrete, yet identical nature makes it possible for the community of blue marbles to say to one another with perfect consistency both we are all the same and, if a few roll away and are lost in a sidewalk grate, that's just their experience, fate, choice, bad luck. If, on the other hand, one imagines a glass full of soap bubbles, with shifting permeable boundaries, expanding and contracting in size like a living organism, then it is not possible for the collective bubbles to describe themselves as all the same. Furthermore, if one of the bubbles bursts, it cannot be isolated as a singular phenomenon. It will be felt as a tremor, a realignment, a reclustering among all. Marbles and soap bubbles are my crude way of elucidating competing conceptions of how to guarantee what we call equal opportunity. One conception envisions that all citizens are equal, with very little variation from life to life or from lifetime to lifetime. Even when there is differentiation among some, the remainder are not implicated in any necessary way. The other conception holds that no one of us is the same, and that although we can be grouped according to our similarities, difference and similarity are not exclusive categories but, instead, are continually evolving. Equal opportunity is not only about assuming the circumstances of hypothetically indistinguishable individuals, it is also about accommodating the living, shifting fortunes of those who are very differently situated. What happens to one may be the repercussive history that repeats itself in the futures of us all. Part 4. Critical Race Theory and Legal Doctrine. Groups, Representation, and Race-Conscious. Districting, a case of The Emperor's Clothes. Lonnie Guinier. And now that the first round of reapportionment has been accomplished, there is need to talk one man, one vote a little less, and to talk a little more of political equity and of functional components of effective representation. A mathematically equal vote that is politically worthless because of gerrymandering or winner-take-all districting is as deceiving as the emperor's clothes. With voices pitched in the high decibel range, critics of race-conscious districting are blasting the Voting Rights Act and its 1982 amendments. A recent Wall Street Journal headline declares that voting is now rigged by race. Ethnic activists, the writer asserts, are collaborating with GOP operatives in an unholy political alliance to herd minorities into their own convoluted urban districts in order to improve GOP prospects in white-majority suburban areas. According to such critics, this is a political one-night stand made possible by misguided federal courts and Department of Justice officials construing the 1982 Act to create districts in which minorities are the majority, the newest form of racial packaging. My students inform me that Cokie Roberts, as part of ABC's election night coverage, dramatically illustrated the concerns of critics when she traced on a map of the Chicago area the earmuff district, allegedly carved out of two non-contiguous Chicago neighborhoods joined by a narrow rod to maximize the possibility that the Latino residents would be able to elect a representative of their choice to Congress. And in June 1993, the Supreme Court discovered a new constitutional right enabling white voters in North Carolina to challenge, based on its odd and irregular shape, a highway district that narrowly tracks the path of an interstate, creating a swatch of voters on either side of the highway from one end of the state to the other. Registered this 54% black district, the most integrated in the state, elected Melvin Watt, one of the first two blacks elected to Congress from that state in this century. The Voting Rights Act codified the right of protected minority groups to an equal opportunity to elect candidates of their choice, although its language disclaims the rights to racial representation by members of the racial group in direct proportion to population. The critics now claim this is special and unwarranted protection for racial and language minority groups. In the name of liberal individualism, these critics assert that the statute effected a radical transformation in the allocation and nature of representation. Although race-conscious districting is their apparent target, these critics have fixed their aim on a deeper message that pressing claims of racial identity and racial disadvantage diminishes democracy. We all lose, the theory goes, when some of us identify in racial or ethnic group terms. For in my view, critics of race-conscious districting have misdirected their fire. Their emperor has no clothes. Their dissatisfaction with racial group representation ignores the essentially group nature of political participation. In this regard, the critics fail to confront directly the group nature of representation itself. Esp. 206. Chaley in a system of geographic districting. Perhaps unwittingly, they also reveal a bias toward the representation of a particular racial group rather than their discomfort with group representation itself. 5. In a society as deeply cleaved by issues of racial identity as ours, there is no one race. In the presence of such racial differences, a system of representation that fails to provide group representation loses legitimacy. Registered. Yet these critics have, in fact, accurately identified a problem with a system of representation based on winner-take-all territorial districts. There is in fact an emperor wearing his clothes, but not as they describe. Rather than expressing a fundamental failure of democratic theory based on group representation per se, the critics have identified a problem with one particular solution. It is districting in general, not race-conscious districting in particular, that is the problem. Winner-take-all territorial districting imperfectly distributes representation based on group attributes and disproportionately rewards those who win the representational lottery. Territorial districting uses an aggregating rule that inevitably groups people by virtue of some set of externally observed characteristics, such as geographic proximity or racial identity. In addition, the winner-take-all principle inevitably wastes some votes. The dominant group within the district gets all the power. The votes of supporters of non-dominant groups or of disaffected voters within the dominant group are wasted. Their votes lose significance because they are consistently cast for political losers. The essential unfairness of districting is a result, therefore, of two assumptions: first, that a majority of voters within a given geographic community can be configured to constitute a group, and second, that incumbent politicians, federal courts, or some other independent set of actors can fairly determine which group to privilege by giving it all the power within the district. When either of these assumptions is inaccurate, as is most often the case, the districting is necessarily unfair. Another effect of these assumptions is gerrymandering, which results from the arbitrary allocation of disproportionate political power to one group. Districting breeds gerrymandering as a means of allocating group benefits. The operative principle is deciding whose votes get wasted. Whether it is racially or politically motivated, gerrymandering is the inevitable byproduct of an electoral system that aggregates people by virtue of assumptions about their group characteristics and then inflates the winning group's power by allowing it to represent all voters in a regional unit. Given a system of winner-take-all territorial districts and working within the limitations of this particular election method, the courts have sought to achieve political fairness for racial minorities. As a result, there is some truth to the assertion that minority groups, unlike other voters, enjoy a special representational relationship under the Voting Rights Act's amendments of 1982 to remedy their continued exclusion from effective political participation in some jurisdictions. However, the proper response is not to deny minority voters that protection. The answer should be to extend that special relationship to all voters by endorsing the equal opportunity to vote for a winning candidate as a universal principle of political fairness. I use the phrase "one vote, one value" to describe the principle of political fairness that as many votes as possible should count in the election of representatives. Registered one vote, one value is realized when everyone's vote counts towards someone's election. The only system with the potential to realize this principle for all voters is one in which the unit of representation is political rather than regional, and the aggregating rule is proportionality rather than winner-take-all. Semi-proportional systems, such as cumulative voting, can approximate the one vote, one value principle by minimizing the problem of wasted votes. One vote, one value systems transcend the gerrymandering problem because each vote has an equal worth independent of decisions made by the voters themselves. These systems revive the connections between voting and representation, whether the participant consciously associates with a group of voters or chooses to participate on a fiercely individual basis. Candidates are elected in proportion to the intensity of their political support within the electorate itself rather than as a result of decisions made by incumbent politicians or federal courts once every 10 years. My project in this paper is to defend the representation of racial groups while reconsidering whether race-conscious districting is the most effective way of representing these groups or their interests. Point 2. My claim is that racial group representation is important, but it is only imperfectly realized through an electoral system based on territorial districting or through the limited concept of racially descriptive representation. Point 7. For many liberal reformers, the one person, one vote principle is politically fair because its ideal of universal suffrage incorporates the respect due and the responsibilities owed to each citizen in a democracy. One person, one vote cases attempt to equalize the purely formal opportunity to cast a ballot through a system of population-based apportionment. Under this rationale, each district contains approximately the same number of people, each person within the district has the same opportunity to vote for someone to represent the district, and each district representative represents the same number of constituents. The one person, one vote principle thus assures all voters the right to cast a theoretically equal ballot. In this section, I argue that this theoretical possibility is unlikely to be realized in an electoral system using winner-take-all districts. I further suggest that neither groups of voters nor individuals are fairly represented under such a system. There are two issues at stake. One raises the question of whether voting is constitutionally protected because it implicates individual rights. If voting is an individual right, the second question asks whether the one person, one vote principles that operate within the confines of geographic districts adequately protect the right to vote. I concede that voting has garnered its highest constitutional protection when presented as an individual rights issue, but the widespread use of winner-take-all districts on Determines the validity of this characterization. The fact that constitutional rules about voting evolved within a system of regional representation suggests that posing the problem as one of individual rather than group rights has been a distraction. I claim that the heavy reliance on one person, one vote jurisprudence to develop a theory of democracy fails both as a theory and as an adequate doctrinal protection of either individual or group rights. A. One person, one vote, and the limits of liberal individualism. In this subsection, I examine the assumption that the allocation of representatives through winner-take-all districting is a form of representation of individuals. The heart of this assumption is that citizenship is the ultimate reflection of individual dignity and autonomy, and that voting is the means for individual citizens to realize this personal and social standing. Under this theory, voters realize the fullest meaning of citizenship by the individual act of voting for representatives who, once elected, participate on the voters' behalf in the process of self-government. Indeed, the very terminology employed in the Supreme Court's one person, one vote constitutional principle suggests that voting is an individual right. For these reasons, some assume that the right at stake is the individual right to an equally weighted vote or an equally powerful vote. The assumption is that constitutional protection for voting is exclusively about protecting an individual right, not necessarily about ensuring equal voting rights. At first, the connection between the two concepts seems plausible because every citizen has the right to vote, and because every citizen has the right to an equally weighted vote. Yet the one person, one vote principle of voting is primarily about equal, not individual, representation. Under this equality norm, the right to fair and effective representation subsumes concerns about equal voting and equal access. As the Supreme Court stated in one of its early reapportionment cases, the principle of equal representation for equal numbers of people is designed to prevent debasement of voting power and diminution of access to elected representatives. Implicit in this equality norm is the moral proposition that every citizen has the right to equal legislative influence. This means an equal opportunity to influence legislative policy. The assumption that voting is an individual right is also unnecessary for the view that voting rights are a means of political empowerment. One person, one vote rules emerged in response to claims about population-based malapportionment and about the right of the majority of people to elect a proportionate share of representatives. 2. In announcing this principle, the Supreme Court recognized that the growing urban majority of the 60s would never command its fair share of legislative power unless the court intervened. In conjunction with concern about both a fair share of power and developments in the law of minority vote dilution, the court also adopted an instrumental view of voting: people would participate when and if they thought their vote mattered. Under this empowerment norm, the primary purpose of voting rights is to empower citizens to participate in the political process. I take the position that the right of the individual to participate politically is a right best realized in association with other individuals, in other words, as a group. As Justice Lewis Powell recognized, the concept of representation necessarily applies to groups. Groups of voters elect representatives, individual voters do not. 3. This is a bottom-up view of representation in which voters are empowered by their collective participation in the process of self-government. Under this view, voters engage in collective action to choose someone to represent their interests within the governing body. The representative is charged with influencing policy on behalf of constituents' collective interests. However, the court's jurisprudence does not consistently express a bottom-up view of representation within either the equality or the empowerment norms. 22 On occasion, though, the court implicitly assumes the value of collective participation and influence in opinions that do not articulate the bottom-up view. For example, the court's discussion in Reynolds v. Sims of a fair share of representation for population majorities suggests that by equalizing the number of people for whom each representative is responsible, the election of a single individual can fairly represent what are in essence collect interests. 3 Another example is Baker v. Carr, where the plaintiff's original complaint alleged a systematic plan to discriminate against a geographical class of persons. The bottom-up view of representation is reflected in some of the court's early language about the importance of having a voice, meaning a public policy vote in the process of self-government. It also is the basis for the court's 1986 decision in Davis v. Vandemer that political gerrymandering claims are justiciable. Registered in his plurality opinion for the court in Davis, Justice White suggests that the policy decision to represent groups fairly already had been made in the context of racial minorities. Of course, one could counter that representation is essentially a process of providing individual constituents with individual service, and that it is therefore an individual right. This is a top-down view of representation in which the representative reaches back to his or her district to return government benefits to district constituents. In this sense, equalizing the number of constituents equalizes access for individuals, not groups of individuals. Representation becomes the formal opportunity to receive one's fair share of government benefits or to have access to one's representative for individual constituency service. Voting creates a personal value, or a symbolic statement of belonging. By the mere act of casting a ballot, a vote is meaningful because it is counted, whether or not it actually affects the outcome. While this top-down view might rest on the assumption that the right to representation is an individual right, it does not mesh well with the assumption that the right to vote is an individual right. Indeed, a voter need not vote at all to be represented under this understanding. Actually casting a vote is less important than establishing voting status. Representation becomes the process of initiating a relationship in which one need not ever participate except by moving into the district. Even non-voters are represented vicariously by choices made on their behalf. Proponents of the philosophy of individual EE 209 ism attempt to use the one person, one vote principle to locate voting in the status of individual or constituent. They rely on the fact that every individual has the opportunity to cast a potentially winning vote or to be represented vicariously by one who does. This approach camouflages the group nature of voting by emphasizing the personal aspects of representation. Consistent with their prevailing political philosophy of individualism, some members of the court have struggled mightily using one person, one vote rules to avoid the concept of group representation. However, even when its nexus to group activity remains disguised, the principle of one person, one vote is as consistent with group as it is with individual representation. Similarly, the one person, one vote principle is consistent with semi-proportional representation systems. Even if voters each were awarded 5 votes to plump as they choose, the one person, one vote principle would be satisfied, since each voter would have the same voting power or voting weight. I argue that despite the efforts of some members of the court to characterize representation as an exclusively individual notion, the concept of group representation became unavoidable for 2 reasons. The first, which I develop in section I, is that the concept of group voting was necessary to understand the political unfairness of excluding racial minorities in a racially polarized constituency. The second, to which I now turn, is that the one person, one vote principle was conceived and articulated within a construction of constituencies based on geography. It is districting itself that merges individual representation with the representation of groups of individuals. Thus, it always has been necessary to acknowledge, at least implicitly, the relationship between districts and interests. B. Group representation and territorial districting. In this subsection, I argue that because of our explicit and implicit recognition of constituencies of geography, we have never actually employed a system of individual representation. Indeed, the use of geographic results as the basis for establishing representational constituencies is at its very heart a system of group-based representation. Moreover, even where districts comply with one person, one vote principles, such districts dilute the voting strength both of individuals and of groups. The concept of representation necessarily applies to groups. Groups of voters elect representatives, individuals do not. Degree representation is more than the individual relationship between constituent and elected representative. Because representation is primarily about political influence, not about political service, bottom-up representation becomes the essential link to a genuine voice in the process of self-government. Districting is a form of group interest representation, albeit an imperfectly realized one. Districting, by definition, assumes that each voter is a member of a group comprised of all the voters in her district. Asterisk. As Justice Potter Stewart noted, the very fact of geographic districting carries with it an acceptance of the idea of legislative representation of regional needs and interests. Asterisk. Regardless of whether other justices of the Warren Court ever consciously adopted the idea of interest representation, in working within territorial districts they assumed that interests reflect where people live. The view that geography approximates political interests is not a new idea. Indeed, the idea that geographic units reflect a common or group identity is part of the historical explanation for the winner-take-all system of districts. The American system of winner-take-all districts was adapted from the system in Britain prior to 1832, which in turn can be traced to feudal origins. The feudal tradition helped to define the law of the franchise on the theory that it was the land, and not men, which should be represented. Asterisk. It was the community, in theory, that was represented, and therefore the qualification for voting was corporative, with the franchise varying between communities. Functional groupings, not individuals, were the basic units of representation. The British system also created a link between political representation and geographically based interests. Elected representatives were not seen as representatives of individual constituencies, they were merely members of Parliament who represented all of Britain. The parliamentary system of representation had I-210 evolved in Britain because of feudal duties and obligations. The lord and his vassals were literally tied to the land, and representation in Parliament was actually part of the lord's feudal service to the king. Similarly, inhabitants of the medieval town were not separate, for representational purposes, from the town itself. The town was a political association, and the status of its inhabitants was defined by the rights of the group to which they belonged, namely the town. This link between political representation and economic or geographic ties was later carried over to the United States during the colonial period. By the late 18th century, towns were directly represented in the American colonial legislatures by representatives with explicit instructions to represent the town's interests. The relevance of town representation is that colonial towns exercised power as a group they had rights, as a group they had powers. Registered representation by geographical groups became the norm, in part because there was often no practical distinction between occupational and territorial representation degree. Indeed, the word representation originated as a term used by medieval jurists to describe the personification of collectivities. The spokesperson for a community was its embodiment, the bearer of its representative personhood. 7 Even in its modern form, representation often connotes the activity of furthering the interests of an abstraction rather than of an individual. Registered. Although many liberal theorists of American democracy espouse the importance of representation of the rational individual, this claim is at odds with the historical roots of an electoral system that relies on regional rather than political units of representation. It is also at odds with the practice of districting. The process of geographic districting collects people into units of representation by virtue of certain group characteristics or assumptions about shared characteristics within geographical communities. Geographic districting grounds the representational relationship in the opportunity to vote for a candidate to represent the interests of voters within a regionally defined political unit. It is assumed that those voters who share the homogeneous characteristics that give the district its identity, its dominant political, regional, or racial affiliation, are in fact represented. Because all voters share at least a common regional identity, they all live within the district's geographic walls. All voters are therefore assumed to be represented without regard to their actual choice of a candidate. However, the geographic unit is not necessarily politically homogeneous or of one mind as to who should represent it. In any contested election, some voters will vote for someone other than the winning candidate. These votes do not lead to the election of any candidate. Although these voters reside in equally populated districts, they have not chosen someone to represent their interests. Their theoretically equal votes are, as a practical matter, wasted in that the casting of their vote did not lead to the selection of their representative. The term wasted votes, therefore, refers to votes cast for a candidate who does not win. In addition, I use the term to refer to votes cast for someone who does not need the votes to win. Constituents do not consciously choose to become members of this group, since very few people move somewhere in recognition of their likely voting efficacy within particular election subdistricts. Similarly, when they move, few people know in advance the particular elected officials by whom they are likely to be represented. In other words, voters do not move to an election district, they move to a neighborhood or community. I am suggesting that constituents within a geographically district group may be there involuntarily, without sharing the same interests as other community residents, and despite pre-existing hierarchical relationships. In this way, membership in the territorial constituency is like membership in a family, with the former imposed by residence and the latter by kinship. Like family, geographic districts may not reflect conscious choice, as compulsory constituencies, though, they nevertheless reflect ties that bind. Moreover, even if this factual assumption is incorrect, voters who might move based on the likelihood that they will reside within a specific election district are not acting rationally. This is because the imperative of the one person, one vote rule mandates continual redistricting*. Even motivated voters can rely on existing district configurations for only limited lengths of time. The level of mathematical equality now required by the courts *registered makes it hard to claim that many election districts are neighborhoods. The upshot of absolute population equality as the basis for representation is that equipopulous districts are more important than districts that preserve communities of interests or leave neighborhoods intact. In this respect, districting under the one-person, one-vote rule is arbitrary. Indeed, this was Justice Stewart's complaint when he accused the Supreme Court of privileging the personal right to vote over the efforts of local government to represent regional needs, communities of interest, or political subunits. Districting justifies the representation of this artificial group using a theory of virtual representation degree *. Virtual representation works like constructive in constructive possession, it means as if or pretended representation degree * in contrast to direct representation or bottom-up representation. Virtual representation relies on three concepts: indirect representation, representation of similar interests elsewhere, and top-down representation. While the theory of virtual representation theoretically could be justified by any one of these concepts, the three assumptions generally are interrelated. Each of these assumptions is critical to the validity of virtual representation. First, virtual representation assumes that the district winner indirectly represents the district losers. For this to hold true, the election winner must do an adequate job of representing all those who reside within the district, including his or her political opponents. This assumption is based on the golden rule principle that the winner will not tyrannize the losers because the winner may become the loser in the next election. The winner realizes the value of political stability, so she will also represent the losers. Thus, in the long run, the losers' votes are not permanently wasted, because they operate to hold the winners in check. The second assumption of virtual representation is that the district losers technically are represented by similarly situated voters elsewhere in the political system. In this assumption, voters are represented when other voters who are like them vote in other districts and succeed in electing their candidate of choice. This reasoning assumes that similarly situated voters are fungible, in other words, that they are essentially indistinguishable on some critical threshold issue, and that groups district voters by characteristics they share with non-district voters. Because of these group characteristics, district losers are vicariously represented by winners in other districts for whom they would have voted had they been given the chance. As a result, the second assumption sees voters as represented based on certain group characteristics that can be externally predetermined for a 10-year period, between census counts, at the time of reapportionment, and can be measured jurisdiction-wide, rather than district-wide. Plus again, the district losers' votes technically are not wasted because these losers are represented by someone, albeit not someone for whom they voted. The third virtual representation assumption is that the district itself is a cognizable group that is represented ultimately as a community of the whole. This incorporates the proposition that a district has some independent existence apart from the discrete individuals who form an electoral majority. This is the historical claim that the district itself has a political or group identity. This argument relies on a top-down view of representation. Living in Pennsylvania, I am represented by 2 U.S. senators even if I am under 18 years old, mentally incompetent, or disenfranchised based on non-citizenship or a criminal conviction. The assumption is that the district, and hence all its residents, are serviced whenever anyone is elected to represent the district. The key element of representation is equal access to the elected representative who is available to each constituent as a result of her status as a district resident. Each of the voters. A. 212. Within the district is represented those who voted for a losing candidate as well as those who did not or could not vote. Because voting is primarily symbolic of personal status within a coherent community, virtual representation argues that no one's vote is wasted. Every voter in a district is presumed to be represented simply because her territorial constituency is represented. The voter within a territorial constituency is represented because she has someone to turn to in case of personal constituency service needs. She is presumed to be represented even if she did not vote for the winning candidate. The fact that she wasted her vote is ignored, because she is nevertheless geographically present within the political subdivision. No stock is placed in the fact that she did not vote for the representative. She is simply represented through the direct representation of her needs and her geographic nexus to the representative's supporters. If districting is to be justified by virtual representation, the entire theory of districting depends upon the juxtaposition of territorial constituencies and interest constituencies. Drawing district boundaries presumably defines communities of interest. District lines determine a set of associations between the voter and a particular representative, as well as among the voters themselves. It is only because voters within a particular district are deemed unlikely to have opposing interests that the notion of a personal relationship between the voter and the representative can survive. Voters are presumed fungible. The representative otherwise would be unable to service disparate personal needs without compromising the interests of other constituents. These virtual representation assumptions are related to two somewhat inconsistent premises of liberal individualism. One is the value of majority rule. The district majority governs with legitimacy, because the district is a coalition of shifting factions whose multiplicity of interests will keep anyone from dominating. The factions demonstrate that the district is not homogeneous, but the winner will virtually represent the losers because the losers are not permanent. The winner may be the loser in the next election. The first premise of liberal individualism thus shares the first premise of virtual representation. It posits that individuals who vote for losing candidates are adequately represented by the winning candidate and have as much opportunity to influence that candidate as do other voters in the district. The second premise is that representation is primarily a personal relationship between the representative and her constituents. In this context, the representative does not know how a particular constituent voted and will service her needs in the hopes of recruiting or sustaining her allegiance. Adherents of the personal relationship perspective do not deny that the representative is more likely to represent faithfully the interests of those who voted for her. They simply suggest that the needs of each constituent also will be met because a district constituency establishes a relationship between the voter and her personal representative without regard to the voter's actual electoral preference. However, this premise, unlike the majority rule premise, is based on a view of relative homogeneity within the district. Because the district constituents have similar needs and interests, it is possible for one representative adequately to service all constituents. If the constituency has such common interests, one would expect a relatively unanimous constituency. By contrast, the majority rule assumption relies on a more fractured constituency to balance the majority's urge to dominate. The personal relationship perspective and the majority rule premise are, therefore, in some tension. They define voting by reference to competing notions of fungibility and personal access, on the one hand, and distinct interests, on the other. As a consequence, the virtual representation assumptions do not fit neatly within a one-dimensional view of representation based on liberal individualism. In fact, the rational individual who serves as the focal point of individualism would often take actions that are wholly inconsistent with virtual representation. The most apparent inconsistency is the idea that one's interests can be effectively represented by someone whom the voter, when given the choice, rationally determined does not reflect her interests. There is something distinctly unliberal in the view that indirect representation of interests is preferable to direct representation of groups or interests as defined by the voters themselves. If the voter who goes to the polls is represented by the person against whom he or she votes, then the representation of the majority of the people becomes a representation of the whole people. The voter is defined not by a rational individual choice but by the majority's choice. Another inconsistency is the notion that the voter will be motivated to participate when she will be adequately represented by whoever is elected. Voting will simply become a habit, a civic duty, although it yields no direct results. In such a scenario, the rational individual would choose not to vote because of the small likelihood of casting the decisive vote. Yet another inconsistency is produced by the virtual representation assumption that wasted votes, those cast for a losing candidate, do not reflect the absence of representation because the territory defines the community, the group, and its interests. This view suggests that mere geographical subdivisions have interests distinct from those of the people who inhabit them. Because individualism posits that the rational individual will act in her own self-interest, this external determination of the interests represented is inconsistent with individualism. Perhaps most inconsistent with the theory of autonomous, rational individuals is virtual representation's notion of fungibility. Virtual representation, explicitly in the second assumption and implicitly in the third, assumes that individuals are interchangeable based on some externally observed characteristics. Accordingly, individual choice is subordinated to the choices made by the majority, and the individual must allow someone in another district to act on her behalf. In these often unstated but related ways, districting conflates the view that territorial constituencies virtually represent discrete individuals who reside therein with the view that territorial constituencies group like-minded voters. Related to each of the virtual representation assumptions, therefore, is the corollary that 213 we can use proxies, in this case geography, for determining voter interests. Such proxies merge voters' own definitions of their interests with the self-interest of political incumbents or with the interests of a homogeneous territorial district majority. The use of such proxies reveals the fundamentally group-based nature of representation, a feature that is inherent in, but inadequately recognized by, our contemporary system of representation. For example, where representation is only virtual rather than direct, those who vote for the losing candidate may find that their interests are not represented at all. The constituency is presumed to be a group based on a single choice, the decision where to reside. This one choice may not be a real choice for some, for others it may not satisfactorily carry all the weight being assigned. Alternatively, the assumption that the geographic constituency is not dominated by a highly organized majority may simply be wrong as a matter of fact. It is important to recognize, therefore, that the districting debate is not only about representing groups, it may also be about representing groups or individuals unfairly. If voting reflects the voter's conscious choice rather than simply representing the voter's state of belonging, then winner-take-all districting in fact wastes votes both of individuals and of groups. First, it makes certain that there are political losers in each district. Those who vote as individuals or as a group for the losing candidate do not obtain any direct political representation. They did not initiate, and they cannot alone terminate, the representational relationship. In response, An individual rights advocate might argue that the individual who votes for a losing candidate is adequately represented by the winning candidate and has as much opportunity to influence that candidate as other voters in the district. This, of course, makes sense only if one assumes both that election results count for very little, and that representation is exclusively about individual access to representatives chosen by others. In response, districts could be made more homogeneous in order to reduce the number of wasted votes. However, this alternative demon 214 straits the second way in which winner-take-all districting wastes votes. When more people vote for the winning candidate than is necessary to carry the district, their votes are technically wasted because they were unnecessary to provide an electoral margin within the district, and they could have been used to provide the necessary electoral margin for a like-minded partisan in another district. In other words, packing voters in homogeneous districts wastes votes because it dilutes their overall voting strength jurisdiction-wide. The third way in which districting wastes votes becomes apparent if we consider voting broadly. I have suggested that voting is not simply about winning elections. The purpose of voting is to influence public policy. Accordingly, I have elsewhere proposed a concept, which I labeled proportionate interest representation, to describe the importance of an equal opportunity to influence public policy, not just to cast a ballot. This concept reflects both the equality and empowerment norms that I discussed earlier, because the right to cast an equally powerful vote subsumes the right to participate directly in the choice of representatives who then presumably enjoy an equal opportunity to influence legislative policy. If voting is understood as a means of exercising policy influence, districting tends to limit that influence. Winner-take-all districting gives the district majority all the power. It creates an incentive, therefore, to seek electoral control of a district. However, electoral control of a district may isolate minority partisans from potential allies in other districts. In this way, districting wastes votes because it forces minorities to concentrate their strength within a few electoral districts and thereby isolates them from potential legislative allies. For example, race-conscious districting attempts to provide disadvantaged racial groups the equal opportunity to participate by drawing geographic districts in which the majority are minorities, a majority-minority district. Proponents of this strategy assume that electoral control becoming a district majority works as a proxy for interest, but creating majority black districts also means creating majority white districts in which the electoral success of white legislators is not dependent upon black votes. In this way, race-conscious districting may simply reproduce within the legislature the disadvantaged numerical and racial isolation that the majority-minority district attempted to cure at the electoral level. Where blacks and whites are geographically separate, race-conscious districting isolates blacks from potential white allies, for example, white women who are not geographically concentrated. It wastes the votes of white liberals who may be submerged within white, Republican districts. As a consequence, districting may suppress the development of cross-racial legislative coalition building. Because majority black districts are necessarily accompanied by majority white districts, black representatives may be disenfranchised in the governing body. In this third sense, districting wastes votes because it fails to ensure legislative influence. The wasted vote phenomenon makes gerrymandering inevitable. Because winner-take-all districting awards disproportionate power to electoral majorities, it inflates the advantage of district control. This inflated power quotient drives the apportionment process and leads some, myself included, to conclude that on some level all districting is gerrymandering. Gerrymandering is inherent in the districting process, which in essence is the process of distributing wasted votes. Where incumbent politicians seek safe districts to ensure their re-election, they may be inclined to gerrymander, that is, to waste the votes for their likely opponent. Where political or racial partisans seek legislative control, they may be inclined to gerrymander, that is, to pack the minority party or minority race into a few districts to diminish their overall influence. Alternatively, they may fracture the likely supporters of the minority party or minority race, spreading out their votes among a number of districts and ensuring that they do not comprise an electoral majority in any district. These votes are counted, but they are essentially irrelevant in influencing the electoral or governing process. The gerrymandering phenomenon illustrates once again the group nature of districting. GER 215. Gerrymandering depends on assumptions about voters' likely behavior based on externally observed or supposed group characteristics or perceived common interests. Although the use of electoral districting has been defended with arguments based on the virtues of individual representation, assumptions about the nature of groups likely form the theoretical underpinnings of the election method. I have tried to show that district representation weakens the connection between the voters' votes and the voters' representative by wasting votes. Unless all the voters in the district vote for the winning candidate, some of their votes are wasted. In addition, if a candidate only needs 51% of the votes to win, but the district is homogeneous and electorally non-competitive, then all votes for the winning candidate over SR% are also technically wasted. The point is that the voter is deemed to be represented whether she votes for the losing candidate, is an unnecessary part of the winning candidate's victory margin, or fails to vote at all. The concept of wasted voting reveals the one-dimensional quality of the virtual representation assumptions. Yet wasted voting is only one of the ways that district representation minimizes the connection between voting and representation. The winner-take-all aspect of territorial constituencies also tends to overrepresent the winning party and to deny the losing party a voice on behalf of their specific interests in the legislative forum where public policy is finally fashioned. In addition, territorial constituencies both submerge and subsume the concept of group representation. They also subsume individual definitions of relevant group identity in favor of individual residential decisions. The artificial nature of these geographic associations suggests the limitations of the view that individual representation is the cornerstone of the right to vote. Territorial constituencies do not realize individual autonomy for at least three reasons. First, many people do not exercise real choice in deciding their place of residence. Second, even where residential decisions are conscious and discretionary, they do not capture the range or salience of interests which voters may hold. Third, the one person, one vote requirement of equipopulous districting makes districting even more artificial. If the major constraint on the drawing of district lines is the number of people within each district, district lines cannot conform to naturally occurring areas of common interest. When incumbents exercise enormous control over the districting process, including the custody of census data and the access to computer technology, communities of interest may become mere re-election opportunities. This is the threat to functional interest representation that various justices have predicted over the years in their dissents to strict population equality principles. IDE. In this section, I argue that race is as effective as geography in functioning as a political proxy. Neither, though, is as effective as allowing voters the opportunity to make their own local choices about the nature and salience of their interests. Semi-proportional systems permit shifting coalitions to form based on voters' own determinations of their interests or their group identity. In other words, geography and race rely on representational assumptions about group association but do not suggest the necessity, standing alone, of either representing or defining group interests a particular way. Modified at-large systems, such as cumulative voting, could be viewed as preferable alternatives that allow members of racial groups, politically cohesive groups, and strategically motivated individuals to be both self-defined and represented, while minimizing the problem of wasted votes for all voters. Race in this country has defined individual identities, opportunities, frames of reference, and relationships. Where race has been of historical importance and continues to play a significant role, racial group membership often serves as a political proxy for shared experience and common interests. At least to the extent that an overwhelming majority of group members experience a common group identity, degree. Those who are group members are more likely 216. To represent similar interests. Degree group members also may share common cultural styles or operating assumptions. Group members also are more likely to be perceived by their constituents as representing them. This definition of representatives as descriptive likeness or racial compatriot has a psychological component. Just as the flag stands for the nation, the presence of racial group members symbolizes inclusion of a previously excluded group. The symbolic role results both from the personal characteristics of the racial group member and from the assumption that, because of those characteristics, the racial group member has had experiences in common with her constituents. As Hannah Pitkin writes in her groundbreaking work on representation, we tend to assume that people's characteristics are a guide to the actions they will take, and we are concerned with the characteristics of our legislators for just this reason. Registered. Thus, many racial minorities do not feel represented unless members of their racial group are physically present in the legislature. As a result, traditional voting rights advocates comfortably rely on race as a proxy for interests. For example, in conventional voting rights litigation, election contests between black and white candidates help to define the degree of racial polarization, that is, the degree to which blacks and whites vote differently. The idea is that the outcome would be different if elections were held only in one community or the other. The assumption of difference extends explicitly to the specific candidate elected, and implicitly to the issues that candidate, once elected, would emphasize. The assumption of this difference between races rests in part on the claim that where black candidates enjoy protection from electoral competition with whites, black voters can ratify their choices to hold their representatives accountable. In this way, the association between race and interests is modified to the extent that voters are given a meaningful choice in both initiating and terminating a representational relationship. Voting rights advocates assume that minority group sponsorship is critical degree **. It is only where minority voters exercise electoral control or have a meaningful opportunity to retire their representative that race functions as a representational proxy. Thus, majority black single-member districts take advantage of segregated housing patterns to use geography as a proxy for racial choice, racial control, and racial representation. I argued in Section I that the one-person, one-vote cases, with their focus on equalizing individual access through equalizing population, conceal the group nature of representation of districting. Race-conscious districting confronts the group nature of representation more directly. It attempts to minimize the wasted vote problem for minority voters whose preferred candidates because of racial bloc voting by the majority experience consistent defeat at the polls. Where voting is racially polarized, white voters and black voters vote differently. Where blacks are a numerical minority, racial bloc voting means that the political choices of blacks rarely are successful. To remedy this problem of being a permanent loser, black political activists and voting rights litigants have sought majority black districts in which the electoral choices of a majority of blacks determine the electoral winner. Nevertheless, some commentators challenge race-conscious districting on the grounds that special protection throughout the political process for the rights of minority groups is unnecessary as long as individual minority group members have a fair chance to participate formally by voting in an election. Registered for these commentators, race-conscious districting is illegitimate because the right to vote is individual, not group-based. Degree relying again on assumptions about fungibility and access. These observers challenge the right of minority groups to representative or responsive government. Given the prominence of racial group identities, I am not persuaded by this criticism to abandon the concept of group representation. Am aware of, but not in accord with, those critics of race-conscious districting who object on moral grounds to the drawing of districts along racial lines. Representation is a bottom-up process that ideally recognizes the importance of influencing public policy decisions on 217. Behalf of constituency interests. Accordingly, we cannot define political fairness merely as electoral fairness guaranteeing non-biased conditions of voting eligibility and equally counted votes. Nor do I think the only issues are whether blacks have special claims for protection or whether whites can or should represent blacks, although I think they can and do. Yet, in making the argument that racial groups deserve representation, I do not rely primarily on the political, sociological, or cultural claims involved in racial group identity, or even on the historic context of group disenfranchisement. My principal argument rests on the distinction within the political process between a claim for group rights and a claim for group representation. I argue for the latter, based on the historic evidence that representation within territorial districts is implicitly about recognition of group interests, not just individual access. However, the future of such group representation, like the future of the group itself, lies less inside geographic boundaries and more within the cultural and political community forged by group consciousness and group identity. Empowerment for a group as well as for an individual comes from active assertion of self-defined interests. A group is represented where it has the opportunity to speak out, not just to be spoken for. The argument for recognition of group interests makes three assumptions about representation. First, legislators should represent unanimous, not divided, constituencies degree registered. Second, each voter's vote should count toward the election of a representative. Third, the unit of representation should be psychological, cultural, and/or political, rather than territorial. In other words, groups should be represented, but in ways that permit automatic, self-defined apportionment based on shifting political or cultural affiliation and interests. This would enable voters to form voluntary affiliative districts without the need for prior authorization or formal recognition of the group as one that deserves special treatment. Because such group identity would be affiliative and interest-based, group representation would encourage both coalition building among racial and political factions and grassroots political organization around issues, not just around individual candidacies. If the decision to represent groups already has been made in the adoption of geographic districting, then group representation based on racial group association or historical oppression becomes less problematic. Whatever the alleged flaws in racial group representation, it is racial representation within a system of geographic districts that must be analyzed. One white Democratic congressman who represents a largely minority constituency is quoted as saying, "I'm torn about it. I do not believe you have to be of the exact same ethnic group to do a good job in representing that community. But, in the end, I think it's that community's choice." Degree. Thus, it is important to emphasize the connection between choice, accountability, and group identification. Whoever represents minority interests, just as whoever represents majority interests, should be directly, not merely virtually, accountable to those interests. However, some critics of race-conscious districting might attempt to distinguish race from geography as a useful political proxy. Such critics claim that the geographic association, unlike race, is temporal, individualistic, and discretionary, at least for some people. There are two problems with this purported distinction. First, geography is neither discretionary nor individualized for members of disadvantaged racial groups. Rather, it reflects the very essence of limitations on choice based on group identity. Race-conscious districting can capture racial communities of interest precisely because residential ghettos are often the result of racial discrimination. As Professor Pamela Carlin writes, residential segregation reflects racial discrimination in both the private and public housing markets. Degree. Because residential segregation by definition results from the absence of choice, race-conscious districting can serve as a proxy for a bundle of distinct political interests. A second problem is that this criticism applies only to race-conscious representation executed within a system of fixed district boundaries. Indeed, the concern can be avoided almost entirely where the voters themselves define their 218 own interests using alternative, modified at-large systems of representation. Representation based on voluntary interest constituencies would unhitch racial group representation from arbitrary, involuntary assignments. The voluntary interest constituencies would be comparable to Professor Iris Marion Young's model of a highly visible social group with emotional, historical, and social salience defined by a sense of group identity, not just shared attributes. According to Young, groups exist only in relation to other groups. The social processes of affinity and differentiation produce groups. Yet group differentiation is not necessarily oppressive nor homogeneous, it is created by multiple, cross-cutting, and shifting differences. The group differentiation of racial minorities is a function of historical oppression, shared experience, and present inequality. Territorial configurations may track this phenomenon to the extent that disadvantaged racial groups are concentrated in substandard housing in urban ghettos, but differentiation by race cuts across geographic lines in many cases. Some racial group members share a group consciousness without sharing group space, others are dispersed in small barrios throughout the jurisdiction. Still others may technically be group members in terms of their racial origin or current residence but not in terms of their racial identity. In addition, group differentiation by race subsumes gender, age, and class differences. A racial group that is politically cohesive on civil rights or welfare policy may have some members with interests that are not shared throughout the group. On these issues, the racial group members may have more in common with group members of another race living outside of their immediate geographic area. In other words, racial groups are not monolithic, nor are they necessarily cohesive. Race in conjunction with geography is a useful but limited proxy for defining the interests of those sharing a particular racial identity. However, it is the assumption that a territorial district can accurately approximate a fixed racial group identity and not the assumption of a racial group identity itself that is problematic. Race-conscious districting, as opposed to racial group representation, may be rigidly essentialist, presumptuously isolating, or politically divisive. For example, different groups may share the same residential space but not the same racial identity. A districting strategy requires these groups to compete for political power through the ability to elect only one representative. Yet strategies for race-conscious districting respond to important deficits in a non-race-conscious geographic districting process. Proponents of racial group representation confront on the jurisdiction-wide level the unfairness of the indirect, virtual representation claims. In justifying race-conscious districting, voting rights activists appropriately employ the concept of racial group identity. They can demonstrate that members of the racial group have distinctive interests that are often ignored by elected officials who suffer no adverse consequences at the polls. In this way, the activists challenge the view that voters are fungible, especially where minority group voters are consistent losers as a result of racial bloc voting by the jurisdiction majority. Based on complaints about the way that virtual assumptions operate at the macro level to dilute minority voting strength, race-conscious strategies seek to control small, majority-minority districts. By making the minority a district majority, race-conscious districting seeks to exercise the prerogatives of majority rule on behalf of a jurisdiction-wide minority. While they challenge the fairness of jurisdiction-wide virtual representation of minority voters by the majority, though, proponents of race-conscious districts replicate many of the same fairness problems at the micro level. The same assumptions about virtual representation that were the object of challenge at the macro level are now reproduced within sub-districts that the racial minority controls. The majority-minority sub-district operates on the same winner-take-all, majority rule principles. Even as an imperfect geometric fractal registered of a larger jurisdiction-wide majority, it carries with it the assumptions of virtual representation to justify the minority group's domination. As a consequence, race-conscious districting raises in microcosm the theoretical questions I raised in section I about districting itself. An illustration of this fractal problem is a 1992 New York City congressional plan that included a Brooklyn-Queens district to represent the interests of a Latino minority. This district concentrated Latinos in a new 12th congressional district. Several Latino activists filed as candidates in the Democratic primary, so did Representative Steven Solars, a white incumbent whose previous district was consolidated within 1/5 of the new Latino district. The entry of a well-financed, 9-term incumbent from a largely Jewish section of Brooklyn shifted the political expectations. The primary, which had been expected to focus on issues of interest to a poor Latino constituency, turned into a debate over whether a minority group could be represented by someone of a different ethnicity. According to a Latino community organizer, the community is saying, "Why is it that this Jewish person who has always represented other interests than ours, comes in now saying he's going to be our savior?" Registered Degree. This complaint that the white incumbent should not enter the race rested on a complex, but misinformed, understanding of group representation. The group is deemed represented where it has electoral control over the winner. The organizers' concern was that the 16% white minority in the district, not the Latino majority, could have electoral control by consolidating their votes and converting their minority status into a plurality win. Since there were at least 4 Latino candidates, the white candidate would most likely win if the Latino vote were split, even though Latinos are 55% of the district's voting age population. If the Latino majority was disaggregated into factions supporting different Latino candidates, it could have been white voters who chose the representative for the new district. Latino activists complained that this did not give their community the choice they deserved. The whole idea was to give our community some degree of choice, Latinos or non-Latinos. 219 who have some connection with the community. The well-financed white incumbent doesn't fit that bill at all. 8 the white candidate answered, "The other candidates fear that TLL win," which somewhat belies their notion that the purpose of this district was to empower the people to make a choice. Registered. The nature of this controversy was captured by a New York Times headline that appeared before the primary: "Does politics of fairness mean only those from minorities should apply?" I propose restating the problem as follows: does politics of fairness mean that self-defined groups are best represented by territorial districts, even those they ostensibly control? So stated, the question shifts the issue from the candidate to the constituency. By asking this new question, we can see the 3 incongruous assumptions inherent in racial control of territorial constituencies. The first assumption is that because they represent a majority of the district population, the 55% Latino voting age population is appropriately empowered to represent the entire district, although 8% of the district is black, 21% Asian, and 16% white. 4 This assumption parallels the first virtual representation assumption: the district losers will be represented indirectly by majority winners. Race-conscious districting is arguably necessary because the jurisdiction-wide majority is organized racially and permanently. Degree. This argument suggests that there is nothing inherently wrong with the principles of indirect representation underlying winner-take-all majoritarian, except where the majority operates based on its prejudices. As long as the current pattern of racial bloc voting continues, the minority cannot become part of the jurisdiction-wide governing coalition. Thus, special smaller majorities are warranted. The second assumption is that a Latino majority in this district will choose a representative for all Latinos in the jurisdiction. This tracks the second vicarious representation assumption that similarly situated voters can represent each other. Because Latino interests are underrepresented in other winner-take-all congressional districts, their interests in the city as a whole, 220, are now fairly represented by virtue of their electoral control over this one district. Conversely, the Asian, black, and white minorities in this one district are vicariously represented by their electoral control over other districts in the city. Thus, Latinos who do not live in the district are virtually represented by choices made by the Latinos who do live in the district. Race-conscious districting only approximates the diversity of voter identities in the jurisdiction as a whole, but not necessarily in each district. With the second assumption, the race-conscious districting approach does not challenge political representation based on geography, it simply suggests that specific groups should dominate specific districts in proportion to their overall statewide or jurisdiction-wide percentage. Here, the claim is that political fairness is measured by a jurisdiction-wide baseline rather than by reference to a critique of group rights or majority domination more generally. Majority domination is acceptable as long as each group gets a chance to be represented somewhere in the jurisdiction by its own localized majority. The third assumption is that the 12th congressional district is a minority district without regard to the actual intra- or inter-minority conflict within the district. The third assumption presumes political cohesion based on the fiction that the district has an identity independent of the actual constituents. It also presumes equal access for constituency service within the district and relies on the claim that a minority identity ensures a minority ideology. Minority group interests will define the district identity and anyone who represents it. The Asian, Black, and white minorities are presumed to be represented because of their choice to live near Latinos. Stated differently, because Latinos are not as residentially segregated as other racial groups, they can represent the interests of their multicultural neighborhood as a whole. Their neighbors' interests are represented both for personal constituency service and for their territorially defined common interests. The third assumption is related to the top-down view of representation. Like the virtual representation view that the district has an independent identity, the 12th congressional district is a Latino district. As a so-called minority district, it has an identity independent of the actual tensions present, the level of political cohesion, or the political participation rates of its constituents. In this way, race-conscious districting incorporates a static, somewhat monolithic, view of representation that, after the initial drawing of a majority-minority district, diminishes the subsequent importance of broad authority from a consenting group of participants. For example, Latinos within the district arguably are represented by any one of the 4 Latino candidates, even where a majority of the Latino residents vote for a losing candidate. The issue of choice is submerged within a presumption of ethnic solidarity in the majority Latino population district, even if Representative Solars did not compete. This is because the district is a Latino district, and the elected representative will therefore service all constituents equally, especially other Latinos. Yet a top-down view of representation does not encourage broad-based political participation among the direct constituency. Non-voters are represented equally with voters. Because representation is viewed primarily as a means of distributing constituency service and benefits and is primarily based on a common group identity, there is little incentive actively to monitor the public policy positions the representative takes within the governing body. Under this top-down view, elections serve not to initiate an interactive relationship, but to ratify an open-ended one. In this way, the assumption of minority district as independent identity ignores issues of multiple, cross-cutting, and shifting differences. This is an empowerment strategy designed primarily to increase the proportion of minority group legislators. Because of the success of individual minority group members, the group as a whole is empowered. However, empowerment is not based on assumptions about phenotypic representation. Voters also must be EE 221. Directly given the opportunity and the information necessary to define their interests for themselves. These 3 assumptions, of course, invite the criticism that race-conscious districting arbitrarily reduces voters to their ethnic or racial identity and then only represents that characteristic in a way that isolates or balkanizes the population. However, the real complaint is not with the race consciousness of the districting, but with the districting process itself. The race-conscious districting assumptions simply replay the same virtual representation assumptions that are used to justify territorial constituencies in the first place. Thus, the race-conscious districting assumptions are neither unique nor necessarily contextual. For example, the winning candidate might be the one Latina who appeals to all the different ethnic and racial groups within the district, winning with a 5% plurality of Latino support and a solid majority of white, Black, and Asian votes. Although this individual might be Latina in identity, she would not in fact be elected directly by Latinos to represent their interests. In fact, the successful candidate was Nydia Velázquez, a former representative of Puerto Rico to New York, who polled 33% of the vote, compared to 27% for Mr. Solars. According to the New York Times, Ms. Velázquez's margin of victory came from overwhelming Latino support in Brooklyn and from strong support from the black community. Registered, she reportedly benefited from the endorsement by the city's black mayor, David Dinkins, and from the firestorm of criticism that erupted when Mr. Solars decided to run in the newly drawn district. Degree 8. One might argue, then, that Ms. Velázquez's election affirmed the second and third assumptions of virtual representation. Because Latinos supported her within the 12th district, Latinos throughout New York City are now vicariously represented even though they could not vote for her. In addition, Ms. Velázquez's black support confirmed the viability of the third assumption that the 12th district is a bona fide minority district. The first virtual representation assumption is not directly implicated by the election because it depends upon post-election behavior of the elected representative. 4 other Latino candidates competed in the primary. Elizabeth Colon polled 26%, Ruben Franco polled 8%, Eric Ruano Melendez and Rafael Mendez each received 3% of the vote registered. Although I do not have the actual precinct totals, these figures do not rebut the possibility that a majority of Latino voters, especially those living in Queens, actually preferred someone other than Ms. Velázquez. Similarly, they do not deny the possibility that blacks, who are only 8% of the district, may have supported Ms. Velázquez, but Asians and whites may have preferred someone else, because Asians, at 21%, are the second largest group in the district. It may not be appropriate to presume that inter-minority political cohesion extends to all of the district's minority voters. The other aspect of the third assumption, that this is a genuine Latino district, is also not clear, since a majority of Latinos may have preferred someone other than Ms. Velázquez. The validity of the first assumption, that the electoral majority will now indirectly represent all the electoral minorities, also remains to be seen. It is currently a theoretical claim based on the operation of Golden Rule reciprocity in conjunction with other assumptions about the individual nature of voting and representation. The district's political reality, however, may defy the theory that the district minority, those who wasted their votes, will act as a potent political check on a shifting district majority. For example, I noted the possibility that the election returns suggest distinct group interests among and within the Asian, Black, and white district community. The votes of these subgroups may, as a practical matter, become permanently wasted. Indeed, over the 10-year term of the district, the Latino majority may act cohesively and return the Latina incumbent to office. Re-election of the incumbent may occur with decrease. 222. ing turnout as a percentage of all the district's population, but with increasing support among those who do vote simply because she is the incumbent. This is consistent with evidence that minority candidacies generate relatively high voter turnout the first time a viable minority candidate competes. Turnout, however, tends to go down when constituents realize that the election of a single minority incumbent changes very little of their day-to-day lives. Nevertheless, the fact that the Latina is now an incumbent gives her tremendous resource advantages over any future opponents. Some may argue that her continued re-election reduces polarization within the district, as the other non-Latina voters see Ms. Velázquez work on their behalf. On the other hand, her predictable re-election success may exacerbate rather than reduce intergroup conflict. The district's complicated racial, ethnic, and linguistic mix is not reflected in the ethnic or racial group membership of its representative. The fact that the district winner in a multi-ethnic district has a psychological, cultural, and sociological connection primarily to one ethnic or racial group may alienate other groups over time. If Asians, for example, feel consigned to permanent minority status within the minority district, they may bide their time until redistricting in the year 2000, when the legislature decides how many minority districts should be created and who should control them. The fight to be the group who gets the district, and with it all the power, pits minorities against each other. The fact that some members of the other minority groups in the 12th district can only cast wasted votes for 10 years encourages each group ultimately to think in terms of its own moral, historical, and pragmatic claims to exclusive or primary district representation. Where representation becomes the lottery of competing oppression, no one wins. Only the second assumption, at least on the psychological level of vicarious representation, is solidly supported by the election of Ms. Velasquez. This is based on evidence that those minority group members who do not vote for group members nevertheless feel represented by them. This phenomenon reflects the continued vitality of racial group identity. Many group members feel most represented by one of their own. Even if the second vicarious representation assumption is true, one could maintain that people are represented without regard for whom they choose to vote simply because of where they choose to live or who they are. Latinos in Queens living a few blocks outside the 12th district, who cannot vote for Ms. Velasquez, will continue to waste their votes within the districts in which they reside. Their votes, which under some other district configuration might help elect an additional, or simply a different, Latino, are submerged within their non-Latino district. Because their votes will be wasted, non-district Latinos are not encouraged to participate directly in the process of self-government. The process of voting itself may become meaningless. Districting ignores this problem with wasted votes by embracing group representation based on territorial contiguity and indirect representation. Because geographic districting wastes votes, neither minority groups nor majority voters are fairly represented. Districting fails to deliver on its virtual representation assumptions, even where districts are drawn to maximize minority voting strength. Districting is not justified by the individual representation value because each voter's vote does not count to the greatest extent possible toward the election of a representative. Districting is not supported by the group representation value because legislators do not represent unanimous constituencies, and they therefore find it either hard to govern or easy to excuse unaccountability. The tensions between values of individual and group representation, between direct and indirect representation, between top-down and bottom-up representation, and between wasted and effective votes permeate virtual representation, even within race-conscious geographic districting. For this reason, modified at-large systems used in corporate governance, such as cumulative voting, should be considered. Under a modified at-large system, each voter is given the 223 same number of votes as open seats, and the voter may plump or cumulate her votes to reflect the intensity of her preferences. Depending on the exclusion threshold, politically cohesive minority groups are assured representation if they vote strategically. Similarly, all voters have the potential to form voluntary constituencies based on their own assessment of their interests. As a consequence, semi-proportional systems such as cumulative voting give more voters, not just racial minorities, the opportunity to vote for a winning candidate. Racial group interests become those self-identified, voluntary constituencies which choose to combine because of like minds, not like bodies. Legitimate interest constituencies are formed among groups of individuals who share similar opinions or identities. These interest constituencies are less fixed than under territorial districting. Nevertheless, racial minority groups may still choose collectively to elect representatives. However, the minority voters' choices are now based on their conception of identity, which may be defined in racial terms because it is either racially apparent, racially derived, or a function of historical treatment by the numerically superior racial majority. Thus, even if voting is thought to be a concept of individual autonomy, the recognition of voluntary choices to affiliate or form associations minimizes wasted voting while transcending artificial groups based solely on residence or race. On the other hand, if voting is seen as a group representation concept, representation systems should minimize wasted votes in order to realize maximum influence and empowerment. Under either view of voting and representation, a semi-proportional system is preferable because it minimizes wasted votes and defines voting behavior based on choices exercised by the voters themselves. Additionally, if racial group identity is a value that deserves representation, territorial constituencies are an imperfect proxy. If racial group membership is thought to be affiliative yet involuntary in the sense that history, culture, and social pressures combine to define one's membership, it is equally important to provide openings within the political process for self-defined group representation. Territorial constituencies do not do this, because they fail to maximize opportunities for group political empowerment and individual group members' participation and self-expression. As a result, whether representation is considered essentially an individual or a group activity, the principle of one vote, one value is necessary to protect voters' interests. Everybody's vote should count for somebody's election. Voters are directly represented only if they actively choose who represents their interests. In this sense, I am arguing for a more expansive account of the representational relationship for all voters. In order to achieve political equality and political fairness, an electoral system should give voters the direct opportunity to initiate and terminate their own representational relationship. It is not enough that some voters choose for everyone or that everyone has an equal chance to be the only electoral winner or electoral loser. Voting should become a positive sum experience in which all voters actively participate in selecting their representative. On the assumption that each participant should enjoy an equal opportunity both to participate and to influence, the concept of one vote, one value describes the idea that each voter should elect someone to represent her interests. This new view of the representational relationship draws on the concepts of equal opportunity to participate and equal opportunity to elect representatives of one's choice, concepts that are embodied in the Voting Rights Act amendments of 1982. It arguably would expand the statutory view of the representational relationship in a way that benefits all voters. The courts, however, have been hesitant to employ a one vote, one value system as a remedy under the Voting Rights Act. In Granville County, North Carolina, black voters challenged the at-large method of electing the county commission. Blacks, who comprised 44% of the county's population, had never been able to elect any person to the five-member commission. The defendant commissioners conceded that black voters were not represented on the county's at-large commission. They also admitted that if the county were district, and if 2 additional commissioner seats were added, blacks would be able to elect one of 7 commissioners, giving the 44% black population electoral control over 14% of the commission. The single-member districting remedy failed to capture much of the black community, which was dispersed throughout the county. The plaintiffs proposed, and the district court approved, retention of the staggered term, at-large method of election with a threshold lowering, semi-proportional modification that allowed voters to cast only 3 votes for the 5 open seats. 1 degree when the modified system was employed, 3 blacks were elected to the 7-person commission. The Fourth Circuit in McGee v. Granville reversed and restricted the relief granted based on a narrow definition of the causal relationship between what the plaintiffs challenged and the available relief. 1 degree. The court ruled that single-member districts were the only appropriate remedy. Since the plaintiffs challenged at-large elections, which prevented black candidates from getting elected, the exclusive remedy was to create single-member districts in which black candidates were likely to get elected. Even if all or many black voters did not reside in the newly configured majority black districts, their remedy was limited to the virtual representation they received from districts that enjoy black electoral success. By articulating its analysis of vote dilution exclusively in terms of single-member districts, the courts have tended to promulgate single-member districts as a talismanic liability and remedial threshold. 1 degree asterisk. At the same time that courts have moved closer to a single-member district, black electoral success standard, they have clearly established descriptive proportional representation as the ceiling. The court in Thornburg v. Jingles, for example, reversed a finding of dilution in District 23, where it appeared that black voters enjoyed proportionate representation because a black was consistently elected over a 12-year period. The court did not discuss the fact that black voters in the district had to employ bullet voting to elect the black candidate and thus forfeited their chance to influence which whites would be elected. Nor did the court address the evidence that the black who was elected was actually chosen by the white voters and had to sail trim, 8 his legislative positions accordingly. Despite judicial reluctance to adopt alternative remedies, the principle of one vote, one value satisfies the representational needs of voters in 2 ways that districting does not. First, It extracts the unfairness of wasted votes from winner-take-all solutions. Votes that would have been wasted in a winner-take-all system are redistributed to voluntary constituencies consistent with the actual level of their political support. Second, it allows voters to choose their representational identity. Rather than imposing a group identity on a given geographic constituency, this system gives voters the opportunity to associate with the identity that fits their own view of psychological, cultural, and historical reality. Thus, racial and other politically cohesive groups could be represented in proportion to their actual strength in the electorate rather than in proportion to their geographic concentration. As a result of political organization, voter education, and strategic voting, any politically cohesive group that is numerous enough to meet the local threshold of representation could mobilize to gain representation. Ultimately, what the one vote, one value principle does is to transform the unit of representation from a territorial or racial constituency to a political or psychological one. This affirms Iris Young's view of the social group as one based on self and historical identification, and it rejects representational groups based simply on the joint possession of externally observable attributes or the choice of a residence plus one vote. One value makes the assumption that each voter should enjoy the same opportunity to influence political outcomes. No one is entitled to absolutely equal influence, but by the same token, no one is entitled to grossly disproportionate influence or a monopoly on control. The majority should enjoy a majority of the power, but the minority should also enjoy some power too. Thus, one vote, one value measures opportunities for fair participation as 225. ing a baseline of actual participation and real political strength. The principle of one vote, one value, as realized through cumulative voting, also restores the link between representation and voting by ensuring that legislators represent unanimous, not divided, constituencies. Representation becomes the process of bottom-up empowerment based on self-defined expressions of interest. Moreover, assuming that voters vote strategically, votes are not wasted either by voting for losing candidates or by packing voters into safe districts. The legislative body can reflect fairly the range of opinions and interests within the public at large, including racial minorities who can be represented based on their electoral strength. Gerrymandering becomes unnecessary and can no longer be used to enhance the disproportionate power of incumbents to ensure their own re-election or to exaggerate the political control of the party in power. Finally, local political organizations may be given the space and the possibility of success. Such parties can fill the needs for political mobilization, voter education, and legislative monitoring, which largely go unfilled in our current system. Thus, by restoring the link between representation and voting, alternative election systems encourage voter participation. They also can broaden the range of debate by allowing local political organizations to emerge and interest-based political coalitions to form. These coalitions would not be limited to neighborhood communities of interest, certain racial groups, or particular elections. Rather, they would contain dynamic possibilities for regional, reciprocal, or cross-racial political cohesion. The race-conscious context of districting might be retained, but only on an election-by-election, issue-by-issue, voter-by-voter basis. In balancing the fears of balkanization against observations about existing alienation, I conclude that exclusiveness is a greater evil than controversy, that passivity does not equal contentment, and that differences need not be permanently enshrined in the electoral configuration. Modified at-large election systems encourage continuous redistricting by the voters themselves based on the way they cast their votes in each election. Whatever differences emerge, therefore, are those chosen by the voters rather than imposed externally on the voters based on assumptions about demographic characteristics or incumbent self-interest. These voter-generated differences may infuse the process with new ideas. Diversity of viewpoint can be enlightening. Finally, the modified at-large system may simply reflect a necessary transition phase from power politics to principled politics. Whether it succeeds in that respect, it at least has the benefit of infusing the process with more legitimacy from the perspective of previously disenfranchised groups. 1. I do not mean to denigrate concerns that the proliferation of political interest constituencies may undermine consensus, exacerbate tension, and destabilize the political system. These concerns reflect a preference for conflict resolution that camouflages rather than identifies political differences. My preference, however, is first to recognize salient differences, and then to work with those differences to achieve positive-sum solutions. My idea is that politics need not be a zero-sum game in which those who win it all. My idea is that where everyone can win something, genuine consensus is possible. There is, in addition, a concern with one vote, one value principles that I have not previously considered. In my focus on wasted votes, I have not yet examined the effect of one vote, one value approaches on communities with large numbers of non-citizens, age-ineligible citizens, or people with other conditions that disable them from voting. For example, concerns about the representation of non-citizens are prominent in the Latino community. Concerns about the disproportionate number of young citizens are also relevant to the Black community. 3. Thus, each of those communities has a special profile in terms of the number of people who are represented ultimately by each voting member of the community. This is a virtual representation problem within the electorate itself. Since districting is based on population rather than on turnout or registration rates, people who do not vote at all are nevertheless represented. This idea is encompassed by the third virtual representation assumption that the district identity is independent, yet consuming, of all constituents. Even if one cannot vote, one's interests are presumably represented by those who can. For minority communities whose population is in greater need of government service, access to representatives based on population may be more fair than access to representatives based on turnout. A voluntary interest constituency composed of like-minded voters devalues the interests of elements within the constituency who cannot or do not vote. Of course, the same criticism can be leveled at safe districting. Although its population base extends top-down representational access to non-voters, these constituents are stuck with whomever the majority of district voters choose. In other words, safe districting assumes that non-voters and voters are fungible in that the voters indirectly represent the interests of the non-voters. Accordingly, children are only indirectly represented by the representatives chosen by adults on their behalf. Admittedly, changing the structure of electoral units is an incomplete solution even to those problems on which I have previously focused. Because of its potential disruption, it is also a solution worth considering only where the existing election system unfairly distributes political power in a way that is itself disruptive or illegitimate. As for the problem of differential participation rates, one can speculate about three possible responses. First, like districting systems, one vote, one value election systems require some sub-districting. Except in very small cities or towns, some multi-member sub-districts would be required both to reduce the complexity of the ballot and to promote access for local communities of interest. In New York City, for example, boroughs might be appropriate multi-member districts for borough-wide cumulative voting. This might accommodate the concern that representatives have a local constituency for whom they are responsible without regard to who actually voted for them. Second, although interest representation based on one vote, one value does not directly protect non-voters any better than do districts, it does create an environment in which they, as well as voters, are encouraged to participate directly. By participation I mean the broad range of bottom-up activity relating to the political process. I specifically disavow an emphasis exclusively on election day voting. Because semi-proportional systems rely on voluntary interest group constituencies, they reward local political organizing efforts more than systems with predetermined constituencies. Representation is earned in proportion to political activity and actual turnout rather than fixed population or majoritarian aggregating rules. This means that local political organizations, with an activated grassroots base, can actually win elections. Non-voters can participate in the organizing and monitoring effects of local political organizations and thus actively assert their own interests. Non-voters can participate in all the pre- and post-election day activities of the political organization. In this way, one vote, one value encourages representation directly of interests, not just of voters. Non-voters can directly support a local organization that articulates their interests rather than passively rely on the presumption that they benefit from choices made by those who virtually vote their interests. Third, the commitment to consensus politics implicit in the one vote, one value approach benefits voters and non-voters, majorities and minorities. It infuses the process with receptivity to new ideas. It promotes a new definition of stability based on inclusiveness, not quietude. It creates positive sum possibilities rather than limiting participation to winners and inevitable losers. With its focus on coalition building and consensus, it does not assume that conflict is better suppressed than voiced, nor does it assume that politics need always be zero-sum. One vote, one value represents a new vision of political participation. It assumes that empowerment comes from opportunities for the active assertion of one's own interests speaking out, not just being spoken for. One vote, one value attempts to mediate directly the tension between individual and group representation that characterizes the districting process at each level. Thus it is more fair both to individuals and to groups. 227. 3 Conc. Controversy over racial group representation offers us an opportunity to re-examine the political fairness of our district-based electoral system. I posit that a system is procedurally fair only to the extent that it gives each participant an equal opportunity to influence outcomes. I call this principle one vote, one value. This is a measure of procedural, not substantive, legitimacy. According to this principle, outcomes are relevant only to the extent that they enable us to measure degrees of input, not to the extent they achieve some objective, substantive notion of distributive justice. The challenge to racial group representation is actually a criticism of a different kind of group representation based on homogeneous geographic constituencies. Race-conscious districting is simply one expression of a larger reality, winner-take-all districting. Both justify wasting votes with often unstated assumptions about the group characteristics of district voters. In other words, the criticism of racial group representation is, at bottom, a criticism of winner-take-all districting in which the district boundaries and the incumbent politicians define the interests of the entire district constituency. I conclude that group representation is as American as winner-take-all districting, that the two are conflated in criticisms of race-conscious districting, and that consideration of alternative means of representing racial groups can shift the debate about political fairness. By directly confronting the problem of wasted voting, we may make the system more legitimate from the perspective of previously disenfranchised groups and more fairly representative of issue-based groups that previously have been aggregated and silenced within the majority. I have proposed a new view of the representational relationship that is more protective of all voters' ability and more conducive to all voters' initiative to choose directly who represents them. By critically examining certain fundamental assumptions about representation, hope to revive our political imagination. Change the way people think, said South African civil rights martyr Stephen Biko, and things will never be the same. Or as Professor Robert Dixon declared almost 25 years ago. And now that the first round of reapportionment has been accomplished, there is need to talk one man one vote a little less and to talk a little more of political equity, and of functional components of effective representation. For mathematically equal vote which is politically worthless because of gerrymandering or winner-take-all districting is as deceiving as emperor's clothes rata. Charles R. Lawrence II. Prologue. T is 1948. I am sitting in a kindergarten classroom at the Dalton School, a fashionable and progressive New York City private school. My parents, both products of a segregated Mississippi school system, have come to New York to attend graduate and professional school. They have enrolled me and my sisters here at Dalton to avoid sending us to the public school in our neighborhood where the vast majority of the students are black and poor. They want us to escape the ravages of segregation, New York style. It is circle time in the 5-year-old group, and the teacher is reading us a book. As she reads, she passes the book around the circle so that each of us can see the illustrations. The book's title is Little Black Sambo. Looking back, I remember only one part of the story, one illustration. Little Black Sambo is running around a stack of pancakes with a tiger chasing him. He is very black and has a minstrel's white mouth. His hair is tied up in many pigtails, each pigtail tied with a different color ribbon. I have seen the picture before the book reaches my place in the circle. I have heard the teacher read the comical text describing Sambo's plight and have heard the laughter of my classmates. There is a knot in the pit of my stomach. I feel panic and shame. I do not have the words to articulate my feelings, words like stereotype and stigma that might help cathartic the shame and place it outside of me where it began. But I am slowly realizing that, as the only black child in the circle, I have some kinship with the tragic and ugly hero of the story, that my classmates are laughing at me as well as at him. I wish I could laugh along with my friends. I wish I could disappear. I am in a vacant lot next to my house with 236 black friends from the neighborhood. We are listening to Amos and Andy on a small radio and laughing uproariously. My father comes out and turns off the radio. He reminds me that he disapproves of this show that pokes fun at Negroes. I feel bad, less from my father's reprimand than from a sense that I have betrayed him and myself, that I have joined my classmates in laughing at us. I am certain that my kindergarten teacher was not intentionally racist in choosing Little Black Sambo. One knew even then, from a child's intuitive sense, that she was a good, well-meaning person. A less benign combination of racial mockery and profit motivated the white men who produced the radio show and played the roles of Amos and Andy. But we who had joined their conspiracy by works our laughter had not intended to demean our race. A dozen years later I am a student at Haverford College. Again, I am a token black presence in a white world. A companion whose face and name I can't remember seeks to compliment me by saying, "I don't think of you as a Negro." I understand his benign intention and accept the compliment. But the knot is in my stomach again. Once again, I have betrayed myself. This happened to me more than a few times. Each time my interlocutor was a good, liberal, white person who intended to express feelings of shared humanity. I did not yet understand the racist implications of the way in which the feelings were conceptualized. I am certain that my white friends did not either. We had not yet grasped the compliment's underlying premise: to be thought of as a Negro is to be thought of as less than human. We were all victims of our culture's racism. We had all grown up on Little Black Sambo and Amos and Andy. Another 10 years pass. I am 33. My daughter, Maya, is 3. I greet a pink-faced, 4-year-old boy on the steps of her nursery school. He proudly presents me with a book he has brought for his teacher to read to the class. "It's my favorite," he says. The book is a new edition of Little Black Sambo. Introduction. His article reconsiders the doctrine of discriminatory purpose that was established by the 1976 decision, Washington v. Davis. 1. This now well-established doctrine requires plaintiffs challenging the constitutionality of a facially neutral law to prove a racially discriminatory purpose on the part of those responsible for the law's enactment or administration. Davis has spawned a considerable body of literature treating its merits and failings. Minorities and civil rights advocates have been virtually unanimous in condemning Davis and its progeny. They have been joined by a significant number of constitutional scholars who have been equally disapproving, if more restrained, in assessing its damage to the cause of equal opportunity. These critics advance two principal arguments. The first is that a motive-centered doctrine of racial discrimination places a very heavy, and often impossible, burden of persuasion on the wrong side of the dispute. Improper motives are easy to hide. And because behavior results from the interaction of a multitude of motives, governmental officials will always be able to argue that racially neutral considerations prompted their actions. Moreover, where several decision-makers are involved, proof of racially discriminatory motivation is even more difficult. The second objection to the Davis doctrine is more fundamental. It argues that the injury of racial inequality exists irrespective of the decision-maker's motives. Does the black child in a segregated school experience less stigma and humiliation because the local school board did not consciously set out to harm her? Are blacks less prisoners of the ghetto because the decision that excludes them from an all-white neighborhood was made with property values and not race in mind? Those who make this second objection reason that the facts of racial inequality are the real problem. They urge that racially disproportionate harm should trigger heightened judicial scrutiny without consideration of motive. EE 237 supporters of the intent requirement are equally adamant in asserting the doctrine's propriety. They echo the four main arguments that the court itself set forth in Davis. 1. A standard that would subject all governmental action with a racially disproportionate impact to strict judicial scrutiny would cost too much. Such a standard, the court argues, would substantially limit legitimate legislative decision-making and would endanger the validity of a whole range of existing tax, welfare, public service, regulatory and licensing statutes. 2. A disproportionate impact standard would make innocent people bear the costs of remedying a harm in which they played no part. 3. An impact test would be inconsistent with equal protection values, because the judicial decision-maker would have to explicitly consider race, and 4. It would be inappropriate for the judiciary to choose to remedy the racially disproportionate impact of otherwise neutral governmental actions at the expense of other legitimate social interests. My own sympathies lie with the critics of the doctrine of discriminatory purpose. The problems posed by a disproportionate impact standard do not seem insurmountable. And none of the current doctrine's proponents explain why it is important to search for bad motives or why such a search is the only alternative to an impact test. But I do not intend to simply add another chapter to the intent/impact debate. Rather, I wish to suggest another way to think about racial discrimination, a way that more accurately describes both its origins and the nature of the injury it inflicts. Much of one's inability to know racial discrimination when one sees it pit results from a failure to recognize that racism is both a crime and a disease. This failure is compounded by a reluctance to admit that the illness of racism infects almost everyone. Acknowledging and understanding the malignancy are prerequisites to the discovery of an appropriate cure. But the diagnosis is difficult, because our own contamination with the very illness for which a cure is sought impairs our comprehension of the disorder. Scholarly and judicial efforts to explain the constitutional significance of disproportionate impact and governmental motive in cases alleging racial discrimination treat these two categories as mutually exclusive. That is, while disproportionate impact may be evidence of racially discriminatory motive, whether impact or motive is the appropriate focus is normally posed in the alternative: should racially disproportionate impact, standing alone, trigger a heightened level of judicial scrutiny? Or, should the judiciary apply a deferential standard to legislative and administrative decisions absent proof that the decision-makers intended a racial consequence? Put another way, the court thinks of facially neutral actions as either intentionally and unconstitutionally or unintentionally and constitutionally discriminatory. I argue that this is a false dichotomy. Traditional notions of intent do not reflect the fact that decisions about racial matters are influenced in large part by factors that can be characterized as neither intentional in the sense that certain outcomes are self-consciously sought nor unintentional in the sense that the outcomes are random, fortuitous, and uninfluenced by the decision-maker's beliefs, desires, and wishes. Americans share a common historical and cultural heritage in which racism has played and still plays a dominant role. Because of this shared experience, we also inevitably share many ideas, attitudes, and beliefs that attach significance to an individual's race and induce negative feelings and opinions about non-whites. To the extent that this cultural belief system has influenced all of us, we are all racists. At the same time, most of us are unaware of our racism. We do not recognize the ways in which our cultural experience has influenced our beliefs about race or the occasions on which those beliefs affect our actions. In other words, A large part of the behavior that produces racial discrimination is influenced by unconscious racial motivation. There are two explanations for the unconscious nature of our racially discriminatory beliefs and ideas. First, Freudian theory states that the human mind defends itself against the discomfort of guilt by denying or refusing to 238. Recognize those ideas, wishes, and beliefs that conflict with what the individual has learned is good or right. While our historical experience has made racism an integral part of our culture, our society has more recently embraced an ideal that rejects racism as immoral. When an individual experiences conflict between racist ideas and the societal ethic that condemns those ideas, the mind excludes his racism from consciousness. Second, the theory of cognitive psychology states that the culture, including, for example, the media and an individual's parents, peers, and authority figures, transmit certain beliefs and preferences. Because these beliefs are so much a part of the culture, they are not experienced as explicit lessons. Instead, they seem part of the individual's rational ordering of her perceptions of the world. The individual is unaware, for example, that the ubiquitous presence of a cultural stereotype has influenced her perception that blacks are lazy or unintelligent. Because racism is so deeply ingrained in our culture, it is likely to be transmitted by tacit understandings. Even if a child is not told that blacks are inferior, he learns that lesson by observing the behavior of others. These tacit understandings, because they have never been articulated, are less likely to be experienced at a conscious level. In short, requiring proof of conscious or intentional motivation as a prerequisite to constitutional recognition that a decision is race-dependent ignores much of what we understand about how the human mind works. It also disregards both the irrationality of racism and the profound effect that the history of American race relations has had on the individual and collective unconscious. It may often be appropriate for the legal system to disregard the influence of the unconscious on individual or collective behavior. But where the goal is the eradication of invidious racial discrimination, the law must recognize racism's primary source. The Equal Protection Clause requires the elimination of governmental decisions that take race into account without good and important reasons. Therefore, equal protection doctrine must find a way to come to grips with unconscious racism. In pursuit of that goal, this article proposes a few tests to trigger judicial recognition of race-based behavior. It posits a connection between unconscious racism and the existence of cultural symbols that have racial meaning. It suggests that the cultural meaning of an allegedly racially discriminatory act is the best available analog for, and evidence of, a collective unconscious that we cannot observe directly. This test would thus evaluate governmental conduct to determine whether it conveys a symbolic message to which the culture attaches racial significance. A finding that the culture thinks of an allegedly discriminatory governmental action in racial terms would also constitute a finding regarding the beliefs and motivations of the governmental actors. The actors are themselves part of the culture and presumably could not have acted without being influenced by racial considerations, even if they are unaware of their racist beliefs. Therefore, the court would apply strict scrutiny. This proposal is relatively modest. It does not abandon the judicial search for unconstitutional motives, nor does it argue that all governmental action with discriminatory impact should be strictly scrutinized. Instead, it urges a more complete understanding of the nature of human motivation. While it is grounded in the court's present focus on individual responsibility, it seeks to understand individual responsibility in light of modern insights into human personality and collective behavior. In addition, this proposal responds directly to the concern that abandoning the Washington v. Davis doctrine will invalidate a broad range of legitimate, race-neutral governmental actions. By identifying those cases where race unconsciously influences governmental action, this new test leaves untouched non-race-dependent decisions that disproportionately burden blacks only because they are overrepresented the decision's targets or the decision targets or beneficiaries. This effort to inform the discriminatory intent requirement with the learning of 20th-century psychology is important for at least 239 3 reasons. First, the present doctrine, by requiring proof that the defendant was aware of his animus against blacks, severely limits the number of individual cases in which the courts will acknowledge and remedy racial discrimination. Second, the existing intent requirements assignment of individualized fault or responsibility for the existence of racial discrimination distorts our perceptions about the causes of discrimination and leads us to think about racism in a way that advances the disease rather than combating it. By insisting that a blameworthy perpetrator be found before the existence of racial discrimination can be acknowledged, the court creates an imaginary world where discrimination does not exist unless it was consciously intended. And by acting as if this imaginary world was real and insisting that we participate in this fantasy, the court, and the law it promulgates subtly shape our perceptions of society. The decision to deny relief no longer finds its basis only in raw political power or economic self-interest, it is now justifiable on moral grounds. If there is no discrimination, there is no need for a remedy. If blacks are being treated fairly yet remain at the bottom of the socio-economic ladder, only their own inferiority can explain their subordinate position. Finally, the intent doctrines focus on the narrowest and most unrealistic understanding of individual fault has also engendered much of the resistance to and resentment of affirmative action programs and other race-conscious remedies for past and continuing discrimination. If there can be no discrimination without an identifiable criminal, then innocent individuals will resent the burden of remedying an injury for which the law says they are not responsible. Understanding the cultural source of our racism obviates the need for fault, as traditionally conceived, without denying our collective responsibility for racism's eradication. We cannot be individually blamed for unconsciously harboring attitudes that are inescapable in a culture permeated with racism. And without the necessity for blame, our resistance to accepting the need and responsibility for remedy will be less ended. Understanding unconscious motivation will also help us comprehend and combat the hegemony of the ideology of equal opportunity. A considerable body of scholarship from the academic left has analyzed the law as a hegemonic tool of domination. According to one theory, domination occurs when the ruling class gains the consent of the dominated classes through a system of ideas that reinforces the morality or inevitability of the existing order. This interest theory sees ideology as a consciously wielded weapon, an intellectual tool that a group uses to enhance its political power by institutionalizing a particular view of reality. Another view of ideology draws upon the theories of unconscious motivation discussed in this article. Under this view, ideology is a defense mechanism against the anxiety felt by those who hold power through means and with motives that they cannot comfortably acknowledge. This strain theory explains ideology as a response to the strains that an individual's or a group's social role or position creates. Ideology provides a symbolic outlet for emotional disturbances generated by social disequilibrium. It enables privileged individuals to continue practices they would otherwise condemn and in which their own complicity would be painful to admit. This understanding of ideology provides valuable insight into the seductive powers of the ideology of equal opportunity as well as into our resistance to abandoning one of its most critical conceptual images, the intent requirement. It reconciles the observation that anti-discrimination law has consistently operated not so much in the interests of blacks as in that of white elites with the seemingly conflicting experience that white men in positions of power have often acted and theorized with benign motives. Strain theory recognizes that no ideology of equal opportunity contrived through conscious manipulation can delude its purveyors as powerfully as one that arises by the process of self-mystification. The purveyors of this ideology, unlike charlatans, are themselves deluded. 240. We have found that as we have been obliged to assume that very powerful mental processes or ideas exist which can produce all the effects in mental life that ordinary ideas do, including effects that can in their turn become conscious as ideas, though they themselves do not become conscious. Whatever our preferred theoretical analysis, there is considerable common sense evidence from our everyday experience to confirm that we all harbor prejudiced attitudes that are kept from our consciousness. When, for example, a well-known sports broadcaster is carried away by the excitement of a brilliant play by an African-American professional football player and refers to the player as a little monkey during a nationally televised broadcast, we have witnessed the prototypical parapraxis, or unintentional slip of the tongue. This sportscaster views himself as progressive on issues of race. Many of his most important professional associates are black, and he would no doubt profess that more than a few are close friends. After the incident, he initially claimed no memory of it and then, when confronted with videotaped evidence, apologized and said that no racial slur was intended registered. There is no reason to doubt the sincerity of his assertion. Why would he intentionally risk antagonizing his audience and damaging his reputation and career? But his inadvertent slip of the tongue was not random. It is evidence of the continuing presence of a derogatory racial stereotype that he has repressed from consciousness and that has momentarily slipped past his ego's censors. Likewise, when Nancy Reagan appeared before a public gathering of then-presidential candidate Ronald Reagan's political supporters and said that she wished he could be there to see all these beautiful white people, one can hardly imagine that it was her self-conscious intent to proclaim publicly her preference for the company of Caucasians. Incidents of this kind are not uncommon, even if only the miscues of the powerful and famous are likely to come to the attention of the press. But because the unconscious also influences selective perceptions, whites are unlikely to hear many of the inadvertent racial slights that are made daily in their presence. Another manifestation of unconscious racism is akin to the slip of the tongue. One might call it a slip of the mind. While one says what one intends, one fails to grasp the racist implications of one's benignly motivated words or behavior. For example, in the late 1950s and early 1960s, when integration and assimilation were unquestioned ideals among those who consciously rejected the ideology of racism, white liberals often expressed their acceptance of and friendship with blacks by telling them that they did not think of them as Negroes. Their conscious intent was complimentary. The speaker was saying, "I think of you as normal human beings, just like me." But he was not conscious of the underlying implication of his words. What did this mean about most Negroes? Were they not normal human beings? If the white liberal were asked if this was his inference, he would doubtless have protested that his words were being misconstrued and that he only intended to state that he did not think of anyone in racial terms. But to say that one does not think of a Negro as a Negro is to say that one thinks of him as something else. The statement is made in the context of the real world, and implicit in it is a comparison to some norm. In this case the norm is whiteness. The white liberal's unconscious thought, his slip of the mind, is, think of you as different from other Negroes, as more like white people. One indication of the non-neutrality of the statement, "I don't think of you as a Negro," when spoken as a compliment by a white is the incongruity of the response, "I don't think of you as white." This could also be a complimentary remark coming from a black, conveying the fact that she does not think of her friend in the usual negative terms she associates with whiteness. But this statement does not make sense coming from an individual who would accept as complimentary a statement characterizing her as unlike other Negroes. If anything, the response only makes sense as a light-hearted but cautionary retort. It conveys the following message: I understand that your conscious intent was benign. But let me tell you something, friend. I think being black is just fine. If anything, our friendship is possible because you are unlike most white folks. Of course, the statements of both these interlocutors are ethnocentric. But it is the white who has made the slip of the mind. He was unmindful of the ethnocentric premise upon which his compliment was based. He would find it painful to know that it is a premise in which he believes. His black friend's ethnocentrism is self-conscious and self-affirming. She is well aware of the impact of her reply. It is a defensive parry against the dominant society's racism. A crucial factor in the process that produces unconscious racism is the tacitly transmitted cultural stereotype. If an individual has never known a black doctor or lawyer or is exposed to blacks only through a mass media where they are portrayed in the stereotyped roles of comedian, criminal, musician, or athlete, he is likely to deduce that blacks as a group are naturally inclined towards certain behavior and unfit for certain roles. But the lesson is not explicit, it is learned, internalized, and used without an awareness of its source. Thus, an individual may select a white job applicant over an equally qualified black and honestly believe that this decision was based on observed intangibles unrelated to race. The employer perceives the white candidate as more articulate, more collegial, more thoughtful, or more charismatic. He is unaware of the learned stereotype that influenced his decision. Moreover, he has probably also learned an explicit lesson of which he is very much aware: good, law-abiding people do not judge others on the basis of race. Even the most thorough investigation of conscious motive will not uncover the race-based stereotype that has influenced his decision. This same process operates in the case of more far-reaching policy decisions that come to judicial attention because of their discriminatory impact. For example, when an employer or academic administrator discovers that a written examination rejects blacks at a disproportionate rate, she can draw several possible conclusions: that blacks are less qualified than others, that the test is an inaccurate measure of ability, or that the testers have chosen the wrong skills or attributes to measure. When decision-makers reach the first conclusion, a predisposition to select those data that conform with a racial stereotype may well have influenced them. Because this stereotype has been tacitly transmitted and unconsciously learned, they will be unaware of its influence on their decision. If the purpose of the law's search for racial animus or discriminatory intent is to identify a morally culpable perpetrator, the existing intent requirement fails to achieve that purpose. There will be no evidence of self-conscious racism where the actors have internalized the relatively new American cultural morality which holds racism wrong, or have learned racist attitudes and beliefs through tacit rather than explicit lessons. The actor himself will be unaware that his actions, or the racially neutral feelings and ideas that accompany them, have racist origins. Of course, one can argue that the law should govern only consciously motivated actions, that societal sanctions can do no more than attempt to require that the individual's ego act as society's agent in censoring out those unconscious drives that society has defined as immoral. Under this view, the law can sanction a defective ego that has not fully internalized current societal morality and has, therefore, allowed illegal racist wishes to reach consciousness and fruition in an illegal act. But the law should not hold an individual responsible for wishes that never reach consciousness, even if they also come to fruition in discriminatory acts. The problem is that this argument does not tell us why the law should hold the individual responsible for racial injury that results from one form of ego disguise but not the other. Believe the law should be equally concerned when the mind censor successfully disguises a socially repugnant wish like racism if that motive produces behavior that has a discriminatory result as injurious as if it flowed from a consciously held motive. To A Tale of Two Theories. His second likely challenge to my proposal acknowledges the existence of unconscious racism but questions whether it is important or even useful to take it into account in interpreting and applying the Equal Protection Clause. This question can best be answered by posing a more general question: what is the wrong that the Equal Protection Clause seeks to address? More specifically, what wrong do we seek to address in applying heightened scrutiny to racial classifications? If we can determine the nature of this wrong, we can determine whether identifying the existence of unconscious racial motivation is important to its prevention or remediation. Two theories have attempted to specify the central function of suspect classification doctrine. The first, the process defect theory, sees the judicial intervention occasioned by strict scrutiny of suspect classifications as an appropriate response to distortions in the democratic process. The second theory cites racial stigma as the primary target of suspect classification doctrine. By examining whether and why the determination of self-conscious motive is important to each of these theories, we will be able to determine whether recognizing the presence of unconscious motive furthers the central rationale of each theory. A. The process defect theory. The chief proponent of the process defect theory has been John Ely. He identifies the systematic exclusion of a group from the normal workings of the political process as the harm that heightened judicial scrutiny for suspect classification seeks to prevent or remedy. The theory begins with Justice Stone's Caroline Products footnote 4. which states that discrete and insular minorities deserve special constitutional protection. Ely notes that if minority referred solely to the fact that the group in question was on the losing side of a particular political battle, or if discrete and insular referred only to its position on the wrong side of the statutory line and its inability to gather enough allies to defeat legislation, then Stone's category would be indeterminate. Justice Stone's reference, argues Ely, was rather to the sort of pluralist wheeling and dealing by which minorities in our society typically interact to protect their interests. It denotes those minorities for which mutual defense pacts will prove recurrently unavailing. The general idea of this theory is clear enough: courts should protect those who cannot protect themselves politically. What Ely has added to Justice Stone's hypothesis is an explanation for why the court should interfere with a political majority's normally legitimate choices in some instances and not in others. It invokes special scrutiny when the minority in question is one that keeps finding itself on the wrong end of legislative classifications because of the distorting effect of prejudice on the judgment of political decision-makers. Ely notes that prejudice distorts the political process in two ways. First, it bars groups that are the objects of widespread vilification from the pluralists' bazaar that Madison believed would allow groups with overlapping interests to create majorities on given issues. The adverse reaction to the vilified minority prevents groups from recognizing and acting upon common interests that would otherwise lead them to form coalitions with the minority on certain issues. Second, prejudice causes the governmental decision-makers to misapprehend the costs and benefits of their actions, because they seize upon positive myths about the group to which they belong and negative myths about those groups to which they do not. The first defect keeps the political process from giving certain minorities in our nation of minorities a chance to protect themselves within that process. The second defect prevents those who have gained control of the process from rationally and accurately assessing the most efficacious means of achieving even constitutionally legitimate goals. Motive and intent are at the center of Ely's theory. The function of suspect classification doctrine is to expose unconstitutional motives that may have distorted the process. A statute that classifies by race is strictly scrutinized, B 243. Cause the requirement of close fit between ends sought and means used will reveal those instances where the actual motive of the legislature was to disadvantage a group simply because of its race. Under present doctrine, the courts look for Ely's process defect only when the racial classification appears on the face of the statute or when self-conscious racial intent has been proved under the Davis test. But the same process distortions will occur even when the racial prejudice is less apparent. Other groups in the body politic may avoid coalition with blacks without a conscious awareness of their aversion to blacks or of their association of certain characteristics with blacks. They may take stands on issues without realizing that their reasons are, in part, racially oriented. Likewise, the governmental decision-maker may be unaware that she has devalued the cost of a chosen path, because a group with which she does not identify will bear that cost. Indeed, because of her lack of empathy with the group, she may have never even thought of the cost at all. Process distortion exists where the unconstitutional motive of racial prejudice has influenced the decision. It matters not that the decision-maker's motive may lie outside her awareness. For example, in Village of Arlington Heights v. Metropolitan Housing Development Corp., degree a predominantly white, upper-middle-class Chicago suburb prevented the construction of a proposed housing development for low and moderate-income families by refusing to rezone the projected site to allow multifamily units. The Supreme Court agreed that the decision not to rezone had racially discriminatory effects, but it rejected the black plaintiffs' equal protection claim on the ground that they had simply failed to carry their burden of proving that discriminatory purpose was a motivating factor in the village's decision. The court focused on the lack of any evidence of conscious intent to discriminate on the part of either the city council in enacting the zoning ordinance that restricted use to single-family homes or the planning commission in administering the ordinance. We can envision several possible scenarios that demonstrate the possible process-distorting effects of unconscious racism on a governmental decision like that in Arlington Heights. 1. The city council refused to rezone for the sole purpose of stigmatizing and denying housing to blacks. This case resembles Plessy v. Ferguson. and Gamillion v. Lightfoot, copyright in which the only motives were unconstitutional, and the ordinances were, therefore, per se unconstitutional. 2. The city claims a legitimate economic or environmental purpose, but evidence shows that it sought to exclude blacks in order to achieve that purpose. This case is the same as a classification by race on the face of a statute for which a legitimate goal is claimed. It is the case Ely describes where blacks are consciously excluded from the political process and devalued in the assessment of costs and benefits. When this self-conscious motive can be proved, the resulting classification is subject to strict scrutiny under existing doctrine. 3. The purpose of the ordinance was economic, i.e., to keep property values up by keeping poor people out, but the decision-makers associated poverty with blacks and would have weighed the costs and benefits differently if the poor people they envisioned excluding were elderly white people on Social Security. This selective sympathy or indifference could have occurred at a conscious or unconscious level. It is more than likely that the decision-makers knew that the poor people they were excluding were black, but they would not be likely to have known that they undervalued the cost to poor people because they thought of them as black rather than white. 4. A constituency within Arlington Heights, for example, elderly whites did not actively campaign for the rezoning because of aversion to blacks who might have benefited from it. This occurred despite the fact that this constituency's interest in low-income housing would otherwise have outweighed its interest in property values. This inability or unwillingness to apprehend and act upon an overlapping interest is precisely the kind of process distortion through group vilification that Ely describes. It is as likely as not that these elderly voters are largely unaware of the vilification and resulting aversion that preempted their potential coalition with blacks. 5. No one in Arlington Heights thought about blacks one way or the other. It was a fight between environmentalists and developers, but an inadvertent devaluing of black interests caused inattention to the costs blacks would have to bear. If one asked the decision-makers how they had valued the cost to blacks of the exclusionary zoning, they might have responded, "I never thought of that." This is an example of selective indifference or misapprehension of costs that occurs entirely outside of consciousness. The process defect theory sees suspect classification doctrine as a roundabout way of uncovering unconstitutional motive by suspecting those classifications that disadvantage groups we know to be the object of widespread vilification. But by only suspecting laws that classify by race on their face or are the result of overtly self-conscious racial motivation, the theory stops an important step short of locating and eliminating the defect it has identified. Where a society has recently adopted a moral ethic that repudiates racial disadvantaging for its own sake, governmental decision-makers are as likely to repress their racial motives as they are to lie to courts or to attempt after-the-fact rationalizations of classifications that are not racial on their face but that do have disproportionate racial impact. Unconscious aversion to a group that has historically been vilified distorts the political process no less than a conscious decision to place race hatred before politically legitimate goals. Moreover, unconscious prejudice presents an additional problem in that it is not subject to self-correction within the political process. When racism operates at a conscious level, opposing forces can attempt to prevail upon the rationality and moral sensibility of racism's proponents. The self-professed racist may even find religion on the road to Damascus and correct his own ways. But when the discriminator is not aware of his prejudice and is convinced that he already walks in the path of righteousness, neither reason nor moral persuasion is likely to succeed. The process defect is all the more intractable, and judicial scrutiny becomes imperative. B. The stigma theory. A second theory posits elimination of racially stigmatizing actions as the central concern of the Equal Protection Clause. Registered under this theory, racial classifications should be strictly scrutinized when they operate to shame and degrade a class of persons by labeling it as inferior. Stigmatization is the process by which the dominant group in society differentiates itself from others by setting them apart, treating them as less than fully human, denying them acceptance by the organized community, and excluding them from participating in that community as equals. If the Equal Protection Clause guarantees the right to be treated as an equal, the constitutional claim in question can be reduced to a claim to be free from stigma. This theory acknowledges a historical experience in which the dominant group has systematically used stigmatizing labels against blacks and other non-whites and has developed a social system of laws, practices, and cultural mores that looks down upon these groups, treating them as different from, and inferior to, the norm. The prevention of stigma was at the core of the Supreme Court's unanimous declaration in Brown v. Board of Education * registered that segregated public schools are inherently unequal. In observing that the segregation of black pupils generates a feeling of inferiority as to their status in the community, * Chief Justice Warren recognized what a majority of the court had ignored almost 60 years earlier in Plessy v. Ferguson *. The social meaning of racial segregation in the United States is the designation of a superior and an inferior caste, and segregation proceeds on the ground that colored citizens are inferior and degraded. * Stigmatizing actions harm the individual in two ways: they inflict psychological injury by assaulting a person's self-respect and human dignity, and they brand the individual with a sign that signals her inferior status to others. 245. And designates her as an outcast. The stigma theory recognizes the importance of both self-esteem and the respect of others for participating in society's benefits and responsibilities. Proponents of this theory have also observed that racial stigma is self-perpetuating. Labeling blacks as inferior denies them access to societal opportunities. As a result, inadequate educational preparation, poverty of experience, and insufficient basic necessities limit their ability to contribute to society, and the prophecy of their inferiority is fulfilled. Furthermore, separate incidents of racial stigmatization do not inflict isolated injuries but are part of a mutually reinforcing and pervasive pattern of stigmatizing actions that cumulate to compose an injurious whole that is greater than the sum of its parts. The injury of stigmatization consists of forcing the injured individual to wear a badge or symbol that degrades him in the eyes of society. But in most cases the symbol is not inherently pejorative. Rather, the message obtains its shameful meaning from the historical and cultural context in which it is used and, ultimately, from the way it is interpreted by those who witness it. Thus the woman who is asked to use a separate public bathroom from her husband is unlikely to be stigmatized by that action. Our society does not ordinarily interpret sex-segregated toilet facilities as designating the inferiority of women. By contrast, the black who is asked to use a different public bathroom from that of a white companion of the same gender is stigmatized. As Richard Wasserstrom has noted, racially segregated bathrooms were an important part of the system of segregation. That system's ideology held not only that blacks were less than fully human but also that they were dirty and impure. Racially segregated bathrooms ensured that blacks would not contaminate the facilities used by whites. If stigmatizing actions injure by virtue of the meaning society gives them, then it should be apparent that the evil intent of their authors, while perhaps sufficient, is not necessary to the infliction of the injury. For example, a well-meaning if misguided white employer, having observed that her black employees usually sat together at lunch, might build a separate dining room for them with the intent of making them more comfortable. This action would stigmatize her black employees despite her best intentions. Similarly, when the city of Jackson, Mississippi, closed its public pools after a federal court ordered it to integrate them, the action stigmatized blacks regardless of whether the government's purpose was racial or economic. Given that stigma occurs whether there is racial animus or not, the answer to our initial question, is knowledge about the intent of the governmental actor significant to the achievement of the Equal Protection Clause's purpose, would seem an obvious no, but many of the stigma theory's advocates find themselves in a quandary when faced with the question of how the court should approach laws that are not apparently race-dependent but that result in disparate and stigmatizing effects. Kenneth Karst, for example, notes the Supreme Court's recent inhospitality to constitutional claims of disproportionate effect, registered, and argues that surely it is still a responsible form of advocacy to argue that some racially disproportionate effects of governmental action ought to be subjected to judicial scrutiny at a level higher than minimum rationality. He does not, however, elaborate on how the court should determine which cases to include among that sum. Moreover, The origin of his reluctance to advocate increased scrutiny of all racially discriminatory impact lies in the disproportionate presence of blacks among the poor. He argues that, because the persistence of a racially identifiable economic underclass is probably beyond the capacity of courts to remedy, it is unrealistic to expect the Supreme Court to endorse this increased use of strict scrutiny in the near future. Similarly, Paul Brest, having persuasively argued the need to eliminate racially disproportionate impact that stigmatizes, cautions that the impact doctrine cannot reasonably be applied across the board and urges that the doctrine be used selectively. He warns that remedies for disproportionate impact may impose heavy costs on institutions and individuals, and cannot be tailored narrowly to compensate all those and only those whose present situation. 246. Is the result of past discrimination. Brest's reference to the overbreadth of remedies for disproportionate impact adds to the general concern about unduly limiting legislative discretion and the particular concern about the legitimacy of courts imposing costs on blameless individuals and conferring benefits on those who have not been directly harmed. The consideration of unconscious intent responds to both of these concerns. Identifying stigmatizing actions that were affected by the actor's unconscious racial attitudes achieves two benefits. First, it significantly decreases the absolute number of impact cases subject to heightened scrutiny without eviscerating the substantive content of the Equal Protection Clause. The bridge toll, the sales tax, and the filing fee can no longer be numbered among the parade of horribles that Justice White suggested in Davis. At the same time, cases where racially discriminatory impact results directly from past intentional discrimination or from current but unprovable racial animus will be well within judicial reach. A law does not stigmatize blacks simply because exclusion itself is stigmatizing, and, in this instance, they are disproportionately represented among the excluded group. Instead, the stigma stems at least in part from society's predisposition to exclude blacks. The fact that unconscious racial attitudes affected a governmental action is evidence that the racially stigmatizing symbolism pre-existed the present impact. Second, consideration of unconscious motivation provides a neutral principle for judicial intervention, i.e., the identification of a process defect. This counters the argument made against the impact test that the judiciary has no principled basis for imposing a priority for the removal of racial stigma over other social goods to which the political branch might choose to give preeminence. In short, stigma often occurs regardless of the intent of those who have engaged in the stigmatizing action. Thus, it is arguable that under the stigma theory neither conscious nor unconscious intent should be considered, and heightened judicial scrutiny should apply in all cases when governmental action produces a stigmatizing effect. Nonetheless, recognizing unconscious racism provides a mechanism for effectively responding to continuing race-based inequalities while minimizing the costs of judicial overreaching. While the cultural meaning test identifies the same elements of the injury of racial discrimination as does the stigma theory, it differs from that theory in two regards. First, it identifies the injury at a different point in the constitutional analysis. The stigma theory explains why recognized racial classifications, i.e., laws whose racial classification is apparent on their face or laws whose racial motive has been proved, should be subject to heightened judicial scrutiny. In nothing that the harm of stigma occurs irrespective of the presence of conscious motive, the cultural meaning test refocuses the stigma theory's inquiry to a different point in time. The presence of racial stigma is viewed as evidence of the existence of a racial classification, not simply as a justification for the heightened scrutiny of such classifications. Second, the cultural meaning test adds content to the stigma theory's analysis. It locates the origin of racial stigma in the accumulation of the individual unconscious and finds the origin of unconscious racism in the presence of widely shared, tacitly transmitted cultural values. The recognition of these mutually reciprocal origins joins the theoretical description of human action as arising out of autonomous individual choice with the view that such action is socially determined. The cultural meaning theory thus describes a dialectic rather than a dichotomy. It demonstrates that ultimately the proponents of the process defect theory and the stigma theory have identified different manifestations of the same cultural phenomenon. 3. Reading the min symbols. How do we identify unconscious racism? In specific cases. A. The cultural meaning test. This article's discussion of the stigma theory has anticipated the third likely challenge to my thesis that equal protection doctrine must address the unconscious racism that underlies much of the racially disproportionate impact of governmental policy. This challenge questions how a court would identify those cases where unconscious racism operated in order to determine whether to subject an allegedly discriminatory act to strict scrutiny. I propose a test that would look to the cultural meaning of an allegedly racially discriminatory act as the best available analog for an evidence of the collective unconscious that we cannot observe directly. This test would evaluate governmental conduct to see if it conveys a symbolic message to which the culture attaches racial significance. The court would analyze governmental behavior much like a cultural anthropologist might, by considering evidence regarding the historical and social context in which the decision was made and effectuated. If the court determined by a preponderance of the evidence that a significant portion of the population thinks of the governmental action in racial terms, then it would presume that socially shared, unconscious racial attitudes made evident by the action's meaning had influenced the decision-makers. As a result, it would apply heightened scrutiny. The unconscious racial attitudes of individuals manifest themselves in the cultural meaning that society gives their actions in the following way: in a society that no longer condones overt racist attitudes and behavior, many of these attitudes will be repressed and prevented from reaching awareness in an undisguised form. But as psychologists have found, repressed wishes, fears, anger, and aggression continue to seek expression, most often by attaching themselves to certain symbols in the external world. Repressed feelings and attitudes that are commonly experienced are likely to find common symbols particularly fruitful or productive as a vehicle for their expression. Thus, certain actions, words, or signs may take on meaning within a particular culture as a result of the collective use of those actions, words, or signs to represent or express shared but repressed attitudes. The process is cyclical. The expression of shared attitudes through certain symbols gives those symbols cultural meaning, and once a symbol becomes an enduring part of the culture, it in turn becomes the most natural vehicle for the expression of those attitudes and feelings that caused it to become an identifiable part of the culture. Cognitive theory provides an alternative explanation of why the racial meaning the culture gives an action will be evidence of the actor's unconscious racial motivation. According to cognitive theory, those meanings or values that are most deeply ingrained in the culture are commonly acquired early in life through tacit lessons. They are, therefore, less recognizable and less available to the individual's consciousness than other forms of knowledge. Looked at another way, if the action has cultural meaning, this meaning must have been transmitted to an individual who is a member of that culture. If he professes to be unaware of the cultural meaning or attitude, it will almost surely be operating at an unconscious level. Thus, an action such as the construction of a wall between white and black communities in Memphis *degree would have a cultural meaning growing out of a long history of whites' need to separate themselves from blacks as a symbol of their superiority. Individual members of the city council might well have been unaware that their continuing need to maintain their superiority over blacks, or their failure to empathize with how construction of the wall would make blacks feel, influenced their decision. But if one were to ask even the most self-deluded among them what the residents of Memphis would take the existence of the wall to mean, the obvious answer would be difficult to avoid. If one told the story leading to the wall's construction while omitting one vital fact, the race of those whose vehicular traffic the barrier excluded, and then asked Memphis citizens to describe the residents of the community claiming injury, few, if any, would not guess that they were black. The current racial meanings of governmental actions are strong evidence that the process defects of group vilification and misapprehension of costs and benefits have occurred whether or not the decision-makers were conscious that. 248. Race played a part in their decision-making. Moreover, actions that have racial meaning within the culture are also those actions that carry a stigma for which we should have special concern. This is not the stigma that occurs only because of a coincidental congruence between race and poverty. The association of a symbol with race is a residuum of overtly racist practices in the past. The wall conjures up racial inferiority, not the inferiority of the poor or the undesirability of vehicular traffic. And stigma that has racial meaning burdens all blacks and adds to the pervasive, cumulative, and mutually reinforcing system of racial discrimination. B. Some easy cases. Applying the cultural meaning test to a series of cases is the best way to examine its operative effect. These first cases are easy in that there will be little disagreement about whether the governmental action in question has racial meaning in our culture. They are cases like the segregated beach, which clearly has racial meaning, and the increased bridge toll, which clearly does not. These cases are instructive for two reasons. The lack of ambiguity in the meaning that will attach to the governmental action allows us to see more clearly the relationship between cultural meaning and unconscious intent. Furthermore, these cases demonstrate the usefulness of a test that distinguishes governmental actions that have racial meaning in addition to racially disparate impact from those that have only racially disparate impact. I. Brown v. Board of Education registered *. Charles Black first discussed the social meaning of segregation in his brilliantly simple and succinct defense of Brown, The Lawfulness of the Segregation Decisions. Degree. He begins with history, and notes that segregation was the direct descendant of slavery and the Black Codes and an integral part of the movement to maintain white supremacy. *. Segregation was not a case of mutual separation but a system that one group imposed on another. Black points to its contextual association with other indisputably and grossly discriminatory practices, such as exclusion from the vote, and to the manner in which segregation as a pattern of law often combined with extra-legal patterns of discrimination *+ plus that separate but equal facilities were almost never really equal is evidence not just of the material inequality they imposed but also of the meaning of segregation to the people who imposed it. He cites the facts that it was actionable defamation in the South to call a white man a Negro and that a small proportion of Negro blood put one in the inferior race for segregation's purposes as further evidence of segregation's meaning. Professor Black closes his catalogue of particulars with the observation that the points he has made are matters of common knowledge, matters not so much for judicial notice as for the background knowledge of educated men who live in the world. *. Degree. Given this common knowledge, it is difficult, if not impossible, to envision how a governmental decision-maker might issue an order to segregate without intending, consciously or unconsciously, to injure blacks. Could the defendants in Brown have escaped this meaning? Could anyone who grew up in the system Charles Black describes have made a decision to put black and white children in separate schools without that decision being influenced by race? The common knowledge, or clear meaning, Black describes is evidence of shared cultural attitudes that have expressed themselves in cultural symbols. The actions involved could have nothing other than a racial meaning within our society. But for purposes of our present analysis, the most important thing to recognize is that an action's meaning derives from a long-term and pervasive association of certain feelings or thoughts with that action. Feelings and thoughts that have become sufficiently widespread and internalized to express themselves in a system of social symbols or meanings do not disappear with the enactment of civil rights legislation. The feelings may be repressed from consciousness, but so long as the symbols they have created retain their meaning, the feelings continue to exist and to shape behavior. Two non-racial actions at the opposite end of the spectrum is a hypothetical increase in the municipal railway fare in a racially and economically diverse municipality. It may be more burdensome on the relatively poor person who must use that transportation than on the relatively rich individual. It may also be true that non-whites are disproportionately represented among the poor and that, therefore, the increase has a racially disparate impact *, but there is no history of using bus or train fares as a way to designate non-whites as inferior, and, most importantly, we do not think of fare increases in racial terms. The same would be true of an increase in the sales tax, the fee for obtaining a driver's license, or the cost of a building permit. These are all cases where the impact on blacks in a particular instance may be greater than it is on whites. They are also cases where some stigma may attach to those who are excluded by the governmental action. but we are likely to think of the in-group and out-group in economic rather than racial terms. These actions do not contribute directly to the system of beliefs that labels blacks as inferior. Where the culture as a whole does not think of an action in racial terms, it is also unlikely that unconscious attitudes about race influence the governmental decision-maker. The easy cases at this end of the spectrum are precisely the kind of cases to which Justice White alluded in Davis when he warned that a discriminatory impact standard might invalidate a whole range of tax, welfare, public service, regulatory, and licensing statutes that may be more burdensome to the poor and to the average black than to the more affluent white. The cultural meaning test, by distinguishing racially stigmatizing statutes from those that only stigmatize indirectly through their economic impact, would go a long way toward obviating Justice White's concern. See some harder cases. Where there is less agreement about the social meaning of allegedly discriminatory governmental action, the application of the cultural meaning test will, of course, be more difficult. But the process of applying the test and its underlying rationale will be the same. By looking at how the test might be applied to several more difficult cases, this section explores in greater detail how a court might gather and interpret evidence of cultural meaning. In Arlington Heights, a nonprofit development corporation obtained a purchase option on 15 acres of land on which it planned to develop a federally subsidized, racially integrated, low and moderate income townhouse project. The proposed site of the project was in the village of Arlington Heights, a Chicago suburb of over 64,000 residents of whom, as of 1970, 27 were black. Because the site was zoned for single-family dwellings, the development corporation petitioned the village to rezone the property for multiple family use. When the village board of trustees, following the recommendation of the Planning Commission, denied the rezoning request, the developer and 3 blacks who were prospective tenants of the proposed project filed suit in federal district court. Several kinds of evidence would be available to demonstrate that denying the zoning variance in these circumstances has a cultural meaning that demeans blacks. Initially, plaintiffs could present evidence of the historical and contemporaneous meaning of residential segregation in the culture as a whole. This would include the history of statutorily mandated housing segregation as well as the use of restrictive covenants among private parties that aim to prevent blacks from purchasing property in white neighborhoods. Studies of racially segregated housing patterns throughout the United States and in the area surrounding Arlington Heights as well as data and attitudinal surveys on residential segregation and white flight would also be relevant. Such studies have indicated that collective and individual tolerances for black neighbors vary from community to community. While they ascribe the intolerance to different causes, they agree substantially on the prominence of race in the minds of both those who flee and those who stay. They also note whites' continuing aversion to housing integration. The body of evidence that documents our culture's frequent attachment of racial meaning to the very existence of segregated housing is extensive and should be more than sufficient to establish the cultural meaning of the Arlington Heights city officials' action. We have rarely come to live in racially segregated enclaves as the result of happenstance or out of mutual choice. We live in segregated neighborhoods because whites have believed that living with or close to blacks lowers their own status. Where one lives is an important index of one's status in our culture, and to live in proximity to those who are looked down upon is to be looked down upon oneself. This evidence of what racially segregated housing patterns mean in our culture would not be the only evidence available to the court. There is also direct evidence of the meaning Arlington Heights residents attached to the city's decision denying the zoning variance. The Planning Commission considered the proposal at a series of 3 public meetings which drew large crowds. Many of those in attendance were quite vocal and demonstrative in their opposition to the project, although some spoke in support of rezoning. But both opponents and supporters referred to the social issue, the desirability or undesirability of introducing low and moderate income housing that would probably be racially integrated into this area of Arlington Heights. The Supreme Court in Arlington Heights noted this evidence and observed that some opponents of the housing project might have been motivated by opposition to minority groups. 40, but the court went on to affirm the trial court's holding that the evidence did not warrant the conclusion that this racial opposition motivated the defendants. *1 If, however, this same evidence is considered for the purpose of determining the cultural meaning of the city's action, it is far more probative. Even the court's terse description of the public meetings makes clear that race was prominent in the minds of both opponents and proponents of the project. The trial court, in its search for discriminatory purpose, found that the obvious prominence of the race issue did not warrant a finding of racial motivation. But, if the court's inquiry had focused on the meaning this community attached to the decision to exclude the project, this evidence of heated debate on the question of race would necessarily carry a great deal more weight. A final source of evidence regarding the racial meaning of the city's action is the unreasonableness of the non-racial criteria upon which the zoning board relied. Single-family residences constituted the dominant and preferred land use in the village. The board invoked a buffer policy that restricted multiple family residences to areas between single-family zones and commercial or industrial zones as its reason for denying the rezoning request. But the proposed multiple family residences were not high-density apartments. The project would have consisted of 22-story buildings on 15 acres of land, 60% of which would have remained open space. A screen of trees and shrubs would have separated the project from neighboring houses. There would have been little to distinguish the project from the tracts of small lot, single-family dwellings in the area. Applying the buffer policy in this case, where none of the legitimate purposes underlying the policy existed, should cast some doubt on whether these normal criteria were applied for normal, that is, non-racial reasons. Alternatively, it may indicate the decision-maker's unconscious, stereotyped view of housing occupied by non-whites. Their image of what the project would look like may have been influenced as much by their expectations about housing occupied by blacks as by the actual plan and drawings presented. Our culture attaches racial meaning to residential segregation. When we see an all-white neighborhood in close proximity to an all-black one, we do not imagine that it is white because its inhabitants' forebears settled there generations ago or that blacks have chosen not to live there. Our initial thought is that it is white because non-whites have been excluded. This 251. Cultural meaning is evidence that no one who is a part of this culture could have made a decision like that made in Arlington Heights without race on his mind, the effectiveness of our psychodynamic sensors notwithstanding. Furthermore, this cultural meaning is considerably more relevant to the stigmatizing injury that blacks suffer than is the conscious intent of the decision makers. If our culture interprets a decision to exclude blacks from a neighborhood as evidence of blacks' continued untouchability, that decision becomes part of the system of mutually reinforcing racial stigma that denies blacks the status of full humanity. 2 Washington v. Davis. Davis presents a more difficult case than Arlington Heights. 2 unsuccessful black candidates for positions in the District of Columbia Metropolitan Police Department alleged that some of the department's hiring practices, particularly Test 21, a written test that blacks failed at a rate roughly 4 times that of whites, discriminated against blacks and violated the guarantee of equal protection implicit in the Fifth Amendment's Due Process Clause. Test 21, which was used throughout the federal civil service, was designed to test verbal ability, vocabulary, reading, and comprehension. While the court found that the test was a useful indicator of success in police training school, there was no proof that either the test scores or the school's examination scores predicted job performance or measured success in job-related training. What evidence might the plaintiffs have presented to establish that the government's action in this case had racial meaning? Unlike segregated housing, we do not ordinarily associate the use of civil service exams with race. But an action that has no racial meaning in one context may have significant racial meaning in another. We have seen that human behavior must be examined in context, as it may well derive its meaning from the specific historical and cultural milieu in which it takes place. Despite the race-neutral origins of civil service exams as a generic entity, one has an intuitive sense that their use in this case has racial connotations, that this case is more like the Memphis Wall than it is like an increased bus fare or a regressive tax. It is important to pay heed to one's intuitions at this juncture. One individual's gut feeling is hardly conclusive evidence of cultural meaning, but such feelings often derive from feelings that are more widely shared, and they may well indicate that more substantial testimony is available. At this point, it is helpful to consider the setting in which Test 21 was employed. Can one identify the contextual elements that have attracted the attention of our intuition? Are there elements not present in other civil service cases, elements that speak in terms of race? The most obvious racial element is the exam's racially disproportionate impact. One can argue that the government's action racially stigmatizes because blacks fail the exam in larger numbers than whites. But not every case of racially disparate impact has racial meaning. An increased bus fare may burden a larger percentage of blacks than whites, but we do not think of the fare increase as a direct stigmatization of blacks. It does not convey a message of racial inferiority. Thus, if the governmental action in Davis conveys a racial message, it must derive that meaning from something other than, or in addition to, its racial impact. Like the traffic barrier in Memphis v. Green, there must be something in the particulars of its historical and cultural context that causes us to interpret this action at least intuitively in racial terms. I suggest that there are two such elements. The first involves the nature of the work or activity from which blacks have been excluded, the job of police officer in a predominantly but not entirely black community. The second relates to the reason given for their exclusion, that they failed to demonstrate sufficient proficiency in verbal and written language skills. It is significant that the challenged action in Davis excluded blacks from working as police officers and not as mail carriers or bus drivers. The occupation of police officer has symbolic meaning within our culture. Police officers represent the law as well as enforce it. They are armed and have discretionary authority to use violence. They are charged with protecting the lives and property of some individuals within society and controlling the violent and unlawful behavior of others. If history, the accumulated meaningful behavior of our culture, has taught us to attach significance to race in considering these elements of the job of police officer: authority, control, protection, and sanctioned violence, then an action that determines the racial composition of a police force also has racial meaning. Furthermore, throughout American history, police forces have had a different relationship to black communities than to white communities. In white communities, the police officer is viewed as a public servant. His job is to protect the lives and property of those in the community where he works. But the job of the law enforcement officer in black communities has been to control the community's inhabitants and to protect the lives and property of whites who perceive blacks as the primary potential source of violence and crime. For blacks, those entrusted with law enforcement and the firepower that gives them authority have always been servants of the white men in power who exploit blacks economically and demean them socially. Slaves were forbidden to bear arms, and a white police force of overseers and sheriff's posses enforced the master's law. With the abolition of slavery, the use of organized, socially sanctioned violence against blacks increased, and the authority of the sheriff's office was often indistinguishable from that of the Ku Klux Klan. As recently as 1967, there were nearly a dozen major American cities where blacks accounted for over 25% of the population that were patrolled by police forces with only a token minority representation. It is not surprising that many black communities continue to view the police as an occupying army. The fact that police officers are authority figures to white as well as black citizens is also significant in determining the cultural meaning of excluding large numbers of blacks from the D.C. police force. To the extent that our culture attaches specific meaning to the assignment of racial groups to certain occupational and hierarchical roles, behavior that maintains those role assignments will have racial meaning. For example, whites are accustomed to seeing blacks as servants performing menial tasks. Thus, whites are generally neither surprised nor threatened when they see black porters, maids, and janitors. This is not simply a reflection of the fact that many blacks have performed these jobs. It is also indicative of a historical and culturally ingrained system of beliefs that leads us to think of blacks as suited to these jobs, to associate the jobs with blacks. By contrast, whites are not accustomed to seeing blacks in positions of authority or power. Black managers, black professors, and black doctors are confronted with reactions ranging from disbelief to resistance to concern about their competence. The historical exclusion of blacks from these jobs has been rationalized by a belief in their unsuitability for these roles. What is at issue here is not just occupational stereotypes born out of habit. These stereotypes manifest a larger and more complex ideology that has legitimized the white over black authority relationship. Stereotypes are cultural symbols. They constitute our contemporary interpretation of past and present meaningful behavior. The argument in defense of all-male police forces provides a useful analog for understanding our less readily apparent attitudes about authority and race. In suits alleging discrimination against women in the selection of patrol officers, police department defendants have argued that women would not make good officers because the job requires an individual who can command respect from the man on the street. Men, they have argued, would not take orders from women, and, therefore, women would be less effective patrol persons. In other words, the department's discriminatory hiring practices have been defended as a necessary adaptation to the sexist beliefs and practices of the culture. Whites would be less likely to verbalize the same argument regarding blacks, but the fact remains that many individuals in our culture continue to resist and resent taking orders from blacks. If the court were convinced that the absence or presence of substantial numbers of black police officers on the DC force would be interpreted as the maintenance or disestablishment of culturally instilled beliefs about the need to control blacks and the appropriate roles for blacks and whites in authority relationships, then the Civil Service Commission's decision to rely on Test 21 would have racial meaning. There is another reason why a significant segment of the culture is likely to view the exclusionary impact of Test 21 in racially stigmatizing terms. Test 21 was primarily a test of verbal and written skills. The Civil Service Commission justified its use of the test by noting its desire to upgrade the communication skills of the city's police officers. Our society has increasingly sought to measure intelligence through the use of written tests, and we have come to believe that performance on such tests accurately reflects the whole of our intelligence. Thus, most people are likely to think of those who performed poorly on Test 21 not simply as lacking in communication skills but as unintelligent. The average person is likely to see the city's use of the test as an admirable and reasonable attempt to ensure that the city has smart police officers. If larger numbers of blacks than whites fail the test, this will be seen as proof that blacks are not smart enough for the job. But evidence of cultural meaning must include more than disproportionate impact. Some whites also performed poorly on the test. Observers of the test's results would not necessarily conclude that, because blacks performed less well on this test, they are intellectually inferior as a group. They might think instead that the blacks who took this test just happened to be a less intelligent group, that less well-educated people performed less well on the test and the blacks who took this test had not on the whole received as good an education as the whites, or that poor people are less intelligent and blacks had done less well because a higher percentage of them were poor. The cultural meaning test would require the plaintiffs to produce evidence that a substantial part of the population will interpret the disproportionate results of Test 21 not as the product of random selection or the differential educational background or socioeconomic status of the test takers but as testimony to the inherent intellectual abilities of the racial groups to which the test takers belong. In other words, the government's use of the test has racial meaning if our culture has taught us to believe that blacks that fail the test have done so because they are black. Plaintiffs trying Davis under the test proposed in this article would present evidence detailing both the history and the contemporary manifestations of this myth. They would seek to convince the court that most people in our culture believe that the average white person is inherently smarter than the average black person and that whites will interpret the racially selective impact of Test 21 as a confirmation of that belief. If the culture gives the governmental action this kind of racial meaning, the action constitutes a direct racial stigmatization. Like the segregated beach and the Memphis Wall, it conveys a message that has its origins in a pervasive and mutually reinforcing pattern of racially stigmatizing actions, and it adds one more stigmatizing action to that pattern. Presumably, the decision-makers who chose to use Test 21 were aware of that message and were influenced by it, whether consciously or unconsciously. Ely's process defect analysis helps explain why proof that governmental action will be interpreted in racial terms should lead a court to closely scrutinize that action. In selecting Test 21 to screen police applicants, the Civil Service Commission weighed a number of benefits and costs. The fact that the test helps select candidates with good communication skills is, presumably, a benefit. Yet the test may also exclude many of those who are best able to establish rapport with the residents of the communities in which they work and best able to inspire their trust and confidence. The test may save time and money by making it unnecessary to offer additional training in communication skills in the police academy. But it may also create costs by selecting those candidates who will most need sensitivity training and community relations workshops. Likewise, the less tangible benefits of maintaining a workforce with which the predominantly white residents of Capitol Hill, visiting tourists, and upper-level bureaucrats will be comfortable must be weighed against the costs of failing to create more employment opportunities for the city's predominantly non-white, low-income residents. This is but a small sampling of the kind of political prioritizing that must take place when any decision is made. Much of this weighing of costs and benefits is implicit. Some considerations receive the lowest priority because they are never considered. The court in Davis tells us that the government's purpose in adopting Test 21 was to modestly upgrade the communicative abilities of its employees. *4 We do not know whether this benefit was considered so important that it outweighed all of the costs listed above, or whether those costs were never even considered. An unconscious belief in the intellectual inferiority of blacks may have led the decision-makers to put more stock in the test's ability to measure relevant skills than was justified. An inarticulate discomfort when confronted by blacks in positions of authority may not have led a commissioner to intentionally exclude blacks from the force, but it may have caused him to respond to the test's potential for discriminatory impact with relief rather than concern. His insensitivity to the importance the city's blacks would attach to more black faces on the beat might mean that this consideration was never even weighed in the balance. These are the very racially selective sympathies and indifferences degree that create misapprehensions of process defects. These sympathies overestimate the validity of generalizations that are self-flattering, for example, that written tests accurately measure an important kind of intelligence. And they undervalue the benefits of alternatives, for example, a test that measures judgment in real-life situations or empathy with community residents that would enhance the fortunes of others. Conclusion. Ultimately, the greatest stumbling block to any proposal to modify the intent requirement will not be its lack of jurisprudential efficacy but the perception among those who give substance to our jurisprudence that it will operate against their self-interest. Derek Bell has noted that the interests of blacks in achieving racial equality have been accommodated only when they have converged with the interests of powerful whites. The legal establishment has not responded to civil rights claims that threaten the superior societal status of upper and middle class whites. Alan Freeman has argued persuasively for the more radical proposition that anti-discrimination law has affirmatively advanced racism by promoting an ideology that justifies the continued economic subjugation of blacks. The intent requirement is a centerpiece in an ideology of equal opportunity that legitimizes the continued existence of racially and economically discriminatory conditions and rationalizes the superordinate status of privileged whites. The workings of the unconscious make this dissonance between efforts to achieve full civil rights for blacks and the self-interest of those who are most able to effect change even more difficult to overcome. The ideology of which Freeman speaks is more than a consciously wielded hegemonic tool of domination. It is also an unconscious defense mechanism against the guilt and anxiety of those who hold power and privilege through means and with motives that they cannot acknowledge. Racism continues to be aided and abetted by self-conscious bigots and well-meaning liberals alike. I do not anticipate that either the Supreme Court or the academic establishment will rush to embrace and incorporate the approach this article proposes. It has not been my purpose to advance an analysis that is attractive for its ease of application or for its failure to challenge accepted and comfortable ways of thinking about equal protection and race. Rather, it is my hope that the preliminary thoughts expressed in the preceding pages will stimulate others to think about racism in a new way and will provoke a discussion of how equal protection doctrine can best incorporate this understanding of racism. This article has argued that judicial exploration of the cultural meaning of governmental actions with racially discriminatory impact is the best way to discover the unconscious racism of governmental actors. This exploration will be beset by the complexities and inadequacies of social interpretation and buffeted by the headwinds of political resistance. Perhaps I am overly optimistic in believing that in the process of this difficult exploration we may discover and understand a collective self-interest that overshadows the multitude of parochial self-interests the unconscious seeks to disguise and shield. But of one thing I am certain. A difficult and painful exploration beats death at the hands of the disease. A critique of our Constitution is colorblind. Neil Gotanda. Introduction. His article examines the ideological content of the claim that our Constitution is colorblind, and argues that the U.S. Supreme Court's use of colorblind constitutionalism, a collection of legal themes functioning as a racial ideology, fosters white racial domination. Though aspects of colorblind constitutionalism can be traced to pre-Civil War debates, the modern concept developed after the passage of the 13th, 14th, and 15th Amendments, and it matured in 1955, in Brown v. Board of Education *, a colorblind interpretation of the Constitution legitimates and thereby maintains the social, economic, and political advantages that whites hold over other Americans. The Supreme Court's colorblind constitutionalism uses race to cover four distinct ideas: status race, formal race, historical race, and culture race. Status race is the traditional notion of race as an indicator of social status. While traditional status race is now largely discredited, it remains important as the racial model for efforts aimed at eradicating intentional forms of racial subordination, with their implication of racial inferiority. The second use of race, formal race, refers to socially constructed formal categories. Black and white are seen as neutral, apolitical descriptions, reflecting merely skin color or region of ancestral origin. Formal race is unrelated to ability, disadvantage, or moral culpability. Moreover, formal race categories are unconnected to social attributes such as culture, education, wealth, or language. This unconnectedness is the defining characteristic of formal race, and no other usage of race incorporates the concept. Historical race, however, does assign substance to racial categories. Historical race embodies past and continuing racial subordination, and is the meaning of race which the court contemplates when it applies strict scrutiny to racially disadvantaging government conduct. The state's use of racial categories is regarded as so closely linked to illegitimate racial subordination that it is automatically judicially suspect. Finally, culture race uses black to refer to African American culture, community, and consciousness. Culture refers to broadly shared beliefs and social practices, community refers to both the physical and spiritual senses of the term, and African American consciousness refers to black nationalist and other traditions of self-awareness, as well as to action based on that self-awareness. Culture race is the basis for the developing concept of cultural diversity. 2. Raciality categories. In constitutional discourse and in larger society, race is considered a legitimate and proper means of classifying Americans. Its frequent use suggests that there is a consensus about what the races are. While the social content of race has varied throughout American history, the practice of using race as a commonly recognized social divider has remained almost constant. In this section, the term racial category refers to this distinct, consistent practice of classifying people in a socially determined and socially determinative way. The American racial classification practice has included a particular rule for defining the racial categories black and white. That rule, which has been termed hypodescent, is the starting point for this analysis. American racial classification, hypodescent. One way to begin a critique of the American system of racial classification is to ask who is black. This question rarely provokes analysis. Its answer is seen as so self-evident that challenges are novel and noteworthy. Americans no longer have need of a system of judicial screening to decide a person's race, the rules are simply absorbed without explicit articulation. The rule of hypodescent. American racial classifications follow two formal rules. The rule of recognition holds that any person whose Black African ancestry is visible is Black. The rule of descent holds that any person with a known trace of African ancestry is Black, notwithstanding that person's visual appearance, or, stated differently, that the offspring of a black and a white is Black. Historians and social scientists have noted the existence of these rules, often summarized as the one drop of blood rule, in their analysis of the American system of racial classification. Anthropologist Marvin Harris has suggested a name for the American system of social reproduction: hypodescent. Two alternatives to hypodescent: the American legal system today lacks intermediate or mixed race classifications. While the establishment of self-contained black or white racial categories may seem obvious, an examination of other classification schemes reveals that the American categories are not exhaustive. Let us posit the two original races, one a pure black, the other a pure white. As interracial reproduction occurs, a multiracial society emerges. Four historically documented examples of non-binary schemes to categorize mixed-race offspring have evolved: mulatto, named fractions, majoritarian, and social continuum. All of these schemes are logically symmetrical, so, at least in theory, neither pure race is privileged over the other. Consider each of the schemes in detail. A. Mulatto. All mixed offspring are called mulattoes, irrespective of the percentages or fractions of their black or white ancestry. B. Named fractions. Individuals are assigned labels according to the fractional composition of their racial ancestry. Thus, a mulatto is 1/2 white and 1/2 black, a quadroon is 1/4 black and 3/4 white, a sambo 1/4 white and 3/4 black, etc. C. Majoritarian. The higher percentage of either white or black ancestry determines the white or black label. D. Social continuum. This is a variation on the named fractions scheme. Labels generally correspond to the proportion of white or black ancestry, but social status is also an important factor in determining which label applies. The result is a much less rigid system of racial classification, for it is worth repeating two observations that apply to all four schemes. First, the use of racial categories presumes that at some time pure races existed. Second, because these schemes are symmetrical, nothing in them suggests inequality or subordination between races. 3. Support for racial subordination. The hypodescent rule, when combined with colorblind constitutionalism, conveys a complex and powerful ideology that supports racial subordination. Briefly, hypodescent imposes racial subordination through its implied validation of white racial purity. Subordination occurs in the very act of a white person recognizing a black person's race. Much of constitutional discourse disguises that subordination by treating racial categories as if they were stable and immutable. Finally, the treatment of racial categories as functionally objective devalues the socio-economic and political history of those placed within them. Through this complex process of assertion, disguise, and devaluation, racial categorization based on hypodescent advances white interests. B. Assertion of racial subordination. I. Equality and the social metaphor of racial purity. Looking at the lack of symmetry between racial categories provides a means of further understanding hypodescent. Under hypodescent, black parentage is recognized through the generations. The metaphor is one of purity and contamination. White is unblemished and pure, so one drop of ancestral black blood renders one black. Black ancestry is a contaminant that overwhelms white ancestry. Thus, under the American system of racial classification, claiming a white racial identity is a declaration of racial purity and an implicit assertion of racial domination. The symmetry of racial categorization systems other than hypodescent brings a sense of objectivity and neutrality to these schemes, and a comparison of hypodescent to symmetrical systems exposes its non-neutral assumptions. 2. Subordination in recognition. Under hypodescent, the moment of racial recognition is the moment in which is reproduced the inherent asymmetry of the metaphor of racial contamination and the implicit impossibility of racial equality. The situation that bears most fully the subordinating aspect of the moment of racial classification arises when a black person is at first mistaken for white and then recognized as black. Before the moment of recognition, white acquaintances may let down their guard, betraying attitudes consistent with racial subordination, but which whites have learned to hide in the presence of non-whites. Their meeting and initial conversation were based on the unsubordinated equality of a white-white relationship, but at the moment of racial recognition the exchange is transformed into a white-black relationship of subordination. In that moment of recognition lies the hidden assertion of white racial purity. The moment of racial recognition is thus characterized by an unconscious assertion of the racial hierarchy implied by hypodescent. See disguising the mutability of racial categorization. One persistent dimension of racial categorization is its treatment of race as a fixed trait. This belief in the immutable quality of race flows from two traditions. One tradition studies race as a phenomenon appropriate to the natural sciences. This tradition initially studied race to prove primarily the inferiority of the Negro race, and is now largely discredited. The second tradition emphasizes physiognomy. It characterizes race as biological, thereby suggesting that race is unchangeable. Both traditions contribute to a societal view of race as a neutral, objective, and apolitical characteristic. This section argues that race is anything but immutable. Neither tradition can claim true objectivity. Further, the American racial categorization scheme is not only historically contingent, but, to some extent, legislatively determined. The scientific legitimation of race. Historically, scientific discourse has played a central role in legitimating status-based racial classifications. For example, the racial science of the 18th and 19th centuries justified slavery by asserting the inferiority of African Americans. The work of Blumenbach, a German comparative anatomist of the late 18th century, who classified humans into 5 principal races: Caucasian, Mongolian, Malay, American, and Ethiopian, was particularly influential. While no longer cited in scientific journals, Blumenbach's racial classifications have remained embedded in popular notions of race. Even after a century of efforts to discredit scientific theories asserting the natural superiority of the white race, race continues to be accepted as a scientific concept. The Supreme Court's modern discussions of race purport to be disengaged from the older scientific tradition registered in a 1987 case, St. Francis College v. Al-Hazraji. The court examined whether an Arab could seek damages for race discrimination under 42 U.S.C. 1981. Answering in the affirmative, the court's unanimous opinion disavowed the traditional anthropological categories of race. Justice Byron White wrote, "Such discrimination is racial discrimination that Congress intended 1981 to forbid, whether or not it would be classified as racial in terms of modern scientific theory." Moreover, in dicta, the court expressed sympathy for the position that race is a socio-political rather than scientific characteristic. However, the court was not ready to back away entirely from the idea that racial categories were based in natural science. Justice White continued, "The Court of Appeals was thus quite right in holding that 1981, at a minimum, reaches discrimination against an individual because he or she is genetically part of an ethnically and physiognomically distinctive subgrouping of Homo sapiens." The court's equivocating in St. Francis College suggests that the justices are not yet comfortable with abandoning entirely the security of immutable racial categories. To the tradition of physiognomy, the immutability of racial classifications can be seen in our everyday understanding of the terms black and white. Generally speaking, these classifications are fixed. We cannot change our race to suit a personal preference. One does not arise in the morning and say, "I think that today is my white day and tomorrow will be my black day." These racial classifications are objective and immutable in the sense that they are external to subjective preferences, and therefore unchanging. The links between racial categorization and skin color, physiognomy, and ancestry reinforce the belief that racial identity is immutable. By contrast, other societies, including racially stratified Western societies, do not insist that their racial labels are objective, Accordingly, their definitions of race are much more fluid. For example, in Brazil one can pass to another racial category regardless of how dark one may be. Brazilians say money whitens, meaning that the richer a dark man gets, the lighter will be the racial category to which he will be assigned by his friends, relatives, and business associates. The Brazilian experience highlights the arbitrariness of the American classification system's assertion that race is a fixed and objective feature. Justice Stewart's dissent in Feudlove v. Klutznick illustrates how racial categories are linked to physiognomy or ancestry and then described as immutable. Under our Constitution, the government may never act to the detriment of a person solely because of that person's race. The color of a person's skin and the country of his origin are immutable facts. Degree Stewart's reference to skin color invokes science. This scientific fact is then transferred to the racial category to assert the immutability of the racial category. This process results in a racial classification that looks like a fact. Facts are commonly thought to be objective and neutral, devoid of normative social significance. However, a distinction must be drawn between the objectivity of scientific facts and the subjectivity of legal facts. Justice Stewart's qualifier immutable suggests a higher level of objectivity than is traditionally accorded legal facts. While Justice Stewart may have been justified in deeming a person's skin color immutable, the implicit link of skin color to race is a social and legal assertion, not a scientific fact. A more recent example of the court confusing racial classifications with scientific fact occurred during oral argument in Metro Broadcasting Incorporated v. FCC trademark. Justice Antonin Scalia engaged in a widely reported exchange with counsel defending the FCC's policy of qualitative enhancement for minority and women seeking broadcast station licenses. Attacking the argument that minorities and women would encourage diversity in programming, Justice Scalia repeatedly asked whether the policy was a matter of blood, at one point charging that the policy reduced to a question of blood. Blood, not background, and environment. The context of Justice Scalia's insistence upon blood suggests he was referring metaphorically to ancestry as determining racial classification. Blood is a rich metaphor and includes, in this context, the suggestion of biological lines of descent. Justice Scalia's implication is that race, as a category of biology and science, has no relation to background and environment. In his view, race and its metaphor, blood, are neutral and without social content and, therefore, inappropriate criteria to be used in granting broadcast licenses. The modern use of the physiognomic tradition has ironic implications when considered in light of the goals of the scientists who originally studied physiognomy. 19th-century racial scientists hoped to prove that the African race was inherently inferior. The modern tradition links racial categories to science in order to show that race is a neutral and apolitical term without social content. However, both traditions support racial subordination. 3. The historical contingency of racial categories. Modern ways of thinking about racial categories evolved throughout American history. In the early colonial period, racial classifications were highly fluid. Social status often depended as much on the labor status of the individual as on his or her place of origin. Typically, Africans were brought to the colonies as captives, and Europeans as contractual or indentured servants. Winthrop Jordan has described the individual political dimensions of labor in 17th-century Virginia and Maryland as states of unfreedom. There was a hierarchy among those who were not slaves but were also not free. The labels for such labor varied. In Virginia and Maryland, where the English colonists were the dominant group, the various unfree were also described as un-English. The term included French, Africans, and Scots. There were additional labels specific to the African laborers. While the early records are incomplete, there is clear evidence that by the middle of the 17th century, English colonists maintained some Africans in a status distinguishable from European indentured labor. Sources from that century variously describe Africans as heathen, infidel, and Negro. These terms were attempts to justify the political status of the Africans. The racial classifications differentiated Europeans from the natives of colonized and imperially exploited parts of the world, but the classifications did not indicate a clearly developed belief that slavery was an appropriate condition for Africans. English colonists gradually came to prefer enslaved African labor over indentured Europeans. By the end of the 17th century, the number of slaves had increased dramatically. As slavery became entrenched as the primary source of agricultural labor, slaveholders developed a complementary ideological structure of racial categories that served to legitimate slavery. The formal legal system was tailored to reflect these categories and enforce slave labor. In 1705, the Virginia Assembly created the first recognizable slave code. Besides codifying punishment for slaves who stole or ran away, the slave code contained specific rules of descent for classifying offspring. Punishments for blacks and mulattoes differed from those for indentured servants. This institutionalization of racial classifications linked to disparate treatment marked the first formal establishment of racial categories in colonial America. The new racial classifications offered a basis for legitimating subordination which was unlike the justifications previously employed. By keying official rules of descent to national origin, the classification scheme differentiated those who were enslavable from those who were not. Membership in the new social category of Negro became itself sufficient justification for enslavability. One can, therefore, do more than assert generally that race is not scientific, or that race is socially constructed. One can say that our particular system of classification, with its metaphorical construction of racial purity for whites, has a specific history as a badge of enslavability. As such, the metaphor of purity is not a logical oddity but, rather, an integral part of the construction of the system of racial subordination embedded in American society. Under colorblind constitutionalism, when race is characterized as objective and apolitical, this history is disguised and discounted. For legislative determination of racial categories, an examination of past American law provides additional support for the assertion that racial classifications are not immutable. Before the Civil War, almost every state had statutes or judicial decisions defining race. Indeed, until World War II, such statutes were common and not limited to the South. Likewise, anti-miscegenation statutes were widespread, even where Jim Crow segregation was not mandated. These statutes demonstrate the variations possible in a scheme of racial classification. Often the race of the offspring of a racially mixed couple was determined by a statutory formula. A widely publicized example of statutory classification of race occurred in Louisiana in the early 80s. While most jurisdictions had abolished mandatory classifications by the 70s, Louisiana's birth certificate statute required a statutorily defined racial identification. A Louisiana woman, Susie Guillory Phipps, on applying for a passport, was sick for 3 days when she discovered that her birth certificate listed both her parents as colored. She challenged the statute in court. At trial and on appeal, the Louisiana courts upheld the constitutionality of the fractional classification statute, and Phipps's birth certificate was not changed. The statutory histories of state racial classification schemes emphasize the role of government in defining racial categories. Government's role has been less obvious since the civil rights movement's focused attention on the rights of individuals already classified as black. Colorblind constitutionalism implicitly adopts a particular understanding of race as objective and immutable, which may be less obvious than legislative enactments, but is no less significant. 3. Formattre cn. Unconnectedness. The Supreme Court has used words such as race, black, and white without explanation or qualification. In doing so, it has disguised its own role in perpetuating racial subordination. The modern court has moved away from the two notions of race which recognize the diverging historical experiences of black and white Americans: status race and historical race. In place of these concepts, the court relies increasingly on the formal race concept of race, a vision of race as unconnected to the historical reality of black oppression. As this section shows, formal race is a concept of limited power analytically and politically. By relying on it, the court denies the experience of oppression and limits the range of remedies available for redress. A. Status race, formal race, and historical race. Status race, Dred Scott. In the antebellum era, the inferior status of blacks was an accepted legal standard. The most famous court decision to embrace the status race concept was Chief Justice Roger Taney's opinion in Dred Scott v. Sandford. Chief Justice Taney wrote that, at the time of the founding of the Republic, the Negro African race had been regarded as beings so far inferior, that they had no rights which the white man was bound to respect. For Chief Justice Taney, the distinct, inferior status of blacks was implicit in the Constitution and overrode any congressional pronouncements to the contrary. The court's modern opinions tolerate the legacy of status race in the private sphere only. Private citizens are free to make contracts, form associations, speak, write, and worship in a manner predicated on the belief that blacks are inferior. A critique of our Constitution is colorblind, ently and biologically inferior to whites. These broad-based individual freedoms protecting status race beliefs significantly aid the legitimation of racist conduct. 2. Formal race, Plessy v. Ferguson. The well-known separate but equal case, Plessy v. Ferguson, epitomizes formal race analysis. In upholding a Louisiana statute requiring separate seating for blacks and whites in public carriers, the P/SE court used race in a manner that sharply differed from the older status race notion in Dred Scott. The Plessy court found the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. 4. Turning a blind eye to history, the court maintained that the segregation statute said nothing about the status of blacks, indeed, that the statute was racially neutral. Besides presuming that racial classifications are unconnected to social status or historical experience, the court's formal race analysis fails to recognize ties between the classification scheme of one statute and the treatment of race in other legislation. The court did not see statutes segregating railroad service, schools, and housing as inherently connected to each other or to a legal and social system that perpetuated the stigma of inferiority based on race. Formal race and status race offer two differing interpretations of Jim Crow segregation. Under the status race approach, which assumes the subordinated status of blacks, racial segregation by custom or statute reflects a common-sense understanding of the natural racial hierarchy. In contrast, the formal race, colorblind approach assumes equal protection of the law based on common citizenship. Given these assumptions, racial segregation is simply a legislative differentiation that must be considered to have no inherent social meaning. Even with formal race's rejection of the inferior status of blacks, Plessy makes clear that formal race unconnectedness often renders harsh results. Historical race. In contrast to the majority opinion in Plessy, Justice John Harlan's oft-quoted dissent argued vigorously against the neutrality of race-based segregation. Everyone knows that the statute in question had its origin in the purpose, not so much to exclude white persons from railroad cars occupied by blacks, as to exclude colored people from coaches occupied by or assigned to white persons. The thing to accomplish was, under the guise of giving equal accommodation for whites and blacks, to compel the latter to keep to themselves while traveling in railroad passenger coaches. Degree. Justice Harlan recognized that segregation based on race is inherently subordinating. By rejecting the majority's view that racial segregation is unconnected to oppression and by refusing to adopt the rigid legalism of formal race, Justice Harlan anticipated by a half-century the spirit of Brown v. Board of Education. Registered Justice Harlan was advocating a peculiar mix of historical race and formal race. Government acts were required to be genuinely neutral, therefore judicial review of race-based legislation should recognize the historical content of race. However, formal race dictated Justice Harlan's vision of the private sphere. The white race deems itself to be the dominant race in this country. And so it is, in prestige, in achievements, in education, in wealth and in power. So, I doubt not, it will continue to be for all time, if it remains true to its great heritage and holds fast to the principles of constitutional liberty. More recently, Justice Thurgood Marshall used historical race in his Bakke v. Regents of University of California dissent. Registered Marshall argued that it is unnecessary in 20th century America to have individual Negroes demonstrate that they have been victims of racial discrimination. The racism of our society has been so pervasive that none, regardless of wealth or position, has managed to escape its impact. The experience of Negroes in America has been different in kind, not just in degree, from that of other ethnic groups. It is not merely the history of slavery alone but also that a whole people were marked as inferior by the law. And that mark has endured. Marshall's comments emphasize that in historical race usage, racial categories describe relations of oppression and unequal power. Historical race usage of black does not have the same meaning as usage of white. Black is the reification of subordination, whereas white is the reification of privilege and superordination. This asymmetry of white and black corresponds to the asymmetry of hypodescent and its metaphor of racial purity and racial contamination. b. Formal race and unconnectedness in ractal discourse. Current Supreme Court cases use race most commonly to mean formal race. Racial classification has lost its connection to social reality. This trend is demonstrated by the voting rights, affirmative action, and jury selection cases, as well as the works of two prominent academics discussed below. This section reveals the pervasiveness and the dangers of the formal race approach. Voting rights. Unconnectedness can be seen in cases concerning the electoral franchise and political power. It appears most clearly in the dissent in Rome v. United States * registered a case upholding the constitutionality of amendments to the Voting Rights Act of 1965.71. The amendments shifted to local jurisdictions the burden of proving that a proposed change in voting arrangements would not adversely affect black voters. Justices Potter Stewart and William Rehnquist, the dissenters, objected to the premise underlying the amendments. The need to prevent this disparate impact is premised on the assumption that white candidates will not represent black interests, and that states should devise a system encouraging blacks to vote in a block for black candidates. For Justices Stewart and Rehnquist, the assumption that race and voting patterns were or ought to be linked was constitutionally impermissible. They objected also to the notion that Congress could empower a later generation of blacks to get even for wrongs inflicted on their forebears. Chief Justice Rehnquist's and Justice Stewart's opposition to Congress's effort to consider the political character of blackness and whiteness stemmed from their belief that white and black are devoid of political content, an assumption negated by any study of the interplay between voters' decisions and race. This presumption of unconnectedness has led Chief Justice Rehnquist and Justice Stewart to argue in other cases that the evidentiary burden should be on plaintiffs to establish both the unfair results of a redistricting plan, and that the intent of the boundary drawers was to be unfair. These justices would make formal race unconnectedness an axiom of constitutional interpretation of voting rights, nullifying any present or future congressional attempts to account for the link between race and political power. Their theory would pose a substantial barrier to race-conscious legislative efforts to halt discrimination against black voters. 2. Affirmative action. In many discussions of affirmative action, advocates of a colorblind position equate race with formal race. An example of this is Justice William Douglas's dissent in De Funes v. Adegaard. De Funes was a white applicant to the University of Washington Law School who charged that less qualified minority applicants had been accepted while he had been denied admission. Justice Douglas stated unequivocally that race is an impermissible consideration in the context of college admissions. A De Funes who is white is entitled to no advantage by reason of that fact, nor is he subject to any disability, no matter what his race or color. Whatever his race, he had a constitutional right to have his application considered on its individual merits in a racially neutral manner. Consideration of past segregation by the University of Washington. Indeed, any consideration of this country's history of oppression at all is impermissible. Justice Douglas's philosophy remains alive on the court today. Justice Scalia quoted Douglas's dissent with approval in his City of Richmond v. J. A. Croson co-concurrence. 7 degree. A critique of our Constitution is colorblind. 3. Jury selection in Batson v. Kentucky. The Supreme Court liberalized the evidentiary requirements for proving that a prosecutor's peremptory jury challenges were racially discriminatory in violation of the Equal Protection Clause. Justice Powell argued that competence to serve as a juror ultimately depends on an assessment of individual qualifications and ability impartially to consider evidence presented at a trial. A person's race simply is unrelated to his fitness as a juror. Registered. The Batson decision redressed the historical race problem of blacks being barred from serving on juries and, therefore, was a significant step forward. However, Justice Powell's statement that race is unrelated invokes that unconnectedness of a juror's formal race classification to any other personal attributes that might relate to jury duty. This reliance upon unconnectedness was unnecessary and unfortunate. Use of unconnectedness separates the decision from the context of Justice Powell's otherwise substantial reliance on historical race analysis. For economic analysis, Richard Posner, in The Economics of Justice, uses the term race per se, that is, race completely divorced from certain characteristics that may be strongly correlated with it to analyze reverse discrimination. Posner would object to the argument that diversity in a student body is a proper basis for preferential treatment of minorities. He argues that here are black people, who have the same tastes, manners, experiences, aptitudes, and aspirations as the whites with whom one might compare them. Consequently, if race per se may be used as a proxy for those characteristics in the diversity context, then race per se may also be legitimately employed in more sinister ways. For example, if race and an undesirable employment characteristic are correlated, then race may be used to justify employment discrimination. Posner's race per se is, of course, identical to formal race. His analysis, like many formal race analyses, overlooks social reality, the presence of a black, any black, notwithstanding his or her correlative factors will likely alter the reactions of whites in a given setting, so per se integration is itself a positive good. The economist Thomas Sowell provides another example of unconnectedness in his writings on the significance of race. Himself black, Sowell illustrates the multiple uses of the word discrimination by discussing the hypothetical treatment of an unnamed group. For example, one typical usage of discrimination is when members of a particular group are accorded fewer and poorer opportunities than members of the general population with the same current capabilities. Racial groups are fungible under all of Sowell's definitions. While he does discuss discrimination against specific minorities, the basis for his discussion is an abstract framework, devoid of historical race content. There is nothing inherent in black or white which renders it unamenable to analysis as just any group. See support for racial subordination. Unconnectedness limits racism to subjective prejudice. Formal race unconnectedness is linked to a particular conceptualization of racism. Race, as formal race, is seen as an attribute of individuality unrelated to social relations. Unconnectedness limits the concept of racism and the label racist to those individuals who maintain irrational personal prejudices against persons who happen to be in the racial category black. Racism is irrational because race is seen as unconnected from social reality, a concept that describes nothing more than a person's physical appearance. Under this view, racism is thought of only as an individual prejudice. Despite the fact that personal racial prejudices have social origins, racism is considered to be an individual and personal trait. Society's racism is then viewed as merely the collection, or extension, of personal prejudices. In the extreme, racism could come to be defined as a mental illness. These extremely individualized views of racism exclude an understanding of the fact that race has institutional or structural dimensions beyond the formal racial classification. However, individual irrationality and mental illness simply do not adequately explain racism and racial subordination. Furthermore, the view that racism is merely an irrational prejudice suggests that the types of remedies available to address racial subordination and oppression are limited. For example, programs providing economic aid would be thought of as an ineffective weapon against racism, because such programs address individual prejudicial attitudes only indirectly. A minority set-aside program such as that proposed by the City of Richmond directly addresses the present effects of past racial exclusion from the building trades as well as the continuing de facto exclusion of non-whites. Yet such a program attacks prejudicial attitudes only indirectly, by demonstrating the capabilities of black contractors, thus denying the validity of status race inferiority, and providing common workplace interactions, thus breaking down irrational prejudice. The Supreme Court's use of formal race unconnectedness is consistent with its view that the particular manifestations of racial subordination substandard housing, education, employment, and income for large portions of the black community are better interpreted as isolated phenomena than as aspects of the broader, more complex phenomenon called race. This disaggregated treatment veils the continuing oppression of institutional racism. It whittles racism down to the point at which racism can be understood as an attitude problem amenable to formal race solutions. However, formal race legalism hinders this country's ability to address the clear correlation between racial minority populations and the concentrations of these various, supposedly distinct problems. Even if one admits that large numbers of the unemployed and undereducated youth in the inner cities are black, unconnectedness hinders the government's ability to use that correlation as a basis for attacking social ills. This hindrance occurs in two ways. First, because each social problem is considered to be independent of its racial component, any proposed government program is analyzed as though it addresses a non-racial issue. Even in cases where the problems are obviously related to dysfunctional interracial relations problems such as housing and employment, the issues are discussed as though they have no history or context at all. Second, the court often invokes the metaphor of the equal starting point when analyzing social problems. This metaphor ignores historical race and the cumulative disadvantages that are the starting point for so many black citizens. The metaphor implies that if blacks are underrepresented in a particular employment situation, it must be a result of market forces. Any statistical correlation is either coincidental or beyond the control of the employer, and is, in any case, unrelated to the employer's past practices. In short, colorblind constitutionalists live in an ideological world where racial subordination is ubiquitous yet disregarded unless it takes the form of individual, intended, and irrational prejudice. Perhaps formal race analysis would be a useful tool for fighting racism if it recognized that racism is complex and systemic. However, as presently used, formal race unconnectedness helps to maintain white privilege by limiting discussion or consideration of racial subordination. 2. Strict scrutiny and affirmative action. Invocation of strict scrutiny, the strongest form of equal protection judicial review, is generally fatal to the race-based government action. The doctrine of strict scrutiny has proved a powerful legal weapon and has regularly been used to strike down Jim Crow segregation throughout public facilities. The distinction among the different uses of race developed in this article suggests two interpretations of strict scrutiny. The first is the interpretation used in Brown v. Board of Education, which considered race a classification that subordinates blacks. This is historical race, and against this background, the court rightly employed strict scrutiny to review government activity. The second interpretation of race in strict scrutiny cases is that of City of Richmond v. J.A. Croson Co. *+, in which race is seen as formal race. In this interpretation, it is the arbitrary character of racial classifications that requires strict judicial scrutiny. Because formal race is a misapprehension of the nature of race in America, the appropriateness of analytically combining formal race with strict scrutiny is open to criticism. Both interpretations of strict scrutiny are further examined below, and used as the basis for a discussion of affirmative action programs. Historical race and strict scrutiny. The historical race rationale for strict scrutiny derives from Brown v. Board of Education, in which the court ruled that segregated education was inherently unequal. The decision rejected the formal race doctrine of P/SE in favor of the theory that race, as used in the context of education, was both intended to, and had the effect of, Subordinating black school children. The cases immediately following Brown continued its approach. They recognized that the use of racial classifications to segregate was inherently subordinating and struck down the vast majority of Jim Crow laws as unconstitutional. Under the Brown interpretation of strict scrutiny, heightened judicial review should be applied to all restrictions that curtail the civil rights of a racial group. In the context of the racial subordination of blacks, the implied rationale for such heightened review has been the past and continuing racial subordination of the group as a whole. If one summarizes these cases by stating that race triggers strict scrutiny, then one is using race to mean historical race. Formal race and strict scrutiny. A different racial usage is involved if one argues that the government's use of any racial classification triggers strict scrutiny. This strong version of colorblind constitutionalism has not yet been adopted by a majority of the Supreme Court, although Justice O'Connor has provided a clear description of the position. The Constitution requires that the court apply a strict standard of scrutiny to evaluate racial classifications. Strict scrutiny requires that, to be upheld, racial classifications must be determined to be necessary and narrowly tailored to achieve a compelling state interest. Degree. This version of racial strict scrutiny, that use of any racial classification is subject to strict scrutiny without reference to historical or social context, is best interpreted as a use of formal race. Strict scrutiny is triggered whether the classification is designed to remedy the effects of past subordination or designed to further oppress a traditionally subordinated racial group. This shift from the use of strict scrutiny to review governmental oppression of blacks to review of any use of race has never been explicitly addressed by the court. The underlying justification for the change remains undiscussed. Judicial review of affirmative action. The court's decision in City of Richmond v. J.A. Croce & Co. degree demonstrates clearly that formal race strict scrutiny can severely limit the range of constitutionally permissible governmental remedies for racial subordination. To see how the strong formal race interpretation of strict scrutiny differs from the historical race interpretation, consider how the Richmond affirmative action program might be analyzed under both interpretations. Under the historical race interpretation, the City of Richmond would explain that its affirmative action program was designed to help blacks by redressing past and continuing racial subordination. Richmond's use of historical race explicitly considers the legacy of racial discrimination in Richmond. Because historical race includes continuing racial subordination, its use provides a rationale for race-conscious remedial governmental action today. In other words, historical race usage is the shorthand summary of the historical and social justifications for race-conscious affirmative action programs. Assuming that the program is well designed, there would be a reasonable fit between the use of racial categories and the goals of the remedial program. Obviously, historical race is not the same for whites as for blacks. The history of segregation is not the history of blacks creating racial categories to legitimate slavery, nor is it a history of segregated institutions aimed at subordinating whites. Indeed, racial categories themselves, with their metaphorical themes of white racial purity and non-white contamination, have different meanings for blacks and whites. If judicial review is to consider the past and continuing character of racial subordination, then an affirmative action program aimed at alleviating the effects of racial subordination should not automatically be subject to the same standard of review as Jim Crow segregation laws. Judicial review using historical race should be asymmetric because of the fundamentally different histories of whites and blacks. Contrast this with the formal race approach, strict scrutiny to evaluate any racial classification. This symmetrical standard of review cannot be justified by racial history, because racial history is skewed. Nor can it mean that the seriousness of past and continuing racial subordination is no longer important. If racial subordination did not pervade society, then heightened judicial review would be unnecessary, and rational basis review would be appropriate for all formal race categorizations. The choice, then, to ignore racial history and existing racial subordination in applying strict scrutiny to all racial classifications is essentially a decision to use only formal race. But what justifies the court's election of formal race strict scrutiny? The strict scrutiny that developed originally in an atmosphere of governmental attempts to curtail black civil rights has been transformed into formal race scrutiny. The result is that government programs designed to assist blacks are being struck down. This is perverse. Historically, racial subordination has been the privileging of whites over non-whites, and a proper remedial program would work to redress that history. Instead, the use of formal race-strict scrutiny is applied to proposed remedies and results in their being declared unconstitutional, thereby perpetuating societal advantages for whites. Justice Scalia's cramped argument at the close of his Croson concurrence demonstrates how formal race fails to account for our nation's history of subordination in the context of remedies. Justice Scalia maintains that a race-neutral remedial program will be constitutionally permissible and will also provide advantages to blacks. He concedes that there has been a history of racial subordination, but he nevertheless advocates a remedy aimed only at the disadvantaged as such. Justice Scalia claims that such a program would have the desirable incidental effect of helping black individuals, but he insists on ignoring any historical connection between harm and race discrimination. The notion of systematic racial subordination of the relevance of the group is totally absent. 4. Colorblind constitutionalism and social change. His section critiques colorblind constitutionalism as a means and as an end for American society. As a means, colorblind constitutionalism is meant to educate the American public by demonstrating the proper attitude toward race. The end of colorblind constitutionalism is a racially assimilated society in which race is irrelevant. However, taken too far, this goal of a colorblind society has disturbing implications for cultural and racial diversity. Other goals, less drastic than complete racial assimilation, are tolerance and diversity. This section defines tolerance as the view that multiculturalism and multiracialism are necessary evils that should be tolerated within American society. Diversity, on the other hand, is defined as the view that racial and cultural pluralism is a positive good. A. Means, the public non-recognition model and its limits. In his Minnick v. California Department of Corrections dissent, Justice Stewart explains that government non-recognition of race is implicitly intended to provide a model for private sphere behavior. The model functions both negatively and positively. The negative model suggests that social progress is most effectively achieved by judging people according to their ability, and, therefore, that race-based decision-making seduces citizens away from a more legitimate merit-based system. There are two problems with the negative model. The first is its unquestioned assumption that meritocratic systems are valid, the second is its implicit denial of any possible positive values to race. In particular, the negative model devalues black culture race in this article and unjustifiably assumes the social superiority of mainstream white culture. The positive behavior model, government non-recognition serving as an example for private conduct, also has problems. First, there is the practical impossibility of non-recognition as a standard for either public or private conduct. Second, the implicit social goal of assimilation degrades positive aspects of blackness. Colorblind constitutionalism not only offers a flawed behavioral model for private citizens, but its effectiveness in promoting social change is limited. Colorblindness strikes down Jim Crow segregation but offers no vision for attacking less overt forms of racial subordination. The colorblind ideal of the future society has been exhausted since the implementation of Brown v. Board of Education and its progeny. One example of how limited the colorblind approach is as a weapon against discrimination can be seen in the area of voting rights, a core area of public life. Colorblind constitutionalists, filing dissents in Rome v. United States and Rogers v. Lodge, argued that Congress had unconstitutionally abandoned a formal individual remedy approach in favor of more sweeping, race-conscious remedies for racial discrimination. As Justice Scalia's concurrence in City of Richmond v. J. A. Croson Co. and the dissent in Metro Broadcasting Incorporated v. FCC make clear, a strong version of public sphere non-recognition would not permit governmental consideration of race, except in an extremely narrow set of court-mandated remedies. Were such a formula adopted, colorblind constitutionalism would limit the abilities of states and Congress to pursue broad remedial legislation aimed at racial disparities. A final example of colorblind non-recognition as limiting racial social change inheres in the public/private distinction. The combination of the view that non-recognition limits government action with the belief that there exists a private sphere right to discriminate constitutes a seductive and consistent ideology, one declaring that the continuance of white racial dominance is a constitutionally protected norm. The end result of this combination is that racial social change remediation for centuries of subordination must take place outside of legal discourse and the sphere of government action. B. Ends. Assimilation, tolerance, and diversity. The examination of colorblind constitutionalism as means leaves open the question of what the colorblind society of the future would look like. This subsection asks that very question. The colorblind assimilationist ideal seeks homogeneity in society rather than diversity. Such an ideal neglects the positive aspects of race, particularly the cultural components that distinguish us from one another. It may not be a desirable result for those cultural components to be subsumed into a society that recognizes commonalities. Culture race. The assimilationist colorblind society ignores and thereby devalues culture race. Culture race includes all aspects of culture, community, and consciousness. The term includes, for example, the customs, beliefs, and intellectual and artistic traditions of Black America, as well as institutions such as Black churches and colleges. With two notable exceptions, the court has devalued or ignored Black culture, community, and consciousness. Its opinions use the same categorical name Black to designate reified systemic subordination, what I have termed historical race, as well as the cultural richness that defines culture race. Only by treating culture race as analytically distinct from other usages of race can one begin to address the link between the cultural practices of Blacks and the subordination of Blacks, elements that are, in fact, inseparable in the lived experience of race. The two exceptions, where the court appropriately recognized culture race, are Metro Broadcasting Incorporated v. FCC 4 Degrees and Bakke v. Regents of University of California * in Metro Broadcasting, his last opinion for the court, Justice Brennan applied an intermediate standard of review, arguing that Congress's desire to promote broadcast opportunities for racial minority viewpoints was a legitimate and important government interest. Drawing heavily on Bakke, the court's landmark case on affirmative action in university admissions decisions, Justice Brennan wrote, Enhancing broadcast diversity is, at the very least, an important governmental objective and is therefore a sufficient basis for the Commission's minority ownership policies. Just as a diverse student body contributing to a robust exchange of ideas is a constitutionally permissible goal on which a race-conscious university admissions program may be predicated, the diversity of views and information on the airwaves serves important First Amendment values. The benefits of such diversity are not limited to the members of minority groups who gain access to the broadcasting industry by virtue of the ownership policies, rather, the benefits redound to all members of the viewing and listening audience. As Congress found, the American public will benefit by having access to a wider diversity of information sources. Justice John Paul Stevens, in his concurrence, distinguished more explicitly the remedial dimension from the diversity consideration. Today, the court squarely rejects the proposition that a governmental decision that rests on a racial classification is never permissible except as a remedy for a past wrong. I endorse this focus on the future benefit, rather than the remedial justification, of such decisions. I remain convinced, of course, that racial or ethnic characteristics provide a relevant basis for disparate treatment only in extremely rare situations, and that it is therefore especially important that the reasons for any such classification be clearly identified and unquestionably legitimate. The public interest in broadcast diversity, like the interest in an integrated police force, diversity in the composition of a public school faculty, or diversity in the student body of a professional school, is in my view unquestionably legitimate. Essentially, Justice Stevens was distinguishing historical race, remedial justification, and culture race, future benefit. Baki and Metro broadcasting notwithstanding, the court usually fails to include the positive aspects of black culture in its deliberations. Palmore v. Sidoti trademark is typical. In that case, the court unanimously rejected a Florida trial court's decision to modify a white mother's custody of her child after the mother married a black man. The court acknowledged that there was a risk that a child living with a step-parent of a different race may be subject to a variety of pressures and stresses not present if the child were living with parents of the same racial or ethnic origin, but nevertheless concluded that a court could not constitutionally consider such private biases. What the court, and most of the subsequent commentary on the decision, failed to consider was the possibility that a black stepfather might offer a positive value to the child beyond a caring home degree the child was to be raised in a bicultural environment. In that environment, the child had the possibility of being exposed not only to her mother's background but also to black culture in a way that the child could never have experienced in her biological father's home within her family environment. The child would have access to a rich life experience, one completely inaccessible in her father's household. The court simply lacked the imagination to consider and separate the subordination dimension of race, the historical race element that accounted for prejudice outside the home, from the positive concept of culture race. Such analysis is a difficult social enterprise and deserves case-by-case review, not a blanket rule that a court may never consider the effects of racism. 2. Assimilation and cultural genocide. Implicit in the colorblind assimilationist vision is a belief that, ultimately, race should have no real significance. Instead, it should be limited to the formal categories of white and black, unconnected to any social, economic, or cultural practice. However, if the underlying social reality of race is understood as encompassing one's social being, then an assimilationist goal that would abolish the significance of minority social categories has far-reaching repercussions. The successful abolition of black as a meaningful concept would require abolishing the distinctiveness that we attribute to black community, culture, and consciousness. The abolition of a people's culture is, by definition, cultural genocide. In short, assimilation as a societal goal has grave potential consequences for blacks and other non-whites. However utopian it appears, the colorblind assimilationist program implies the hegemony of white culture. 3. Colorblind tolerance and diversity as a social ideal. Tolerance is the acceptance of race as a necessary evil. Diversity, on the other hand, considers race to be a positive good. Tolerance seems closest to the approach of colorblind advocates such as Justice Scalia. However, Justice Scalia's comments seem more limited in scope and cynical in tone. He strongly asserts the constitutional limitations on those seeking an end to racism but offers nothing substantive as an alternative. In his City of Richmond v. J. A. Croson co-concurrence, Justice Scalia suggests that one should address the specifics of past discrimination in non-racial terms. He proposes the use of race-neutral remedial programs but offers no explanation as to how such a program would avoid the very problem to which it is addressed, the concentrations of black poverty and political powerlessness. Such programs either would be doomed to be ineffective solutions for blacks, or else would violate the intent standard of Washington v. Davis. In short, as a goal, tolerance fails to suggest a better society or improved social relations. Under the goal of racial diversity, racial distinctions would be maintained, but would lose their negative connotations. Each group would make a positive and unique contribution to the overall social good. The vision of diversity has significant, subtle limits. As normally articulated, diversity is premised on the existence of race as it now exists, as a conflation of subordination, black culture, and colorblind unconnectedness. Without more, diversity accepts the prevailing limits and social practices of race, including the hypodescent rule. The assumption that it is possible to identify racial classifications of black and white, to consider them apart from their social setting, and then to make those same racial categories the basis for positive social practice is unfounded. Without a clear social commitment to rethink the nature of racial categories and abolish their underlying structure of subordination, the politics of diversity will remain incomplete. The difficulty of transforming traditional racial categories into a positive construct can be seen in the construct of whiteness. A crucial dimension of whiteness is white racial privilege. Whiteness becomes a political issue where an entrenched position of dominance is challenged. A different dimension of whiteness is ethnic or national heritage. The immigrant origins of ethnic white European Americans are accepted and often embraced, though not always denominated as racial. Whiteness as racial dominance substantially overlaps, and sometimes supersedes, the ethnic experience. Indeed, some of the most deeply embedded explicit racial violence and assertions of racial inferiority have come from white ethnic enclaves. European ethnicity has a social existence apart from racial domination, but the separation of racial subordination from such ethnicity can be a complex political and social enterprise. Aside from European ethnicity, there are other cultural aspects of whiteness as racial domination. The Confederate flag is a complex symbol, but whiteness as domination is clearly a significant aspect of its symbolism. As representative of a Southern culture, the Confederate flag has provided a point of symbolic controversy as it flies over Southern state houses or is worn in schools or displayed in public. An unstated problem in these debates is that of cultural self-identification when one does not claim a particular ethnic identity. If one identifies oneself simply as a white American without any particular ethnic or racial identity, my suggested model of whiteness as reified racial privilege does not make available any particularized identity. A goal of public sphere diversity has its social price. Diversity in its narrow sense does not truly challenge existing racial practice but, rather, seeks to accommodate present racial divisions by casting them in a positive light. All too often, discussions of diversity do not address its central problem, the transformation of existing categories of domination into an altogether different, positive social formation. An alternative to colorblind. Constitutionalism. A. Minimal requirements for a revised approach to race. This article's central claim is that modern colorblind constitutionalism supports the supremacy of white interests and must therefore be regarded as racist. There is no legitimate rationale for the automatic rejection of all governmental consideration of race. However, strict scrutiny should not be abandoned altogether, given its efficacy as a weapon against segregation in years past. In particular, we shall see that a rhetoric of rights remains vital to the anti-racist struggle. This section, therefore, suggests some minimal requirements for an alternative constitutional approach to race. First, any revised approach to race and the Constitution must explicitly recognize that race is not a simple, unitary phenomenon. Rather, as discussed above, race is a unique social formation with its own meanings, understandings, discourses, and interpretive frameworks. As a socially constructed category with multiple meanings, race cannot be easily isolated from lived social experience. Moreover, race cannot legitimately be described and understood according to legal discourse. Any effort to understand its nature must go beyond legal formalism. Second, constitutional jurisprudence on race must accommodate legitimate governmental efforts to address white racial privilege. The Supreme Court must not only acknowledge the multiple dimensions of race in the abstract but also expressly permit the different aspects of race to be considered in judicial and legislative decisions. Further, any constitutional program must recognize the cultural genocide implicit in the development of a colorblind society and acknowledge the importance of Black culture, community, and consciousness. Because of a genuine concern that any change in doctrine may weaken the struggle against racial oppression, the court must maintain all existing constitutional protection for racial minorities against a resurgence of the white supremacist movement. Equal protection and due process should be buttressed as ideological and political barriers against Jim Crow and segregationist variations of white supremacy rather than transformed into barriers against legitimate government efforts to address racial subordination. Finally, a revised approach to race must recognize the systemic nature of subordination in American society. The Supreme Court's efforts to interpret the equal protection and due process clauses have addressed race, gender, sexuality, and class. To date, The court has regarded these phenomena as distinct, but racial subordination is inherently connected to other forms of subordination. The deep social context in which they are interwoven has begun to draw increasing attention. The free exercise and anti-establishment of religion, religion blindness, and color blindness. There is a body of constitutional doctrine that suggests a more subtle approach to constitutional review. The First Amendment religion clauses, the free exercise and establishment clauses provide a possible analogy accommodating some of the criteria outlined above when applied to race. The court's recent decisions on religion betray a qualitative difference between the court's attitudes toward religion and toward race. In church-state questions, the court has rejected a religion-blind standard for governmental activity. That is, the court recognizes the importance of religious affiliation to many Americans and does not see its goal as diminishing or eradicating the institution of religion in American life. While some have argued that religion blindness is the appropriate role for government, their arguments have not prevailed either in the public imagination or with the court. The court has instead proceeded along the two related lines dictated by the Constitution, promoting the free exercise of religion and preventing the establishment of any one religion. 273. These two approaches, while doctrinally distinct and separately discussed in judicial opinions, are logically linked as theoretical opposites. For example, where religious establishment is alleged, such as when Christian prayers are said in public schools, a corresponding free exercise problem exists. Students of other religions are prevented from exercising their own faiths during prayer time. Registered similarly, a free exercise issue such as the use of peyote in ceremonies of the Native American Church, involves the establishment of traditional religion, where the use of peyote warrants criminal penalties. The free exercise cases are informed by the attitude that religion and religious practice are important and valuable aspects of human experience. B. Religion jurisprudence as a model for race jurisprudence. The free exercise and establishment clause decisions provide a model for constitutional adjudication in the area of race to supplant the color-blind model. The race jurisprudence of the Supreme Court contains only an inkling of the deference found in its religion jurisprudence. Once we appreciate the complex and socially embedded character of race, however, we may view the concerns and considerations involved in judicial review of racial decision-making as being similar to those involved in interpreting the religion clauses. If the religion cases are intellectually or emotionally unsatisfying, they at least represent a serious effort by the court to address a complex of social issues with nuanced, historically grounded legal distinctions. Once the historical context of racial subordination has been acknowledged, remedies that explicitly consider race become constitutionally possible. Instead of a constricted discourse on the legitimacy of the use of race, a more measured discussion of the proper standard of review becomes possible. Issues of racial remedies, like decisions about the relationship between church and state, can then be discussed as policy decisions rather than as complex studies of judicial review of the democratic process. Culture race, with its wide range of social and cultural references, makes possible a form of free exercise of the positive aspects of race, recognizing black and white cultures as legitimate aspects of the American social fabric. Further, free exercise of race would allow, within appropriate limits, open discussion and implementation of governmental remedies to address the historical legacy of racial discrimination. Also protected will be the culture, community, and consciousness of American racial minorities. European American cultures would also be recognized and respected, of course, even though their existence has not been challenged in the same manner as black culture. Just as permitting the free exercise of religion is, in theory, not an endorsement of any one religion but, rather, only a recognition of respect for the practice of religion, so the free exercise of culture race would not be an endorsement of racism. There is also an establishment analog for race. What is impermissible, what the government may not establish, is racial subordination and white supremacy, the use of either status race or formal race to establish domination, hierarchy, and exploitation. The paired considerations of racial establishment and free exercise are mixed in our social existence. The free exercise of some aspects of a white culture may overlap or coincide with racial domination, as with the attachment of many white Southerners to the Confederate flag. Efforts to abolish domination will, therefore, interfere with the free exercise of race in such instances. The suggestion from the religion cases about how to approach this conflict is that the two discussions of racial subordination and of black culture can be considered together. Any problem should be addressed in its particular context, without the doctrinal compulsion to satisfy all aspects of either racial subordination or respect for racial ethnic culture. 6 Con Nclusion. B** returning to strict scrutiny as the sole equal protection principle for racial judicial review, the colorblind constitutionalists would have the Supreme Court risk perpetuating racism and undermining its own legitimacy. This article invokes a parallel between the modern civil rights movement and the first Reconstruction. The Supreme Court's civil rights decisions of 1989 are the equivalent of the Compromise of 1877, which ended the first Reconstruction. By fixating on formal race and ignoring the reality of racial subordination, the court, in this second post-Reconstruction era, risks establishing a new equivalent of Plessy v. Ferguson. There is, however, a second parallel for the court. The greater danger for the current court is that it will face the loss of legitimacy which confronted the Taney court after Dred Scott. The United States is entering a period of cultural diversity more extensive than any in its history. In the past, white racial hegemony went essentially unchallenged. The court today faces a far more complex set of issues. Whatever the validity in 1896 of Justice Harlan's comment in Plessy that our Constitution is colorblind, the concept is inadequate to deal with today's racially stratified, culturally diverse, and economically divided nation. The court must either develop new perspectives on race and culture, or run the risk of losing legitimacy and relevance in a crucial arena of social concern. Whiteness as property. Cheryl I. Harris. She walked into forbidden worlds impaled on the weapon of her own pale skin. She was a sentinel at impromptu planning sessions of her own destruction. Cheryl I. Harris, Poem for Alma. Petitioner was a citizen of the United States and a resident of the state of Louisiana of mixed descent, in the proportion of 7/8 Caucasian and 1/8 African blood, that the mixture of colored blood was not discernible in him, and that he was entitled to every recognition, right, privilege, and immunity secured to the citizens of the United States of the white race by its Constitution and laws, and thereupon entered a passenger train and took possession of a vacant seat in a coach where passengers of the white race were accommodated. Plessy v. Ferguson. Introduction. And the 30s, some years after my mother's family became part of the great river of black migration that flowed north, my Mississippi-born grandmother was confronted with the harsh matter of economic survival for herself and her two daughters. Having separated from my grandfather, who himself was trapped on the fringes of economic marginality, she took one long hard look at her choices and presented herself for employment at a major retail store in Chicago's central business district. This decision would have been unremarkable for a white woman in similar circumstances, but for my grandmother it was an act of both great daring and self-denial, for in so doing she was presenting herself as a white woman. In the parlance of racist America, she was passing. Her fair skin, straight hair, and aquiline features had not spared her from the life of sharecropping into which she had been born in Anywhere/Nowhere, Mississippi, the outskirts of Yazoo City. In the burgeoning landscape of urban America, though, anonymity was possible for a black person with white features. She was transgressing boundaries, crossing borders, spinning on margins, traveling between dualities of Manichean space, rigidly bifurcated into light/dark, good/bad, white/black. No longer immediately identifiable as Lula's daughter, she could thus enter the white world, albeit on a false passport, not merely passing but trespassing. Every day my grandmother rose from her bed in her house in a black enclave on the south side of Chicago, sent her children off to a black school, boarded a bus full of black passengers, and rode to work. No one at her job ever asked if she was black. The question was unthinkable. By virtue of the employment practices of the fine establishment in which she worked, she could not have been catering to the upper middle class. Understated tastes required that blacks not be allowed. She quietly went about her clerical tasks, not once revealing her true identity. She listened to the women with whom she worked discuss their worries, their children's illnesses, their husbands' disappointments, their boyfriends' infidelities, all of the mundane yet critical things that made up their lives. She came to know them, but they did not know her, for my grandmother occupied a completely different place. That place where white supremacy and economic domination meet was unknown turf to her white co-workers. They remained oblivious to the worlds within worlds that existed just beyond the edge of their awareness and yet were present in their very midst. Each evening, my grandmother, tired and worn, retraced her steps home, laid aside her mask, and re-entered herself. Day in and day out, she made herself invisible, then visible again, for a price too inconsequential to do more than barely sustain her family and at a cost too precious to conceive. She left the job some years later, finding the strain too much to bear. From time to time, as I later sat with her, she would recollect that period, and the cloud of some painful memory would pass across her face. Her voice would remain subdued, as if to contain the still remembered tension. On rare occasions, she would wince, recalling some particularly racist comment made in her presence because of her presumed shared group affiliation. Whatever retort might have been called for had been suppressed long before it reached her lips, for the price of her family's well-being was her silence. Accepting the risk of self-annihilation was the only way to survive. Although she never would have stated it this way, the clear and ringing denunciations of racism she delivered from her chair when advanced arthritis had rendered her unable to work were informed by those experiences. The fact that self-denial had been a logical choice and had made her complicit in her own oppression at times fed the fire in her eyes when she confronted some daily outrage inflicted on black people. Later, these painful memories forged her total identification with the civil rights movement. Learning about the world at her knee as I did, these experiences also came to inform my outlook and my understanding of the world. My grandmother's story is far from unique. Indeed, there are many who crossed the color line never to return. Passing is well known among black people in the United States. It is a feature of race subordination in all societies structured on white supremacy. Notwithstanding the purported benefits of black heritage in an era of affirmative action, passing is not an obsolete phenomenon that has slipped into history. The persistence of passing is related to the historical and continuing pattern of white racial domination and economic exploitation, which has invested passing with a certain economic logic. It was a given for my grandmother that being white automatically ensured higher economic returns in the short term and greater economic, political, and social security in the long run. Becoming white meant gaining access to a whole set of public and private privileges that materially and permanently guaranteed basic subsistence needs and, therefore, survival. Becoming white increased the possibility of controlling critical aspects of one's life rather than being the object of others' domination. My grandmother's story illustrates the valorization of whiteness as treasured property in a society structured on racial caste. In ways so embedded that it is rarely apparent, the set of assumptions, privileges, and benefits that accompany the status of being white have become a valuable asset, one that whites sought to protect and those who passed sought to attain, by fraud if necessary. Whites have come to expect and rely on these benefits, and over time these expectations have been affirmed, legitimate, and protected by the law. Even though the law is neither uniform nor explicit in all instances, in protecting settled expectations based on white privilege, American law has recognized a property interest in whiteness that, although unacknowledged, now forms the background against which legal disputes are framed, argued, and adjudicated. This article investigates the relationships between concepts of race and property, and it reflects on how rights in property are contingent on, intertwined with, and conflated with race. Through this entangled relationship between race and property, historical forms of domination have evolved to reproduce subordination in the present. The construction of race and the emergence of whiteness as property. racialization of identity and the racial subordination of blacks and Native Americans provided the ideological basis for slavery and conquest. Although the systems of oppression of blacks and Native Americans differed in form, the former involving the seizure and appropriation of labor, the latter entailing the seizure and appropriation of land, undergirding both was a racialized conception of property implemented by force and ratified by law. The origins of property rights in the United States are rooted in racial domination. Even in the early years of the country, it was not the concept of race alone that operated to oppress blacks and Indians, rather, it was the interaction between conceptions of race and property which played a critical role in establishing and maintaining racial and economic subordination. The hyper-exploitation of black labor was accomplished by treating black people themselves as objects of property. Race and property were thus conflated by establishing a form of property contingent on race. Only blacks were subjugated as slaves and treated as property. Similarly, the conquest, removal, and extermination of Native American life and culture were ratified by conferring and acknowledging the property rights of whites in Native American land. Only white possession and occupation of land was validated and therefore privileged as a basis for property rights. These distinct forms of exploitation each contributed in varying ways to the construction of whiteness as property. A. Forms of racialized property, relationships between slavery, race, and property. The convergence of racial and legal status. Although the early colonists were cognizant of race, racial lines were neither consistently nor sharply delineated among or within all social groups. Captured Africans sold in the Americas were distinguished from the population of indentured or bond servants on free white labor, but it was not an irrebuttable presumption that all Africans were slaves, or that slavery was the only appropriate status for them. The distinction between African and white indentured labor grew, however, as decreasing terms of service were introduced for white bond servants. Simultaneously, the demand for labor intensified, resulting in a greater reliance on African labor and a rapid increase in the number of Africans imported to the colonies. The construction of white identity and the ideology of racial hierarchy were intimately tied to the evolution and expansion of the system of chattel slavery. The further entrenchment of plantation slavery was in part an answer to a social crisis produced by the eroding capacity of the landed class to control the white labor population. The dominant paradigm of social relations, however, was that while not all Africans were slaves, virtually all slaves were not white. It was their racial otherness that came to justify the subordinated status of blacks. The result was a classification system that keyed official rules of descent to national origin, so that membership in the new social category of Negro became itself sufficient justification for enslavability. Although the cause of the increasing gap between the status of African and white labor is contested by historians, it is clear that the economic and political interests defending black slavery were far more powerful than those defending indentured servitude. By the 1660s, the especially degraded status of blacks as chattel slaves was recognized by law. Between 1680 and 1682, the first slave codes appeared, enshrining the extreme deprivations of liberty already existing in social practice. Many laws parceled out differential treatment based on racial categories. Blacks were not permitted to travel without permits, to own property, to assemble publicly, or to own weapons, nor were they to be educated. Racial identity was further merged with stratified social and legal status. Black racial identity marked who was subject to enslavement, whereas white racial identity marked who was free or, at minimum, not a slave. The ideological and theoretical move from slave and free to black and white as polar constructs marked an important step in the social construction of race. Two implications for property: the social relations that produced racial identity as a justification for slavery also had implications for the conceptualization of property. This result was predictable, as the institution of slavery, lying at the very core of economic relations, was bound up with the idea of property. Through slavery, race and economic domination were fused. Slavery produced a peculiar, mixed category of property and humanity, a hybrid with inherent instabilities that were reflected in its treatment and ratification by the law. The dual and contradictory character of slaves as property and persons was exemplified in the Representation Clause of the Constitution. Representation in the House of Representatives was apportioned on the basis of population computed by counting all persons and 3/5 of all other persons slaves. Gouverneur Morris's remarks. Before the Constitutional Convention posed the essential question, upon what principle is it that slaves shall be computed in the representation? Are they men? Then make them citizens and let them vote. Are they property? Why then is no other property included? The cruel tension between property and humanity was also reflected in the law's legitimation of the use of black women's bodies as a means of increasing property. Registered in 1662, the Virginia Colonial Assembly provided that children got by an Englishman upon a Negro woman shall be bond or free according to the condition of the mother. In reversing the usual common law presumption that the status of the child was determined by the father, the rule facilitated the reproduction of one's own labor force. Because the children of black women assumed the status of their mother, slaves were bred through black women's bodies. The economic significance of this form of exploitation of female slaves should not be underestimated. Despite Thomas Jefferson's belief that slavery should be abolished, like other slaveholders, he viewed slaves as economic assets, noting that their value could be realized more efficiently from breeding than from labor. A letter he wrote in 1805 stated, "I consider the labor of a breeding woman as no object, and that a child raised every 2 years is of more profit than the crop of the best laboring man." Registered even though there was some unease in slave law, reflective of the mixed status of slaves as humans and property, the critical nature of social relations under slavery was the commodification of human beings. Productive relations in early American society included varying forms of sale of labor capacity, many of which were highly oppressive, but slavery was distinguished from other forms of labor servitude by its permanency and the total commodification attendant to the status of the slave. Slavery as a legal institution treated slaves as property that could be transferred, assigned, inherited, or posted as collateral. For example, in Johnson v. Butler, the plaintiff sued the defendant for failing to pay a debt of $496 on a specified date. Because the covenant had called for payment of the debt in money or Negroes, the plaintiff contended that the defendant's tender of one Negro only, although valued by the parties at an amount equivalent to the debt, could not discharge the debt. The court agreed with the plaintiff. This use of Africans as a stand-in for actual currency highlights the degree to which slavery propertized human life. Because the presumption of freedom arose from color white and the black color of the race raised the presumption of slavery, whiteness became a shield from slavery, a highly volatile and unstable form of property. In the form adopted in the United States, slavery made human beings market alienable and in so doing, subjected human life and personhood that which is most valuable to the ultimate devaluation. Because whites could not be enslaved or held as slaves, the racial line between white and black was extremely critical. It became a line of protection and demarcation from the potential threat of commodification, and it determined the allocation of the benefits and burdens of this form of property. White identity and whiteness were sources of privilege and protection, their absence meant being the object of property. Slavery as a system of property facilitated the merger of white identity and property. Because the system of slavery was contingent on and conflated with racial identity, it became crucial to be white, to be identified as white, to have the property of being white. Whiteness was the characteristic, the attribute, the property of free human beings. B. Critical characteristics of property and whiteness. Whiteness as a traditional form of property. Whiteness fits the broad historical concept of property described by classical theorists. In James Madison's view, for example, property embraces everything to which a man may attach a value and have a right, referring to all of a person's legal rights. Property as conceived in the founding era included not only external objects and people's relationships to them, but also all of those human rights, liberties, powers, and immunities that are important for human 280. Well-being, including freedom of expression, freedom of conscience, freedom from bodily harm, and free and equal opportunities to use personal faculties. Whiteness defined the legal status of a person as slave or free. White identity conferred tangible and economically valuable benefits, and it was jealously guarded as a valued possession, allowed only to those who met a strict standard of proof. Whiteness. The right to white identity as embraced by the law is property, if by property one means all of a person's legal rights. Other traditional theories of property emphasize that the natural character of property is derivative of custom, contrary to the notion that property is the product of a delegation of sovereign power. This bottom-up theory holds that the law of property merely codifies existing customs and social relations. Under that view, government-created rights such as social welfare payments cannot constitute legitimate property interests because they are positivistic in nature. Other theorists have challenged this conception, and argued that even the most basic of customary property rights, the rule of first possession, for example, is dependent on its acceptance or rejection in particular instances by the government. Citing custom as a source of property law begs the central question: whose custom? Rather than remaining within the bipolar confines of custom or command, it is crucial to recognize the dynamic and multifaceted relationship among custom, command, and law, as well as the extent to which positionality determines how each may be experienced and understood. Indian custom was obliterated by force and replaced with the regimes of common law which embodied the customs of the conquerors. The assumption of American law as it related to Native Americans was that conquest did give rise to sovereignty. Indians experienced the property laws of the colonizers and the emergent American nation as acts of violence perpetuated by the exercise of power and ratified through the rule of law. At the same time, these laws were perceived as custom and common sense by the colonizers. The founders, for instance, so thoroughly embraced Lockean labor theory as the basis for a right of acquisition because it affirmed the right of the New World settlers to settle on and acquire the frontier. It confirmed and ratified their experience. The law's interpretation of those encounters between whites and Native Americans not only inflicted vastly different results on them but also established a pattern, a custom of valorizing whiteness. As the forms of racialized property were perfected, the value and protection extended to whiteness increased. Regardless of which theory of property one adopts, the concept of whiteness established by centuries of custom, illegitimate custom, but custom nonetheless, and codified by law may be understood as a property interest. 2. Property and expectations. Property is nothing but the basis of expectation, according to Jeremy Bentham, consisting in an established expectation, in the persuasion of being able to draw such and such advantage from the thing possessed. The relationship between expectations and property remains highly significant, as the law has recognized and protected even the expectation of rights as actual legal property. This theory does not suggest that all values or all expectations give rise to property, but those expectations in tangible or intangible things which are valued and protected by the law are property. In fact, the difficulty lies not in identifying expectations as a part of property but, rather, in distinguishing which expectations are reasonable and therefore merit the protection of the law as property. Although the existence of certain property rights may seem self-evident, and the protection of certain expectations may seem essential for social stability, property is a legal construct by which selected private interests are protected and upheld. In creating property rights, the law draws boundaries and enforces or reorders existing regimes of power. The inequalities that are produced and reproduced are not givens or inevitabilities, rather, they are conscious selections regarding the structuring of social relations. In this sense, it is contended that property rights and interests are not natural but creations of law. In a society structured on racial subordination, white privilege became an expectation and, to apply Margaret Radin's concept, whiteness became the quintessential property for personhood. The law constructed whiteness as an objective fact, although in reality it is an ideological proposition imposed through subordination. This move is the central feature of reification. Its basis is that a relation between people takes on the character of a thing and thus acquires a phantom objectivity, an autonomy that seems so strictly rational and all-embracing as to conceal every trace of its fundamental nature, the relation between people. Whiteness was an object over which continued control was an i.e. expected : because the law recognized and protected expectations grounded in white privilege, albeit not explicitly in all instances, these expectations became tantamount to property that could not permissibly be intruded upon without consent. As the law explicitly ratified those expectations in continued privilege or extended ongoing protection to those illegitimate expectations by failing to expose or to disturb them radically, the dominant and subordinate positions within the racial hierarchy were reified in law. When the law recognizes, either implicitly or explicitly, the settled expectations of whites built on the privileges and benefits produced by white supremacy, it acknowledges and reinforces a property interest in whiteness that reproduces black subordination. 3. The property functions of whiteness. In addition to the theoretical descriptions of property, whiteness also meets the functional criteria of property. Specifically, the law has accorded holders of whiteness the same privileges and benefits accorded holders of other types of property. The liberal view of property is that it includes the exclusive rights of possession, use, and disposition. Its attributes are the right to transfer or alienability, the right to use and enjoyment, and the right to exclude others. Even when examined against this limited view, whiteness conforms to the general contours of property. It may be a bad form of property, but it is property nonetheless. A. Rights of disposition. Property rights are traditionally described as fully alienable. Because fundamental personal rights are commonly understood to be inalienable, it is problematic to view them as property interests. However, as Margaret Radin notes, inalienability is not a transparent term. It has multiple meanings that refer to interests that are non-saleable, non-transferable, or non-market alienable. The common core of inalienability is the negation of the possibility of separation of an entitlement, right, or attribute from its holder. Classical theories of property identified alienability as a requisite aspect of property, thus, that which is inalienable cannot be property. As the major exponent of this view, John Stuart Mill argued that public offices, monopoly privileges, and human beings, all of which were or should have been inalienable, should not be considered property at all. Under this account, if inalienability inheres in the concept of property, then whiteness, incapable of being transferred or alienated either inside or outside the market, would fail to meet a criterion of property. As Radin notes, however, even under the classical view, alienability of certain property was limited. Mill also advocated certain restraints on alienation in connection with property rights in land and, probably, other natural resources. In fact, the law has recognized various kinds of inalienable property. For example, entitlements of the regulatory and welfare states, such as transfer payments and government licenses, are inalienable, yet they have been conceptualized and treated as property by law. Although this new property has been criticized as being improper that once, not appropriately cast as property, the principal objection has been based on its alleged lack of productive capacity, not on its inalienability. The law has also acknowledged forms of inalienable property derived from non-governmental sources. In the context of divorce, courts have held that professional degrees or licenses held by one party and financed by the labor of the other is marital property whose value is subject to allocation by the court. A medical or law degree is not alienable either in the market or by voluntary transfer. Nevertheless, it is included as property when dissolving a legal relationship. Indeed, Radin argues that as a deterrent to the dehumanization of universal commodification, market inalienability may be justified to protect property important to the person and to safeguard human flourishing. She suggests that non-commodification or market inalienability of personal property or those things essential to human flourishing is necessary to guard against the objectification of human beings. To avoid that danger, we must cease thinking that market alienability is inherent in the concept of property. Following this logic, then, the inalienability of whiteness should not preclude the consideration of whiteness as property. Paradoxically, its inalienability may be more indicative of its perceived enhanced value rather than of its disqualification as property. b. Right to use and enjoyment. Possession of property includes the rights of use and enjoyment. If these rights are essential aspects of property, it is because the problem of property in political philosophy dissolves into questions of the will and the way in which we use the things of this world. As whiteness is simultaneously an aspect of identity and a property interest, it is something that can both be experienced and deployed as a resource. Whiteness can move from being a passive characteristic as an aspect of identity to an active entity that, like other types of property, is used to fulfill the will and to exercise power. The state's official recognition both of a racial identity that subordinated blacks and of privileged rights in property based on race, elevated whiteness from a passive attribute to an object of law and a resource deployable at the social, political, and institutional level to maintain control. Thus, a white person used and enjoyed whiteness whenever she took advantage of the privileges accorded white people simply by virtue of their whiteness. When she exercised any number of rights reserved for the holders of whiteness. Whiteness as the embodiment of white privilege transcended mere belief or preference, it became usable property, the subject of the law's regard and protection. In this respect, whiteness, as an active property, has been used and enjoyed. c. The conception of reputation as property found its origins in early concepts of property which encompassed things, such as land and personality, income, such as revenues from leases, mortgages, and patent monopolies, and one's life, liberty, and labor. The idea of self-ownership, then, was particularly fertile ground for the idea that reputation, as an aspect of identity earned through effort, was similarly property. Moreover, the loss of reputation was capable of being valued in the market. The direct manifestation of the law's legitimation of whiteness as reputation is revealed in the well-established doctrine that to call a white person black is to defame her. Registered although many of the cases were decided in an era when the social and legal stratification of whites and blacks was more absolute, as late as 1957 the principle was reaffirmed, notwithstanding significant changes in the legal and political status of blacks. As one court noted, there is still to be considered the social distinction existing between the races, and the allegation was likely to cause injury. 1 degree. A black person, however, could not sue for defamation if she was called white. Because the law expressed and reinforced the social hierarchy as it existed, it was presumed that no harm could flow from such a reversal. Private identity based on racial hierarchy was legitimate as public identity in law. Even after the end of slavery and the formal end of legal race segregation. Whiteness as interpersonal hierarchy was recognized externally as race reputation. Thus, whiteness as public reputation and personal property was affirmed. The absolute right to exclude. Many theorists have traditionally conceptualized property as including the exclusive rights of use, disposition, and possession, with possession embracing the absolute right to exclude. The right to exclude was the central principle, too, of whiteness as identity, for whiteness in large part has been characterized not by an inherent unifying characteristic but by the exclusion of others deemed to be not white. The possessors of whiteness were granted the legal right to exclude others from the privileges inhering in whiteness. Whiteness became an exclusive club whose membership was closely and grudgingly guarded. The courts played an active role in enforcing this right to exclude, determining who was or was not white enough to enjoy the privileges accompanying whiteness. In that sense, the courts protected whiteness as they did any other form of property. Moreover, as it emerged, the concept of whiteness was premised on white supremacy rather than on mere difference. White was defined and constructed in ways that increased its value by reinforcing its exclusivity. Indeed, just as whiteness as property embraced the right to exclude, whiteness as a theoretical construct evolved for the very purpose of racial exclusion. Thus, the concept of whiteness is built on exclusion and racial subjugation. This fact was particularly evident during the period of the most rigid racial exclusion, for whiteness signified racial privilege and took the form of status property. At the individual level, recognizing oneself as white necessarily assumes premises based on white supremacy. It assumes that black ancestry in any degree, extending to generations far removed, automatically disqualifies claims to white identity, thereby privileging white as unadulterated, exclusive, and rare. Inherent in the concept of being white was the right to own or hold whiteness to the exclusion and subordination of blacks. Because identity is, continuously being constituted through social interactions, the assigned political, economic, and social inferiority of blacks necessarily shaped white identity. In the commonly held popular view, the presence of black blood, including the infamous one drop, consigned a person to being black and evoked the metaphor of purity and contamination, in which black blood is a contaminant and white racial identity is pure. Recognizing or identifying oneself as white is thus a claim of racial purity, an assertion that one is free of any taint of black blood. The law has played a critical role in legitimating this claim. See white legal identity. The law's acceptance and legitimation of the law assumed the crucial task of racial classification, and accepted and embraced the then current theories of race as biological fact. This core precept of race as a physically defined reality allowed the law to fulfill an essential function to parcel out social standing according to race and to facilitate systematic discrimination by articulating seemingly precise definitions of racial group membership. This allocation of race and rights continued a century after the abolition of slavery. The law relied on bounded, objective, and scientific definitions of race, what Neil Gotanda has called historical race, to construct whiteness as not merely race, but race plus privilege. By making race determinant and the product of rationality and science, dominant and subordinate positions within the racial hierarchy were disguised as the product of natural law and biology rather than as naked preferences. Whiteness as racialized privilege was then legitimate by science and was embraced in legal doctrine as objective fact. Case law that attempted to define race frequently struggled over the precise fractional amount of black blood, traceable black ancestry, that would defeat a claim to whiteness. Although the courts applied varying fractional formulas in different jurisdictions to define black or, in the terms of the day, Negro or colored, the law uniformly accepted the rule of hypodescent, degree racial identity was governed by blood, and white was preferred. This legal assumption of race as bloodborne was predicated on the pseudosciences of eugenics and craniology, which saw their major development during the 18th and 19th centuries. The legal definition of race was the objective test propounded by racist theorists of the day, who described race to be immutable, scientific, biologically determined and unsullied fact of the blood rather than a volatile and violently imposed regime of racial hierarchy. In adjudicating who was white, courts sometimes noted that, by physical characteristics, the individual whose racial identity was at issue appeared to be white and, in fact, had been regarded as white in the community. Yet if an individual's blood was tainted, she could not claim to be white as the law understood, regardless of the fact that phenotypically she may have been completely indistinguishable from a white person, may have lived as a white person, and may have descended from a family that lived as whites. Although socially accepted as white, she could not legally be white. Blood as objective fact predominated over appearance and social acceptance, which were socially fluid and subjective measures. In fact, though, blood was no more objective than that which the law dismissed as subjective and unreliable. The acceptance of the fiction that the racial ancestry could be determined with the degree of precision called for by the relevant standards or definitions rested on false assumptions that racial categories of prior ancestors had been accurately reported, that those reporting in the past shared the definitions currently in use, and that racial purity actually existed in the United States. Ignoring these considerations, the law established rules that extended equal treatment to those of the same blood, albeit of different complexions, because it was acknowledged that, here are white men as dark as mulattoes, and there are pure-blooded albino Africans as white as the whitest Saxons. 7. The standards were designed to accomplish what mere observation could not, that even blacks who did not look black were kept in their place. Although the line of demarcation between black and white varied from rules that classified as black a person containing any drop of black blood to more liberal rules that defined persons with a preponderance of white blood to be white, the courts universally accepted the notion that white status was something of value that could be accorded only to those persons whose proofs established their whiteness as defined by the law, because legal recognition of a person as white carried material benefits. False or inadequately supported claims were denied like any other unsubstantiated claim to a property interest. Only those who could lay legitimate claims to whiteness could be legally recognized as white, because allowing physical attributes, social acceptance, or self-identification to determine whiteness would diminish its value and destroy the underlying presumption of exclusivity. In effect, the courts erected legal no trespassing signs. In the realm of social relations, racial recognition in the United States is thus an act of race subordination. In the realm of legal relations, judicial definition of racial identity based on white supremacy reproduced that race subordination at the institutional level. In transforming white to whiteness, the law masked the ideological content of racial definition and the exercise of power required to maintain it. It converted an abstract concept into an entity. To whiteness as racialized privilege, the material benefits of racial exclusion and subjugation functioned, in the labor context, to stifle class tensions among whites. White workers perceived that they had more in common with the bourgeoisie than with fellow workers who were black. Thus, W.E.B. Du Bois' classic historical study of race and class, Black Reconstruction * registered noted that, for the evolving white working class, race identification became crucial to the ways that it thought of itself and conceived its interests. There were, he suggested, obvious material benefits, at least in the short term, to the decision of white workers to define themselves by their whiteness. Their wages far exceeded those of blacks and were high even in comparison with world standards. Moreover, even when the white working class did not collect increased pay as part of white privilege, there were real advantages not paid in direct income. Whiteness still yielded what Du Bois termed a public and psychological wage vital to white workers. Thus, Du Bois noted that whites were given public deference. Because they were white, they were admitted freely with all classes of white people, to public functions, to public parks. The police were drawn from their ranks, and the courts, dependent on their votes, treated them with leniency. Their votes elected public officials, and while this had small effect upon the economic situation, it had great effect on their personal treatment. White schoolhouses were the best in the community, and conspicuously placed, and they cost anywhere from 2 to 10 times as much per capita as the colored schools. Registered, the central feature of the convergence of white and worker lay in the fact that racial status and privilege could ameliorate and assist in evading rather than confronting class exploitation. Although not accorded the privileges of the ruling class, in both the North and South, white workers could accept their lower class position in the hierarchy by fashioning identities as not slaves and as not blacks. Degree whiteness produced and was reproduced by the social advantage that accompanied it. Whiteness was also central to national identity and to the Republican project. The amalgamation of various European strains into an American identity was facilitated by an oppositional definition of black as other. As Andrew Hacker suggests, fundamentally, the question was not so much who is white but, rather, who may be considered white, for the historical pattern was that various immigrant groups of different ethnic origins were accepted into a white identity shaped around Anglo-American norms. Current members then ponder whether they want or need new members as well as the proper pace of new admissions into this exclusive club. Through minstrel shows in which white actors masquerading in blackface played out racist stereotypes, the popular culture put the black at solo spot center stage, providing a relational model in contrast to which masses of Americans could establish a positive and superior sense of identity. 1. Established by an infinitely manipulable negation comparing whites with a construct of a socially defenseless group. It is important to note the effect of this hypervaluation of whiteness. Owning white identity as property affirmed the self-identity and liberty of whites and, conversely, denied the self-identity and liberty of blacks. The attempts to lay claim to whiteness through passing painfully illustrate the effects of the law's recognition of whiteness. The embrace of a lie, undertaken by my grandmother and the thousands like her, could occur only when oppression makes self-denial and the obliteration of identity rational and, in significant measure, beneficial. The economic coercion of white supremacy on self-definition nullifies any suggestion that passing is a logical exercise of liberty or self-identity. The decision to pass as white was not a choice, if by that word one means voluntariness or lack of compulsion. The fact of race subordination was coercive, and it circumscribed the liberty to define oneself. Self-determination of identity was not a right for all people but a privilege accorded on the basis of race. The effect of protecting whiteness at law was to devalue those who were not white by coercing them to deny their identity in order to survive. Whiteness, rights, and national identity. The concept of whiteness was carefully protected because so much was contingent upon it. Whiteness conferred on its owners aspects of citizenship which were all the more valued because they were denied to others. Indeed, the very fact of citizenship itself was linked to white racial identity. The Naturalization Act of 1790 restricted citizenship to persons who resided in the United States for 2 years, who could establish their good character in court, and who were white. Moreover, the trajectory of expanding democratic rights for whites was accompanied by the contraction of the rights of blacks in an ever-deepening cycle of oppression. The franchise, for example, was broadened to extend voting rights to unpropertied white men. At the same time that black voters were specifically disenfranchised, arguably shifting the property required for voting from land to whiteness. This racialized version of republicanism, this Herrenvolk republicanism, constrained any vision of democracy from addressing the class hierarchies adverse to many who considered themselves white. The inherent contradiction between the bondage of blacks and Republican rhetoric that championed the freedom of all men was resolved by positing that blacks were different. The laws did not mandate that blacks be accorded equality under the law because nature, not man, not power, not violence had determined their degraded status. Rights were for those who had the capacity to exercise them, a capacity denoted by racial identity. This conception of rights was contingent on race, on whether one could claim whiteness a form of property. This articulation of rights that were contingent on property ownership was a familiar paradigm, as similar requirements had been imposed on the franchise in the early part of the Republic. For the first 200 years of the country's existence, the system of racialized privilege in the public and private spheres carried through this linkage of rights and inequality, of rights and property. Whiteness as property was the critical core of a system that affirmed the hierarchical relations between white and black. 3. The persistence of whiteness as property. A. The persistence of whiteness as valued social identity. Even as the capacity of whiteness to deliver is arguably diminished by the elimination of rigid racial stratifications, whiteness continues to be perceived as materially significant. Because real power and wealth never have been accessible to more than a narrowly defined ruling elite, for many whites the benefits of whiteness as property, in the absence of legislated privilege, may have been reduced to a claim of relative privilege only in comparison to people of color. Nevertheless, whiteness retains its value as a consolation prize. It does not mean that all whites will win, but simply that they will not lose, if losing is defined as being on the bottom of the social and economic hierarchy, the position to which blacks have been consigned. Andrew Hacker, in his 1992 book Two Nations *, recounts the results of a recent exercise that probed the value of whiteness according to the perceptions of whites. The study asked a group of white students how much money they would seek if they were changed from white to black. Most seemed to feel that it would not be out of place to ask for $50 million, or $1 million for each coming black year. Whether this figure represents an accurate amortization of the societal cost of being black in the United States, it is clear that whiteness is still perceived to be valuable. The wages of whiteness are available to all whites, regardless of class position, even to those whites who are without power, money, or influence. Whiteness, the characteristic that distinguishes them from blacks, serves as compensation even to those who lack material wealth. It is the relative political advantages extended to whites, rather than actual economic gains, that are crucial to white workers. Thus, as Kimberly Crenshaw points out, whites have an actual stake in racism because blacks are held to be inferior, although no longer on the basis of science as antecedent determinant but, rather, by virtue of their position at the bottom. It allows all whites to include themselves in the dominant circle. Although most whites hold no real power, all can claim their privileged racial identity. White workers often identify themselves primarily as white rather than as workers because it is through their whiteness that they are afforded access to a host of public, private, and psychological benefits. It is through the concept of whiteness that class consciousness among white workers is subordinated and attention is diverted from class oppression. Although dominant societal norms have embraced the ideas of fairness and non-discrimination, removal of privilege and anti-subordination principles are actively rejected or at best ambiguously received, because expectations of white 287 privilege are bound up with what is considered essential for self-realization. Among whites, the idea persists that their whiteness is meaningful. Whiteness is an aspect of racial identity surely, but it is much more. It remains a concept based on relations of power, a social construct predicated on white dominance and black subordination. b. Subordination through denial of group identity. Whiteness as property is also constituted through the reification of expectations in the continued right of white-dominated institutions to control the legal meaning of group identity. This reification manifests itself in the law's dialectical misuse of the concept of group identity as it pertains to racially subordinated peoples. The law has recognized and codified racial group identity as an instrument of exclusion and exploitation. However, it has refused to recognize group identity when asserted by racially oppressed groups as a basis for affirming or claiming rights. The law's approach to group identity reproduces subordination, in the past through racing a group, that is, by assigning a racial identity that equated with inferior status, and, in the present, by erasing racial group identity. In part, the law's denial of the existence of racial groups is not only predicated on the rejection of the ongoing presence of the past, but it is also grounded on a basic tenet of liberalism that constitutional protections inhere in individuals, not in groups. As informed by the Lockean notion of the social contract, the autonomous, free will of the individual is central. Indeed, it is the individual who, in concert with other individuals, elects to enter into political society and to form a state of limited powers. This philosophical view of society is closely aligned with the anti-discrimination principle, the idea being that equality mandates only the equal treatment of individuals under the law. Within this framework, the idea of the social group has no place. Although the law's determination of any fact, including that of group identity, is not infinitely flexible, its studied ignorance of the issue of racial group identity ensures wrong results by assuming a pseudo-objective posture that does not permit it to hear the complex dialogue concerning identity questions, particularly as they pertain to historically dominated groups. Instead, the law holds to the basic premise that definition from above can be fair to those below, that beneficiaries of racially conferred privilege have the right to establish norms for those who have historically been oppressed pursuant to those norms, and that race is not historically contingent. Although the substance of race definitions has changed, what persists is the expectation of white-controlled institutions in the continued right to determine meaning, the reified privilege of power that reconstitutes the property interest in whiteness in contemporary form. 4. Delegitimating the property interest in whiteness through affirmative action. In the worlds of de jure and de facto segregation, whiteness has value, whiteness is valued, and whiteness is expected to be valued in law. The legal affirmation of whiteness and white privilege allowed expectations that originated in injustice to be naturalized and legitimate. The relative economic, political, and social advantages dispensed to whites under systematic white supremacy in the United States were reinforced through patterns of oppression of blacks and Native Americans. Materially, these advantages became institutionalized privileges. Ideologically, they became part of the settled expectations of whites, a product of the unalterable original bargain. The law masks as natural what is chosen, it obscures the consequences of social selection as inevitable. The result is that the distortions in social relations are immunized from truly effective intervention, because the existing inequities are obscured and rendered nearly invisible. The existing state of affairs is considered neutral and fair, however unequal and unjust it is in substance. Although the existing state of inequitable distribution is the product of tt. 288. Institutionalized white supremacy and economic exploitation, it is seen by whites as part of the natural order of things, something that cannot legitimately be disturbed. Through legal doctrine, expectation of continued privilege based on white domination was reified, whiteness as property was reaffirmed. The property interest in whiteness has proven to be resilient and adaptive to new conditions. Over time it has changed in form, but it has retained its essential exclusionary character and continued to distort outcomes of legal disputes by favoring and protecting settled expectations of white privilege. The law expresses the dominant conception of constructs such as rights, equality, property, neutrality, and power. Rights mean shields from interference, equality means formal equality, property means the settled expectations that are to be protected, neutrality means the existing distribution, which is natural, and power is the mechanism for guarding all of this. Affirmative action begins the essential work of rethinking rights, power, equality, race, and property from the perspective of those whose access to each of these has been limited by their oppression. From this perspective, affirmative action is required on moral and legal grounds to delegitimate the property interest in whiteness, to dismantle the actual and expected privilege that has attended white skin since the founding of the country. Like passing, affirmative action undermines the property interest in whiteness. Unlike passing, which seeks the shelter of an assumed whiteness as a means of extending protection at the margins of racial boundaries, affirmative action denies the privileges of whiteness and seeks to remove the legal protections of the existing hierarchy spawned by race oppression. What passing attempts to circumvent, affirmative action moves to challenge. Rereading affirmative action to delegitimate the property interest in whiteness suggests that if, historically, the law has legitimate and protected the settled whites' expectations in white privilege, delegitimation should be accomplished not merely by implementing equal treatment, but also by equalizing treatment among the groups that have been illegitimately privileged or unfairly subordinated by racial stratification. Obviously, the meaning of equalizing treatment would vary, because the extent of privilege and subordination is not constant with reference to all societal goods. In some instances, the advantage of race privilege to poorer whites may be materially insignificant when compared to their class disadvantage against more privileged whites. But exposing the critical core of whiteness as property, the unconstrained right to exclude, directs attention toward questions of redistribution and property that are crucial under both race and class analysis. The conceptions of rights, race, property, and affirmative action as currently understood are unsatisfactory and insufficient to facilitate the self-realization of oppressed people. A. Affirmative action, a new form of status property. If whiteness as property is the reification, in law, of expectations of white privilege, then according privilege to blacks through systems of affirmative action might be challenged as performing the same ideological function, but on the other side of the racial line. As evidence of a property interest in blackness, some might point out that, recently, some whites have sought to characterize themselves as belonging to a racial minority. Equating affirmative action with whiteness as property, however, is false and can only be maintained if history is ignored or inverted while the premises inherent in the existing racial hierarchy are retained. Whiteness as property is derived from the deep historical roots of systematic white supremacy, which have given rise to definitions of group identity predicated on the racial subordination of the other, and have reified expectations of continued white privilege. This reification differs in crucial ways from the premises, intent, and objectives of affirmative action. Fundamentally, affirmative action does not re-establish a property interest in blackness, because black identity is not the functional opposite of whiteness. Even today, whiteness is still 289. Intertwined with the degradation of blacks and is still valued because the artifact of whiteness sets a floor on how far whites can fall. Acknowledging black identity does not involve the systematic subordination of whites, nor does it even set up a danger of doing so. Affirmative action is based on principles of anti-subordination, not principles of black superiority. The removal of white privilege pursuant to a program of affirmative action would not be implemented under an ideology of subordination, nor would it be situated in the context of the historical or present exploitation of whites. It is thus not a matter of implementing systematic disadvantage to whites or installing mechanisms of group exploitation. Whites are not an oppressed people and are not at risk of becoming so. Those whites who are disadvantaged in society suffer not because of their race but in spite of it. Refusing to implement affirmative action as a remedy for racial subordination will not alleviate the class oppression of poor whites. Indeed, failing to do so will reinforce the existing regime of race and class domination, which leaves lower-class whites more vulnerable to class exploitation. Affirmative action does not institute a regime of racialized hierarchy in which all whites, because they are white, are deprived of economic, social, and political benefits. It does not reverse the hierarchy, rather, it levels the racial privilege. Even if one rejects the notion that properly constructed affirmative action policies cause whites no injustice, affirmative action does not implement a set of permanent, never-ending privileges for blacks. Affirmative action does not distort black expectations because it does not naturalize these expectations. Affirmative action can only be implemented through conscious intervention, and it requires constant monitoring and re-evaluation so it does not function behind a mask of neutrality in the realm beyond scrutiny. Affirmative action for blacks does not refy existing patterns of privilege, nor does it produce subordination of whites as a group. If anything, it might fairly be said that affirmative action creates a property interest in true equal opportunity and means that are equalized. B. What affirmative action has been, what affirmative action might become. The truncated application of affirmative action as a policy has obscured affirmative action as a concept. The ferocious and unending debate on affirmative action cannot be understood unless the concept of affirmative action is considered and conceptually disengaged from its application in the United States. As policy, affirmative action does not have a clearly identifiable pedigree, rather, it was one of the limited concessions offered in official response to demands for justice pressed by black constituencies. Despite uneven implementation in the areas of public employment, higher education, and government contracts, it translated into the attainment by blacks of jobs, admissions to universities, and contractual opportunities. Affirmative action programs did not, however, stem the tide of growing structural unemployment and underemployment among black workers, nor did it prevent the decline in material conditions for blacks as a whole. Such programs did not change the subordinated status of blacks, in part because of structural changes in the economy, and in part because the programs were not designed to do so. However, affirmative action is more than a program, it is a principle, internationally recognized, based on a theory of rights and equality. Formal equality overlooks structural disadvantage and requires mere non-discrimination or equal treatment. By contrast, affirmative action calls for equalizing treatment by redistributing power and resources in order to rectify inequities and to achieve real equality. The current polarized debate on affirmative action and the intense political and judicial opposition to the concept is thus grounded in the fact that, in its requirement of equalizing treatment, affirmative action implicitly challenges the sanctity of the original and derivative present distribution of property, resources, and entitlements, and it directly confronts the notion that there is a protectable property interest in whiteness. If 290. Affirmative action doctrine were freed from the constraint of protecting the property interest in whiteness, if, indeed, it were conceptualized from the perspective of those on the bottom, it might assist in moving away from a vision of affirmative action as an uncompensated taking and inspire a new perspective on identity as well. The fundamental precept of whiteness, the core of its value, is its exclusivity, but exclusivity is predicated not on any intrinsic characteristic, but on the existence of the symbolic other, which functions to create an illusion of unity among whites. Affirmative action might challenge the notion of property and identity as the unrestricted right to exclude. In challenging the property interest in whiteness, affirmative action could facilitate the destruction of the false premises of legitimacy and exclusivity inherent in whiteness and break the distorting link between white identity and property. Affirmative action in the South African context offers a point of comparison. It has emerged as one of the democratic movement's central demands, appearing in both the constitutional guidelines and draft Bill of Rights issued by the African National Congress. These documents simultaneously denounce all forms of discrimination and embrace affirmative action as a mechanism for rectifying the gross inequities in South African society. The South African conception of affirmative action expands the application of affirmative action to a much broader domain than has typically been envisioned in the United States. That is, South Africans consider affirmative action a strategic measure to address directly the distribution of property and power, with particular regard to the maldistribution of land and the need for housing. This policy has not yet been clearly defined, but what is implied by this conception of affirmative action is that existing distributions of property will be modified by rectifying unjust loss and inequality. Property rights will then be respected, but they will not be absolute, rather, they will be considered against a societal requirement of affirmative action. In essence, this conception of affirmative action is moving toward the reallocation of power and the right to have a say. This conception is in fact consistent with the fundamental principle of affirmative action and effectively removes the constraint imposed in the American model, which strangles affirmative action principles by protecting the property interest in whiteness. Conclusion. Whiteness as property has carried and produced a heavy legacy. It is a ghost that has haunted the political and legal domains in which claims for justice have been inadequately addressed for far too long. Only rarely declaring its presence, it has warped efforts to remediate racial exploitation. It has blinded society to the systems of domination that work against so many by retaining an unvarying focus on vestiges of systemic racialized privilege which subordinates those perceived as a particularized few the others. It has thwarted not only conceptions of racial justice but also conceptions of property which embrace more equitable possibilities. In protecting the property interest in whiteness, property is assumed to be no more than the right to prohibit infringement on settled expectations, ignoring countervailing equitable claims predicated on a right to inclusion. It is long past time to put the property interest in whiteness to rest. Affirmative action can assist in that task. If properly conceived and implemented, it is not only consistent with norms of equality but also essential to shedding the legacy of oppression. Race in the 21st Century. Equality through law. Linda Green. The burden of proof is always upon him. For the interpretation and realization of these rights he was forced to appeal to the Supreme Court. Thus the Negro has been compelled to substitute the complicated, arduous, and expensive processes of litigation for the ballot box. What other groups are able to do for themselves, the Negro hopes the judiciary to do for him. There was more than ample evidence in the decisions of the Supreme Tribunal of the land on questions involving the rights of the Negro to disprove the possibility of any general relief from this quarter. Dr. Ralph Bunche, 1934. Introduction. During 1989, the Supreme Court decided several important civil rights cases to which civil rights leaders responded with dismay. All these decisions concerned discrimination in employment and addressed a wide range of issues, whether white employees collaterally may attack court-approved consent decrees, the proof requirements in Griggs v. Duke Power * disparate impact cases, the applicability of Reconstruction-era civil rights statutes to private discrimination degree as well as the constitutionality of a local government program requiring contractors to employ minority subcontractors. In each of these cases, the majority of the court employed formalistic and hyper-technical reasoning to limit the scope of redress for the racial inequities plaguing racial minority groups. In ingenious ways, these decisions explode the post-Brown registered assumptions about racial discrimination's existence, its meaning and importance, and the role of the judiciary in its redress. These decisions contribute to the development of a legal structure in which racial inequities may be immune from legal redress and, perhaps more important, in which racial discrimination plausibly may be denied. In short, the 1989 Supreme Court decisions create barriers to changes in the racial status quo. The civil rights decisions of the 1989 term force us to refocus on a question presented time and time again, before and after Dred Scott, whether meaningful equality can be obtained for African Americans through law. I will discuss these decisions by elaborating on several themes embodied in these decisions. These themes include formalism and equality, the tendency to interpret statutes rigidly, narrowly, and hypertechnically, thereby stripping them of transformative content, politics and equality, the tendency to reduce all questions of racial equality to political questions, thereby stripping constitutional legitimacy from racial civil rights, and the rights of whites and equality, the tendency to give legal legitimacy to the efforts of whites, who historically have benefited from racism, to maintain the racial status quo. Formalism and equality. A. Introduction. One theme embodied in the 1989 civil rights cases is formalism, the tendency to approach the task of interpretation as an enterprise unaffected by either contextual reality or likely result. This tendency is particularly obvious in Ward's Cove Packing Co. v. Ateneo Registered and Patterson v. McLean Credit Union. In these cases, the Supreme Court majority uses language that preserves the appearance of proper concern for achieving equality, yet, in both, the reasoning seems indifferent to reality and to the impact of the decisions on the historical victims of racial discrimination. B. Ward's Cove Packing Co. v. Ateneo. The Ward's Cove decision may have the greatest impact on equality law because of the sweeping changes it arguably makes in employment discrimination law. Ward's Cove does not follow the Griggs v. Duke Power tradition of ferreting out policies that perpetuate segregation in employment. Instead, Ward's Cove treats segregative policies as socially neutral and cautions courts to refrain from interfering with employment policies. This result is accomplished through the use of an often surreal analysis of statistics, as well as through a casual disregard of 20 years of employment discrimination law. 293. In Ward's Cove, the court considered whether a cannery company's maintenance of a segregated workforce violated Title VII. The record revealed that Ward's Cove hired season after season predominantly white workers in its skilled positions and predominantly non-white, Alaskan Natives, workers in its unskilled positions. Non-white cannery workers claimed that the employer's method of selecting employees created an illegally segregated workforce. They also attacked the employer's maintenance of racially segregated housing and dining facilities. Though the court below considered both disparate impact and disparate treatment claims, the court granted certiorari for the purpose of addressing these disputed questions of the proper application of Title VII's disparate impact theory of liability. A majority of the court decided that the lower court's decision had accorded too much weight to statistics that had demonstrated the segregated nature of the employer's workforce. Justice Byron White, in whose opinion Chief Justice William Rehnquist and Justices Sandra Day O'Connor, Antonin Scalia, and Anthony Kennedy joined, accused the Ninth Circuit of giving too much weight to statistics and to racial imbalance. The court rejected the statistical comparison of the predominantly white non-cannery workforce to the predominantly non-white cannery workforce. The cannery workforce in no way reflected the pool of qualified job applicants or the qualified population in the labor force. Justice White said that Title VII requires a proper comparison between the racial composition of the qualified persons in the labor market and the persons holding at-issue jobs. Registered according to Justice White, the racial disparities in skilled positions were just as likely to be due to a dearth of qualified non-white applicants, for reasons that are not petitioner's fault. Though this reasoning implied that comparisons between the non-skilled cannery positions, predominantly held by non-whites, and the skilled non-cannery positions, predominantly held by whites, might well have been considered appropriate. Justice White rejected this possibility. Racial imbalance in one segment of an employer's workforce does not, without more, establish a prima facie case rate impact with respect to the selection of workers for the employer's other positions, even where workers for the different positions may have somewhat fungible skills, as is arguably the case for cannery and unskilled non-cannery workers. Point 1 registered. Justice White advised lower courts that this kind of statistical evidence may be ignored unless challengers show evidence of barriers to application, deterrence, or that the percentage of non-whites selected is significantly lower than that of non-whites applying. It seems counterintuitive that the plantation-like segregation of Ward's Cove can be maintained under Title VII, but Justice White said that the alternatives were unacceptable. According to him, strict judicial scrutiny of workplace segregation would drive employers to adopt quotas. A New York employer who had a segment of his workforce that was for some reason racially imbalanced, could be hauled into court and forced to engage in the expensive and time-consuming task of defending the business necessity of the methods used to select the other members of his workforce. The only practicable option for many employers will be to adopt racial quotas, ensuring that no portion of his workforce deviates in racial composition from other portions thereof. Thus, Justice White suggested that the court's abhorrence for quotas and its reluctance to impose undue burdens on employers required the court to give Ward's Cove's statistics of segregation little weight. These racial balance and employer burden considerations also may account for some of the questionable logic used to justify the irrelevance of Ward's Cove's statistics. For instance, Justice White attempts to demonstrate the irrelevancy of Ward's Cove's decision to hire only non-whites for cannery work and whites for non-cannery work by suggesting that the company, at any moment, could cease to use the segregated union it had chosen to supply its cannery jobs with non-white workers. If the company did so, Justice White argues, the factual basis of the non-white workers' complaints about predominantly white non-cannery jobs would disappear. 294 Because the company could eliminate the segregated nature of its cannery workforce overnight. 7 The court gave no weight to the context in which these disparities occurred, one in which the employer exercised complete control over the workforce availability, for both cannery and non-cannery work, by choosing where to recruit potential employees. Rather, the court's logic seems driven by an important subtext: glaring racial segregation is more likely to be the result of the employer's innocence. Even if one suspends judgment and concedes the validity of such a principle, the plantation facts in Ward's Cove suggest that innocence was the least likely explanation. If Justice White had written no more, Ward's Cove could have been distinguished as a decision limited to the nuances, vagaries, and complexities of workforce statistical analyses. However, his opinion also addressed the evidentiary burden that employers must meet to justify and retain segregative employment policies. Justice White declared that employment practices which produce workplace segregation need not be essential or indispensable to the employer, rather, they merely need serve the legitimate employment goals of the employer. Moreover, he also explained that the Ninth Circuit had erred in requiring that Ward's Cove bear the burden of persuasion on the business justification for its segregative practices. Justice White cited none of the court's decisions that firmly had placed upon the employer the burden of proving the business necessity of segregative policies, Nor did he acknowledge that in the 2 decades since Griggs, courts, employers, and Title VII claimants have understood that upon proof of disparate impact, the burden of persuasion would shift to the employer. 73 In 2 casual paragraphs, devoid of any discussion on the rationale for disparate impact theory, Justice White may have rewritten the 2 most important principles in Title VII law. First, the Act proscribes not only overt discrimination but also practices that are fair in form, but discriminatory in operation. Second, in order to limit the extent to which employment policies create built-in headwinds against protected groups, Congress has placed on the employer the burden of showing that any given requirement must have a manifest relationship to the employment in question. Whether Ward's Cove squarely overturns Griggs may be open to debate, but the reasoning in Ward's Cove seriously undermines the policies of Title VII as articulated in Griggs. 2 Ward's Cove treats workplace segregation as a neutral phenomenon free of negative connotation and illegal implication. While Griggs followed Brown's aspiration to a society free of racial distinctions, Ward's Cove rejects such aspirations as meddlesome to employers and tainted with the possibility of racial parity. After Ward's Cove, Title VII remains, but it seems an empty shell where its content matters most. Cases in which employment policies prevent whole groups, not merely individuals, from enjoying employment opportunities. Disparate impact theory allowed the notion of equality to have palpable substantive content, not merely formal content, in a new era in which employers no longer advertise whites only but still manage to maintain and perpetuate workplace segregation. Disparate impact theory embodied normative notions about the workplace environment, about the positive aspects of interracial association * registered about the value of employment choices to individuals, about the potential of historically excluded groups to make greater contributions to American society, and about the risks we all incur when race and economic status are linked too closely. Ward's Cove rejects all this in a decision formally cast in statistical analyses and evidentiary rules. More than a century ago, Justice John Harlan warned that the Supreme Court was turning the precious rights so recently acquired by the freedmen into planted baubles fit for no practical purpose. Then he spoke of the court's creative arguments that amounted to a refusal to give the same force and content to the Civil War amendments as the court had given the slavery clauses of the Constitution. Justice Harlan saw his court creating a legal structure in which consequences of slavery would linger, and in which racism would flourish. Ward's Cove suggests the development of a trend similar. I-295. To that prophetically observed by Harlan. By treating segregative practices as neutral, and by rejecting racial pluralism as a positive development, the court is moving to limit the transformative possibilities of Title VII. If this trend continues, the court will guarantee that the unfinished racial business of the 20th century will be passed down to the next century. See Patterson v. McLean Credit Union. Patterson v. McLean Credit Union also employed formalistic reasoning to strip an equality statute of content and importance. In Patterson, the court considered whether Section 1981 a Reconstruction-era civil rights statute, applied to the racial discrimination and harassment a black female bank teller suffered after a credit union hired her *. Brenda Patterson's supervisor stared at her, assigned her cleaning duty, made racist remarks in her presence, and refused to train or promote her *. In Patterson, Justice Kennedy, joined by Chief Justice Rehnquist and Justices White, O'Connor, and Scalia, decided that the racial indignities suffered by Brenda Patterson were not actionable under Section 1981, and Joan of the conduct which petitioner alleges as part of the racial harassment against her involves either a refusal to make a contract with her or the impairment of her ability to enforce her established contract rights. Rather, the conduct which petitioner labels as actionable racial harassment is post-formation conduct by the employer relating to the terms and conditions of continuing employment. The court concluded that the language of Section 1981, all persons shall have the same right to make and enforce contracts, as is enjoyed by white citizens, does not include the right to be free from racial harassment in the performance of a contract. Justice Kennedy used structural, semantic, and logical arguments to limit the scope of the statute. The crucial structural argument was his treatment of Section 1981 as embodying two rights, rather than a bundle of rights flowing from the elimination of slave status: the right to make contracts and the right to enforce contracts. Justice Kennedy discussed these two rights separately. He invoked the plain meaning talisman to limit the meaning of the word make to formation, refusal to enter into a contract, or offering to make a contract only on discriminatory terms. The right to make contracts does not extend, as a matter of either logic or semantics, to conduct by the employer after the contract relation has been established, including breach of the terms of the contract or imposition of discriminatory working conditions. Such post-formation conduct does not involve the right to make a contract, but rather implicates the performance of established contract obligations and conditions of continuing employment. Degree. Justice Kennedy also relied upon the plain meaning approach to conclude that the words "the same right to enforce" contracts, as is enjoyed by white citizens were irrelevant to the actual performance of a contract degree. In this portion of the opinion, he treated the word enforce as if it were self-explanatory, while explaining the word nonetheless. His search for authoritative support stopped with his rather curious citation of Justice White's dissent in Runyon v. McCrary, the 1976 decision which held that Section 1981 applied to private contracts. Justice Kennedy also concluded that a limited interpretation of Section 1981 was required because Title VII exists. There is no attempt to suggest that Congress sought to repeal or limit Section 1981 when it enacted, and subsequently amended, Title VII. Rather, Justice Kennedy simply suggests that matters involving performance and conditions of employment are matters more naturally governed by Title VII, and that allowing these matters to be actionable under Section 1981 would undermine the detailed and well-crafted procedures for conciliation and resolution of Title VII claims. For thus, while he scrupulously avoided the assertion that Congress intended to restrict Section 1981 when it enacted Title VII, he nevertheless decided that Congress's inclusion of the conciliation processes in Title VII may be read to suggest a preference for those processes, however lengthy, prior to the commencement of litigation. Justice Kennedy also used federalism argue 296 ments to limit the rights protected by Section 1981, asserting that endorsing more than minimal coverage would necessarily require the federalization of state contract law and remedies. He argued that because Section 1981 covers all contracts, not just employment contracts, any contract breached because of racial animus would be actionable. In this manner, Justice Kennedy limited the scope of Section 1981. He combined federalism and floodgate arguments. As such, his opinion here is reminiscent of those 19th-century arguments that rejected, on federalist grounds, the notion that the national government ought to be primarily responsible for guaranteeing the rights of the freedmen or ensuring meaningful equality. Finally, Justice Kennedy rejected and labeled as bootstrap the argument that the racial harassment Brenda Patterson experienced after her contract was made suggested that her contract had not been made in a racially neutral manner. The question under 1981 remains whether the employer, at the time of the formation of the contract, in fact intentionally refused to enter into a contract with the employee on racially neutral terms. We think it clear that the conduct challenged by petitioner relates not to her employer's refusal to enter into a contract with her, but rather to the conditions of her employment. One striking aspect of Justice Kennedy's opinion was his failure to address the context in which Section 1981 was passed and the intent and values that the 39th Congress embodied in that statute. This legislative history was briefly reviewed by Justice William Brennan, who dissented, with Justices Thurgood Marshall and Harry Blackmun, from the court's decision to exclude claims of racial harassment from Section R98R. Justice Brennan noted that Section 1981 grew out of Congress's realization that former masters and other employers were hiring blacks and then treating them as if the institution of slavery had never been abolished. He noted that whippings and the meting out of harsher punishments to black employees were among the practices brought to the attention of the 39th Congress. In short, Justice Brennan said that the 39th Congress had observed the recreation of slave conditions of employment even when the relations between employers and laborers had been fixed by contract. And a cursory review of the state legislation passed immediately after emancipation provides some insight into how the dream of emancipation became a nightmare for many former slaves. The state legislation in regard to freedmen seemed to have for its object the perpetuation of the spirit of slavery after its body had been decently buried. A Mississippi law passed in 1865 permitted former masters both to obtain the service of their former slaves who were unemployed and to administer corporal punishment. Another 1865 Mississippi law provided that Negroes who left their jobs without good cause before the end of their contracts would forfeit all wages. And 1865 South Carolina statute declared that HALL persons of color who make contracts for service or labor shall be known as servants, and those with whom they contract as masters. These are a few of the laws that attempted to dictate the relationships between white employers and the freedmen after contracts had been made. In addition to these statutes, historians note that despite the recent guarantee of emancipation, blacks were subjected to violence when they attempted to act as free men in their contractual relations. According to Eric Foner, freedmen were assaulted and murdered for attempting to leave plantations, disputing contract settlements, not laboring in the manner desired by their employers, attempting to buy or rent land, and resisting whipping. One black who refused to be bound and whipped was shot dead by his employer, a prominent Texas lawyer. When the 39th Congress acted to protect the rights of blacks, the horrors of the post-emancipation period did not allow Congress an escape into the distinctions between formation, enforcement, and performance which Justice Kennedy found so intriguing. The issue in 1866 was how to give to blacks what they had been denied since 1619, the dignity and sanctity of contract without its antithesis, the degradation of slavery. No phrase could have better summed up Congress's intent to break 297 with the pat than the same rights as whites. Justice Kennedy ignored this history. It is not surprising, then, that his opinions do not dare to venture into the 19th century. Had they done so, he would have had to acknowledge that harassment, intimidation, verbal abuse, subjugation, threats of violence, and violence were the conditions of the slave experience. He would also have had to note that after emancipation, and despite some protective laws, former slave masters continued to act as if the master-slave relation had never been dissolved. History shows that the immediate problem was not reluctance to contract in the most limited sense of the word, there was as much work to be done after the end of slavery as before. Rather, what the former slave masters resisted was treating the freedmen as equal persons entitled to the respect accorded whites throughout the course of the contractual relationship. These masters insisted on using the same violence, intimidation, and harassment they had used with impunity before emancipation. In 1866, if having the same right as whites to make and enforce a contract meant anything, it meant the right to be free from slavery conditions during the entire scope of the contractual relationship. Justice Kennedy's arguments were based on semantics and logical abstractions devoid of 19th and 20th century realities. According to his reasoning, as long as a black is permitted to agree to work, the racism that ensues is not a denial of the right to make and enforce a contract. If the employer fails to warn that he expects sexual favors from his black female employee and then asks for them, there is no relief under Section 1981. If an employer puts the black employees out of the sight of customers, refers to them as N in front of co-workers and customers alike, there is no relief under Section 1981. If an employer inflicts corporal punishment, there is no relief either. None of this, according to Justice Kennedy, concerns the right to make and enforce a contract. At the turn of the 21st century, 120 years after the official end of slavery, how unseemly for America, and how tragic for black Americans, that civil rights advocates must petition Congress to provide immediate and effective judicial relief in racial harassment cases. But, as the historian Foner suggests, our racial past is prologue, from the enforcement of the rights of citizens to the stubborn problems of economic and racial justice. The issues central to Reconstruction are as old as the American Republic, and as contemporary as the inequalities that still afflict our society. Degree 4. Three reguts or whites. Another theme embodied in the 1989 decisions is concern for the rights of whites. City of Richmond v. J. A. Croson, Oates surely embodies this theme. Justice O'Connor's decision vigorously protects whites against both the economic aspirations of black contractors and the political effectiveness of black leaders and constituents. Ward's Cove also respects and facilitates the rights of whites in two ways, by offering legitimacy to segregated job categories, thereby benefiting the historical beneficiaries of segregation, and by granting virtual legal immunity to employers using such categories, by stacking the litigation deck in their favor. However, the case most explicit on the rights of whites is Martin v. Wilkes. In Martin v. Wilkes, white firefighters sued the city of Birmingham and alleged that the city was promoting less qualified blacks on the basis of race. In 1974, blacks had sued the city of Birmingham, alleging that the city's employment policies excluded them from employment, in violation of Title VII. After a trial concerning applicant screening tests, the district court found a Title VII violation. A second trial was held on the city's promotional practices. After the evidence was presented but before the judge issued his decision, the parties, the blacks and the city, negotiated and agreed to a consent decree. The court required the parties to provide notice of the proposed consent decree to all interested persons. Thereafter, the court held a fairness hearing at which a group of black employees complained that the proposed relief was inadequate, and a group of white employees complained that race 298 conscious relief was illegal and inappropriate. The district court explicitly considered whether the race-conscious measures of the consent decree were compatible with previous Supreme Court decisions. After the district court approved the consent decree, the white firefighters, who had presented their objections to the decree, sought intervention as well as an injunction against the enforcement of the consent decree. These requests were denied and Birmingham immediately implemented the consent decree by promoting 8 whites and 5 blacks. Immediately thereafter, a new group of white firefighters sued. These firefighters were aware of the original lawsuit but had not asked to intervene. The district court dismissed this lawsuit as an impermissible collateral attack on the consent decree. In Martin v. Wilkes, Chief Justice Rehnquist, in an opinion joined by Justices White, O'Connor, Scalia, and Kennedy, held that the collateral attack was not barred. The court candidly acknowledged that the Third, Fourth, Fifth, Sixth, and Ninth Circuits had barred such collateral attacks. Chief Justice Rehnquist then distinguished Martin v. Wilkes from one of the court's major cases holding non-parties bound to a consent decree, the Penn Central merger and N&W inclusion cases. Penn Central was distinguishable, according to Chief Justice Rehnquist, because of the extraordinary nature of the proceedings challenging the merger of giant railroads. This sort of complex lawsuit should not be compared with ordinary civil actions in a district court. For these ordinary civil actions, Rule 19 of the Federal Rules of Civil Procedure requires joinder, hence, the collateral attack was not barred. Chief Justice Rehnquist dismissed the argument that permitting unlimited collateral attacks would be burdensome to civil rights litigation. He acknowledged that the court had a choice between either requiring those who might be affected by a judgment to intervene or requiring plaintiffs to join all parties who might be affected. He simply chose to burden the plaintiffs. Chief Justice Rehnquist also rejected the argument that permitting these collateral attacks would undermine the congressional policy favoring voluntary settlement of employment discrimination claims. He ordered the remand of Martin v. Wilkes for trial on the legality of the consent decree. The remainder of the court dissented. Justices Marshall, Brennan, and Blackmun joined an opinion written by Justice Stevens. Justice Stevens saw a distinction between legal rights such as contractual rights, which may not be impaired unless the individuals possessing such rights are parties to a consent decree, and conditions of employment, such as promotions for blacks, which as a practical matter, may have a serious effect on their opportunities for employment or promotion. Justice Stevens conceded that even those in the latter category might attack a consent decree on limited grounds, but that the circumstances would have to be extraordinary. Any other conclusion would subject large employers who seek to comply with the law by remedying past discrimination to a never-ending stream of litigation and potential liability. It is unfathomable that either Title VII or the Equal Protection Clause demands such a counterproductive result. Justice Stevens reminded the majority that the whites who collaterally attack today were and are the beneficiaries of past discrimination against blacks. Any remedy that seeks to right these wrongs will necessarily have an adverse impact on whites, who must now share their job and promotion opportunities with blacks. Just as white employees in the past were innocent beneficiaries of illegal discriminatory practices, so is it inevitable that some of the same white employees will be innocent victims who must share some of the burdens resulting from the redress of the past wrongs. While the rights of whites dimension of Martin v. Wilkes is glaring, the same sentiments are present in Ward's Cove in a less obvious fashion. In Ward's Cove, the formal question involved the burden of proof applicable in Title VII disparate impact cases, yet the court also considered the interests of whites in maintaining a system that prefers them as submerged in the interest of the employer. The employer was treated not as having an interest in the maintenance of the racial status quo but, rather, as having an interest in the preservation 299 of management prerogatives. In Martin v. Wilkes, the interests are posed much more directly. May white employees, unhappy with the effect of a consent decree on their prerogatives, attack it, despite the Birmingham Fire Department's historical protection of their group's interests? May they intervene, not to protect contractually acquired rights such as seniority or benefits, but to protect their interest in promotions pursuant to a test that perpetuates a racial hierarchy? Martin v. Wilkes is also interesting and important because it suggests that the interests of white employees no longer converge with those of employers. Martin v. Wilkes ignores the historical protection that white employers have accorded white employees, but it implicitly acknowledges the reality that public employers now have new obligations and more diverse constituencies to protect. The idea of the rights of whites is not a new one in American race law. Certainly we can trace it to the unloading of slaves at Annapolis and Jamestown before the 18th century, to the slavery compromises of 1789, and to its verbal apogee in Dred Scott. The idea was more covered after the passage of the Civil War amendments, though it is ironic that shortly after the Supreme Court's grand pronouncements about the purpose of these amendments in the slaughterhouse cases, Justice Bradley bitterly and candidly suggested that the time had come for blacks to cease to be a special favorite of the laws. After Plessy registered sanctioned state racism, the court did not need to speak openly of white rights, rather, the discussion centered on the reasonableness of distinctions and customs and usages of the community, and even on the benefits to blacks of disadvantageous treatment. A half-century later, Brown IP's all deliberate speed language arguably invited lower courts to covertly consider the interests of whites in the maintenance of the status quo. By the late 60s, the courts were beginning to consider what sort of Title VII remedies would be appropriate to remedy the blatant job segregation that still persisted in many companies. These job segregation cases provide an interesting insight into the process by which the rights of whites were incorporated into modern equality law. In cases in which the relationship of white jobs and income to overtly racist policies could not be denied, the courts sought to reconcile the idea of complete relief for blacks against the vested interest of white employees in maintaining the status quo. The competing remedial theories were evaluated openly in terms of their impact on whites, and compromises were struck that, assuming economic growth, would permit an eventual change in the status quo without divesting whites of the jobs they held, in part because of historic racial discrimination against blacks. However, it was De Funes v. Adegaard, in which a white student asserted a 14th Amendment challenge to a University of Washington Law School program to admit blacks, that ushered in a new era of legal rhetoric about white rights. Though the De Funes case was dismissed as moot, his cause was taken up by Bakke, Fula Love, Croson, and others. The objective, the invocation of strict legal scrutiny for challenges made by white males against programs designed to provide new opportunity for blacks, was finally achieved in Croson. In Ward's Cove, Croson, and Wilkes, the rights of whites find recognition and protection. In each case, the source of protection is different, but the result is the same. It is troubling that none of these cases acknowledges that the interests asserted may be characterized as an interest in the continued racial hegemony of whites, in the subordination of blacks. To be sure, our principles of due process do not permit contractual rights, property rights, or seniority rights to be impaired without notice and opportunity to be heard. But it is quite different, or at least it should be quite different in the post-Brown era, to come to the courts with a simple request to maintain the racial status quo. In light of our history, it is not surprising that such claims have been made. It is, however, troubling that the claims have been judicially validated. For Cohen-Selous Ion. He hoped that the ideal of racial equality might be made legitimate through law, that racial equality might be achieved through law, has sustained many members of the post. 300. Brown generation. Charles Hamilton Houston, one of the greatest constitutional lawyers and an architect of 20th-century constitutional equality, was quite realistic about the possibility of achieving equality through law. He viewed his legal assault on segregation not as an end in itself but, rather, as an opportunity to determine the limits of the system's tolerance for freedom and equality. In late 1949, a few months before his death, Houston spoke these prescient words. "I regard what I am doing and my work as a lawyer not as an end in itself, but simply as the means of a technician probing in the courts, which are products of the existing system, how far the existing system will permit the exercise of freedom before it clamps down." Degree. Another important black American was even more skeptical than Houston about the possibilities of achieving equality through law. In 1934, Ralph Bunche outlined a variety of tactics blacks might employ to improve their status. Bunche stated that the confidence blacks had in the possibilities of civil libertarianism as a basis of struggle for equality was misplaced. The utility of the 13th, 14th, and 15th Amendments as a basis for black equality was limited. The Constitution is a very flexible instrument, and that, in the nature of things, it cannot be anything more than the controlling elements of the American society wish it to be. And, what the courts and legislatures wish it to be can never be more than what American public opinion wishes it to be. It follows, therefore, that the policy of civil libertarianism is circumscribed by the dominant mores of the society. Its success, in the final analysis, must depend upon its ability to create a sympathetic response to its appeals among the influential elements in the controlling population. Dr. Bunche wrote in 1934, but his warning about the limits of the court are still important. It is no accident that the 1989 decisions reflect a selective activism and restraint, with results usually detrimental to blacks. This result is not surprising. The justices appointed to the court by President Reagan have joined to form a majority that opposes a strong role for the courts in identifying and remedying discrimination. A new legal structure is being erected. It comes complete with reassuring caveats, technical analyses, and evidentiary nuances. It surrounds, and it legitimizes the racial status quo. In the long run, the new structure may be just as effective as the rationalizations of the Plessy era, with one important distinction: the new regime is cloaked in post-Brown legitimacy and sustains Brown's myth of a new racial order. Racism is now plausibly deniable. In a short Ward's Cove dissent, Justice Blackmun lamented the judicial turn of events represented by Ward's Cove and other recent decisions. One wonders whether the majority still believes that race discrimination, or, more accurately, race discrimination against non-whites, is a problem in our society, or even remembers that it ever was. It is not too early to ask the questions that Houston and Bunche raised. While the efforts that have led to the demise of overt legal racism must be applauded, the creation of a new legal order that legitimates the maintenance of racial subordination and domination must be condemned. In the short run, there may be no choice but to continue to probe the existing system for the possibility that it may yield racial justice. In the long run, though, it may be necessary to ask whether the confinement of the movement for racial equality to civil rights litigation exposes the movement to great risk. It is not only possible that if so confined, meaningful equality may not be achieved, but also that the very legitimacy of alternate avenues to racial justice may be compromised. It is perhaps too early to concede the limits of a legal strategy in the 21st century. However, given the recent Supreme Court trends, those who seek racial justice must remain prepared to expose more dramatically, as did the students of Greensboro, the manner in which the existing legal framework may immorally and unduly limit and dampen the aspiration of African Americans for universal freedom *degree. Racial realism. Derek A. Bell, Jr. He struggle by black people to obtain freedom, justice, and dignity is as old as this nation. At times, great and inspiring leaders rose out of desperate situations to give confidence and feelings of empowerment to the black community. Most of these leaders urged their people to strive for racial equality. They were firmly wedded to the idea that the courts and judiciary were the vehicle to better the social position of blacks. In spite of dramatic civil rights movements and periodic victories in the legislatures, black Americans by no means are equal to whites. Racial equality is, in fact, not a realistic goal. By constantly aiming for a status that is unobtainable in a perilously racist America, black Americans face frustration and despair. Over time, our persistent quest for integration has hardened into self-defeating rigidity. Black people need reform of our civil rights strategies as badly as those in the law needed a new way to consider American jurisprudence prior to the advent of the legal realists. By viewing the law and, by extension, the courts as instruments for preserving the status quo and only periodically and unpredictably serving as a refuge of oppressed people, blacks can refine the work of the realists. Rather than challenging the entire jurisprudential system, as the realists did, blacks' focus must be much narrower, a challenge to the principle of racial equality. This new movement is appropriately called racial realism, and it is a legal and social mechanism on which blacks can rely to have their voice and outrage heard. Reliance on rigid application of the law is no less damaging or ineffectual simply because it is done for the sake of ending discriminatory racial practices. Indeed, racial realism is to race relations what legal realism is to jurisprudential thought. The legal realists were a group of scholars in the early part of the 20th century who challenged the classical structure of law as a formal group of common law rules that, if properly applied to any given racial realism 303 situation, lead to a right and therefore just result. The realists comprised a younger generation of scholars average age 42 who were willing to challenge what they viewed as the rigid ways of the past. More than their classical counterparts, they had been influenced by the rapid spread of the scientific outlook and the growth of social sciences. Such influence predisposed them to accept a critical and empirical attitude toward the law in contrast to the formalists who insisted that law was logically self-evident, objective, a priori valid, and internally consistent. The great majority of the movement's pioneers had practical experience, which strengthened their awareness of the changing and subjective elements in the legal system. This awareness flew in the face of the Langdellian conception of law as unchanging truth and an autonomous system of rules. The realists took their cue from Oliver Wendell Holmes, who staged a 50-year battle against legalistic formalism. According to Holmes's scientific and relativistic lines of attack, judges settled cases not by deductive reasoning, but rather by reliance on value-laden, personal beliefs. To Holmes, such judges engineered socially desirable policies based on these beliefs, which, like all moral values, were wholly relative and determined by one's particular environment. Registered realist notions also were grounded in the views of the progressives during the 1890s. Concerned with social welfare legislation and administrative regulation, the progressives criticized the conceptualization of property rights being expounded by the United States Supreme Court. Creating a remedy based upon the finding of a property right was the court's way of subtly imposing personal and moral beliefs. Abstraction was the method it used to accomplish its purpose. The realists stressed the function of law, however, rather than the abstract conceptualization of it. The realists also had a profound impact by demonstrating the circularity of defining rights as objective, which definition depended, in large part, on a distinction between formalistically bounded spheres between public and private. Classical judges justified decisions by appealing to these spheres. For example, an opinion would justify finding a defendant liable because she had invaded the private property rights of the plaintiff, but such a justification, the realists pointed out, was inevitably circular because there would be such a private property right if and only if the court found for the plaintiff or declared the statute unconstitutional. The cited reasons for decisions were only results, and as such served to obscure the extent to which the state's enforcement power through the courts lay behind private property and other rights claims. Closely linked with the realists' attack on the logic of rights theory was their attack on the logic of precedent. No two cases, the realists pointed out, are ever exactly alike. Hence, a procedural rule from a former case cannot simply be applied to a new case with a multitude of facts that vary from the former case. Rather, the judge must choose whether or not the ruling in the earlier case should be extended to include the new case. Such a choice basically is about the relevancy of facts, and decisions about relevancy are never logically compelled. Decisions merely are subjective judgments made to reach a particular result. Decisions about the relevance of distinguishing facts are value-laden and dependent upon a judge's own experiences. The imperatives of this realist attack were at least two. First, to clear the air of beguiling but misleading conceptual categories, so that thought could be redirected toward facts, rather than non-existent spheres of classism and ethics. If social decision-making was inevitably moral choice, policymakers needed some ethical basis upon which to make their choices. And second, the realists' critique suggested that the whole liberal worldview of private rights and public sovereignty mediated by the rule of law needed to be exploded. The realists argued that a worldview premised upon the public and private spheres is an attractive mirage that masks the reality of economic and political power. This two-pronged attack had profoundly threatening consequences. It carried with it the potential collapse of legal liberalism. Realism, in short, changed the face of American jurisprudence by exposing the result. 304. Oriented, value-laden nature of legal decision-making. Many divergent philosophies emerged to combat, not a little defensively, the attack on law as instrumental, not self-evidently logical, and made by judges, rather than simply derived from transcendent or ultimate principles. Degree as every civil rights lawyer has reason to know, despite law school indoctrination and belief in the rule of law, abstract principles lead to legal results that harm blacks and perpetuate their inferior status. Racism provides a basis for a judge to select one available premise rather than another when incompatible claims arise. A paradigm example presents itself in the case of Regents of the University of California v. Bakke. Registered relying heavily on the formalistic language of the 14th Amendment and utterly ignoring social questions about which race in fact has power and advantages and which race has been denied entry for centuries into academia, the court held that an affirmative action policy may not unseat white candidates on the basis of their race. By introducing an artificial and inappropriate parity in its reasoning, the court effectively made a choice to ignore historical patterns, to ignore contemporary statistics, and to ignore flexible reasoning. Following a realist approach, the court would have observed the social landscape and noticed the skewed representation of minority medical school students. It would have reflected on the possible reasons for these demographics, including inadequate public school systems in urban ghettos, lack of minority professionals to serve as role models, and the use of standardized tests evaluated according to white criteria. Taking these factors into consideration, the court very well may have decided Bakke differently. 1. Registered Bakke serves as an example of how formalists can use abstract concepts, such as equality, to mask policy choices and value judgments. Abstraction, in the place of flexible reasoning, removes a heavy burden from a judge's task. At the same time, her opinion appears to render the right result. Thus, cases such as Bakke should inspire many civil rights lawyers to re-examine the potential of equality jurisprudence to improve the lives of Black Americans. The protection of whites' race-based privilege, so evident in the Bakke decision, has become a common theme in civil rights decisions, particularly in many of those decided by an increasingly conservative Supreme Court. The addition of Judge Clarence Thomas to that court, as the replacement for Justice Thurgood Marshall, is likely to add deep insult to the continuing injury inflicted on civil rights advocates. The cut is particularly unkind because the choice of a black like Clarence Thomas replicates the slave master's practice of elevating to overseer and other positions of quasi-power those slaves willing to mimic the master's views, carry out orders, and by their presence provide a perverse legitimacy to the oppression they aided and approved. For liberals in general, and black people in particular, the appointment of Thomas to the Supreme Court, his confirmation hearings, and the nation's reaction to Professor Anita Hill's sexual harassment charges, all provide most ominous evidence that we are in a period of racial rejection, a time when many whites can block out their own justified fears about the future through increasingly blatant forms of discrimination against blacks. The decline of black people is marked by a precipitous collapse in our economic status and the frustration of our political hopes. An ultimate rebuff and symbol of our powerlessness is President Bush's elevation of one of us who is willing to denigrate and disparage all who look like him to gain personal favor, position, and prestige. 2 degree here, historical parallels contain a fearful symmetry. In 1895, Booker T. Washington, another black man who had risen from the bottom in Washington's case, that bottom was slavery itself, gained instant and lasting status in white America by declaring, in his now famous Atlanta Compromise speech, that black people should eschew racial equality and seek to gain acceptance in the society by becoming useful through trades and work skills developed through hard work, persistence, and sacrifice. Whites welcomed Washington's conciliatory, non-confrontational policy and deemed it a sufficient self-acceptance for the society's involuntary subordination of blacks in every area of life. E. Racial Realism 305. The historian, Lewis R. Harlan, informs us that Booker T. Washington, in his own way, was a double agent. While preaching black humility to whites, Washington privately fought lynching, disenfranchisement, peonage, educational discrimination, and segregation. It is not even a close question, however, that no amount of private support for black rights could undo the damage of Washington's public pronouncements. The Booker T. Washington speech marked a watershed in race relations at the close of the 19th century. There is more than ample reason to believe the Thomas appointment and confirmation proceedings that followed will mark and mar the status of blacks well into the 21st century. Certainly, the high and low drama in those hearings contained enough racial symbols to challenge analysts for years to come. In the first phase of the confirmation hearings, Justice Thomas's testimony provided a definitive illustration of waffling, obfuscation, and disingenuousness. Thomas, and those who prepared him for his appearance, assumed accurately as it turned out that his seat on the nation's most prestigious court could be secured by ignoring every politically controversial statement that he had ever said or written, while recalling precisely everything his grandfather did for him. The hearings also provided further proof that even the most accomplished blacks can be ignored with impunity when they seek to challenge an exercise of white, conservative power. Thus, the opposition to the Thomas appointment by some of the most prestigious black legal academics, including Charles Lawrence of Stanford, Drew Days of Yale, Christopher Edley of Harvard, Dean Haywood Burns of City University of New York at Queens, and Patricia King of Georgetown, easily was neutralized by a collection of Thomas's childhood friends, former staff members, and well-meaning but confused blacks who, unaware of and unconcerned about his record or the anti-black stance of the conservative whites supporting him, nevertheless hoped for the best as they supported Thomas because he was a brother. The second phase of the confirmation hearings provided further proof that black people, notwithstanding their growing numbers in the middle class, are at risk of remaining in a subordinate status. I consider the nationally televised Senate proceedings an American morality play, conducted under circumstances that forced both Judge Clarence Thomas and Professor Anita Hill to disparage each other's character regarding matters of deeply personal conduct. The battle, fought in front of the upper echelons of the white power structure, was unwinnable from the start and desired by neither combatant. Its proximate causes were the president's hypocrisy in using race to shield his effort to stack the Supreme Court with conservative judges, and the Senate's insensitivity to women's growing awareness and resentment of sexual harassment in the workplace. The hearings were a reminder of how frequently in American history blacks became the involuntary pawns in defining and resolving society's serious social issues. Recall that blacks' rights were sacrificed when the framers built slavery into the Constitution in 1787 to enable the forming of a new and stronger government. Their rights were sacrificed again in the Hayes-Tilden Compromise of 1877 to avoid another civil war. 73 Clarence Thomas, a black man who overcame humble beginnings and gained professional eminence by embracing the self-help ideology of those who have aided his climb, became a symbol of the crumbling of the judicial nomination process, in which conservatism is more important than professional eminence. Anita Hill, a silenced victim of alleged unwanted sexual overtures of a former supervisor and mentor, became the unwilling agent through which opponents of the nominee hoped to block President Bush's plan to stack the court with his followers. Rather than face repetition of the embarrassing and trauma-filled confirmation process, the administration and the Senate likely will try to avoid another grueling battle if a Supreme Court seat becomes vacant in the future. And as a result of the hearings' focus on the meaning of sexual harassment in the workplace, many men, particularly at the professional level, will $306. Speak with considerable thought about matters of sexuality to female colleagues and subordinates. Both reforms are much needed. As in the Reconstruction era, blacks will serve as the involuntary sacrifices whose victimization helps to point white society and their country in the right direction. Beyond symbolism, though, the message of the Thomas appointment virtually demands that equality advocates reconsider their racial goals. This is not, as some may think, an overreaction to a temporary setback in the long march to freedom that blacks have been making since far before the Emancipation Proclamation. Rather, the event is both a reminder and a warning of the vulnerability of black rights and of the willingness of powerful whites to sacrifice and subvert these rights in furtherance of political or economic ends. I speak here not of some new prophetic revelation. Rather, these are frequently stated yet seldom acknowledged truths that we continue to ignore at our peril. What was it about our reliance on racial remedies that may have prevented us from recognizing that abstract legal rights, such as equality, could do little more than bring about the cessation of one form of discriminatory conduct, which soon appeared in a more subtle though no less discriminatory form? I predict that this examination will require us to redefine goals of racial equality and opportunity to which blacks have adhered with far more simple faith than hard-headed reflection. I would urge that we begin this review with a statement that many will wish to deny, but none can refute. It is this: black people will never gain full equality in this country. Even those Herculean efforts we hail as successful will produce no more than temporary peaks of progress, short LVED victories that slide into irrelevance as racial patterns adapt in ways that maintain white dominance. This one's a hard-to-accept fact that all history verifies. We must acknowledge it and move on to adopt policies based on what I call racial realism. This mindset or philosophy requires us to acknowledge the permanence of our subordinate status. That acknowledgement enables us to avoid despair and frees us to imagine and implement racial strategies that can bring fulfillment and even triumph. Legal precedents we thought permanent have been overturned, distinguished, or simply ignored. All too many of the black people we sought to lift through law from a subordinate status to equal opportunity are more deeply mired in poverty and despair than they were during the separate but equal era. Despite our successful effort to strip the law's endorsement from the hated Jim Crow signs, contemporary color barriers are less visible but no less real or less oppressive. Today, one can travel for thousands of miles across this country and never come across a public facility designated for colored or white. Indeed, the very absence of visible signs of discrimination creates an atmosphere of racial neutrality which encourages whites to believe that racism is a thing of the past. Today, blacks experiencing rejection for a job, a home, a promotion anguish over whether race or individual failing prompted their exclusion. Either conclusion breeds frustration and eventually despair. We call ourselves African Americans, but despite centuries of struggle, none of us, no matter our prestige or position, is more than a few steps away from a racially motivated exclusion, restriction, or affront. There is little reason to be shocked at my prediction that blacks will not be accepted as equals, a status that has eluded us as a group for more than 300 years. The current condition of most blacks provides support for this position. It is surely possible to use statistics to distort, and I do wish for revelations showing that any of the dreadful data illustrating the plight of so many black people is false or misleading. Yet there is little effort to discredit the shocking disparities contained in these reports. Even so, the reports have little effect on policymakers or the society in general. Statistics and studies reflect racial conditions that transformed the "we have a dream" mentality of the 60s into the trial by racial ordeal so many blacks are suffering in the 90s. The adverse psychological effects of non-existent opportunity are worse than the economic end. Racial Realism 307. Social Loss. As the writer Maya Angelou put it recently, in these bloody days and frightful nights when an urban warrior can find no face more despicable than his own, no ammunition more deadly than self-hate, and no target more deserving of his true aim than his brother, we must wonder how we came so late and lonely to this place. As a veteran of a civil rights era that is now over, I regret the need to explain what went wrong. Clearly, we need to examine what it was about our reliance on racial remedies that may have prevented us from recognizing that these legal rights could do little more than bring about the cessation of one form of discriminatory conduct, which soon appeared in a more subtle though no less discriminatory form. The question is whether this examination requires us to redefine goals of racial equality and opportunity to which blacks have adhered for more than a century. The answer must be a resounding yes. Traditional civil rights law is highly structured and founded on the belief that the Constitution was intended, at least after the Civil War amendments, to guarantee equal rights to blacks. The belief in eventual racial justice, and the litigation and legislation based on that belief, was always dependent on the ability of believers to remain faithful to their creed of racial equality while rejecting the contrary message of discrimination that survived their best efforts to control or eliminate it. Despite the realist challenge that demolished its premises, the basic formalist model of law survives, although in bankrupt form. Bakke, as well as numerous other decisions that thwart the use of affirmative action and set-aside programs, illustrates that notions of racial equality fit conveniently into the formalist model of jurisprudence. Thus, a judge may advocate the importance of racial equality while arriving at a decision detrimental to black Americans. In fact, racial equality can be used to keep blacks out of institutions of higher education, such as the one at issue in Bakke. By reasoning that race-conscious policies derogate the meaning if racial equality, a judge can manipulate the law and arrive at an outcome based upon her worldview, to the detriment of blacks seeking enrollment. The message the formalist model conveys is that existing power relations in the real world are by definition legitimate and must go until /a lengd. Equality theory also necessitates such a result. Nearly every critique the realists launched at the formalists can be hurled at advocates of liberal civil rights theory. Precedent, rights theory, and objectivity merely are formal rules that serve a covert purpose. Even in the context of equality theory, they will never vindicate the legal rights of black Americans. Outside of the formalistic logic in racial equality cases, history should also trigger civil rights advocates to question the efficacy of equality theory. After all, it is an undeniable fact that the Constitution's framers initially opted to protect property, including enslaved Africans in that category, through the Fifth Amendment. Those committed to racial equality also had to overlook the political motivations for the Civil War amendments, self-interested motivations almost guaranteeing that when political needs changed, the protection provided the former slaves would not be enforced. Registered analogize this situation with that presented in Bakke. Arguably the court ruled as it did because of the anti-affirmative action rhetoric sweeping the political landscape. In conformation with past practice, protection of black rights is now predictably episodic. For these reasons, both the historic pattern and its contemporary replication require review and replacement of the now-defunct, racial equality ideology. Racism translates into a societal vulnerability of black people that few politicians including our last two presidents seem able to resist. And why not? The practice of using blacks as scapegoats for failed economic or political policies works every time. The effectiveness of this racial bonding by whites requires that blacks seek a new and more realistic goal for our civil rights activism. It is time we concede that a commitment to racial equality merely perpetuates our disempowerment. Rather, we need a mechanism to make life bearable in a society where blacks are a permanent, subordinate class. Our empowerment lies in recognize. 308ing that racial realism may open the gateway to attaining a more meaningful status. Some blacks already understand and act on the underlying rationale of racial realism. Unhappily, most black spokespersons and civil rights organizations remain committed to the ideology of racial equality. Acceptance of the racial realism concept would enable them to understand and respond to recurring aspects of our subordinate status. It would free them to think and plan within a context of reality rather than idealism. The reality is that blacks still suffer disproportionately higher rates of poverty, joblessness, and insufficient health care than other ethnic populations in the United States. The ideal is that law, through racial equality, can lift them out of this trap. I suggest we abandon this ideal and move on to a fresh, realistic approach. Casting off the burden of equality ideology will lift the sights, providing a bird's-eye view of situations that are distorted by race. From this broadened perspective on events and problems, we can better appreciate and cope with racial subordination. While implementing racial realism, we must simultaneously acknowledge that our actions are not likely to lead to transcendent change and, despite our best efforts, may be of more help to the system we despise than to the victims of that system we are trying to help. Nevertheless, our realization, and the dedication based on that realization, can lead to policy positions and campaigns that are less likely to worsen conditions for those we are trying to help and more likely to remind those in power that there are imaginative, unabashed risk-takers who refuse to be trammeled upon. Yet confrontation with our oppressors is not our sole reason for engaging in racial realism. Continued struggle can bring about unexpected benefits and gains that in themselves justify continued endeavor. The fight itself has meaning and should give us hope for the future. I am convinced that there is something real out there in America for black people. It is not, however, the romantic love of integration. It is surely not the long-sought goal of equality under law, though we must maintain the struggle against racism, else the erosion of black rights will become even worse than it is now. The racial realism that we must seek is simply a hard-eyed view of racism as it is and our subordinate role in it. We must realize, as our slave forebears did, that the struggle for freedom is, at bottom, a manifestation of our humanity which survives and grows stronger through resistance to oppression, even if that oppression one's never overcome. A final remembrance may help make my point. The year was 1964. It was a quiet, heat-hushed evening in Harmony, a small black community near the Mississippi Delta. Some Harmony residents, in the face of increasing white hostility, were organizing to ensure implementation of a court order mandating desegregation of their schools the next September. Walking with Mrs. Biana McDonald, one of the organizers, up a dusty, unpaved road toward her modest home, I asked where she found the courage to continue working for civil rights in the face of intimidation that included her son losing his job in town, the local bank trying to foreclose on her mortgage, and shots fired through her living room window. "Derek," she said slowly, seriously, "I am an old woman. I lives to harass white folks." Mrs. McDonald did not say she risked everything because she hoped or expected to win out over the whites who, as she well knew, held all the economic and political power, and the guns as well. Rather, she recognized that powerless as she was, she had and intended to use courage and determination as weapons to harass white folks. Her fight, in itself, gave her strength and empowerment in a society that relentlessly attempted to wear her down. Mrs. MacDonald did not even hint that her harassment would topple whites' well-entrenched power, rather, her goal was defiance, and its harassing effect was more potent precisely because she placed herself in confrontation with her oppressors with full knowledge of their power and willingness to use it. Mrs. MacDonald avoided discouragement and defeat because at the point that she determined to resist her oppression, she was triumphant. Nothing the all-powerful whites could. Racial realism. Do to her would diminish her triumph. Mrs. MacDonald understood 25 years ago the theory that I am espousing in the 90s for black leaders and civil rights lawyers to adopt. If you remember her story, you will understand my message. Part 5. The search for an oppositional voice. 5. The search for an oppositional voice. As many essays in the foregoing chapters illustrate, critical race scholarship often contends that mainstream claims to racial and cultural neutrality improperly take as a baseline norm white cultural patterns. In this section, several critical race theorists confront the same claim in one of its most traditional domains, the implied objective, neutral, and impersonal voice of mainstream scholarship. Each of the essays in this section exemplifies the possibility of grounding a scholarly voice in the material, aesthetic, emotional, and spiritual experiences of people of color. Each starts from the assumption that the medium of expression necessarily reflects and expresses culture and meaning. All contest the very language of mainstream legal and social analysis. In addition to providing a systematic description of critical race theory, John Calmore's essay Critical Race Theory, Archie Shepp, and Fire Music presents the challenge of authenticity that blacks face when confronted with the feigned impersonality of the conventional scholarly voice. The essay itself is organized to mirror a jazz ensemble piece, as Calmore weaves together riffs on Archie Shepp, the revolutionary idea of fire music, the aspirations of critical race theory, and the articulation of a social theory of multiculturalism within which African Americans would retain cultural distinctiveness and thus remain a people. While Calmore is focused on the voice of the scholar as writer, Tanya Banks and Charles Lawrence each explore the meaning of a distinctive voice in the context of pedagogy. In Banks's narrative description of her experiences as a black woman in law school classrooms, she not only articulates the particular ways that a black woman is constructed, by reigning representational frameworks, but also subverts those categories, sometimes implicitly and sometimes as part of a self-conscious intervention into manner in which the social structure of legal education distributes power, prestige, and legitimacy. Similarly, in his article Charles Lawrence addresses the ways in which progressive scholars of color can conceive of themselves as liberation workers even within the confines of school culture. In Lawrence's description, the false objectivity of the conventional scholarly voice is mirrored by the false neutrality assumed by the reigning image of the teacher. Drawing upon the African American tradition of resistance, he offers an alternative that links the existential grounding of the narrative method with the concrete dynamics of the classroom. 315. Part 5. The search for an oppositional voice. Critical race theory, Archie Shepp, and Fire Music, securing an authentic intellectual life in a multicultural world. John O. Calmore. If you ever find yourself somewhere lost and surrounded by enemies who won't let you speak in your own language, who destroy your statues, instruments, who ban your boom ba boom, then you are in trouble. They ban your boom ba boom, you in deep trouble. Humph. Probably take you several hundred years to get out. Amory Baraka, Wise/Wise. Introduction. A. Orientation principles, oppositional cultural practice, fundamental criticism, and border crossings. This article addresses the matters of race and culture. It reacts against assumptions similar to Gunnar Myrdal's that it is to the advantage of American Negroes as individuals and as a group to become assimilated into American culture, to acquire the traits held in esteem by dominant Americans. This promise of social mobility is made in opposition to the idea that blacks and whites in the United States are inevitably tied to distinctly separate cultures. While I do not believe that distinct cultural division is inevitable, it is a persistent fact of life. Moreover, normatively I do not believe this is necessarily a bad thing. As many whites experience competitive advantage and relative prosperity over blacks, they are encouraged to believe in an imagined cultural superiority that, in turn, reinforces their conviction like that of 19th-century missionaries that our blackness is a condition from which we must be liberated. In retreat briefly during the 60s, this conviction is once again salient. This article examines its underlying assumptions and value judgments against a background in which the nation's meanings of race and social justice are being contested within a context of the increasingly complex dynamics of an evolving multicultural society, as non-European outside others press for a reinterpretation of America's common ground, shared values, and rules of the game. African American jazz music relates to my quest here. Cornel West makes a number of points about jazz appreciation which I believe reflect upon how the art form inspires my approach to scholarship, to the point that I place so much jazz stuff in a law review article. According to West, one of the reasons jazz is so appealing to large numbers of white Americans is precisely because they feel in this black musical tradition, not just black musicians but black humanity is being asserted by artists who do not look at themselves in relation to whites or engage in self-pity or white put-down. Jazz is the middle road between invisibility and anger. It is where self-confident creativity resides. Black music is paradigmatic of how black persons have best dealt with their humanity, their complexity, their good and bad, negative and positive. 316 The search for an oppositional body aspects, without being excessively preoccupied with whites. Duke Ellington, Louis Armstrong, and Coltrane were just being themselves. In the mid-60s, Archie Shepp took his fundamentally critical tenor saxophone and stepped outside the commercially laden mainstream's musical community of assumptions and voiced his dissent beyond the ways it would be tolerated within the constraints of conventional jazz. 25 or so years later, some legal scholars of color, including myself, are voicing our dissent from many of the law's underlying assumptions. It is critical race theory's basic move from bit criticism to fundamental criticism that authenticates us as intellectuals of color and legitimatizes us as exemplars of oppositional cultural practice. We are grounding critical race scholarship in a sense of reality which reflects our distinctive experiences as people of color. Race-conscious experience is a springboard from which we engage in fundamental criticism. 2 Archie Shepp, The Who and Wherefore. A. Archie Shepp, the creative intellectual, and his oppositional cultural practice as artistic expression. Archie Shepp's music reflects much of what critical race theory's legal scholarship reflects, for art denotes skill in performance, as acquired through experience and observation as well as through study. Although this is an obsolete use, art once meant learning and scholarship. In its most distinct sense, art implies a personal, unanalyzable creative imagination and power. Art is a direct cultural manifestation that synthesizes and refines a lifestyle and worldview. Critical race theory's scholarship, at its best, creates an art style that represents a fulfillment of culture. Not content to imitate white or dominant scholarship's canons, methods, and analyses, people of color are adding our own distinctly stylized dimensions to legal scholarship. As Albert Murray observes, art stylizes experience, what it objectifies, embodies, abstracts, expresses, and symbolizes is a sense of life. More specify. Cali, an art style is the assimilation in terms of which a given community, folk, or communion of faith embodies its basic attitudes toward experience. 4 Archie Shepp was born in Fort Lauderdale, Florida, in 1937, and he grew up in Philadelphia. He graduated from Goddard College in 1959 with a degree in dramatic literature. Shepp first came to popular attention in this country in the early 60s. My association with Shepp dates back to my junior year of college at Stanford, in 1966, when the university sponsored a jazz weekend and Shepp presented his music. It was one of the most moving and black reinforcing experiences of my life. Then as now, black intellect and black culture, black voices, if you will, were greatly misperceived and discounted. In college I was a token representative in what was literally an alien land, and from that position, the psychology of race compelled me to examine how values about differences were formulated and acted upon. Through Archie Shepp's Fire music I came to appreciate how the psychology of race forces us to examine behavior at the personal, interpersonal, and societal levels. Prior to college, growing up in the black Northwest community of an otherwise white Pasadena, I had never been forced to undertake such an examination, at least not rigorously, because in my small world being black was not the tight fit it proved to be in Palo Alto. Archie Shepp entered this foreign, sometimes hostile world and stood as an artistic and intellectual giant who, in no more than 2 or 3 hours, presented to me, and the predominantly white audience, a counter-dominant difference that simply had to be valued. He played his horn brilliantly and he articulated, with words like transmogrification, what his role and artistry were all about. He personified a positive contrast not only to the musical world of white America but also to the assimilationist ethic that purportedly had to be embraced and represented in order to succeed. Amari Baraka has described Shepp's music as openly agitational art meant to get people hot and make them do something about the ugliness of what is. It was meant to be a revolue. Critical Race Theory, Archie Shepp, and Fire Music, Securing an Authentic Intellectual Life 317. Shinari Art, A People's Art, Fuel for Social Transformation. Degree Critical Race Theory, as I see it, finds its finest expression when it, too, serves as fuel for social transformation. In that sense, our efforts must, while directed by critical theory, extend beyond critique and theory to lend support to the struggle to relieve the extraordinary suffering and racist oppression that is commonplace in the life experiences of too many people of color. John Coltrane, who died on July 17, 1967, is the exemplar of Fire music. Shepp said, after playing with him during the summer of 1965, that Coltrane taught people to listen beyond the expected, how to hear themselves and their times in jazz. Degree thus, like critical race theory, Fire music represented a distinctly African American approach to cultural expression, heavily influenced by an experiential perspective. The growling, raspy tenor saxophone of Archie Shepp resembled black voices of life and protest. Baraka has claimed, the most expressive black music of any given period will be an exact reflection of what the African American himself is. It will be a portrait of the black in America at that particular time. Who he thinks he is, what he thinks America or the world to be, given the circumstances, prejudices and delights of that particular America. Shepp has personified the best of this tradition. If we substitute the words legal scholarship for music in the above quotation, we begin to appreciate the depth and resonance of the current legal writing by so many people of color. B. The bebop roots of Fire music. Bebop represented a conscious step toward African and African American music that could not be commercialized by whites. Beboppers began to see themselves as artists rather than as entertainers. Major innovators of this music include Charlie Parker, Dizzy Gillespie, Thelonious Monk, Bud Powell, Max Roach, Kenny Clarke, and Charlie Christian. Many of these musicians played in the big bands of Billy Eckstine. A second line of bebop was formed by such musicians as Miles Davis, Fats Navarro, and Dexter Gordon. With origins in the blues and the bop era of the 40s, Fire music also represented a reformulation of jazz in terms of a deliberate expression of a black aesthetic that was neither effortless nor achieved instantaneously. In Blues People, Baraka explains, the direction, the initial response, which led to hard bop is more profound than its excesses. It is as much of a move within the black psyche as was the move north in the beginning of the 20th century. The idea of the Negroes having roots and that they are a valuable possession, rather than the source of ineradicable shame, is perhaps the profoundest change within the Negro consciousness since the early part of the century. It is a re-evaluation that could only be made possible by the conclusions and redress of attitude that took place in the 40s. The form and content of Negro music in the 40s recreated, or reinforced, the social and historical alienation of the Negro in America, but in the Negro's terms. By the 50s this alienation was seen by many Negro musicians not only as valuable, in the face of whatever ugliness the emptiness of the general culture served to emphasize, but as necessary. Registered sometime in the 70s, and continuing today, many African Americans lost sight of this. With this point of view and direction, however, Shep's saxophone has played the fire music toward which African American legal scholars must, by analogy, now return. At an earlier time, the oppression of the race was more universal, and, because we were in the same boat together, it was easier to know what we were against and what we were for. Now, we must deliberately stand against racist oppression and class subjugation, even though some of us may have sailed into a relatively safe harbor. See Fire Music Contextualized. Frank Kofsky has analyzed the revolutionary music, the fire music that came out of the 60s, and he demonstrates that developments in that music paralleled the developments in the black community, developments that were characterized by black nationalism, the return to African roots, and increasing expressions of militancy. He argues that this music did not evolve in an aesthetic vacuum but, rather, reflected the social history of urban blacks in 318 The Search for an Oppositional Body America. At the time, many of the primary jazz innovators were expressing and anticipating black ghetto moods, emotions, and aspirations. He thus introduced his book with the normative assertion of Archie Shepp: the Negro musician is a reflection of the Negro people as a social phenomenon. His purpose ought to be to liberate America aesthetically and socially from its inhumanity. Just as some have questioned the distinctive voice of critical race theory, jazz critics sought to devalue the music of Shepp and other blacks who had departed from the mainstream. These critics argued that jazz is not primarily an African American art form because anyone can learn to play it. Jazz has no particular social content specifically, it in no way pertains more closely to black experiences, perceptive modes, sensibilities, and so on, than it does to white. 1. It is of course true that whites play jazz. Indeed, groups led by Archie Shepp often included important white musicians, such as bassist Charlie Hayden and trombonist Russell Rudd. Moreover, many of the most famous and commercially successful jazz musicians have been white: Dave Brubeck, Bob James, Stan Getz, David Sanborn, Bill Evans, Gary Mulligan, Chet Baker, Benny Goodman, and Stan Kenton come to mind. But the jazz that whites play has historically been very different from that played by blacks. Much jazz innovation has been led by black artists whose music was influenced by their experience of living in a black world segregated from white society. For example, a Langston Hughes poem explains bop music's derivation as follows. "You must not know where bop comes from," said Simple, astonished at my ignorance. "I do not know," I said. "Where?" "From the police," said Simple. "What do you mean, from the police?" "From the police beating Negroes' heads," said Simple. "Every time a cop hits a Negro with his billy club, that old club says, bop, bop, bebop, mop, bop. That Negro hollers, Oolyaku, Ouoo. Old cop just keeps on, mop, mop, bebop, mop. That's where bebop came from, beaten right out of some Negro's head into them horns and saxophones and piano keys that plays it." Degree. The contention that the fire music of the 60s was either anti-jazz or devoid of social content is myopic. As Shepp says, some of us jazz musicians are more bitter about the way things are going. We are only an extension of that entire civil rights black Muslims black nationalist movement that is taking place in America. That is fundamental to music. By relying on an identification with urban black America and by rejecting the canons of European culture, Shepp's fire music was distinctively black. And like critical race theory's readership, For many listeners it was an acquired CHES. 3. Criticat race theory themes, perspectives, and directions. A. An overview of critical race theory. Critical race theory begins with the recognition that race is not a fixed term, instead, it is a fluctuating, descente or complex of social meanings that are formed and transformed under the constant pressures of political struggle. The challenge thus presented is to examine how individual and group identities, under broadly disparate circumstances, as well as the racial institutions and social practices linked to those identities, are formed and transformed historically by actors who politically contest the social meanings of race. As a form of oppositional scholarship, critical race theory challenges the universality of white experience and judgment as the authoritative standard that binds people of color and normatively measures, directs, controls, and regulates the terms of proper thought, expression, presentment, and behavior. As represented by legal scholars, critical race theory challenges the dominant discourses on race and racism as they relate to law. The task is to identify values and norms that have been critical race theory, Archie Shepp, and fire music, guised and subordinated in the law. As critical race scholars, we thus seek to demonstrate that our experiences as people of color are legitimate, appropriate, and effective basis for analyzing the legal system and racial subordination. This process is vital to our transformative vision. This theory-practice approach, a praxis, if you will, finds a variety of emphases among those who follow it, and the concepts are now rather open and still being explored. John Brancaman provides some insight as to what makes critical race theory critical. Although he focuses on how literary criticism can foster social criticism, his critical hermeneutics can be applied to interpreting texts as I have characterized them here. He sees culture as constituting the forms of symbolization, representation, and expression through which a group secures its identity and solidarity. Culture enables a group to situate reciprocal relationships and mutual understandings while simultaneously differentiating itself from other groups with which it is interdependently linked, whether as a matter of cooperation or of antagonism. Hence, there is a tightly woven interplay between social critique, especially as oppositional cultural practice, and experiential interpretation. One's hermeneutic experience, however, does not automatically lend itself to critique. Instead, Brancaman contends that what determines whether our interpretations are socially critical or uncritical is the set of commitments we develop regarding the symbolic and social struggles between the legitimation and the opposition to domination, oppression, and injustice. So, then, critical race theory can be identified as such not because a random sample of people of color are voicing a position but, rather, because certain people of color have deliberately chosen race-conscious orientations and objectives to resolve conflicts of interpretation in acting on the commitment to social justice and anti-subordination. Drawing again from Brancaman, I contend that critical race theory can be described in part as an expression of critical hermeneutics which reflects what he characterizes as a way of appreciating the dynamics of a critical utopian interpretation of cultural practices and traditions. Securing an authentic intellectual life 319. Degree in grasping the dynamics at play here, he argues that through trying to understand the past while assuming responsibility for the future, we shape our critical relation to society as we oppose business as usual. As a result, our orientation moves us in directions both critical and anticipatory. On the one hand, we challenge the forms of domination that structure not only culture's production but also its reception. On the other, we try to identify and clarify progressive social changes whose needs arise from the symbolic world of culture, and whose realization lies in political self-organization and action. Moreover, to advance such a project, we discover the required interpretive procedures, fire music or what have you, at the point where cultural heritages and social critique converge. In sum, as critical race theorists confront the texts of America's dominant legal, social, and cultural strata, we are critical, fundamentally so, because we engage these texts in a way that counters their oppressive and subordinating features. In this endeavor we are not simply in opposition, We are not rebels without a cause. We are the new interpreters who demand of the dominant institutions a new validity, as described in the following passage from Bren-Kman. Insofar as the transmitted text comes to address new interpreters, it occasions or invites a communicative experience that is no longer contained within the horizon of the text's original context or the close circle of its original audience. As soon as the text comes to address interpreters who are differently situated historically and socially, its promise of uncoaxed mutual understanding undergoes a change. The text now makes a claim to validity that was not immanent in its original context. The new claim to validity comes from the specific, historically contingent demands for validity on the part of the interpreter's demands shaped by contemporary forms of resistance and opposition to domination and to the systematic distortions of communication which legitimate domination. Degree. Like fire music's oppositional stance, critical race theory presents not only a different methodology and grounding but also a message different from traditional race scholarship, now euphemistically known as civil rights or anti-320 discrimination scholarship. Critical race theory recombines and extends existing means of legal redress, hence, it is necessarily eclectic, incorporating what seems helpful from various disciplines, doctrines, styles, and methods. The theory attempts to extend the narrow world of traditional legal scholarship without indulging in dysfunctional deviance, instead establishing intellectual credibility, on the one hand, and reconciling the elements of effective theory and practice, on the other. Explanation arises from the particular and the personal. In contrast to traditional scholarship, the focus is much more extra-legal and contextual, less restricted by doctrinal analysis as a controlling center. It is concerned with redressing conditions of oppression and subordination which exist beyond their narrow translation into judicially recognizable claims and relief. Historical discrimination and its legacy merge more definitively and symbiotically with the present to provide the temporal context. While not abandoning a faith in rights strategy, critical race theory recognizes that such a strategy cannot be divorced from the larger economics and politics of things. It recognizes that whatever the specific issues of legal cases and controversies may be, the overriding issues of social justice and institutional legitimacy always lurk nearby. Critical race theory recognizes the inadequacy of disaggregating individual plaintiffs and causes of action from the larger context of social conflict which lies at the heart of a racist regime. Hence, formal, individualized equality of opportunity and objective norms of meritocracy can hardly serve as viable opposition to group inequality and subjective bias. Moreover, societal fault and accountability cannot be reduced to actionable claims only when evidenced by individual responsibility for intentional wrong. Finally, many adherents of critical race theory see an interlocking set of oppressions that extend beyond the singular base of race and include the bases of gender, economic class, and sexual orientation. Critical race theory attempts to construct a social reality and direct operation within it. It is a way of finding meaning within legal scholar. The search for an oppositional voice. Ship through combining language, thought, and experience. Voice is important. How voice is expressed, how voice is informed, how our voice differs from the dominant voice. Hence, critical race theory's linguistics is experiential and pragmatic, focusing on the nature of language as a social instrument, an instrument through which human beings create or constitute or stipulate a social world they may share, and then get things done with words in that world. Our voice, as heard in legal scholarship, recounts our perception, experience, and understanding of law in ways that are primarily colored, if you will, by our own unique biography and history. As people of color, we recognize the centrality of race in a social order that is maintained and perpetuated in significant ways by the rule of law. As scholars, our writing acknowledges the centrality that contextualizes our work. b. Authenticity and the existential grounding of critical race theory. The power to define ourselves and our world is radical per se. However, critical race theory also helps to erect and maintain a sense of authenticity, without which our work will probably fail to connect significantly with our community's agenda of social action. Authenticity implies trustworthiness and good faith in presentment. I associate it quite closely with integrity. According to Robert Terry, by guiding our actions, authenticity characterizes a force in our lives that allows us not only to make sense of our world but also to act purposefully within it. In this way, authenticity connotes being true to both oneself and one's world. Terry explains further, if I am untrue to the world, I lose my grasp on what is happening around and to me and thus make judgments that lead to behaviors inappropriate to situations in which I find myself. I distort what is happening to me and, because of this false diagnosis of my situation, continually make erroneous judgments. 18 Terry is analyzing racism as a source of inauthenticity in white people, their organizations, and their institutions. He distinguishes the inauthenticity of whites from the alienation of critical race theory, Archie Shepp, and fire music, Securing an Authentic Intellectual Life 321. People of color. Racism, though, particularly in integrated settings, however minimal or token, tends to move people of color from the alienated to the inauthentic. Amatsi Etsione's distinction is helpful here, for he observes that an inauthentic relation, institution, or society presents the appearance of responsiveness against the backdrop of an underlying alienating condition. While inauthentic and alienating conditions both exclude inauthentic structures, more than alienating ones, they operate to conceal their contours and to generate a feigned flexibility, or mere appearance of responsiveness. Authenticity exists where responsiveness exists and is experienced as such. The world responds to the actor's efforts, and its dynamics are comprehensible. Authenticity requires not only that the actor be conscious, committed, and hold a share of the societal power, but also that the three components of the active orientation be balanced and connected. It is the fate of the inauthentic man that what he knows does not fit what he feels, and what he affects is not what he knows or is committed to do. His world has come apart. Degree. Hence, a major theme of critical race theory reflects the colored intellectual's persistent battle to avoid being rendered inauthentic by the pressures of adapting to the white world and, instead, to take an oppositional stance by relying on one's true existential life, which is rooted in a world of color even though not stuck there. As a reflection of authenticity, critical race scholarship also rejects the traditional dictates that implore one to write and study as a detached observer whose work is purportedly objective, neutral, and balanced. In the classic sense of professing, critical race scholars advocate and defend positions. Fran Olson points out that traditional scholarship's appearance of balance presupposes a status quo baseline that hinders both understanding and social change. Critical race theory tends, in response, toward very personal expression that allows our experiences and lessons, learned as people of color, to convey the knowledge we possess in a way that is empowering to us and, it is hoped, ultimately empowering to those on whose behalf we act. Those of us who profess critical race theory are, in simplest terms, trying to be true to ourselves. And in so doing, we quest more for social transformation and self-respect than for social acceptance, scholarly citation, or, in some cases, even tenure. Critical race theory, at bottom, is a matter of existential voice. As people of color we recognize the centrality of race and write about law, its operation, its social ordering, its history, its values, and its ideological vectors in a way that reflects our different experience, insight, and views. See linking separate African American class interests. Largely as a result of the civil rights movement and the surging economy of the 60s, the black middle class more than doubled in size by 1970 and constituted 27% of all black workers. As institutions of business, industry, and higher learning presented new opportunities to African Americans, class division within the race became more pronounced. Indeed, Morton Wenger argues that dominant America's provision of instant mobility to the black middle class reflected an ideological substitution of the new petite bourgeoisie's personal achievements for class liberation. This division imposes a risk that the class situation, social orientation, and living space of black intellectuals may remove us from a strong identification with the black poor's values, interests, and needs. Thus, the question becomes, how credible is it for us as black intellectuals to speak about the black community, not to mention speaking on its behalf? Certain facts evidence bridges that enable those of us in white legal academies nonetheless to speak meaningfully about overall community betterment. As recently as 1962, few middle-class children were able to remain in that class during adulthood, and even fewer working-class children succeeded in moving up to the middle class as adults. Bart Landry explains that in the mid-70s, as a result of increased mobility opportunities, the middle class was mainly recruited from the sons and daughters of garbage collectors, assembly line workers, domestics. 322 The search for an oppositional voice. Waiters, taxicab drivers, and farmers. Asterisk. Even though during this time the passing of middle-class status from one generation to the next increased, this recruitment from the lower classes helps to explain why 80% of the present middle class is first generation. Most of us have roots extending into the neighborhoods and homes, the communities and families, where poor and working-class blacks still reside. Additionally, it is now clear that the black middle class still resides within segregated communities, even though many of its members no longer live in inner-city ghettos. The large majority of black middle-class households are in close proximity to poor blacks, and they share neighborhoods with skilled and unskilled numbers of the working class. Under these circumstances, intellectual talk of a black community is not necessarily academic. Moreover, the experiential basis of our writing need not defeat our own intragroup diversities, it need not collapse into an absurd essentialism. Generally, the life chances, experiences, and styles of blacks and whites, however, are distinctively separate, sufficiently so, indeed extremely so, to provide very different data that support certain generalizations. Critical race theory, though anti-essentialist, nonetheless emphasizes the commonalities developed from a race consciousness that recognizes, in Patricia Williams's words, that the simple matter of the color of one's skin so profoundly affects the way one is treated, so radically shapes what one is allowed to think and feel about this society, that the decision to generalize from this division is valid. Asterisk. What critical race theory expresses in this way is not a matter of essence, but certainly one of prevalence. It is not a matter of necessary, inevitable expression but, rather, one of deliberate identification and incorporation of data available from colored histories and subjugated narratives, from colored biographies and group identities. The distinctiveness of colored voices often traces back to an oppositional cultural frame of reference that is shaped by our experiences of racial stratification rather than benign race relations. Of course, African American culture is rich and extends far beyond reacting to this stratification. However, because of the long history and starkness of black-white stratification, the oppositional cultural frame of reference is a key factor that generates a distinctive voice orientation. When people of color deem phasize an individuality that tries to transcend color, when we attempt, in other words, to express valid generalizations generated out of race consciousness, we challenge the underlying inadequacy of dominant legal discourse, what Kimberly Crenshaw has labeled perspectivelessness. Trademark such a position holds that legal analysis is possible without taking into account various conflicts of individual values, experiences, and worldviews. According to Crenshaw, by stripping away the analysis of any particular cultural, political, or class characteristic, this perspectivelessness is presented as the objective, neutral legal discourse, with a corollary of colorblindness, used to reduce conflict and devalue the relevance of our particular perspectives. The concept of culture and the significance of cultural analysis. A subordinate group's cultural heritage reflects both internal and external traits and patterns that are mediated through a distinctive institutional life within its subsociatal structure. Internal traits and patterns derive directly from a shared history and value system, going to the core of the culture. External traits and patterns represent the historical vicissitudes of a group's adaptation of response to its immediate environment. The evolution of a subordinated culture's external traits and patterns often reflects a reaction to cultural containment. The issue of cultural containment manifests strange dynamics. Through marginalized experiences and perspectives, people of color who choose to do so can move, literally and figuratively, from one cultural realm to the next. Historically, African American cultural life has experienced a tension between an emphasis on maintaining and experiencing a unique self-identity, on the one hand, and an emphasis on fully participating in American society by relying on universalistic, rather than racially critical race theory, Archie Shepp, and fire music. Distinct orientations, on the other. This dialectical tension is a fundamental duality in African American life. Law, of course, is not only an instrument of social control but also a symbolic expression of dominant society. An important aspect of cultural analysis incorporates consideration of how these two characteristics of social control and symbolic expression intersect with symbolic boundaries that separate or integrate diverse peoples and cultures. Without negating the importance of force and fraud as determinants of oppression, or the social structure that supports that oppression, symbolic boundaries separate realms, creating the contexts in which meaningful thought and action can take place. The focus on symbolic boundaries, however, should not detract from concrete investigation. Viewing culture as an observable aspect of human behavior emphasizes the realities of symbolic boundaries. Beyond conceptual distinctions in people's minds, these boundaries are publicly visible in discourse, in the way in which social interaction occurs, and in tangible objects. Society expends resources in creating and maintaining them, and its activities may often reflect efforts to sharpen eroded boundaries, to redefine cultural distinctions, or as symptoms of ambiguous frameworks. Identifying these activities is a concrete task to which cultural analysis can be applied. Degree E. Cultural orientation and liberating practice. We should use culture to provide different ways of seeing the world as a prelude to socially reconstructing it. My approach here emphasizes the sociology of knowledge itself, the analysis of cultural orientation itself, and the intersection of the two. Thus, my position that culture is extremely important to critical race theory and liberating practice eschews any claim that culture maintains a super-autonomy that reduces all facets of social experience to issues of culture, and that cultural change is therefore the key to all other change. One must avoid the risk that an emphasis on cultural investigation can be misinterpreted as culturalism, which, according to Arif Derlich, is that ensemble of intellectual orientations. Securing an authentic intellectual life 323. That crystallize methods logically around the reduction of social and historical questions to abstract questions of culture. To ignore the issue of culture, however, is to remain locked in a state of cultural unconsciousness, under the control of imposed and conditioned vistas. This likely would defeat the self-conscious critical orientation that is part of the initial preparation for radical activity. The reciprocal relationship between community and culture grows more tenuous as we recognize that individuals do not belong merely to one discrete community. Marking the multiple, often overlapping communities that a person belongs to are such factors as place of birth, socialization, formal education, church, residence and work, race, ethnicity, gender and age, scholarship and readership. Thus, as a product of community, culture can be ambiguously produced and received. One way to militate against negative ambiguity is to emphasize the cultural distinctiveness that stems from our home culture. Another way is to commit to relying on that distinctiveness to resist domination and subordination. These efforts, in turn, help to identify the significance of critical race scholars as a unique intelligentsia within the legal academy. To use Duncan Kennedy's characterization, critical race scholars constitute a knowledge class of law professors who, acting individually or within self-organizing groups, work at defining their community's identity, its interests in competition and cooperation with other communities, and its possible strategies. 8. Because our effectiveness is largely determined by our access to resources that lie within white institutional hands, an emphasis on our distinctiveness is not easily accommodated within the normal arrangements and practices. How people of color adapt to this situation gives rise to conflicts in orientation, as we must emphasize whether we are more directed by assimilation or autonomy, by individual self-fulfillment or collective responsibility, by group accommodation or group resistance. Critical race scholars adopt in each case the latter orientation. To do otherwise is to accept an integrated context that reflects tokenism, gradu. 324 The search for an oppositional voicealism, and paternalism. To do otherwise is to discount too greatly the prevalence of group domination and subordination. Critical race theory is based significantly on culture, its adherents not only recognize this but emphasize it. When we assert that our voices and experiences are distinctively not white, we are also saying that we are inner-directed as to white people because we reflect distinctively colored cultural backgrounds, valuations, and frames of reference. This is so in spite of any number of border crossings that, at any given moment, may situate us more within dominant culture rather than our home cultures. How could it be otherwise unless all of the interested parties were, color, blind and amnesic? Tying critical race theory so blatantly to ideology may take us involuntarily into deep water, because the term ideology is associated with so many negatives. The ideology of critical race theory should not scare away people of color. Our ideology maps social reality in an attempt to make incomprehensible social situations meaningful, to so construe them as to make it possible to act purposefully within them. This is true whether we refer to our intellectual roles within the legal academy or to our activist roles there and outside that rarefied air. As John Brosen Childs has argued, culture represents the keystone upon which the foundation of modern African American intellectual thought has developed. Degree critical race theory can mature toward a significant representation of cultural analysis as it bears on legal values and thereby move to destroy the foundations and structures of racial subordinationis. For Critique race theory and Futruer society Rick HTS. A. The attack on cultural racism. Racism combines individual, institutional, and cultural aspects. All three facets of racism must continue to be marked as points of attack. It is cultural racism, however, that commands my attention in this writing. Dominant society relies heavily on cultural racism and stereotypes to bias both its interpretation and evaluation of the subordinated group. Cultural bias sets standards for performance in terms of the tendencies, skills, or attributes of white America, and it is against these standards that all other groups are measured. Poor performance by the members of these groups is translated into inferior capacity that represents general group traits. A second and related fundamental cultural bias is dominant society's practice of giving more value and status to areas in which white people excel or find interest than to those areas in which people of color have excelled or demonstrated aptitude or interest. Take, for example, the ways many whites characterize the suitable employee. In a recent study to assess the importance of race as a factor in hiring decisions, one interviewed employer indicated that the styles of interaction characteristic of many blacks were inappropriate to the business world. I think for most middle-class white people there's a big cultural gap between them and the culture I would call typical of many Chicago black men, and it's not something that a lot of white people are comfortable with. There's a certain type of repartee that goes on between black guys, even in this building you see it. We have a security guard and a couple of his friends that come in. I'm real uncomfortable with that. You know, I do my best to realize it's a cultural thing, but I don't like it. I don't think it's being professional, and I don't think it's the right atmosphere for a building. Another employer focused on black speech patterns and styles of dress. We have a couple of black workers. A friend of mine, one of the black secretaries who's been here several years, said, well, they're black but their soul is white and, because culturally, they're white. They do not have black accents. They do not. I think the accent is a big part of it. If someone, it doesn't matter if someone is black but they speak with the same accent as a Midwestern white person, it completely changes the perception of them. And then dress is part of it. So, you're dealing with what is almost more socio-economic prejudice than purely racial prejudice *#. A placement director focused not on styles of interaction but on styles of presentation as critical race theory, Archie Shepp, and fire music, securing an authentic intellectual life. 325. Inappropriate, complaining that a lot of the blacks still wear their hair in tons and millions of braids all over their heads. They're sort of hostile. Degree 3 in the lower skilled blue-collar and service job market, trainability rather than experience is often valued and blacks get stereotyped as untrainable and undependable. Again, it's a cultural thing. It is through dominant cultural understandings, then, that whites act out and reinforce racism as it is found in social relations, institutional arrangements, and personal behavior. Generated through culture, racism is self-generative, and thus change is difficult because the appearance of change often substitutes for substantive change. I do not want to understate the significance of personal and institutional racism, but I agree strongly with Benjamin Bowser and Raymond Hunt that if we were somehow able to separate interest group manipulated institutions from their cultural hearts, racism would lose its ideological veil, appear as exactly what it is, and thereby lose legitimacy. Degree white racism results, in part, from cultural conditioning that reinforces and in turn is reinforced by the particular actions of interest groups. Institutional arrangements are organized and manipulated by power holders in our political economy with the aim of securing maximum social control and selective privilege. As Bowser and Hunt contend, racism is an element of culture which conveniently lends itself to interest group struggles for social power. Success in gaining societal control and securing its benefits reinforces cultural racism by verifying the truth of white supremacy and buttresses its institutional bastions. Institutional racism finally compels personal racism. Degree. Through racialized colorblindness, the core civic ideals advanced today by the new racism are radically individualized opportunity based substantially on the operation of a free market economy, and minimal state intervention, particularly by the federal government. There is no need to be racist in the old sense if the reigning ideology adopts a colorblind orientation that defeats the legitimacy of group rights and the corresponding attempts to establish collective equality by imposing responsibility on the national government to redress racial subordination and structural inequality, as currently practiced and as a legacy of past state-sanctioned racism. In discussing race and reaction, Michael Omi and Howard Winant correctly point out that the new racism, which is camouflaged in code words and cultural messages, continues to subordinate those historically disadvantaged as a result of overt racism. They contend that the forces of racial reaction have seized on the notion of racial equality advanced by the racial minority movements and re-articulated its meaning for the contemporary period. Racial reaction has repackaged the earlier themes, infusing them with new political meaning and linking them to other key elements of conservative ideology. Registered. The discussion of cultural racism indicates that racial identification is a social construction of self-identification and societal determination. In all regions of the United States, black-white relations are still marked by this we-they character. Conversely, there is simultaneously at work an external, societally designated racial distinctiveness that raises the they-ness side of the duality. In this regard, many white Americans see the African American as a conflicting, contrasting conception of whites. This affects and is affected by such factors as dominant society's nullification of our distinctiveness and the delegitimation of African Americans as a group, and, at the other, more benevolent extreme, the nullification of our unique group characteristics and absorption of the group into larger society, which often takes form in socio-cultural assimilation or biological amalgamation through intermarriage. The latter route to assimilation or amalgamation has never been successfully traveled by Black America at large, although at any given time, in a variety of situations, individual blacks have tokenistically made progress this way. European ethnic groups have done much better, indeed, it is the disparate histories of African Americans and these white ethnic groups in traveling along this path that argues for a need to distinguish race from ethnicity rather than treating these categories as combined. As a civil rights promise, integration was I. 326 The search for an oppositional voice conceived as a reciprocal process whereby white and black Americans would gravitate toward each other, exchanging culture and sharing decision-making power over institutions and communications. This concept of integration was based on an appreciation of American society's culturally pluralistic nature. However, things have gone off track. As viewed by Tony Brown, the ideal of assimilation replaced the hard-fought for integration as pluralism which stemmed from a respect for differences *. In theory and fact, African Americans generally came to pursue social association with whites for its own sake, implying that inferior blacks must mix with superior whites and emulate them. A surefire formula for black failure * degree in 1897, W.E.B. Du Bois said that our destiny is not absorption by the white Americans *. Assimilation resembles the attempt to run away from ourselves, with success coming only through the negation of self, history, culture, and community. Beyond an opposition to assimilation, adherents of critical race theory must act in formally organized and also informal ways to advance a bridging project that will facilitate, among people of color, dialogue, understanding, and collaboration among our own communities. Our community relations must be broadened and deepened. Multiculturalism need not be merely an overly romanticized abstraction, it can be made to serve as a viable organizing concept for valuing diversity. After the recent disturbance in Los Angeles, a group of Asian Pacific American leaders offered a perspective on human relations that we should adopt. Los Angeles must resolve misunderstandings and hate revealed by the riots. We need mechanisms for interactive, multicultural synergy. The notion of interactive, multicultural synergy is a call not just to people of color, but to the nation. Those of us engaged in critical race theory are undertaking an ambitious commitment to personify movement intellectuals rather than established intellectuals. Because we are professionally engaged in the production of ideas or the manipulation of symbols as colored professors of law at established institutions, we must go out of our way to contribute to the ideological direction of critical social movements for rights and social justice. Critical race theory presents the opportunity not simply to carve out space to challenge established intellectuals and to reinterpret established practices. As a growing movement, it can provide opportunities for new types of intellectuals to emerge. Not only must we confront dominant society and culture's ideological right wing, but also we must contend with a growing segment of colored intellectuals who have joined that camp. These colored intellectuals are prone to suffer a race image anxiety, rely on a Eurocentric cultural frame of reference, and adopt a model of resolving racial conflict that emphasizes assimilationist and integrationist goals and value orientations. Conclusion. Through a connection with African American culture, as expressed in the Fire Music of Archie Shepp, I have tried to illustrate how critical race scholarship provides an oppositional expression that challenges oppression. In the process, white experience and judgment are rejected as paradigms against which people of color must be measured. As reality itself is contested as a culturally directed and socially constructed reference, critical race theorists are insurgents in the effort to undermine dominant, context-setting assumptions and truths. This oppositional grounding is a distinctive, experiential, and subjective orientation, which directs critical race theorists to connect politics and culture insofar as they offer alternative definitions of reality. The fundamental identity of critical race theorists also is culturally directed and socially constructed so that people of color deliberately emphasize their outside other marginality and turn it toward advantageous perspective building, intellectual presentment, ideological commitment, and concrete advocacy on behalf of those oppressed by virtue of race and, perhaps, such other interlocking factors as economic class, gender, and sexual orientation. Authenticity toward oneself and toward the world are reinforced as colored intellectuals reject critical race theory, Archie Shepp, and Fire Music, securing an authentic intellectual life. letting absorption and rely instead on cultural autonomy, even while fighting to bring oppressed peoples into the national community as American citizens or members of society who are viably integrated within the nation's structures of opportunity, power, and privilege. Recognizing oppression as a condition that directs redress, I have explicitly sought to explain oppression in terms of cultural silencing and invasion, exploitation, structured containment and expendability, and the dominant imposition of a prescribed reality. To the extent that rights assertion and exercise are viable, I have contended that, at present, the principal force of a rights strategy lies in its wedge-like rhetorical challenges that attempt to awaken a sense of injustice among both victims and victimizers. Rights are constructed as claims to power, privilege, and resources. These claims also bear on improving viable collective identity and solidarity. In a rights-driven social movement, I have argued, we must take into account not only social relations, but also cultural orientations, not only oppositional social projects, but also contested structures of oppression. At present, the development of legal doctrine associated with race law unfolds from a stony judiciary largely divorced from the needs and aspirations of people of color, people who do not unquestioningly accept the inevitability and legitimacy of their own continued oppression. To redirect dominant society and its state apparatus, I have urged an all-out attack on cultural racism. We must employ rights and social justice claims like a wedge in order to break free of dominant truths that tell lies about the colored past, present, and future. I have earnestly thought about how to end this article, rather than just stop writing. I have, however, arrived at no satisfying way to do it. Part of the difficulty, I suspect, is an audience problem. When all is said and done, this writing is probably for my children, 10-year-old Jonathan and 6-year-old Kenai, and for their rainbow of little friends, associates, and peers, who at this time cannot really appreciate fully what I have struggled to write here. Perhaps the slim hope, however, does indeed lie in cohort replacement. Asterisk. 327. The nation's pressing challenge, I think, lies in adults providing good answers to questions such as these: can this one nation under God continue as currently constituted and oriented without burning out or burning up before Jonathan, Kenai, and their group can position themselves to improve the situation? When they are able, will they still be willing, as they are now when left to their own devices, to reconcile human differences? Will they properly recognize those differences as culturally and socially constructed determinants of value which place a disproportionately high premium on whiteness, elitism, maleness, high income, or wealth? Will enough of them reject the pursuit of life, liberty, and happiness which is so constricted by a material aggrandizement secured at the expense of social relations that value people, cooperation, inclusive community, and true broad access to the realization, finally, of America's high positive ideals? Can we save the children so that they will have their chance to save the nation? 2 life stories. Reflections of one black woman. Law professor Tanya Lovell Banks. He dispute at Harvard Law School over the absence of black women from the faculty is disturbing. Particularly distressing is the use of the term role model as the articulated rationale for hiring a black woman law professor. The term role model seems soft, unlike the word mentor. A role model is a person whose behavior in a particular role is imitated by others. Most often a role model is passive, an image to be emulated. On the other hand, a mentor is more aggressively involved with protégé. The word mentor has an intellectual connotation that the term role model generally lacks. Because mentors provide some intellectual guidance, they also must be respected intellectually. Good law teachers are intellectually challenging and aggressively involved with students. Thus, the need for black women mentors/intellectuals is a better justification for hiring black women as law teachers than is the need for role models. Law faculties may not take this argument seriously because of the societal bias against all women, and black men, as intellectuals and leaders. Today there still are teachers at prominent colleges and universities who openly espouse the intellectual inferiority of blacks and all women. Arguments challenging the legitimacy of non-white intellectuals suppose the correctness of a cultural imperialism based on male-dominated, Eurocentric norms. This unicultural perspective sees different and complex human experiences as weakening rather than enriching the intellectual community. My argument for the inclusion of more women law teachers to serve as mentors/intellectuals goes beyond modeling arguments, to the very nature of the scholarly dialogue. In arguing for the inclusion of black women on law faculties, I do not pretend that there is a single set of common experiences that all black people or black women share. Nor do I contend. 330 The search for an oppositional body. That a black woman can capture the complexities or varied lifestyles, and, approaching legal issues of concern to all black women. How, varied life experiences of being black and female in a white male-dominated society affect our individual perspectives. Thus, the absence of black women from the legal landscape, especially as legal academia, impoverishes the imagination of law students and other legal academicians. There is, however, an important but subtle difference between opening the legal landscape to black women and attempting to discover, prove, and legitimate their intellectual worth. In opening the legal landscape to black women, who are generally perceived as being at the bottom of the American hierarchy, it becomes possible to open the legal landscape to all members of American society. However, any attempt to justify the inclusion of black women law professors based on some assertion of a special perspective common to all blacks, or to all black women, may be both difficult to make and politically risky, although ultimately right. If not carefully crafted, these arguments can be distorted by opponents in order to legitimate further charges regarding our intellectual inferiority. As it is, black women academics/intellectuals already occupy a precarious position in legal education. We are misfits, not fully accepted by the black or white community, and as women, we still are not full members of the feminist community. We are, as Harold Cruz characterized black intellectuals almost 30 years ago, a rootless class of displaced persons, outsiders even within our own communities. Thus, my struggle as an academic is to teach and write truthfully and accurately, despite feeling that I fit into no world. Truth-telling for me is easier with some issues, notably race, than others, especially class. I still have some discomfort with my own class background. Only lately have I come to accept that I am a third-generation college teacher. All of my grandparents attended college, and both my parents have doctoral degrees. This part of my background is unusual, even for most of my white colleagues. Although not wealthy, I grew up middle class in Black Washington, D.C., a community infamous for its class and color, literally, shades of skin color. In these respects, my background is different from that of many other black women law teachers. As with all people, there are degrees of difference among black women academics. We're part of multiple cultures based on gender, RZ race, class, region, and for some, ethnicity and sexuality. Unfortunately, the nature of traditional legal dialogue within law schools and legal education devalues life experiences. Instead, it favors the notion that bland, objectively reasoned arguments, often devoid of any humanistic concern, are the only way to convey important legal ideas. This is a one-dimensional scholarly dialogue, a cerebral discussion of law. The body of legal scholarship should be more diverse, since the law, at the very least, is two-dimensional. This second dimension, the inclusion of multiple life experiences, is missing from the legal scholarly dialogue. These excluded or devalued life experiences raise legal, social, and moral issues that are worthy of discussion and should be addressed by legal scholars because they reflect law as it operates. This second dimension is missing from classroom discussions as well. For example, my presence in the classroom and the academic community creates a potentially richer learning experience. I bring a whole segment of life experiences related to law which is missing from the legal landscape. Law teachers, like scholars, tend to ignore or minimize these experiences because they are unaware of the negative consequences of exclusion. They are unaware because law faculties are so few, especially as regards race and gender. Degree: I will use two stories to illustrate how my life experiences affect my point of view. The first story has to do with my perceived position in American society. The second story shows how my experiences influence the way I view legal issues. Recently, I discovered that most of my conversations with friends are a series of stories we tell each other. Through these stories we indirectly learn much about each other's lives, unhindered by modesty or shame. Sometimes standard English words just strung together in two life stories, Reflections of One Black Woman Law Professor 331. Logical, straightforward sentences are not always the best way to convey important legal ideas. My first story relates an experience common to almost all black people. It illustrates how black people who are unknown to whites are categorized by them only on the basis of color. I toa levator. Any Saturday afternoon I entered an elevator in a luxury condominium in downtown Philadelphia with 4 other black women law professors. We were leaving the apartment of another black woman law professor. The elevator was large and spacious. A few floors later, the door opened and a white woman in her late 50s peered in, let out a muffled cry of surprise, stepped back and let the door close without getting on. Several floors later the elevator stopped again, and the doors opened to reveal yet another white middle-aged woman, who also decided not to get on. Following the first incident, we looked at each other somewhat puzzled. After the second incident we laughed in disbelief, belatedly realizing that the 2 women seemed afraid to get on an elevator in a luxury condominium with 5 well-dressed black women in their 30s and 40s. Our laughter, the nervous laugh blacks often express when faced with the blatant or unconscious racism of white America, masked our shock and hurt. The elevator incident is yet another reminder that no matter how well-educated, well-dressed, or financially secure we may be, we are black first and thus still undesirable others to too many white Americans. It reminds me that no matter what my accomplishments, I am still perceived as less than equal and even dangerous. The elevator incident is a painful reminder that white attitudes about race have not changed, and that too often we assimilated blacks buy into these white attitudes. I used to think that whites were afraid only of black men, and I felt safe from that form of racism due to my gender. Now, I realize that any black person is threatening. Groups of black women are very threatening even to their white sisters. We are threatening even when encountered during the day in a secure building complete with a doorman. We should not have been surprised by the white women's fear, because of the dominance of fear in women's lives generally. As women we fear rape, assault, and harassment in the street or workplace. Feminist writers point out that the dominance of fear as a part of women's life experience is one way our experiences differ from men's, at least from white men's. On the other hand, though, we tend to think that only black men's lives are dominated by the experience of being feared. Yet in this instance, by virtue of color alone, we too were feared. Thus, being feared is not simply a black male experience, it is part of the black experience. However, I think some of us were surprised that we were not insulated by gender, and perhaps class, from the fear that whites have of blacks. We were instantly categorized, stripped of our individuality, well before those women waiting for the elevator had a chance to know us. We were deprived of our community of gender, and perhaps class, simply because we were classified as black at birth. It is an experience that can happen to any black woman, and in this way black women's experiences are not simply sometimes black and sometimes female. Our experiences as black women fit neither paradigm. In the elevator we were feared, but not because of being black and male. Nevertheless, as a black woman academic in America, I am constantly asked to fit within only one paradigm at a time. I am categorized as being part of a black world, or a white world, or a female world, or a world of poverty and cultural deprivation. Being so variously categorized often causes me to think about all of these worlds collectively when viewing common life experiences. My second story illustrates how this kind of thinking operates, and how it can operate in a law classroom. 2 Tuesday train ride. Always enjoy the train because it is pleasant, reasonably comfortable, usually F.I. 332 The search for an oppositional voice. Efficient, and safe. Recently, as the train pulled out of Wilmington, Delaware heading south, I glanced across the aisle and noticed that a man now occupied the window seat. I looked again because there was something about this man which set him apart from the usual train passenger. Finally, I realized that it was his dress. He had a double hood pulled over his head and that hungry and scared look I see on the faces of some homeless people I pass daily on my walk to work. The man glanced furtively at me, smiled, and seemed to relax as he removed his hood, revealing close-cut salt and pepper hair and a stubby white hint of a beard. I resumed reading, still vaguely discomforted by the passenger across the aisle. He had no baggage, and alternately chastising myself for some subconscious class bias. Suddenly, I felt someone staring at me. I looked up and glanced across the aisle and was sickened when I saw the man smiling at me as he wiggled his bared penis. Determined to stop this man from disturbing other passengers, I started to get up to find a conductor. The man, sensing I was about to betray him, also got up and mumbled something inaudible as he passed me. Like someone in a B movie, I shouted, "Stop that man. He just exposed himself." The cashier behind the refreshment counter looked up, and I repeated my alarm. A conductor met the man and escorted him to the rear car. Feeling relieved, I resumed reading until the conductor approached and asked what had happened. I related the events, and he asked what I wanted him to do with the man. It was an annoying question, since it seemed obvious that the man had committed a criminal offense, indecent exposure. Registered. It also was a typical response to a victim of a wrong which society does not take seriously. It was the same question posed to me by colleagues who had heard that a white student told classmates he asked to be transferred to another class because he was too prejudiced to be taught by a black woman. My immediate thought in that case was, how could a black person understand how to reach a white person who obviously believes and openly espouses an ideology of white supremacy? I had a similar thought when the train conductor posed the same question: how can a woman understand how to stop a man who feels compelled to expose himself to women in public places? In each instance, the question seemed both inappropriate and insulting, or at the very least, insensitive. The conductor seemed appropriately indignant. He expressed a desire to beat the man and also offered to scare him. Intellectually, I realized that neither action would solve the problem, because obviously the man was sick, so I asked what options were available. The conductor replied that I could press charges. I was non-committal, and the conductor left. Subsequently, the conductor returned with a second conductor who informed me that the man, probably homeless, had no ticket or money. The first conductor apologized and explained that there had never been such an incident on his train. But was this because no other woman had protested? Once again they asked me what I wanted done with the man. This time I quickly replied that I would be willing to press charges. There seemed no other way to stop this man from exposing himself to other women. They left only to return shortly with a third conductor. Together they explained that the law required them to put a person without a ticket off the train at the next station. No one was listening to what I wanted. When I inquired whether riding on a train without paying the fare was a crime, they responded that it was, but that the police would probably release the man and bar him from the train station. They said that the same thing would happen if I tried to press charges against the man for indecent exposure. As an alternative, they offered to hold the man until I was off the train and safely in a cab, leaving him free to expose himself to other women passengers, who might not openly object. During the 43-minute ride from Wilmington to Baltimore, many things went through my mind. Only now do I wonder if the outcome would have been different had I been a white woman. Perhaps not. After all, I am just a woman. From a feminist perspective, I viewed this man's exposed penis directed toward me, a woman unknown to him, as a sexual assault. 18. 2 Life Stories, Reflections of One Black Woman Law Professor 333. However, it would be difficult to argue that the man was attempting sexual battery, and it is doubtful that he intended to create apprehension in my mind of an immediate sexual battery. The man was simply displaying his penis, perhaps as an invitation. At one level, I have great difficulty viewing the man's action as a simple misdemeanor. Exposing one's naked body in a public setting, nudity per se, is not offensive or threatening. However, the man's conscious sexual actions directed toward me left me shaken and repulsed. They invaded my sense of privacy and safety. At another level, though, a pure feminist analysis does not fully convey my feelings. The man was old and black, and as a black person I had mixed emotions about filing a complaint against him for a sex offense. Perhaps the conductors, all white men, would have reacted differently had I been a white woman and the man black. I am keenly aware of the historical misuse of sex crimes to oppress black men in the United States. After all, I rationalized, most social science studies indicate that men who expose themselves seldom commit a more serious sex offense such as rape. 7 degree People who expose themselves in public are sick, and punishing sick people seems inherently unjust. I question the use of criminal sanctions against a mentally ill person who, theoretically, posed no real danger to society. Yet my feminist voice whispered, he does pose a real danger, look at how his actions affected you. However, I bring still another life experience to this incident which further complicates my analysis. I fear this disclosure will trouble some of my family members, but more perceptive readers might have sensed some connection anyway. My uncle, a quiet and kind man, has been mentally ill for more than 25 years, except for a short time at the onset of his illness. He has lived at home with his sister. How different his life might have been had no family member been willing to care for him. His presence in our family has affected us all. But for my family, though, my uncle might be a homeless man. The analysis of my experience on the train could easily be transferred to my criminal law class. Even raising the issue of indecent exposure in a criminal law class would be novel, since most casebooks omit minor sex offenses. I might ask students how society should treat, as opposed to categorize, a man who intentionally exposes his genitals to an unwilling onlooker in public. We could discuss how race and class often affect the ways such a law is enforced against sex offenders, or whether the victim's gender makes a difference in criminalizing conduct and in the seriousness assigned the crime. We might also explore whether women and men differ in their reaction to such conduct, and if so, whether the law recognizes that difference, especially since women are almost exclusively the victims of indecent exposure. I might ask students whether, even if they believe the act should not be criminalized, it would be kinder to file charges against the man. After all, at least he would get some meals and have a warm place to sleep for a few days. However, students might note that jails and prisons are unsafe places and argue that providing food but unsafe shelter is not a kind act. We might decide that even if jails and prisons were safe, it seems unjust and unconstitutional to deprive an individual of liberty for an act that is not criminal, merely because American society is unwilling to feed and shelter all of its members. In my seminar on disability law, I might ask students whether, assuming the man is mentally ill, institutionalization and treatment would be an appropriate means of minimizing the problem. We would discuss the constitutional restrictions on involuntary detention and treatment of mentally ill individuals. I would explain that 20 years ago many of today's homeless women and men would have been confined in mental institutions, where they would have been sheltered, fed, and clothed, although not equally. We would learn that a few received treatment, but too many were mistreated or neglected, and that as a result, deinstitutionalization proponents wanted to ensure a more humane and less restrictive environment for non-dangerous mentally ill individuals by providing community-based treatment and, where needed, shelter in group homes. 334 The search for an oppositional voice. I would ask students why the states failed to provide treatment, and why community residents resisted efforts to place group homes in their neighborhoods. I would note that without either treatment or shelter, the mentally ill, who theoretically pose no danger to themselves or to society, an assumption still open to question, roam American city streets starving and dying as an indifferent public walks by wishing they would just disappear. Students would be asked to explore why American society feels no obligation to protect and provide for the mentally ill unless they are institutionalized. I would ask students whether the presence of this mentally disturbed penniless man reflects society's failure to help all homeless people, approximately 1/3 of whom suffer from serious mental illnesses. Students would be asked to look beyond the numbers to find out more about homeless women and men, look at their age, race, class, and quality of life. We would discuss why mentally ill people are appearing in growing numbers on the streets. The presence of increasing numbers of homeless families on American streets also reflects the unwillingness of one of the wealthiest countries in the world to include food and shelter among those basic rights guaranteed by the Constitution, surely an issue for my constitutional law class. I would ask whether it matters that a disproportionate number of homeless people are women, people of color, and children who are both female and black, or whether society's indifference here reflects its indifference to important issues of race, gender, and class generally. It is this frame of reference I bring into my classroom. My life stories influence my perspective, a perspective unable to function within a single paradigm, because I am too many things at one time. My perspective often transcends race and gender and is sometimes fully or partially conscious of the complexities and intersection of race, gender, and class. It is a multiple perspective not represented in our casebooks or legal literature. The Word and the River, Pedagogy. As Scholarship as Struggle. Charles R. Lawrence, Illinois. The genesis of the article. Reflecting on what we think about and do. A. Talking to students about being a scholar. What is the role of the word, the spoken word, the preached word, the whispered in the nighttime word, the written word, the published word in the fight for black freedom? A group of students at Stanford have asked me to speak on minority scholarship, and I have begun my presentation with this quote from There Is a River, Vincent Harding's compelling and inspirational history of black radicalism in America. I have told the panel's organizers that I am neither willing nor able to attempt even a cursory description of the multifaceted work of my colleagues of color, but that I would be glad to ruminate on my own work as well as my aspirations for that work. I have recently assigned several chapters from Harding's book to one of my classes, and his portrayal of the tradition of radical teaching among dominated Africa peoples has given focus to my reflections concerning my own scholarship. I feel an immediate kinship with the tradition that Harding describes and names the word for. It is a tradition of teaching, preaching, and healing, an interdisciplinary tradition wherein healers are concerned with the soul and preachers with the pedagogy of the oppressed, a tradition that eschews hierarchy in the face of the need for all of us who seek liberation to be both teachers and students. The word is an articulation and validation of our common experience. It is a vocation of struggle against dehumanization, a practice of raising questions about reasons for oppression, an inheritance of passion and hope. The Word and the River, Pedagogy as Scholarship as Struggle. B. Understanding that preaching and practice are one. Within the Word we find two dimensions. That if one is sacrificed even in part, the other immediately suffers. There is no true word that is not at the same time a praxis degree. It is evident to me that the word requires a unity of pedagogy and scholarship, and that I should not, separate methodology from substance or objective. This was not a new idea to me, I had heard it from others and nodded my head in agreement. I had even been a practitioner of this ideal, probably more so than most. But this was nonetheless a eureka type of experience. This was a way of understanding what might enable me to transmit my experience to others. If the role of the word includes its use and value as a unifying force, a statement of protest, an expression of courage, an organizing tool, the articulation of utopian dreams or a higher law, then our methodology must inspire and advance those uses and values. If the nature of the word is that it is subjective, consciously historical, and revisionist, if it is both pragmatic, responding to the immediate necessities of survival and struggle, and poetic, responding to the immediate need of expression of feeling, if it must proceed from the specifics of experience and articulation of that experience toward the abstraction of theory, if it is reflection on action, informed by active struggle and in turn informing that struggle, if it is double-voiced, expressing the ambiguity of those who know the experience of belonging and not belonging, then our methodology must be a vehicle designed to carry out these complex and varied tasks. Our way of speaking the word, of gathering the word, of spreading the word, must be open. It must be a form that admits all comers, that does not have a dress code or a requirement that it be filed in triplicate. One of the ways I have experienced this necessary relationship between substance and methodology, between reflection and action, is through my teaching and the way my teaching informs my scholarship. In fact, my teaching. 337 as, in the broadest sense, my dialogue with others, is the chief source of nourishment for my scholarship. The word is praxis, not just in the more obvious ways the thoughtful work of a scholar provides strategy or frames new conceptual arguments for the activist lawyer or community organizer, but in the ongoing work of the scholar as teacher. By speaking and hearing the word in our classrooms, in our offices, or in community meetings, we transform our own understanding of our relationship with the world and thereby transform the world. In my teaching about law, I try to leave space for, to encourage, and to value, the articulation of feeling and experience. This is particularly important in teaching law, where the story that is told within the dominant discourse has systematically excluded the experience of people of color and other outsiders, and where we are trained to believe that the story told by those in power is a universal story. Every new and important understanding or insight that I have reached and found a way to articulate in my writing has come from dialogue with my students and with teachers. The conversations that produce theory are those which identify and articulate dissonance between existing legal theory and our individual/collective feeling and experience. Articulate descriptions of what we experience and feel must be placed alongside the descriptions produced by dominant theorists. Where there is discourse or where there are notes missing in the law's written score, our conversations must be an improvisational search for notes that are harmonious with the way we experience the world. Il. Tuesday Gertz of the Verb, a paradigm for scholars/teachers. And this part of the article I address the elements or characteristics of the paradigm I have called the word and explore how it expresses itself in both scholarship and pedagogy. In so doing, I will refer to the work of exemplary scholars, artists, teachers, and activists, keeping in mind my earlier observation that the word eschews any segregation of these roles. I begin by focusing on that part of the word that would. 338 The search for an oppositional voice. Be called scholarship in the dominant academic culture. This is that part of our work that manifests itself in a formal written product. The gift of identity, embracing subjectivity, a self-conscious commitment to a subjective perspective, is critical to the work of practitioners of the word. I will consider three separate though interrelated meanings that may be given to the term subjective, which enable and are central to our scholarship. These meanings are the following: subjective, indicate in the scholar's positioned perspective in viewing and recording social constructs; subjective, indicating non-neutrality of purpose, that the scholar embraces certain values and that hair work is avowedly political, read liberationist; subject-/tutive, indicating that the scholar places herself in the linguistic position of subject rather than object, a being capable of acting upon the world rather than as one upon whom others act. Subjectivity as positioned perspective. Most legal academics aspire to the classical scholarly paradigm of the detached, objective observer/recorder. This model envisions scholars achieving an unbiased and universal perspective by distancing themselves from the social reality they seek to describe. The word, in stark contrast, embraces positioned perspective. It recognizes the impossibility of distance and impartiality in the observation of a play in which the observers must also be actors. However, championing subjectivity is more than an acknowledgement of the existence and validity of many different and competing perspectives. Registered practitioners of the word must learn to privilege their own perspectives and those of other outsiders, understanding that the dominant legal discourse is premised upon the claim to knowledge of objective truths and the existence of neutral principles. We must free ourselves from the mystification produced by this ideology. We must learn to trust our own senses, feelings, and experiences, and to give them authority, even, or especially, in the face of dominant accounts of social reality that claim universality. Universal accounts are particularly pernicious when the assertion of universality is left unstated, as is most often the case. An exchange between two colleagues, one a white male and the other a woman of color, demonstrates both the oppressive power of the unstated, universalized premise and the liberating power of the outsider's ability to give her own positioned perspective authority. A faculty group to which I had presented my thoughts on teaching and on my race discrimination class was also developing a curriculum for lawyering for social change. We were now in our second semester of regular meetings. Two of my colleagues had taken on the burdensome and thankless task of assembling materials for the group to read and discuss in a seminar format. The third set of readings included a series of articles discussing IQ and theories about its relationship to race and poverty. The articles were highly technical scientific pieces and, with the exception of a chapter from Stephen Jay Gould's The Mismeasure of Man, were all by neoconservative authors. The cover memorandum attached to the materials reads as follows: "We thought we'd begin by continuing the discussion on Marxism, focusing on the Reich/Edwards/Gordon material. I've attached a set of readings on neoconservative theory, not because they'd necessarily come next in the actual course, but because they seem to pose a very different, but very powerful, set of pedagogical problems. Unlike the Marxist material, unfamiliar and difficult, these materials may seem quite familiar but quite offensive to a large number of the students. I'd like to discuss that problem, as well as the substantive issues. Several days before we met to discuss these materials, another member of the working group, a black woman colleague, came by my office. She was upset and concerned about the readings, particularly by their format and the cover memo that accompanied them. I shared many of her concerns and encouraged her to draft a memorandum sharing them with the group. Although the memorandum, an 11-page effort, is too long to quote in full here, the section that responded to the cover memorandum is most relevant to this. The Word and the River, Pedagogy as Scholarship as Struggle. Discussion in that it demonstrates how outsiders can be liberated by embracing a positioned perspective. Here is a very small, subtle, perhaps unconscious but devastating frame contained in the cover memo to these materials. I refer to the language that these materials may seem offensive. This is a laissez-faire, open-ended throwaway that implies that the opinions expressed herein are just opinions and that all opinions are valid or equal. While this may be true in some ultimate sense, as reflecting the truth of the speaker's world, I thought we wanted, in this course, to have a more specific political agenda. It seems to me that an important shift of reference comes about when you assume not that some might be offended but that these are offensive because there are some who are not just offended, but powerful and visible enough to have that opinion extend itself as an attribute of the materials themselves. I am offended. Therefore, these materials are offensive. It is at this point that we can begin to have a discussion about why I am offended, about what it is in these materials that has the property of offense to me. Any other stance, I think any other balance, allows the laziness of majoritarian opting out. The materials, because they might be offensive to an invisible unnamed some, therefore take on the property of might being a little bit offensive in small part. But because, after all, they only might be offensive, they could just as well take on the character of being for the most part not offensive. It is thus that materials can get manipulated imagistically rather than analytically, as though the topic were something that could be decided by a simple vote. So if a majority of people enter the class feeling that their 1.Q is higher than that of blacks, these readings, as presently constituted, will allow them to feel okay about that. Black inferiority is just one of several valid interpretations. And if most of the class is authorized to feel that way by the cues in the materials or in the presentation of them, then we have succeeded only in legitimating the status quo and in subordinating the already subordinated. I am offended. Therefore, these materials are offensive. It is these words that are revolutionary. The author has done much more than offer a different perspective on the materials. She has given her/our perspective authority, and in doing so she has shown us that we can do the same. The unstated assertion of objectivity and universality in the materials and in their presentation is made explicit and challenged. It is 339. Unmasked and revealed as a perspective that advances values and goals inimical to our own. Thus, by embracing a positioned perspective, this gifted practitioner of the word reallocated the power to define what is real. Mari Matsuda has observed that the jurisprudence of color is consciously historical and revisionist, and has identified a particularly important function of positioned perspective. Adopting a positioned perspective is to write our histories, to tell the silenced stories, the unrecorded perspectives, of our foremothers and forefathers. Historical revisionism is critical because full personhood is itself defined in part by one's authority to tell one's own story. Historians make history even as they record it. Discovering and rewriting the record reshapes history itself, and our contemporary social context is in turn changed. This becomes important to the liberating task of embracing a positioned perspective. What we see and feel today, our own perspectives and perceptions, appear distorted and unreal when they appear against the background of a history that has excluded the voices of those who have seen the world from positions most like our own. When we hear their stories, our own stories take on a contextual frame that gives them meaning. They become more comprehensible. They are easier to trust. To subjectivity as taking sides, embracing non-neutrality. If anything I do, in the way of writing novels or whatever I write, isn't about the village or the community or about you, then it isn't about anything. I am not interested in indulging myself in some private exercise of my imagination, which is to say, yes, the work must be political. Degree. The word is also subjective in the sense that it makes no claim to value neutrality. Matsuda describes the jurisprudence of people of color as pragmatist and bottom-line instrumentalist, for Freeman contrasts the result-oriented victim perspective with a perpetrator perspective that claims to seek neutral principles. 340 based on shared values but is ultimately indifferent to the condition of the victim. Degree. This is another way of saying that practitioners of the word evaluate work product, judicial opinions, legislation, organizing tactics, ideas, theory, poetry, according to the degree to which the effort serves the cause of liberation. Embracing instrumentalism, like owning one's perspective, serves a dual liberatory purpose. By keeping our politics at the forefront and measuring our work and that of others by the bottom line of results, we can be certain that theory is disciplined by purpose and guided by the needs and resulting insight of those for whom change is most urgent. An avowedly political posture also serves as an antidote to the mystifying and oppressive properties of the dominant ideology of shared values and neutral principles. This is particularly important to the scholar concerned with racial equality under circumstances in which the dominant legal ideology of equal opportunity employs the rhetoric of anti-discrimination and equal treatment to disguise the clash in values between those who are burdened by and committed to ending discriminatory conditions and those who are responsible for and benefit from those conditions. The contrast between the word's non-neutral commitment to results and dominant scholarship's professed quest for value neutrality and the identification of shared values, a quest that may well be indifferent to results, is striking in the context of faculty debates over the appropriateness of quotas and set-asides to achieve race and gender diversity on law school faculties. A student paper submitted for my race discrimination class recounts the history of students' efforts to encourage the Stanford faculty to increase the numbers of minorities and women teaching at the law school. These efforts had included several informational forums featuring the dean and members of the appointment committee, informal conversations with individual faculty members, letters to the student paper, a student-sponsored affirmative action proposal, at times referred to as student demands, and student demonstrations in the dean's office and the faculty club. The paper. The search for an oppositional voice. Also reports faculty responses to the student hiring proposal, a proposal that was submitted to the faculty by a coalition of student organizations representing minorities, women, and progressive white male students. 3. Subjectivity as standing in the position of the subject stories are important. They keep us alive. In the ships, in the camps, in the quarters, fields, prisons, on the road, on the run, underground, under siege, in the throes, on the verge, the storyteller snatches us back from the edge to hear the next chapter, in which we are the subjects. We, the hero of the tales. Our lives preserved. How it was, how it be. Passing it along in the relay. That is what I work to do, to produce stories that save our lives. I am somebody. Jesse Jackson. In this section I use the word subjectivity to indicate that as practitioners of the word we must endeavor to place ourselves in the linguistic position of subject rather than object. That is, we must be actors rather than those upon whom others act. This is, for us, an especially important understanding of subjectivity, for the language we use to describe ourselves is both evidence of how we see ourselves and part of the means whereby our self-image is shaped. Language shapes our reality even as it describes it. This, in part, was the lesson of my discussion of positioned perspective. However, I want to suggest something more than what is learned from the observation that our perceptions of the world are valid, and that the articulation of those perceptions must be privileged in the context of a discourse which objectifies and universalizes the perceptions of those who dominate that discourse. When we use language to refer to ourselves, we do more than offer another possible description of the world around us, we define ourselves and our relationship to that world. The language of self-description has been a particularly powerful and important weapon in The Word and the River, Pedagogy as Scholarship as Struggle. The Liberationist Struggle by African Americans. The absence of a collective black voice was central to the ethnocentric ideology of the European Renaissance and the Enlightenment, an ideology that denied Africans their humanity and thereby justified their enslavement. Henry Louis Gates notes that for the Enlightenment philosophers the absence of a self-portrayal, of a written history, meant that Africans had no true self-consciousness, no power to present or represent the black and terrible self, be black slave veiled in a shroud of silence, invisible not because they had no face, but rather because they had no voice. Voice, after all, presupposes a face. That alone which separates the subject from the object is, for Hegel, the absence or presence of the voice, the phenomenological voice. The blackness of invisibility is the blackness of this silence. Without a voice, the African is absent, or defaced, from history. Early practitioners of the word recognized the necessity of self-representation to combat this dehumanizing ideology that determined one's very being by presence, or lack thereof, in history and, in turn, viewed one's absence from history as proof of one's lack of consciousness. Frederick Douglass and others created the genre of slave narratives to render in horrific detail the inhumanity of the slave system, but their purpose was also to break the silence that made them objects. Gates says of the slave narratives, his written language of the ex-slave signified for someone even before it signified something. 7 degrees. Postmodern literary theorists have articulated the occurrence of this act of self-identification through language by defining subjectivity as the capacity of the speaker to posit himself as subject. Subjectivity is viewed as a fundamental property of language. It is in and through language that man constitutes himself as subject, because language alone establishes the concept of ego in reality, in its reality. Thus, language is important because its use signifies, is symbolic of, the speaker's capacity for creativity, and it is the capacity for creativity that makes us human. 341. The history of African American efforts to name ourselves, as the first enunciating act of self-definition, and of the resistance to that effort, is testimony to the importance of the symbolism of language in the political/cultural hegemony of American racism. African slaves were prohibited from using their family, ancestral, and tribal names. Instead, they were required to use the Christian names by which their masters chose to identify them. After emancipation, the practice of whites naming blacks and denying blacks the power to name themselves remained central to the system of symbols that objectified African Americans and denied their humanity. In the 20s, the NAACP launched a hard-fought campaign for the use of the word Negro, with a capital N. For too long African Americans had heard themselves called niggers, jigs, dinge, blackbirds, crows, and spooks. Colored, the word then used by respectable whites and many Negroes, was offensive in the main because whites insisted on using it. Whatever its origin, the name was now the white man's property, a word he used to name those who could not name themselves. Our insistence, in the 60s, on being called black rather than Negro was likewise an effort to assume the position of subject. Practitioners of the word must assume the position of subject. We must assert our humanity by making ourselves the heroes and heroines of our tales and by unashamedly employing I and we in our language. We must describe other subjects in our stories and, by presenting multiple points of view, subvert the closed, coherent, non-contradictory world that makes us objects. B. The gift, and burden, of second sight. Embracing duality. The universe sends me fabulous dreams. Early this morning I dreamed of a two-headed woman. Literally. Who was giving advice to people. Her knowledge was for everyone and it was all striking. While one head talked the other seemed to doze. I was so astonished. For what I realized in the dream is that two-headedness was at 1/342 time an actual physical condition and that two-headed people were considered wise. Perhaps this accounts for the adage two heads are better than 20 to 1. In 1903, W.E.B. Du Bois, in his small and powerful work The Souls of Black Folk, described the gift and burden that are inherent in the dual and conflicting heritage of all African Americans. He Negro is a sort of seventh son, born with a veil, and gifted with second sight in this American world, a world that yields him no true self-consciousness, but only lets him see himself through the revelation of the other world. It is a peculiar sensation, this double consciousness, this sense of always looking at oneself through the eyes of others, of measuring one's soul by the tape of a world that looks on in amused contempt and pity. One ever feels this two-ness in the American Negro. Two souls, two thoughts, two unreconciled strivings, two warring ideals in one dark body, whose dogged strength alone keeps it from being torn asunder. Du Bois' unconsciousness and understanding of this duality within himself was critical to his work as one of the leading practitioners of the word. He kept his two-ness before him despite the pain and anxiety it caused him. He understood that the gift of second sight was contained within and was nurtured by the burden and the pain. The first gift of our inherent duality is its revelation of the inevitability and value of positional perspective. What Du Bois described as this sense of always looking at oneself through the eyes of others gives the outsider at least two pictures of the object that is himself. As non-whites, we are constantly bombarded with more or less severe caricatures of ourselves as we are seen by whites. We cannot help contrasting these views, these perspectives, of who and what we are with our own experience. Nor can we help understanding that our own view is not universal. Those who stand wholly within the dominant culture seldom if ever hear how others view them, and they often ignore or deny those descriptions on the rare occasions when they are confronted by them. The search for an oppositional voice. Duality also engenders empathy. One can put oneself in the shoes of another and share another's experience and feeling only to the extent that one can imagine an experience other than one's own. We who experience the duality of belonging and not belonging know the possibility of different, even conflicting, experience at the same moment in time and space, and our ability to imagine experience other than our own is thus enhanced. This talent for empathy is particularly important for practitioners of the word whose ultimate task is to liberate. We must strive to understand experiences of oppression that are not our own. We must work in concert with those who experience other forms of oppression, because we cannot achieve freedom while others remain enslaved. Our duality also allows us to empathize with the oppressor. This is essential to the task of casting out that part of each of us that is a slave master. Our ability to recognize the oppressor's experience, to know it within ourselves, is also useful in our efforts to heal and reform others who participate in our oppression. When we have struggled with that part of our duality which identifies with the oppressor, we possess an empathy that helps us explain how our oppression is integrally linked to that of our oppressors. There are heavy burdens that accompany the gift of second sight, the talent for bridge building, and the skill of bilingualism. Bearing these burdens is especially stressful for people of color who work in the relative isolation of the white academy, and these burdens can become disabling if they go unrecognized or ignored. Practitioners of the word must learn to support one another in bearing these burdens, and they must learn how and when to refuse to carry the load. There is a saying among Irish poets that the translator is a traitor. Black scholars work within a tradition and discourse in which the white male voice is dominant. Much of our work is necessarily translation. We are either translating the work of our colleagues in the legal establishment for use by our brothers and sisters who seek needed, if temporary, remedies in that establishment's legal institutions, or we are translating the life experience of our broth. The word and the river, pedagogy as scholarship as struggle. ERS and sisters in the hope that broader awareness of that experience will produce new converts to the cause of liberation. However, translation is a treacherous business. Translation of the colonizer's canon spreads its hegemonic message to ears and minds that it might not otherwise have reached. I experience a strong sense of ambivalence as I help black law students to understand and work with legal doctrine. As they become fluent in this new language, I watch them internalize its assumptions and accept its descriptions and meanings. I see them lose fluency in first and second languages of understanding that they brought with them to law school. I also watch myself struggle to maintain some fluency in languages that are expressive of liberating themes. This is particularly difficult when one is submerged in an institutional and professional culture where neither these languages nor the themes they express are valued or rewarded. When, for example, I was writing my article on the intent requirement and unconscious racism, I found myself constantly struggling to maintain an integrity of both voice and substantive position. I recognized quite early on that it was my effort to speak to two audiences, the ambivalent, and potentially treacherous, role of translator that was causing me such anxiety and fueling an always lurking writer's block. In order to integrate new insights into existing theory and case law, I was forced to speak in terms that accepted by implication certain assumptions I did not share. Even when managed to remain true to my convictions, professional pressures required that I employ language and references that threatened to make my work inaccessible to a large part of the audience I most hope to reach. We must always keep in mind Du Bois' insight that it is precisely these burdens that bear the gift of second sight. We must learn not to flee to the safety of assimilation or isolationism but, rather, must learn from the war within us and use the pluralist integration of our two selves as a guiding star in our pursuit of liberation. We must strive for a single voice that does not subvert or subordinate either of ourselves, one which instead demands that 343 others recognize in our contradictory persona a paradigm for multidimensionality, for connecting understandings of our reality, understandings that reveal the complexity of social meaning and foster the fight for freedom. See the gift of storytelling. Embracing narrative. We are a tongued folk. A race of singers. Our lips shape words and rhythms which elevate our spirits and quicken our blood. What I enjoy most in my work one's the laughter and the outrage and the attention to language. Forays to the Apollo with my daddy and hanging tough on speaker's corner with my mama taught me the power of the word, the importance of the resistance tradition, and the high standards our community has regarding verbal performance. Registered. If the word is to validate and legitimate the experience of those it seeks to serve, its form as well as its content must say to our brothers and sisters that what you see, think, and feel, the way you experience life and your creative articulation of that experience, is scholarship/art is valid and of value. Storytelling, the articulation of experience and imagination in narrative, poetry, and song, is an important part of the tradition of African peoples. There is also a tradition of storytelling in the law. Litigation is highly formalized storytelling. The drafting of a contract tells the story of an agreement and future expectations. But the law's tradition of storytelling is very different from the African tradition. Where our tradition values rich contextual detail, the law excludes large parts of the story as irrelevant. Where we seek to convey the full range and depth of feeling, the law asks us to disregard emotions. Where we celebrate the specific and the personal, the law tells stories about disembodied reasonable men. Where our tradition is oral, anticipating that the story will change with each new teller and listener, the law gives primacy to the words within the four corners of the contract or evidentiary record, making time stand still and silencing the storyteller who comes with news of events or understandings that preceded or followed the written word. 344 The search for an oppositional voice. However, the most important difference in these traditions is that they embody different sets of stories. Our stories have, for the most part, not been told or recorded in the literature that is the law. Accordingly, the first reason for embracing narrative is that more of our stories must be told and heard. We remain invisible and unheard in the literature that is the evidentiary database for legal discourse, and when we are seen, in stories told by others, our images are severely distorted by the lenses of fear, bias, and misunderstanding. There is great persuasive power in narrative. Sarah Lawrence Lightfoot locates the source of this power in the story's ability to inspire feelings of commonality and connectedness among tellers, listeners, and the subjects of stories. As stories express depth and complexity. They allow for ambiguity, multiple interpretation, and refracted images. The reader or listener can be convinced and moved, by intellect and emotion. And stories are not exclusive property. One story invites another as people's words weave the tapestry of human connection. Consider the insight, the compellingly articulated non-rational knowledge, that is contained in the following student reflection pieces responding to readings I assigned in recent classes on Title II of the 1964 Civil Rights Act and on the First Amendment and racist speech. Heart of Atlanta Motel, sometimes, news travels slowly. Summer, 1965. Father, mother, brother, me. En route to New York City, by way of Gettysburg, Pennsylvania, Washington, D.C., and Annapolis, Maryland. First stop Annapolis, late, tired from hours of driving, and hungry. Hotel, after hotel, after hotel, we find simply no room for a family like mine. Brother to the rescue. Colored bellhop gives directions to the nearest colored inn, where we find club sandwiches and a good night's sleep. I could talk about how it felt to see my father go in and out of those red and brown brick buildings, in the rain, wondering how they said what they said to him, but I promised myself not to get angry the strip. Anyway, my grandfather earned a good living for many years as the proprietor of the two colored hotels in Columbus, Ohio, made profitable by the grace of segregation. What factors have made it harder to integrate the schools than to integrate the lunch counters, buses and hotels? The white folks at lunch counters work the same too long, for the same too little, while we pay, side by side, for the privilege that is not, and we pay, though the key to the hotel suite opens neither minds nor opportunity, and we pay, though the ribs in the bottom are sweet. White folks never give, only sell that which is worth less, and we pay. Protecting racist speech. Last summer, a summer associate and I drove from Memphis to Nashville to see a concert. The next morning, her car broke down just outside of Nashville, so we spent the day in a small town waiting to get it fixed. We sat in the convenience store connected to the gas station/repair shop watching customers come and go. One young woman wore a t-shirt saying, Fifth Avenue Annual Nigger Nationals. The free ride is over. Between the two lines was a drawing of a black man in chains being pulled in opposite directions by two white men on motorcycles. The black man held a banner saying, "Get back, Jack." Would Justice Black consider this addressed to or about individuals? I don't think she planned on running into me. Needless to say, we did not acknowledge each other, or any other blacks on that day. Does that matter? Why should it matter that the depiction was of a cartoonish character and not of someone in specific? Friday Night Videos, April 15, 1988. Two white comedians host. One describes the Democratic front-runners as Spanky, Buckwheat, and Alfalfa. Goes on to say that the white voters of Wisconsin finally woke up and realized they couldn't vote for Jackson because it is the White House and, after all, rules are rules. Both have a good laugh. I'm not interested in banning books or in monitoring Klan meetings, but those bastards came into my home and burned a cross right in the middle of my living room. It is this power of narrative to build bridges of validation, understanding, and empathy that makes it so powerful as an intellectual and political tool. We must flood the market with our stories. Only when these stories are told will we begin to recognize the limitations and distortions of narrowly constructed traditional legal analysis. Only as these rich and varied. The word and the river, pedagogy as scholarship as struggle. Stories are increasingly heard will we begin to shape a new public discourse. Narrative as methodology for contextualization. Stories always refer to a particular context, place, and moment. The historical and cultural setting is critical to the reader's interpretation of facts, feelings, and understandings. Much of legal analysis is both a historical and a contextual *. Human problems considered and resolved in the absence of context are often misperceived, misinterpreted, and mishandled. Yet the hazards and liabilities of non-contextual interpretation and decision-making are not experienced randomly. Blacks and others whose stories have been and are excluded from the dominant discourse are more likely to be injured by the error of non-contextual methodology. This is because the reader considering facts and abstract argument without context will inevitably provide a setting of his or her own. This imaginary, though often unacknowledged, contextualization will be based on his or her experiences or upon stories that he or she has heard. The imagined context often directly contradicts the context that would be described by the stories of individuals who are actually involved. For example, in the case of City of Richmond v. J. A. Crosenko, Justice Sandra Day O'Connor adopts an ahistorical, non-contextual analysis in finding that there was no direct evidence of race discrimination on the part of the city in letting contracts or any evidence that the city's prime contractors had discriminated against minority-owned subcontractors in declining to hear the many stories that might describe the experience of pervasive historical and contemporary racism in Richmond. Stories that would give the city's set-aside policy a compelling purpose. She substitutes stories of her own, stories told by those who have not been the victims of racism. The unarticulated, perhaps unconscious, thought process underlying her opinion goes as follows: I have not seen or heard stories of discrimination that have moved me to empathize with the black person who has been denied access to the contracting business. In fact, the stories I have heard are stories about men and 345. Women who are able to go as far as their talents and motivations will take them. Thus, Justice O'Connor is able to speculate that perhaps the dearth of minority contractors can be explained by the small number of blacks who desire to become contractors. Justice O'Connor's substitute context is also shaped by an abstract ideal, the colorblind society. Thus, implicitly she treats this ideal as if it had already been achieved. The set-aside program is placed in the setting of a society where discrimination has been eradicated. Consequently, the city must present evidence that Richmond is an aberration, an exception in this society that is free of racism. Furthermore, she warns against the creation of race consciousness in the future, raising the specter of the destruction of this already achieved ideal. If we are to bring fairness and justice to legal interpretation and discourse, those processes must be informed by the context of history and culture. Our stories must become a chief source of that contextualization. 2. Stories as text. Narrative as a form of knowing. It is not enough for us to tell our stories. We must use them as text for research and interpretation. Giving narrative form to experience creates a rich evidentiary record for analysis and assessment of complex social processes. This text will look quite different from that which has served as a ground of inquiry for research and discourse in an academy dominated by white men. This is so because new stories will be told and heard. Yet it is also essential that narrative be valued as a source of data. Degree 9. In embracing the use of narrative as cultural text, practitioners of the word must consider and employ methodologies of research and interpretation which draw upon the wealth of articulated experience and feelings contained in our stories. These methodologies must also serve to give legitimacy and authority to this way of knowing. In the white male academy, narrative is valued primarily as an instrument of private expression and self-actualization. Scientists and politicians may occasionally employ 346. The private sphere of literature as a diversionary escape, or they may find, in literary criticism, useful paradigms for the interpretation of legal or cultural text. However, narrative is most often viewed by legal scholars and other social scientists as a source of distortion rather than as a resource for understanding. Fortunately, we are not without role models in our efforts to give authority to narrative. There is a strong tradition among black scholars of wedding literary narrative to social political science. Frederick Douglass, W.E.B. Du Bois, Zora Neale Hurston, Paul Robeson, Ira Reid, and Pauli Murray all found artistic expression to be an important source of social political knowledge as well as an indispensable vehicle for sharing that knowledge. Du Bois' Souls of Black Folk is perhaps the paradigmatic example of literature as social science and political theory. Other examples include Du Bois' autobiography, Dusk of Dawn *, Degree, and the autobiographical works of Douglass, Hurston, Hughes, and Murray. Narrative is valuable as text because it is dense in the detailed and moving articulation of the teller's or subject's life experience and feeling. Paradoxically, its value as a vehicle for cultural interpretation also arises out of its capacity to create space for the reader's imagination. Patricia Williams's work is exemplary in this use of narrative. In applying the insights of critical theory to the jurisprudence of rights, she uses language and style in a self-conscious effort to unearth understandings that the law has buried in arcane vocabulary and abstraction. She says of her work, "It is not my goal merely to simplify. I hope that the result is a text that is multilayered, that encompasses the straightforwardness of real life and that reveals complexity of meaning. I am trying to create a genre of legal writing to fill the gaps of traditional legal scholarship. I would like to write in a way that reveals the intersubjectivity of legal constructions, that forces the reader both to participate in the construction of meaning and to be conscious of that process in the form of her argument." Williams presents a paradigm for its substantive themes. The search for an oppositional voice. Critiques partializing, constricting social legal construction in which rights are conceived as islands of employment and where there is no safe haven for those whose life is not described and inscribed by those islands. In making this critique, Williams seeks to practice what she preaches by employing narrative to create framework, setting, and tone that are inclusive, not exclusive. She uses words with multifaceted meanings so that different readers will bring different meanings to the text, and so that the same reader will recognize the many possibilities of meaning. She describes personal experiences, which most of her audience will have shared, to introduce analogous unshared experiences. She leaves thoughts and scenes unfinished and white space on the printed page. Her images are both powerful and muted. Her prose is both spare and dense. If these adjective pairs seem paradoxical, they are. Our own imaginations, our own experiences, provide the density that fills the space she creates. In short, narrative text facilitates our knowledge of others by its capacity for rich and complex contextual description of events and emotions. At the same time, stories leave space for interpretive intervention that furthers our ability to know ourselves and discover our interrelationship with others. 3. Poetry is not a luxury, narrative as imagination as social text. The gift of storytelling is especially precious to those who would practice the word because it is the narrative form that gives license and authority to imagination. Through stories, poems, and dreams we are able to explore inarticulate feelings and experiences and to give them name and form. Imagination is the key to our deepest insights and sympathies. It allows us to create, in the mind or in an outward form, images of things once known but absent, of things never seen in their entirety, of things actually non-existent, of things created new from diverse old elements, or of things perfected or idealized. *8 In writing about the life of W.E.B. Du Bois, Arnold Rampersad identifies Du Bois' The Word and the River, pedagogy as scholarship as struggle. Imagination as the sine qua non of his genius, and notes that it was this faculty that compelled and pervaded his life's work as a historian, sociologist, journalist, activist, teacher, and autobiographer. Rampersad presents Du Bois' life as a paradigm of the place of imagination in the practical world. Du Bois was a sometime poet, dramatist, and novelist, and while this literary work was more avocation than vocation, his work as a social scientist and activist is also suffused with poetry and narrative. Du Bois declined to see a separation between science and art, believing that such a distinction violated the integrity of intelligence, which could set no wall between one fundamental form of knowledge and another, since all belonged to the world of nature, of truth. He devoted himself to a knowledge of this world equal to the power of his mind to imagine a better one. Science, social science, historical science, the daily observations of persons, places, events became the mast to which the sail of the imaginary was lashed. *degree. The use of literature and literary criticism to inform legal analysis remains at the fringes of legal discourse but is sufficiently well represented in legal academia to be called a movement. I will suggest, however, that there are critical differences in the way the law and literature movement has used and valued stories and the paradigm that is presented in the work of Du Bois, Hurston, and Hughes. Most advocates of a literary analysis of the law view law and the humanities as two distinct enterprises distinguished in the main by different goals and purposes. The law and literature movement has advanced a number of arguments for the desirability of informing the legal enterprise with the narrative voice. One such argument is similar to one that I made earlier. Traditional legal discourse is dominated by an abstract, mechanistic, professional, and rationalist voice, a voice that would be well complemented by the concrete, empathetic, passionate, human voice of literary narrative. Thus, Julius Getman argues that legal education and scholarship are impoverished by the undervaluing of human voice. Getman stresses the value of language that uses ordinary concepts and familiar situations as an 347 adversarial tool, but also notes the power of such language in undermining the self-serving belief among academicians that their sophistication gives them a special and more authoritative perspective on legal issues. Paul Gerwards makes a different but related point by reminding us that passion, intuition, and feeling are inevitable cohabitants with reason in law, and by arguing that literature advances the legal enterprise because it nourishes the kinds of human understanding not achievable through reason alone. I agree fully with both of these observations. As I have noted earlier, though, blacks and other marginalized persons are doubly disabled by the exclusion of the narrative voice. For those of us whose story has not been told, an expansion of the scope and nature of the text has particularly important, and even revolutionary, implications. A second important theme of the law and literature movement focuses on what the law can learn from literature as a parallel form of cultural interpretation. Ronald Dworkin, the chief proponent of this theme, urges that literary criticism serve as a paradigm for the interpretation of legal texts. If the role of literary criticism is to find a way of reading a text that shows it as the best possible work of art, then by analogy interpreters of legal texts should seek the meaning that enables the text to manifest the soundest principle of social or political philosophy it can embody. This suggested use of literary interpretation as an analog for legal interpretation rests on Dworkin's vision of the unity of ethics and aesthetics in a larger cultural or social text. It is a vision that he shares with James Boyd White. White urges the integration of law and literature as a way of understanding the contingency in all intellectual, artistic, and political forms, and of knowing that writers and readers delineate and define communities and cultures through the creation and interpretation of text. These insights are valuable, but their value is limited. Indeed, they may even be counterproductive for those individuals and groups whose life experience has been largely excluded from the text. Robin West recognizes this danger when she notes that White's vision of a culture 348 shaping its ideals and moral codes through the criticism of shared constitutive texts is unduly bound by the very text he sets out to criticize. Like the community he criticizes, the critic's morality is the product of the community's texts. The result is social criticism, which is constrained and stunted by the texts it criticizes. For the constraint to which West refers is caused by the exclusion of outsiders, those whose voice is not heard and who are therefore not part of the community's constitutive and defining text. Those who are excluded from participation simply do not exist for the Whitean moral textualist. Because they do not participate as subjects in the process of critique and self-transformation, they become literally objectified. Because they are outside the community, they do not speak. Because they do not speak, they are objects. Degree this exclusion and objectification is for West, and for me, the more serious problem. If social criticism is grounded in texts that systematically exclude certain voices, then the critics will never see the excluded. They will be morally invisible. However, I am not entirely sanguine about West's proposed solution to the oppressive inadequacies of Whitean moral textualism. For it seems to me that West's different answer to the questions of how we form community and how we might form better ones does not promise more inclusion and may well perpetuate the objectification of blacks and other outsiders. West substitutes an interactive community for the community that is defined by text. She says that this community will be more inclusive because it will include those with whom we interact in non-textual ways, those we oppress and violate, and those with whom we are loving and intimate. She argues that the way to improve our non-textual interactive community is not to transform our texts, but ourselves. 48. My uneasiness with West's formulation lies not in her desire to broaden the scope of the interpretive enterprise. Rather, it derives from her reasons for abandoning the textual metaphor. In examining the oppressive objectification of textualism, West contrasts two novels. The Search for an Oppositional Voice. Mark Twain's Huckleberry Finn and Toni Morrison's Beloved. Beloved takes as its explicit subject matter the very problem with moral textualism which Huckleberry Finn only illustrates. Moral textualism objectifies by excluding those who do not participate in the production, interpretation, or criticism of a society's texts. Huckleberry Finn illustrates the problem with authorial irony, but Beloved explores and corrects it. In Beloved, the silenced and objectified communicate and become subjects. In Beloved, those on the outside of the textual community, the dead, the illiterate, the young, the foreign, the gagged, speak without speech to those on the inside. The illiterate and the linguistically incompetent impose their presence. The gagged, the excluded, and the objectified all become subjects. Beloved explores communications to, from, and among the textually excluded. When the textually excluded communicate in B/Oved, they communicate without texts. They communicate, instead, through imagery. They communicate with color, language, song, dance, and play. And body. There is a striking ambivalence in West's language here. She speaks of objects who become subjects, and yet these subjects are without speech and linguistically incompetent. The characters in Beloved communicate without texts. Instead they use color, body language, song, dance, and play. West sees that Morrison has turned Twain's objects into subjects by giving them voice, but their voice is not text. Indeed, it seems that she has done something more than simply make the observation that Dworkin's, White's, and Twain's community of critics will not hear these voices or know this is text when they see it. For even when the characters in Beloved communicate with each other, when they sing and dance for themselves, West sees them communicating without texts. West suggests that we adopt the paradigm of interactive communities because she abhors and condemns the exclusion of those without texts, degree, but I fear that in this description she has inadvertently compounded the objectification, or at best failed to escape what she calls the unbreakable circle of objectivity. Degree. The Word and the River, Pedagogy as Scholarship as Struggle. Why are Morrison's characters linguistically incompetent? Their language is rich and moving and conceptually precise. Why are song and dance atextual? I see these characters engaged in a parallel text, a text that constitutes another community in which those who are objectified by the dominant society become subjects. The speakers of this text are surely as linguistically competent as those who objectify them. West herself notes that their language expresses feelings as well as words. In fact, this community's text is broader than that of the excluding community, for while Morrison's character Sethe may not have known of the Dred Scott decision, she almost certainly understood white folks better than they understood her. My insistence that the voices of the excluded be viewed as text is more than a matter of semantics. The ability to produce text, to stand in the position of subject and tell one's own story, is central to one's humanity and one's freedom. It is central to the word. The fact that our text has been largely oral does not mean that it is not a text. Morrison becomes an exemplary practitioner of the word by her own valuing of this oral text in B/Oved. Historian Blanca Silvestrini, in discussing the use of women's stories in Caribbean historiography, speaks of the exclusion of Puerto Rican women from written texts and of the importance of valuing oral text, but most of our women did not have access to the written word. For some publishing was beyond any reasonable expectation, they lacked the power, both of making their stories thinkable in a media controlled by men and of making it appear in print. For others, like my grandmother, a large portion of the written text was inaccessible, they were not given the gift of the written word. Does this mean then that a majority of women in the Caribbean were voiceless, thus ahistorical, and without culture, or does it point to the need to revise our conceptions of what makes a voice a historical source? Asterisk. This understanding of the existence of and the need to validate a parallel text among those who are excluded and objectified by the dominant text is what separates the use of narrative by those who would practice the word from its 349 use by the mainstream of the law and literature movement. For us, the contextualization of ethical debate, the recognition of the contingency and complexity of textual meaning, and, above all, the assertion of our subjective presence as creators and interpreters of text are political acts. The practitioner of the word does not view art and literature as a privatized enterprise. No less than the social-political sciences, the arts and literature are viewed as informing and defining public discourse and morality. The way one is portrayed in literature and the way one's own stories are valued are symbolic of one's status in the culture and in the body politic. Moreover, our literature is a necessary vehicle of our liberation. Audre Lorde rightly insists that poetry is not a luxury. It is a vital necessity of our existence. It forms the quality of light within which we predicate our hopes and dreams towards survival and change, first made into language, then into idea, then into more tangible action. Poetry is the way we help give name to the nameless so it can be thought. As they become known to and accepted by us, our feelings and honest exploration of them become sanctuaries and spawning grounds for the most radical and daring of ideas. They become a safe house for that difference so necessary to change and the conceptualization of any meaningful action degree. Lorde's recognition of storytelling as the birthplace of revolutionary theory reaffirms a tradition that values the transposition of feelings and experience into language as a political discipline. The gift of the dream, embracing utopia. I heard a loud voice in the heavens, and the Spirit instantly appeared to me and said, I should arise and prepare myself, and slay my enemies with their own weapons, for the time was fast approaching when the first should be last and the last should be first. Nat Turner, 1831. I have a dream that one day this nation will rise up and live out the true meaning of its creed. I have a dream that one day on the red hills of Georgia, the sons of former slaves and the sons of I. 350 The search for an oppositional voice. Former slave owners will be able to sit down together at the table of brotherhood. I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin but by the content of their character. Martin Luther King, 1963. Perhaps the greatest gift bestowed upon THIRD-WORLDISm of the word is the gift of the dream. It is also the most elusive gift. It is both difficult to define and infrequently bestowed. Dreams are unconscious and instinctual. They are more closely related to feeling and emotion than to rational thought, more akin to matters of the spirit than to matters of science. Thus, dreaming is thought to be the occupation of religious leaders, poets, and indolents. It is hardly considered a scholarly endeavor. Yet the scholar who would also be a freedom fighter must not be afraid to dream. For dreams are by their nature liberating. Furthermore, those who are gifted with the talent of dreaming are often engaged in some way with the work of liberation. Dreamers, be they prophets, politicians, or philosophers, challenge established understandings with the new and unfamiliar. Black Americans, as a people and a culture, have been dreamers. We have valued our dreams and respected their power. As a community we have taken seriously the heightened empathy of the child born with a call. We have listened to the voices of our ancestors even when we did not know where those voices came from. We have venerated those women and men within our communities who knew how to heal psychic wounds through prayer and the laying on of hands. And there has been a special place in our hearts for those with visions of new and better futures. It is the revolutionary dreamer who is most revered in the black community. 8 Those who have enslaved and oppressed blacks have told a story of a people whose indolence, irrationality, excess of passion, and superstition justified their subordinated status. The black scholar who calls upon his colleagues to dream must be careful to distinguish his position from any that supports the stereotype of the naive primitive ruled by emotion and belief in the fantastic. In insisting upon the value of inspirational insight, I do not intend to imply that rigorous rational analysis is not a critical part of this work. Dreams, sleeping or wakeful, may inspire the breakthrough to a new paradigm, but the work of carefully and critically testing that paradigm is essential. The intersection of race and gender. As these articles illustrate, critical race theorists reject the liberal conceptualization of race as a natural category, understanding race instead to be constituted through a social process of meaning attribution in which law has played a central role. People are, as Kendall Thomas frames it, race D. A related subtheme is that one is race D in tandem with other social factors, such that one can say that being race D as a woman of color may diverge significantly from the means by which those engendered as male are race D. Yet anti-discrimination law as well as liberal race and gender politics overlook the ways that racing and engendering are interpolated. Just as race is presumed to be a natural category existing independently and apart from law, so too, other identity components are regarded as natural and mutually exclusive. The rigidity of this framework and its continued centrality in law, politics, and public policy create a host of problems that Austin, Robert, and Crenshaw explore. In Mapping the Margins, Kimberly Crenshaw presents a broad-scale structural accounting of the ways in which identity movements based on gender and racial liberation have failed to address the intersectionality of social domination, focusing on the manner in which domestic violence has been addressed both in national political discourses and in governmental policy. Crenshaw argues that the realities of black female life have been erased. Mainstream civil rights rhetoric is based on the experience of black men, while mainstream feminism has taken the life experiences of white women as the paradigm. Thus, black women are presented with the double burden of race and gender domination but have no discourse responsive to their specific position in the social landscape. Instead, they are constantly forced to divide loyalties as social conflict is presented as a choice between grounds of identity. Crenshaw called for a critical analysis that would account for the intersectional complexity of social power while also comprehending the fluid, dynamic and contested character of representational categories such as African American, and Regina Austin situates her article Le Sapphire Bound in the space constituted by the absence of legal scholarship addressing the legal problems of black women, and simultaneously, the presence of developed and often complex stereotypes about black women. Austin calls for a black feminist research agenda that would be grounded in the life circumstances of black women. Rather than reject the negative imagery around sapphiredom, she contends that black women can and should subvert the imagery by embracing it. As such, Sapphire Bound describes a process of social transformation that connects the struggle for racial liberation with the history of racial subordination as part of a shared communal history. Austin then directs her black feminist critique to Chambers v. Omaha Girls Club, a case upholding the dismissal of a black woman from her position as an inner-city youth counselor after becoming pregnant. Austin argues that the decision to fire Crystal Chambers and the opinion justifying the termination supposedly due to the message her presence would send to other teenaged girls are premised upon notions of role modeling that are as uninformed as they are subordinating. Austin shows that the reigning assumptions about black females tethers the scope of black women's reproductive freedom to white middle-class social values. Issues of reproductive freedom also serve as the focal point for Dorothy Roberts' article, Punishing Drug Addicts Who Have Babies. Roper's analysis starts from the fact that rates same between black and white pregnant women, yet black women are significantly more likely to be prosecuted for child abuse. Roberts argues that the disproportionate prosecution of black women reveals the continuing power of stereotypes that cast black women as irresponsible mothers. Roberts argues that the punitive, as opposed to therapeutic or welfare-oriented, measures directed against black mothers who use drugs is part of a larger societal process of dehumanization. In her view, social policy must be based on support for black women's reproductive autonomy. Sleda pisses ipum vlosan tig tit wa sinus nide oni bivtira and engitlave gry homers by, bream woes aliweed batons, sold frag bay rathout val du avon leovios om toa painel, I avotso erdi ig wads ra lea waben sertl. Part 6. The intersection of race and gender. Mapping the margins. Intersectionality, identity, politics, and violence against women of color. Kimberla Williams Crenshaw. Introduction. The last 2 decades, women have organized against the almost routine violence that shapes their lives. 1 Drawing from the strength of shared experience, women have recognized that the political demands of millions speak more powerfully than do the pleas of a few isolated voices. This politicization in turn has transformed the way we understand violence against women. For example, battering and rape, once seen as private, family matters, and aberrational, errant sexual aggression, are now largely recognized as part of a broad-scale system of domination that affects women as a class. This process of recognizing as social and systemic what was formerly perceived as isolated and individual has also characterized the identity politics of African Americans, other people of color, and gays and lesbians, among others. For all these groups, identity-based politics has been a source of strength, community, and intellectual development. The embrace of identity politics, however, has been in tension with dominant conceptions of social justice. Race, gender, and other identity categories are most often treated in mainstream liberal discourse as vestiges of bias or domination, that is, as intrinsically negative frameworks in which social power works to exclude or marginalize those who are different. According to this understanding, our liberatory objective should be to empty such categories of any social significance. Yet implicit in certain strands of feminist and racial liberation movements, for example, is the view that the social power in delineating difference need not be the power of domination, it can instead be the source of social empowerment and reconstruction. The problem with identity politics is not that it fails to transcend difference, as some critics charge, but rather the opposite, that it frequently conflates or ignores intragroup differences. In the context of violence against women, This illusion of difference in identity politics is problematic, fundamentally because the violence that many women experience is often shaped by other dimensions of their identities, such as race and class. Moreover, ignoring difference within groups contributes to tension among groups, another problem of identity politics which bears on efforts to politicize violence against women. Feminist efforts to politicize experiences of women and anti-racist efforts to politicize experiences of people of color have frequently proceeded as though the issues and experiences they each detail occur on mutually exclusive terrains. Although racism and sexism readily intersect in the lives of real people, they seldom do in feminist and anti-racist practices. Thus, when the practices expound identity as woman or person of color as an either/or proposition, they relegate the identity of women of color to a location that resists telling. My objective in this article is to advance the telling of that location by exploring the race and gender dimensions of violence against women of color. Contemporary feminist and anti-racist. 358. Discourses have failed to consider intersectional identities, such as women of color. Focusing on two dimensions of male violence against women, battering and rape, I consider how the experiences of women of color are frequently the product of intersecting patterns of racism and sexism * and how these experiences tend not to be represented within the discourses either of feminism or of anti-racism. Because of their intersectional identity as both women and of color within discourses shaped to respond to one or the other, women of color are marginalized within both. If in an earlier article, I used the concept of intersectionality to denote the various ways in which race and gender interact to shape the multiple dimensions of black women's employment experiences, my objective there was to illustrate that many of the experiences black women face are not subsumed within the traditional boundaries of race or gender discrimination as these boundaries are currently understood, and that the intersection of racism and sexism factors into black women's lives in ways that cannot be captured wholly by looking separately at the race or gender dimensions of those experiences. I build on those observations here by exploring the various ways in which race and gender intersect in shaping structural, political, and representational aspects of violence against women of color. I should say at the outset that intersectionality is not being offered here as some new, totalizing theory of identity. Nor do I mean to suggest that violence against women of color can be explained only through the specific frameworks of race and gender considered here. Indeed, factors I address only in part or not at all, such as class or sexuality, are often as critical in shaping the experiences of women of color. My focus on the intersections of race and gender only highlights the need to account for multiple grounds of identity when considering how the social world is constructed. I have divided the issues presented in this article into 3 categories. In part I discuss /structural intersectionality, the ways in which the location of women of color at the intersection of race and gender makes our actual experience. The intersection of race and gender. Ints of domestic violence, rape, and remedial reform qualitatively different from that of white women. I shift the focus in RAR intersectionality, where I analyze how feminized and anti-racist politics have both, paradoxically, often helped to marginalize the issue of violence against women of color. Finally, I address the implications of the intersectional approach within the broader scope of contemporary identity politics. Structural intersectionality. A. Structural intersectionality and battering. I observed the dynamics of structural intersectionality during a brief field study of battered women's shelters located in minority communities in Los Angeles. In most cases, the physical assault that leads women to these shelters is merely the most immediate manifestation of the subordination they experience. Many women who seek protection are unemployed or underemployed, and a good number of them are poor. Shelters serving these women cannot afford to address only the violence inflicted by the batterer, they must also confront the other multilayered and routinized forms of domination that often converge in these women's lives, hindering their ability to create alternatives to the abusive relationships that brought them to shelters in the first place. Many women of color, for example, are burdened by poverty, child care responsibilities, and the lack of job skills. These burdens, largely the consequence of gender and class oppression, are then compounded by the racially discriminatory employment and housing practices often faced by women of color as well as by the disproportionately high unemployment among people of color that makes battered women of color less able to depend on the support of friends and relatives for temporary shelter. Where systems of race, gender, and class domination converge, as they do in the experiences of battered women of color, intervention strategies based solely on the experiences of women who do not share the same class or race backgrounds will be of limited help to women who face different obstacles because of race and class. Such was the case in 1990 when Congress 359 amended the marriage fraud provisions of the Immigration and Nationality Act to protect immigrant women who were battered or exposed to extreme cruelty by the U.S. citizens or permanent residents these women immigrated to the United States to marry. Under the marriage fraud provisions of the Act, a person who immigrated to the United States in order to marry a U.S. citizen or permanent resident had to remain properly married for 2 years before even applying for permanent resident status registered, at which time applications for the immigrant's permanent status were required of both spouses. Predictably, under these circumstances, many immigrant women were reluctant to leave even the most abusive of partners for fear of being deported. When faced with the choice between protection from their batterers and protection against deportation, many immigrant women chose the latter. Reports of the tragic consequences of this double subordination put pressure on Congress to include in the Immigration Act of 1990 a provision amending the marriage fraud rules to allow for an explicit waiver for hardship caused by domestic violence. 1 degree Yet many immigrant women, particularly immigrant women of color, have remained vulnerable to battering because they are unable to meet the conditions established for a waiver. The evidence required to support a waiver can include, but is not limited to, reports and affidavits from police, medical personnel, psychologists, school officials, and social service agencies. For many immigrant women, limited access to these resources can make it difficult for them to obtain the evidence needed for a waiver. Cultural barriers, too, often further discourage immigrant women from reporting or escaping battering situations. Tina Shum, a family counselor at a social service agency, points out that His law sounds so easy to apply, but there are cultural complications in the Asian community that make even these requirements difficult. Just to find the opportunity and courage to call us is an accomplishment for many. The typical immigrant spouse, she suggests, may live in an extended family where several generations live together. There may be no privacy on the telephone, no opportunity to leave the house, and no understanding of public phones. 1. As a consequence, many immigrant women are wholly dependent on their husbands as their link to the world outside their homes. Immigrant women are also vulnerable to spousal violence because so many of them depend on their husbands for information regarding their legal status. Many women who are now permanent residents continue to suffer abuse under threats of deportation by their husbands. Even if the threats are unfounded, women who have no independent access to information will still be intimidated by such threats. Further, even though the domestic violence waiver focuses on immigrant women whose husbands are U.S. citizens or permanent residents, there are countless women married to undocumented workers, or are themselves undocumented, who suffer in silence for fear that the security of their entire families will be jeopardized should they seek help or otherwise call attention to themselves. Language barriers present another structural problem that often limits opportunities of non-English speaking women to take advantage of existing support services. Such barriers limit access not only to information about shelters but also to the security that shelters provide. Some shelters turn non-English speaking women away for lack of bilingual personnel and resources. These examples illustrate how patterns of subordination intersect in women's experience of domestic violence. Intersectional subordination need not be intentionally produced, in fact, it is frequently the consequence of the imposition of one burden interacting with pre-existing vulnerabilities to create yet another dimension of disempowerment. In the case of the marriage fraud provisions of the Immigration and Nationality Act, the imposition of a policy specifically designed to burden one-class immigrant spouses seeking permanent resident status exacerbated the disempowerment of those already subordinated by other structures of domination. By failing to take into account immigrant spouses' vulnerability to domestic violence, Congress positioned these 360 the intersection of race and gender. Women to absorb the simultaneous impact of its anti-immigration policy and their spouses' abuse. The enactment of the domestic violence waiver of the marriage fraud provision similarly illustrates how modest attempts to respond to certain problems can be ineffective when the intersectional location of women of color is not considered in fashioning the remedy. Cultural identity and class both affect the likelihood that a battered spouse could take advantage of the waiver. Although the waiver is formally available to all women, the terms of the waiver make it inaccessible to some. Immigrant women who are socially, culturally, or economically privileged are more likely to be able to marshal the resources needed to satisfy the waiver requirements. Those immigrant women who are least able to take advantage of the waiver, women who are socially or economically the most marginal, are the ones most likely to be women of color. Podatrika L. Intersectionality. The concept of political intersectionality highlights the fact that women of color are situated within at least two subordinated groups that frequently pursue conflicting political agendas. The need to split one's political energies between two sometimes opposing groups is a dimension of intersectional disempowerment which men of color and white women seldom confront. Indeed, their specific race and gendered experiences, although intersectional, often define as well as confine the interests of the entire group. For example, racism as experienced by people of color who are of a particular gender male tends to determine the parameters of anti-racist strategies, just as sexism as experienced by women who are of a particular race white tends to ground the women's movement. The problem is not simply that both discourses fail women of color by not acknowledging the additional issue of race or of patriarchy, but, rather, that the discourses are often inadequate even to the discrete tasks of articulating the full dimensions of racism and sexism. Because women of color experience racism in ways not always the same as those experienced by men of color and sexism in ways not always parallel to experiences of white women, anti-racism and feminism are limited, even on their own terms. Among the most troubling political consequences of the failure of anti-racist and feminist discourses to address the intersections of race and gender is the fact that, to the extent that they can forward the interest of people of color and women, respectively, one analysis often implicitly denies the validity of the other. The failure of feminism to interrogate race means that feminism's resistance strategies will often replicate and reinforce the subordination of people of color. Likewise, the failure of anti-racism to interrogate patriarchy means that anti-racism will frequently reproduce the subordination of women. These mutual alliances present a particularly difficult political dilemma for women of color. Adopting either analysis constitutes a denial of a fundamental dimension of our subordination and precludes the development of a political discourse that more fully empowers women of color. A. The politicization of domestic violence. That the political interests of women of color are obscured and sometimes jeopardized by political strategies that ignore or suppress intersectional issues is illustrated by my experiences in gathering information for this article. I attempted to review Los Angeles Police Department statistics reflecting the rate of domestic violence interventions by precinct, because such statistics can provide a rough picture of arrests by racial group, given the degree of racial segregation in Los Angeles. The LAPD, however, would not release the statistics. A representative explained that the statistics were not released, in part, because domestic violence activists both within and outside the LAPD feared that statistics reflecting the extent of domestic violence in minority communities might be selectively interpreted and publicized in ways that would undermine long-term efforts to force the LAPD to address domestic violence as a serious problem. Activists were worried that the statistics might permit opponents to dismiss domestic violence as a minority problem and, therefore, not deserving of aggressive action. OEOAE 361. The informant also claimed that representatives from various minority communities opposed the release of these statistics. They were concerned, apparently, that the data would unfairly represent black and brown communities as unusually violent, potentially reinforcing stereotypes that might be used in attempts to justify oppressive police tactics and other discriminatory practices. These misgivings are based on the familiar and not unfounded premise that certain minority groups, especially black men, have already been stereotyped as uncontrollably violent. Some worry that attempts to make domestic violence an object of political action may only serve to confirm such stereotypes and undermine efforts to combat negative beliefs about the black community. This account sharply illustrates how women of color can be erased by the strategic silences of anti-racism and feminism. The political priorities of both have been defined in ways that suppress information that could facilitate attempts to confront the problem of domestic violence in communities of color. Domestic violence and anti-racist politics. Within communities of color, efforts to stem the politicization of domestic violence are often grounded in attempts to maintain the integrity of the community. The articulation of this perspective takes different forms. Some critics allege that feminism has no place within communities of color, that the issues are internally divisive, and that they represent the migration of white women's concerns into a context in which they are not merely irrelevant but harmful. At its most extreme, this rhetoric denies that gender violence is a problem in the community and characterizes any effort to politicize gender subordination as itself a community problem. This is the position taken by Shahrazad Ali in her controversial book, The Black Man's Guide to Understanding the Black Woman. In this stridently anti-feminist tract, Ali draws a positive correlation between domestic violence and the liberation of African Americans. Ali blames the deteriorating conditions within the black community on the insubordination of black women and on the failure of black men to control them. Registered, she goes so far as to advise black men to physically chastise black women when they are disrespectful. 17 While she cautions that black men must use moderation in disciplining their women, she argues that they must sometimes resort to physical force to re-establish the authority over black women that racism has disrupted. Ali's premise is that patriarchy is beneficial for the black community, and that it must be strengthened through coercive means if necessary. 8 Yet the violence that accompanies this will to control is devastating, not just for the black women who are victimized but for the entire black community. The recourse to violence to resolve conflicts establishes a dangerous pattern for children raised in such environments and contributes to many other pressing problems. 2 It has been estimated that nearly 40% of all homeless women and children have fled violence in the home. And an estimated 63% of young men between the ages of 11 and 20 who are imprisoned for homicide have killed their mother's batterers. 22 Moreover, while gang violence, homicide, and other forms of black-on-black crime have increasingly been discussed within African American politics, patriarchal ideas about gender and power preclude the recognition of domestic violence as yet another compelling form of black-on-black crime. Efforts such as Ali's to justify violence against women in the name of black liberation are indeed extreme. 2 The more common problem is that the political or cultural interests of the community are interpreted in a way that precludes full public recognition of the problem of domestic_violence. While it would be misleading to suggest that white Americans have come to terms with the degree of violence in their own homes, it is nonetheless the case that race adds yet another dimension to sources of suppression of the problem of domestic violence within non-white communities. People of color often must weigh their interests in avoiding issues that might reinforce distorted public perceptions against the need to acknowledge and address intra-community problems. Yet the cost of suppression one seldom recognized, in part because the failure to discuss the issue shapes 362 perceptions of how serious the problem is in the first place. The controversy over Alice Walker's novel The Color Purple can be understood as an intra-community debate about the political costs of exposing gender violence within the black community. Some critics chastised Walker for portraying black men as violent brutes. One critic lambasted Walker's portrayal of Celie, the emotionally and physically abused protagonist who finally triumphs in the end, the critic contended that Walker had created in Seeley a black woman whom she couldn't imagine existing in any black community she knew or could conceive of. 44 The claim that Seeley was somehow an inauthentic character might be read as a consequence of silencing discussion of intra-community violence. Seeley may be unlike any black woman we know because the real terror experienced daily by minority women is routinely concealed in a misguided, though perhaps understandable, attempt to forestall racial stereotyping. Of course, it is true that representations of black violence, whether statistical or fictional, are often written into a larger script that consistently portrays black and other minority communities as pathologically violent. The problem, however, is not so much the portrayal of violence itself as it is the absence of other narratives and images portraying a fuller range of black experience. Suppression of some of these issues in the name of anti-racism imposes real costs. Where information about violence in minority communities is not available, domestic violence is unlikely to be addressed as a serious issue. The political imperatives of a narrowly focused anti-racist strategy support other practices that isolate women of color. For example, activists who have attempted to provide support services to Asian and African American women report intense resistance from those communities. At other times, cultural and social factors contribute to suppression. Nilda Rimonte, director of Every Woman's Shelter in Los Angeles, points out that in the Asian community, saving the honor of the family from shame is a priority. Unfortunately, this priority tends the intersection of race and gender to be interpreted as obliging women not to scream rather than obliging men not to hit. Race and culture contribute to the suppression of domestic violence in other ways as well. Women of color are often reluctant to call the police, a hesitancy likely due to a general unwillingness among people of color to subject their private lives to the scrutiny and control of a police force that is frequently hostile. There is also a more generalized community ethic against public intervention, the product of a desire to create a private world free from the diverse assaults on the public lives of racially subordinated people. The home is not simply a man's castle in the patriarchal sense it may also function as a safe haven from the indignities of life in a racist society. However, but for this safe haven in many cases, women of color victimized by violence might otherwise seek help. Poet. Lens against women of color as just another manifestation of racism. In this sense, the relevance of gender domination within the community is reconfigured as a consequence of discrimination against men. Of course, it is probably true that racism contributes to the cycle of violence. Given the stress that men of color experience in dominant society, it is therefore more than reasonable to explore the links between racism and domestic violence. Yet the chain of violence is more complex and/or beyond a single link. Racism is linked to Jamin Enjoy. When violence is understood as an acting out of being denied male power in other spheres, it seems counterproductive to embrace constructs that implicitly link the solution to domestic violence to the acquisition of greater male power. The more promising political imperative is to challenge the legitimacy of such power expectations by exposing their dysfunctional and debilitating effect on families and communities of color. Moreover, while understanding links between racism and domestic violence is an important component of any effective intervention strategy, it is also clear there is also a general tendency within anti-racist discourse to regard the problem of that women of color need not await the ultimate triumph over racism before they can expect to live violence-free lives. To race and the domestic violence lobby, not only do race-based priorities function to obscure the problem of violence suffered by women of color, feminist concerns often suppress minority experiences as well. Strategies for increasing awareness of domestic violence in the white community tend to begin by citing the commonly shared assumption that battering is a minority problem. The strategy += then focuses on demolishing this straw man. 2. Stressing that spousal abuse also occurs in the S_white community. Countless first-person stories copyright begin with a statement like, "I was not supposed to be a battered wife." That battering occurs in copyright Amilies of all races and all classes seems to BQLM9. equals an ever-present theme of anti-abuse campaigns. First-person anecdotes and studies, for example, consistently assert that battering cuts across racial, ethnic, economic, educational, and religious lines. Such disclaimers seem relevant only in the presence of an initial, widely held belief that domestic violence occurs primarily in minority or poor families. Indeed, some authorities explicitly renounce the stereotypical myths about battered women. A few commentators have even transformed the message that battering is not exclusively a problem of the poor or minority communities into a claim that it equally affects all races and classes. Yet these comments seem less concerned with exploring domestic abuse within stereotyped communities than with removing the stereotype as an obstacle to exposing battering within white middle and upper class communities. Degree efforts to politicize the issue of violence against women challenge beliefs that violence occurs only in homes of others. While it is unlikely that advocates and others who adopt this rhetorical strategy intend to exclude or ignore the needs of poor and colored women, the underlying ise_ of this seemingly universalistic appeal is to keep the sensibilities of dominant social groups focused on the experiences of those groups. Indeed, as subtly suggested by the opening comments of Senator David Boren, Democrat Oklahoma, in support of the Violence Against Women Act of 1991, the displacement of the other as the presumed victim of domestic violence works primarily as a political appeal to rally white elites. Boren said, "Violent crimes against women are not limited to the streets of the inner cities, but also occur in homes in the urban and rural areas across the country. Violence against women affects not only those who are actually beaten and brutalized, but indirectly affects all women. Today, our wives, mothers, daughters, sisters, and colleagues are held captive by fear generated from these violent crimes, held captive not for what they do or who they are, but solely because of gender." Degree rather than focusing on and illuminating how violence is disregarded when the home is somehow other, the strategy implicit in Senator Boren's remarks functions instead to politicize the problem only within the dominant community. This strategy permits white women victims to come into focus, but it does little to disrupt the patterns of neglect that permitted the problem to continue as long as it was imagined to be a minority problem. Minority women's experience of violence is ignored, except to the extent that it gains white support for domestic violence programs in the white community. Senator Boren and his colleagues no doubt believe that they have provided legislation and resources that will address the problems of all women victimized by domestic violence. Yet despite their universalizing rhetoric of all women, they were able to empathize with female victims of domestic violence only by looking past the plight of other women and by recognizing the familiar faces of their own. The strength of the appeal to protect our women must be its race and class specificity. After all, it has always been someone's wife, mother, sister, or daughter who has been abused, even when the violence was stereotypically black or brown, and poor. The point here is not that the Violence Against Women Act is particularistic on its own terms, but that unless the senators and other policymakers ask why violence remained insignificant as long as it was understood as a minority problem, it is unlikely that 364 women of color will share equally in the distribution of resources and concern. It is even more unlikely, however, that those in power will be forced to confront this issue. As long as attempts to politicize domestic violence focus on omnis whites that this is not a minority problem but share problem, any authentic and sensitive attention to the experiences of black and other minority women probably will continue to be regarded as jeopardizing the movement. While Senator Boren's statement reflects a self-consciously political presentation of domestic violence, an episode of the CBS News program 48 Hours shows how similar patterns of othering non-white women are apparent in journalistic accounts of domestic violence as well. The program presented 7 women who were victims of abuse. 6 were interviewed at some length along with their family members, friends, supporters, and even detractors. The viewer got to know something about each of these women. These victims were humanized. Yet the 7th woman, the only non-white one, never came into focus. She was literally unrecognizable throughout the segment, First introduced by photographs showing her face badly beaten and later shown with her face electronically altered in the videotape of a hearing at which she was forced to testify. Other images associated with this woman included shots of a blood-stained room and blood-soaked pillows. Her boyfriend was pictured handcuffed while the camera zoomed in for a close-up of his bloodied sneakers. Of all the presentations in the episode, hers was the most graphic and impersonal. The overall point of the segment featuring this woman was that battering might not escalate into homicide if battered women would only cooperate with prosecutors. However, in focusing on its own agenda and failing to explore why this woman refused to cooperate, the program diminished this woman, communicating, however subtly, that she was responsible for her own victimization. Unlike the other women, all of whom, again, were white, this black woman had no name, no family, no context. The viewer sees her only as victimized and uncooperative. She cries when the intersection of race and gender. Shown pictures, she pleads not to be forced to view the blood-stained room and her disfigured face. The program does not help the viewer to understand her predicament. The possible reasons she did not want to testify, fear, love, or possibly both, are never suggested. Most unfortunately, she, unlike the other 6, is given no epilogue. While the fates of the other women are revealed at the end of the episode, we discover nothing about the black woman. She, like the others she represents, is simply left to herself and soon forgotten. I offer this description to suggest that other women are silenced as much by being relegated to the margin of experience as by total exclusion. Tokenistic, objectifying, voyeuristic inclusion is at least as disempowering as complete exclusion. The effort to politicize violence against women will do little to address black and other minority women if their images are retained simply to magnify the problem rather than to humanize their experiences. Similarly, the anti-racist agenda will not be advanced significantly by forcibly suppressing the reality of battering in minority communities. As the 48 Hours episode makes clear, the images and stereotypes we fear are indeed readily available, and they are frequently deployed in ways that do not generate sensitive understanding of the nature of domestic violence in minority communities. 3. Race and domestic violence support services. Women working in the field of domestic violence have sometimes reproduced the subordination and marginalization of women of color by adopting policies, priorities, or strategies of empowerment that either elide or wholly disregard the particular intersectional needs of women of color. While gender, race, and class intersect to create the particular context in which women of color experience violence, certain choices made by allies can reproduce intersectional subordination within the very resistance strategies developed to respond to the problem. This problem is starkly illustrated by the inaccessibility of domestic violence support services for many non-English speaking women. In a letter written to the Deputy Commissioner of the New York State Department of Social Services, Diana Campos, Director of Human Services for Programas de Ocupaciones y Desarrollo Económico Real Incorporated, Poder, detailed the case of a Latina in crisis who was repeatedly denied accommodation at a shelter because she could not prove that she was English proficient. The woman had fled her home with her teenage son, believing her husband's threats to kill them both. She called the domestic violence hotline administered by Poder, seeking shelter for herself and her son. However, because most shelters would not accommodate the woman with her son, they were forced to live on the streets for 2 days. The hotline counselor was finally able to find an agency that would take both the mother and her son, but when the counselor told the intake coordinator at the shelter that the woman spoke limited English, the coordinator told her that they could not take anyone who was not English proficient. When the woman in crisis called back and was told of the shelter's rule, she replied that she could understand English if spoken to her slowly. As Campos explains, Mildred, the hotline counselor, told Wendy, the intake coordinator, that the woman said that she could communicate a little in English. Wendy told Mildred that they could not provide services to this woman because they have house rules that the woman must agree to follow. Mildred asked her, "What if the woman agrees to follow your rules? Will you still not take her?" Wendy responded that all of the women at the shelter are required to attend a support group and they would not be able to have her in the group if she could not communicate. Mildred mentioned the severity of this woman's case. She told Wendy that the woman had been wandering the streets at night while her husband is home, and she had been mugged twice. She also reiterated the fact that this woman was in danger of being killed by either her husband or a mugger. Mildred expressed that the woman's safety was a priority at this point, and that once in a safe place, receiving counseling in a support group could be dealt with. Registered. The intake coordinator restated the shelter's policy of taking only English-speaking women, and stated further that the woman would have to call the shelter herself for screening. If the woman could communicate with them in English, she might be accepted. When the woman called the Poder hotline later that day, she was in such a state of fear that the hotline counselor who had been working with her had difficulty understanding her in Spanish. The woman had been slipping back into her home during the day when her husband was at work. She remained in a heightened state of anxiety because he was returning shortly, and she would be forced to go back out into the streets for yet another night. Campos directly intervened at this point, calling the executive director of the shelter. A counselor called back from the shelter. As Campos reports, the counselor told her that they did not want to take the woman in the shelter because they felt that the woman would feel isolated. I explained that the son agreed to translate for his mother during the intake process. Furthermore, that we would assist them in locating a Spanish-speaking battered women's advocate to assist in counseling her. Marie stated that utilizing the son was not an acceptable means of communication for them, since it further victimized the victim. In addition, she stated that they had similar experiences with women who were non-English speaking, and that the women eventually just left because they were not able to communicate with anyone. I expressed my extreme concern for her safety and reiterated that we would assist them in providing her with the necessary services until we could get her placed someplace where they had bilingual staff. After several more calls, the shelter finally agreed to take the woman. The woman called once more during the negotiation. However, once a plan was in place, the woman never called back. Said Campos, after so many calls, we are now left to wonder if she is alive and well, and if she will ever have enough faith in our ability to help her to call us again the next time she is in crisis. Despite this woman's desperate need, she was unable to receive the protection afforded English-speaking women, due to the shelter's rigid commitment to exclusionary policies. Perhaps even more troubling than the shelter's lack of bilingual resources was its refusal to allow a 366 the intersection of race and gender friend or relative to translate for the woman. This story illustrates the absurdity of a feminist approach that makes the ability to attend a support group without a translator a more significant consideration in the distribution of resources than the risk of physical harm on the street. The point is not that the shelter's image of empowerment is empty but, rather, that it was imposed without regard to the disempowering consequences for women who didn't match the kind of client the shelter's administrators imagined. Thus, they failed to accomplish the basic priority of the shelter movement to get the woman out of danger. Here the woman in crisis was made to bear the burden of the shelter's refusal to anticipate and provide for the needs of non-English speaking women. Said Campos, it is unfair to impose more stress on victims by placing them in the position of having to demonstrate their proficiency in English in order to receive services that are readily available to other battered women. Asterisk. The problem is not easily dismissed as one of well-intentioned ignorance. The specific issue of monolingualism and the monistic view of women's experience that set the stage for this tragedy were not new issues in New York. Indeed, several women of color have reported that they had repeatedly struggled with the New York State Coalition Against Domestic Violence over language exclusion and other practices that marginalized the interests of women of color. 3. Yet despite repeated lobbying, the coalition did not act to incorporate the specific needs of non-white women into its central organizing vision. Some critics have linked the coalition's failure to address these issues to the narrow vision of coalition that animated its interaction with women of color in the first place. The very location of the coalition's headquarters in Woodstock, New York, an area where few people of color live, seemed to guarantee that women of color would play a limited role in formulating policy. Moreover, efforts to include women of color came, it seems, as something of an afterthought. Many were invited to participate only after the coalition was awarded a grant by the state to recruit women of color. However, as one recruit said, they were not really prepared to deal with us or our issues. They thought that they could simply incorporate us into their organization without rethinking any of their beliefs or priorities, and that we would be happy. Even the most formal gestures of inclusion were not to be taken for granted. On one occasion, when several women of color attended a meeting to discuss a special task force on women of color, the group debated all day over including the issue on the agenda. The relationship between the white women and the women of color on the board was a rocky one from beginning to end. Other conflicts developed over differing definitions of feminism. For example, the board decided to hire a Latina staff person to manage outreach programs to the Latino community, but the white members of the hiring committee rejected candidates favored by Latina committee members who did not have recognized feminist credentials. As Campos pointed out, by measuring Latinas against their own biographies, the white members of the board failed to recognize the different circumstances under which feminist consciousness develops and manifests itself within minority communities. Many of the women who interviewed for the position were established activists and leaders within their own community, a fact in itself suggesting that these women were probably familiar with the specific gender dynamics in their communities and were accordingly better qualified to handle outreach than were other candidates with more conventional feminist credentials. Degree. The coalition ended a few months later. When the women of color walked out. Many of these women returned to community-based organizations, preferring to struggle over women's issues within their communities rather than struggle over race and class issues with white middle-class women. Yet, as illustrated by the case of the Latina who could find no shelter, the dominance of a particular perspective and set of priorities within the shelter community continues to marginalize the needs of women of color. The struggle over which differences matter and which do not is neither abstract nor insignificant. Indeed, these conflicts are about more than difference as such, they raise critical issues of power. The problem is not simply that women who dominate the anti-violence movement are different from women of color, but, rather, that they frequently have the power to determine, either through material resources or rhetorical resources, whether the intersectional differences of women of color will be incorporated at all into the basic formulation of policy. Thus, the struggle over incorporating these differences is not a petty or superficial conflict about who gets to sit at the head of the table. In the context of violence, it is sometimes a deadly serious matter of who will survive and who will not. 3. B. Political intersectionalities in rape. In the previous sections, I have used intersectionality to describe or frame various relationships between race and gender. I have used it as a way to articulate the interaction of racism and patriarchy generally. I have also used intersectionality to describe the location of women of color both within overlapping systems of subordination and at the margins of feminism and anti-racism. When race and gender factors are examined in the context of rape, intersectionality can be used to map the ways in which racism and patriarchy have shaped conceptualizations of rape, to describe the unique vulnerability of women of color to these converging systems of domination, and to track the marginalization of women of color within anti-racist and anti-rape discourses. Registered. Racism and sexism in dominant conceptualizations of rape. Generations of critics and activists have criticized dominant conceptualizations of rape as racist and sexist. These efforts have been important in revealing the way in which representations of rape both reflect and reproduce race and gender hierarchies in American society. Black women, at once women and people of color, are situated within both groups, each of which has benefited from challenges to sexism and racism, respectively, yet the particular dynamics of gender and race relating to the 367 rape of black women have received scant attention. Although anti-racist and anti-sexist assaults on rape have been politically useful to black women, at some level, The monofocal anti-racist and feminist critiques have also produced a political discourse that disserves black women. Historically, the dominant conceptualization of rape as quintessentially involving a black offender and a white victim has left black men subject to legal and extra-legal violence. The use of rape to legitimize efforts to control and discipline the black community is well established, and the casting of all black men as potential threats to the sanctity of white womanhood is a familiar construct that anti-racists confronted and attempted to dispel over a century ago. Feminists have attacked other dominant, essentially patriarchal, conceptions of rape, particularly as represented through law. The early emphasis of rape law on the property-like aspect of women's chastity resulted in less solicitude for rape victims whose chastity had been in some way devalued. Some of the most insidious assumptions were written into the law, including the early common law notion that a woman alleging rape must be able to show that she resisted to the utmost in order to prove that she was raped rather than seduced. Women themselves were put on trial, as judge and jury scrutinized their lives to determine whether they were innocent victims or women who essentially got what they were asking for. Legal rules thus functioned to legitimize a good/bad woman dichotomy, and women who led sexually autonomous lives were usually the least likely to be vindicated if they were raped. Today, long after the most egregious discriminatory laws have been eradicated, constructions of rape in popular discourse and in criminal law continue to manifest vestiges of these racist and sexist themes. As Valerie Smith notes, a variety of cultural narratives that historically have linked sexual violence with racial oppression continue to determine the nature of public response to interracial rapes. Smith reviews the well-publicized case of a jogger who was raped in New York's Central Park to expose how the public discourse on the assault made the story. 368 The intersection of race and gender. Of sexual victimization inseparable from the rhetoric of racism. Smith contends that in dehumanizing the rapists as savages, wolves, and beasts, the press shaped the discourse around the event in ways that inflamed pervasive fears about black men. Given the chilling parallels between the media representations of the Central Park rape and the sensationalized coverage of similar allegations that in the past frequently culminated in lynchings, one could hardly be surprised when Donald Trump took out a full-page ad in 4 New York newspapers demanding that New York bring back the death penalty, bring back our police. Other media spectacles suggest that traditional gender-based stereotypes that oppress women continue to figure in the popular construction of rape. In Florida, for example, a controversy was sparked by a jury's acquittal of a man accused of a brutal rape because, in the juror's view, the woman's attire suggested that she was asking for sex. Even the press coverage of William Kennedy Smith's rape trial involved a considerable degree of speculation regarding the sexual history of his accuser. The racism and sexism written into the social construction of rape are merely contemporary manifestations of rape narratives emanating from a historical period when race and sex hierarchies were more explicitly policed. Yet another is the devaluation of black women and the marginalization of their sexual victimizations. This was dramatically shown in the special attention given to the rape of the Central Park jogger during a week in which 28 other cases of first-degree rape or attempted rape were reported in New York. Many of these rapes were as horrific as the rape in Central Park, yet all were virtually ignored by the media. Some were gang rapes, and in a case that prosecutors described as one of the most brutal in recent years, a woman was raped, sodomized, and thrown 50 feet off the top of a 4-story building in Brooklyn. Witnesses testified that the victim screamed as she plunged down the air shaft. She suffered fractures of both ankles and legs, her pelvis was shattered and she suffered extensive internal injuries. This rape survivor, like most of the other forgotten victims that week, was a woman of color. In short, during the period when the Central Park jogger dominated the headlines, many equally horrifying rapes occurred. None, however, elicited the public expressions of horror and outrage that attended the Central Park rape. To account for these different responses, Smith suggests a sexual hierarchy in operation that holds certain female bodies in higher regard than others. Statistics from prosecution of rape cases suggest that this hierarchy is at least one significant, albeit often overlooked, factor in evaluating attitudes toward rape? A study of rape dispositions in Dallas, for example, showed that the average prison term for a man convicted of raping a black woman was 2 years, as compared to 5 years for the rape of a Latina and 10 years for the rape of a white woman. A related issue is the fact that African American victims of rape are the least likely to be believed. Registered. The Dallas study and others like it also point to a more subtle problem: neither the anti-rape nor the anti-racist political agenda has focused on the black RAEAEE wet victim. This inattention stems from the way the problem of rape is conceptualized within anti-racist and anti-rape reform discourses. Although the rhetoric of both agendas formally includes black women, racism is generally not problematized in feminism, and sexism is not problematized in anti-racist discourses. Consequently, the plight of black women is relegated to a secondary importance. The primary beneficiaries of policies supported by feminists and others concerned about rape tend to be white women, and the primary beneficiaries of the black community's concern over racism and rape tend to be black men. Ultimately, the reformist and rhetorical strategies that have grown out of anti-racist and feminist rape reform movements have been ineffective in politicizing the treatment of black women. Race and the anti-rape lobby. Feminist critiques of rape have focused on the way that rape law has reflected dominant rules. A 369. And expectations that tightly regulate the sexuality of women. In the context of the rape trial, the formal definition of rape as well as the evidentiary rules applicable in a rape trial discriminate against women by measuring the rape victim against a narrow norm of acceptable sexual conduct for women. Deviation from that norm tends to turn women into illegitimate rape victims, leading to rejection of their claims. Historically, legal rules dictated, for example, that rape victims must have resisted their assailants in order for their claims to be accepted. Any abatement of struggle was interpreted as the woman's consent to the intercourse, under the logic that a real rape victim would protect her honor virtually to the death. While utmost resistance is not formally required anymore, rape law continues to weigh the credibility of women against narrow normative standards of female behavior. A woman's sexual history, for example, is frequently explored by defense attorneys as a way of suggesting that a woman who consented to sex on other occasions was likely to have consented in the case at issue. Past sexual conduct as well as the specific circumstances leading up to the rape are often used to distinguish the moral character of the legitimate rape victim from women who are regarded as morally debased or in some other way responsible for their own victimization. This type of feminist critique of rape law has informed many of the fundamental reform measures enacted in anti-rape legislation, including increased penalties for convicted rapists and changes in evidentiary rules to preclude attacks on the woman's moral character. These reforms limit the tactics attorneys might use to tarnish the image of the rape victim, but they operate within pre-existing social constructs that distinguish victims from non-victims on the basis of their sexual character. Thus, these reforms, while beneficial, do not challenge the background cultural narratives that undermine the credibility of black women. Because black women face subordination based on both race and gender, reforms of rape law and judicial procedures which are premised on narrow conceptions of gender subordination may not address the devaluation of black women. Much of the problem results from the way that certain gender expectations for women intersect with certain sexualized notions of race that are deeply entrenched in American culture. Sexualized images of African Americans go all the way back to Europeans' first engagement with Africans. Blacks have long been portrayed as more sexual, more earthy, more gratification-oriented. These sexualized images of race intersect with norms of women's sexuality, norms that are used to distinguish good women from bad, Madonnas from whores. Thus, black women are essentially prepackaged as bad women in cultural narratives about good women who can be raped and bad women who cannot. The discrediting of black trademark women's claims is the consequence of a complex APAA intersection of a gendered sexual system, 1. that constructs rules appropriate for good and bad women, and a race code that provides images defining the allegedly essential nature of black women. If these sexual images form even part of the cultural imagery of black women, then the very representation of a black female body at least suggests certain narratives that may make black women's rape either less believable or less important. These narratives may explain why rapes of black women are less likely to result in convictions and long prison terms than are rapes of white women. Rape_law_reform measures that do not in some way engage and challenge the narratives that are read onto black women's bodies are unlikely to affect the way that cultural beliefs oppress black women in rape trials. While the degree to which legal reform can directly challenge cultural beliefs that shape rape trials is limited, the very effort to mobilize political resources toward addressing the sexual oppression of black women can be an important first step in drawing greater attention to the problem. One obstacle to such an effort has been the failure of most anti-rape activists to analyze specifically the consequences of racism in the context of rape. In the absence of a direct attempt to address the racial dimensions of rape, black women are simply presumed to 370 the intersection of race and gender. Be represented in and benefited by prevailing feminist critiques. 3. Anti-racism and rape anti-racist _ critiques of rape law. Focus on how the law operates primarily to condemn rapes of white women by black men. While the heightened concern with protecting white women against black men has been primarily criticized as a form of discrimination against black men, it just as surely reflects devaluation of black women. This disregard for black women results from an exclusive focus on the consequences of the problem for black men *. Of course, rape accusations historically have provided a justification for white terrorism against the black community, generating a legitimating power of such strength that it created a veil virtually impenetrable to appeals based on either humanity or fact. Ironically, while the fear of the black rapist was exploited to legitimate the practice of lynching, rape was not even alleged in most cases. The well-developed fear of black sexuality served primarily to increase white tolerance for racial terrorism as a prophylactic measure to keep blacks under control. Within the African American community, cases involving race-based accusations against black men have stood as hallmarks of racial injustice. The prosecution of the Scottsboro Boys and the Emmett Till tragedy, for example, triggered African American resistance to the rigid social codes of white supremacy. To the extent that tape of black women is thought to dramatize racism, JT is usually cast as an assault on black manhood, demonstrating his inability. In women, the direct assault on black womanhood is less frequently seen as an assault on the black community. The sexual politics that this limited reading of racism and rape engenders continues to play out today, as illustrated by the Mike Tyson rape/accused of raping them trial. The use of anti-racist rhetoric to mobilize support for Tyson represented an ongoing practice of viewing with considerable suspicion rape accusations against black men and interpreting sexual racism through a male-centered frame. The historical experience of black men has so completely occupied the dominant conceptions of racism and rape that there is little room to squeeze in the experiences of black women. Consequently, racial solidarity was continually raised as a rallying point on behalf of Tyson, but never on behalf of Desiree Washington, Tyson's black accuser. Leaders ranging from Benjamin Hooks to Louis Farrakhan expressed their support for Tyson, yet no established black leader voiced any concern for Washington. Thus, the fact that black men have often been falsely accused of raping white women underlies the anti-racist defense of black men accused of rape even when the accuser herself is a black woman. As a result of this continual emphasis on black male sexuality as the core issue in anti-racist critiques of rape, black women who raise claims of rape against black men are not only disregarded but also sometimes vilified within the African American community. One can only imagine the alienation experienced by a black rape survivor such as Desiree Washington when the accused rapist is embraced and defended as a victim of racism while she is, at best, disregarded and, at worst, ostracized and ridiculed.